ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ,
ಎರಡಲ್ಲಿ ಲಾಸ್ಟ್
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಪ್ರೆಸ್ ಮ್ಯಾಟರ್ ಸುಮ್ಮನೆ ಲಿಸ್ಟೇ ಆಗಿಲ್ಲ.
ಒಂದ್ ನಿಮಿಷ, ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗೋದೇ ಕಷ್ಟ, ಅದ್ರಲ್ಲಿ ಬರ್ದೇ ಇರೋದ್ ಬೇರೆ.
ಇಲ್ಲ ಮೇಲಾಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇತ್ತು.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಸ್ಮಾಲ್ ಸಬ್ಮಿಷನ್ ಟುಮಾರೋ.
ವೇಟ್ ಫ್ರೆಶ್ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ.
ಸುಮ್ಮನೆ ಲಾಸ್ಟ್ ಟೈಮ್ 25 ರೀಚ್ ಆಗಿಲ್ಲ ಸುಮ್ಮನೆ, ಸುಮಾರು ಪೆಂಡಿಂಗ್ ಇದೆ ಸುಮ್ಮನೆ 6 ಮಂತ್ ಆಗಿದೆ
ಸರ್. 25 ತಗೊಳ್ದೇ ಇರೋದ್ರಲ್ಲಿ ಬರುತ್ತೆ, ಕೊಡಿ.
ಮೇಲಾಡ್ ಟುಮಾರೋ.
There's some urgency. The Lordship may have a date.
ಏನಾಗಲ್ಲ, ಕೊಡಿ ಪ್ಲೀಸ್. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ ಕೊಡಿ, ಬರುತ್ತೆ, ಕೊಡಿ.
ಗಿವನ್ ಡೇಟ್.
ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್. ವೈ ಆರ್ ಯು ಆಲ್ ವೈಟಿಂಗ್? ಐ ಡೋಂಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಏನ್ 2:30 ಎಲ್ಲ ತಗೊಳಕ್ ಆಗಲ್ಲ, ಕೊಡಿ. So what?
Madam.
It's all right. Why sir? Fresh matter? ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಈ ವಾರ ಯಾವ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು ಇಲ್ಲ. ಲಿಸ್ಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ನೋಟಿಫೈಡ್. ಪ್ಲೀಸ್ ಗಿವ್. ಎಸ್ ಎಸ್, ಕೊಡಿ ಎಲ್ಲ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಕೊಡೋಂಗಿದ್ರೆ ಕೊಡಿ.
ಟುಮಾರೋ
give everything. Today, this week, no fresh matters. I've already notified the list. Unless there is something head going, only then.
My lord.
Harassment is not head going at all.
My lord, 20. My lord.
ಅಂತದಿದ್ರೆ ಕೊಡಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ. ಅಯ್ಯೋ, so what sir? So what sir? ಬರತ್ ಬೇಲ್ ತಗೊಳ್ಳಿ, ಬೇಲ್. Then don't worry. Why will become infructuous sir? ಏನ್ infructuous ಆಗಲ್ಲ ಸರ್, ಕೊಡಿ.
My lord.
ಅಲ್ಲ, ಮೆಮೊಗಳು ಕೊಟ್ಬಿಡಿ. ಯಾಕೆ ಈ ವಾರ ಏನಿಲ್ಲ, ಕೊಡಿ.
My lord.
Give all the memos. Harassment is not a ground for urgency at all.
My lord.
Vacating stay ಕೊಡಿ.
Your lordship, end of the list, my lord.
Wait, end of the list. Vacating stay ಎಲ್ಲೆಲ್ಲಿದೆ ಕೊಡಿ.
ಟುಮಾರೋ.
Then all of you want end of the list, is it?
My lord.
All of you want end of the list? What is this?
498 for
recall application ಹಾಕಿ ಬರುತ್ತೆ.
My lord.
ಈ ತರ ಆದ್ರೆ ಏನು ತಗೊಳಕ್ಕಾಗಲ್ಲ. ಮೆಮೊ ಕೊಟ್ಬಿಡಿ.
My lord.
Vacating stay ಎಲ್ಲ ಕೊಡಿ.
My lord.
All vacating stay applications you give.
Lordship's pending matter.
Fresh matter next week. Next week ಬರುತ್ತೆ.
Lordship's pending.
ಅಯ್ಯೋ, ಬರುತ್ತೆ ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನಾಳೆ ನಾಡಿದಂತೂ ಆಗಲ್ಲ. ಕೊಡಿ.
Lordship's pending matter.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಯಾವತ್ತು ಡೇಟ್? ಯಾವ ವರ್ಷದ್ದು? 23 ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇನೆ ಬರೋದು. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ ಏನ್ ಪರವಾಗಿಲ್ಲ, ಎಲ್ಲ ಕೊಡಿ. ಗಿವ್ ದ ಮೆಮೋಸ್.
My lord. 26.
ಪ್ಲೀಸ್ ಟುಮಾರೋ
ಎಲ್ಲ ಕೊಡಿ ಮೆಮೋಸ್.
My lord.
ಟುಮಾರೋ
ಮೆಮೋಸ್ ಕೊಡಿ.
My lord.
ಮೆಮೋಸ್ ಕೊಡಿ ಸರ್. ನಾನು ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ಹಾಕ್ಸ್ತೀನಿ, ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್, ಈ ವಾರ.
My lord.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್. ವೈ?
My lord.
ಪರ್ಚೇಸ್ ಇಲ್ಲ, ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಇದೆಯಾ? ಬಿಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ, ಕೊಡಿ. ಬೇಲ್ ಡೋಂಟ್ ಕನ್ವರ್ಟ್ ದಿಸ್ ಕೋರ್ಟ್ ಟು ಬೇಲ್ ಕೋರ್ಟ್ ಎಕ್ಸೆಪ್ಟ್ ಇನ್ ಅಟ್ರಾಸಿಟೀಸ್ ಕೇಸಸ್.
My lord.
ಪರವಾಗಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ.
My lord.
ಬರುತ್ತೆ, ಡೇಟ್ ಕೊಡಲ್ಲ, ಕೊಡಿ. ಈ ವಾರದ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಆಗೋಗಿದೆ, ಡೇಟ್ ಇಲ್ಲ, ಕೊಡಿ. ಯಾಕೆ ನೆನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ರಲ್ಲ ಅದು?
My lord.
ನಾಳೆಗೆ ಹಾಕಿ ಮಾಡಿ.
My lord.
ಸಾರಿ, ಅಯ್ಯೋ ಪರವಾಗಿಲ್ಲ, ಬಿಡಿ.
My lord.
ಫಾರ್ ವಾಟ್?
My lord.
ಬನ್ನಿ.
My lord.
Give the memos.
My lord.
I seriously don't understand. Please give the memos. No fresh matter to the. No problem, sir. I can't help. Give it, yes. You give it, sir. Which year, sir? It is notice is issued, sir. Then it did not reach, is it? Not reached matters kodi. ತಗೊಳ್ಳಿ.
My lord, my lord,
Previous bench ಅಲ್ಲಿ which have not seen the light of the day ಅದ್ ಮಾತ್ರ ಕೊಡಿ. Notice ಆಗಿದ್ರೆ I am going to adjourn it to 2027 without granting an interim order.
my lord,
Yes.
my lord, 26th,
My lord,
my lord,
already
26th,
ಬರೋದೇ ಇಲ್ಲ.
my lord,
ನೋಟಿಸ್
My lord.
ರೀಚ್ ಆಗದೆ ಇರೋದು ಮಾತ್ರ ಕೊಡಿ.
my lord,
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದ್ರೆ 27ಕ್ಕೆ ಹಾಕ್ತಾ ಇದ್ದೀನಿ. ಎಸ್ ಕೊಡಿ.
my lord,
ಗಿವ್ ಅದು ಇದು ಮೇಡಮ್ ನೈಜೀರಿಯಾ ಕೊಡಿ.
my lord, my lord,
ಪ್ರಾಬ್ಲಮ್ ಮೇಡಮ್. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ
my lord, 26th,
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮೆಮೋಸ್. ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್ ಇನ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್.
my lord,
ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್.
Your lordship,
my lord ಇದ್ರಲ್ಲಿ ಒಂದು
ಗಿವ್
stay
ಆಲ್
ಇದೆ.
ದಿ ಮೆಮೋಸ್ ಇನ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್.
my,
ವಿ ವಿಲ್ ಗೆಟ್ ಇಟ್ ಲಿಸ್ಟೆಡ್. ನಾನು 1000 ಎಲ್ಲ ತಗೊಳಕ್ಕಾಗಲ್ಲ, ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ತಗೊಂಡ್ ಮಾಡ್ತೀನಿ.
My lord,
ಎಲ್ಲ ಮೆಮೋ ಕೊಟ್ಬಿಡಿ.
ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಅಲ್ಲಿ
my lord,
ಯಾವ್ದಾರು ಇರ್ಲಿ ಮೆಮೋ ಕೊಟ್ಬಿಡಿ ಸರ್. ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್, ಕೊಡಿ ಸರ್.
my lord ಇದು ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ my lord.
ಮೆಮೋ ಕೊಡಿ ಸರ್. ಮೆಮೋಗಳು ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
end of the list, my lord.
ಇಲ್ಲ ಮೆಮೋ ಕೊಡಿ.
My lord,
my lord,
Lordship, end of the list.
my lord, 26th,
ನೋ ಡೇಟ್ ಇನ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಪ್ಲೀಸ್. ಐ ಟೆಲ್ ಯು, ನೋ ಡೇಟ್ ಇನ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್. ನನಗೆ ಎಷ್ಟಾಗುತ್ತೆ ದಿನಕ್ಕೆ ಅಷ್ಟು ಹಾಕ್ಸ್ತೀನಿ ನಾನು.
my lord,
my lord,
ನೋ ಡೇಟ್. ಒಂದ್ ನಿಮಿಷ, 1 minute. ಸೆಟಲ್ಮೆಂಟ್ ಇನ್ ಯಾವ್ದಾರು ಇದೆಯಾ? ಆಲ್ ಸೆಟಲ್ಮೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ
my lord, 26th charge is there, your honor.
ಆಲ್ರೆಡಿ.
My lord,
ಅದು ನಾಟ್ ರೀಚ್ ಕೊಡಿ.
My lords,
my lord,
lord,
Petitioner is not able
26th,
to conduct his business, my lords. The petitioner is not able to conduct his business, my lords. He is being harassed by the
ಓ
police.
ನೋ ಪ್ರಾಬ್ಲಮ್ಸ್. ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಾ?
My lords, I have secured the bail, my lords. I am not able
My
to.
lord.
my lords, end of the
My
list.
lords, out of.
ನೋ ಅದೆಲ್ಲ
My lord.
ಅದೆಲ್ಲ ರೀಸನ್ನೇ ಅಲ್ಲ. ದಟ್ ಇಸ್ ನಾಟ್ ದಿ ರೀಸನ್. ದಟ್ ಇಸ್ ನಾಟ್
The
ರೀಸನ್ ಫಾರ್
lordship-
ಅರ್ಜೆನ್ಸಿ ಅಟ್ ಆಲ್.
my lord ಇದು ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ my
ಫ್ರೆಶ್
lord.
ಮ್ಯಾಟರ್ ಅಲ್ವಾ?
Fresh matter, my lords. It's more than 3 weeks. It's
So what, sir? How many can I
tried to
take?
move 2-3
How many can I take? Go before any other court and move and come.
My apologies, my lords.
Go before any other court and move and come. We'll see.
My lords,
My
end
lord,
of the list.
Because I'm showing indulgence, you're abusing it. Kodi sumne.
my lord, my lord,
Kodi, give all the memos.
my lord ಇದು ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್
Give all the memos.
my lord ಇದು ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್
Wait.
my lord ಇದು ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ my lord. ಇದು ನಿನ್ನೆ ಬಂದಿರೋ ಮ್ಯಾಟ್ರು.
ಸರಿ, ಅದಕ್ಕೇನೀಗ?
ಟುಮಾರೋ ಲಿಸ್ಟ್
ಕೊಡಿ. Next
My
week
lord.
ಬರುತ್ತೆ ಕೊಡಿ.
My lord, the petitioners are.
ಅಪ್ಲೈಸ್ my lord.
ಏನಾದ್ರೂ ಇರ್ಲಿ, ಪ್ಲೀಸ್ ಗಿವ್ ಇಟ್. ಈ ವಾರ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇಲ್ಲ. ಬೇಲ್ ಇದೆ
Your
ತಾನೆ?
lordship, end of the list.
Why? Where hospitalized? ಬೇಲ್ ಆಗಿದೆಯಲ್ಲ. ಅದು ನಾನು ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡೋದೇ ಇಲ್ಲ. No, I will not relax. You file that relaxation before the concerned court. No, sir.
my lord, my lord,
My lords, end of
My
the
lord.
list, my lords.
ಈ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲ ಗೊತ್ತು ನನಗೆ. Nothing doing. You appear or bail will get cancelled.
my lord,
ಉತ್ತರ ಪ್ರದೇಶ ಬರಕ್ಕಾಗಲ್ವಾ? ಅದು you move that matter before the same court seeking relaxation.
my lord, my lord,
No, sir. ಬರ್ಲಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ನಥಿಂಗ್. ಇವೆಲ್ಲ ಸುಮ್ನೆ ಹೇಳಿ. ಸರ್ಟಿಫಿಕೇಟ್ಸ್ ಹೆಂಗ್ ಬರುತ್ತೆ ಗೊತ್ತು. Yes. No, what's the offense? 498 and ಕೊಡಿ 230. Yes.
my lord, my lord,
My lord, may I make one matter, my lord, at the end?
my lord, 26th,
Huh? Amend it. Amend it, sir.
my lord, my lord,
My lord.
my lord,
What amendment? See, it's 11 o'clock. How long do I?
End of the list.
I'll
my
get up at 4:45 and go every day. This is take. Please give the memos.
Your lordship, end of
Please give
the
the
list.
memos. No 2:30, no tomorrow. Give the memos.
My lord,
Give all the memos.
may I make one submission?
If you want to give the memos. Yes.
Your lordship, we are under the threat of arrest, your lordship.
Nothing doing. Give the memos.
End of the list.
ಏನಾರು ಆಗಿರ್ಲಿ. Give the memos. sir. ಈ ತರ chaos ಫಿಶ್ ಮಾರ್ಕೆಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಅಲ್ಲ, ಯಾವ್ದೋ ಮಾರ್ಕೆಟ್ ಆಗಿದೆ. ಕೊಡಿ ಇಲ್ಲಿ.
My lord, may
Nothing. Give the memos. If you want to give the memos, sir, please.
my lord, may I make one?
ಈ ವಾರ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಯಾವ್ದು ಇಲ್ಲ. ಅದು ಬರುತ್ತೆ ಅದ್ರ ಪಾಡ್ಗೆ ಬಿಡಿ.
my lord,
Give all the memos, sir.
My lord, may I make one submission?
No submission also, sir. Yes.
My lord.
Call the cases, please.
Lordship,
So what? You want to get
Being
married?
spoken to, my lords.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
My lord,
Lordship.
being spoken to.
ಎಲ್ಲ ಕೊಡಿ.
My lord, 138 connected matters.
If you want to give the memos, give all the memos.
My lord, 7 connected matters.
All the memos, no dates on any memo, please give it.
End of
No dates on any memos, give it, yes.
My lord, 6 connected matters in 138.
ಕೊಡಿ sir, memo ಕೊಡಂಗಾರೆ ಕೊಡಿ.
My lord, once.
No, I am not granting any date. This is the chaos, I am not taking any, giving any date. ಸುಮ್ನೆ, what is all this? ಕೊಡಿ sir. ಪರವಾಗಿಲ್ಲ ಕೊಡಿ.
Your Lordship,
Indulgence ತೋರಿಸಿ
My lord,
ತೋರಿಸಿನೇ ಆಗಿರೋದು ಹಿಂಗೆ.
7 connected matters in.
No, in well 2:30 I will stop. Give it, give
My
it.
lord,
Lordship, kindly leave, my lords.
Give all the memos, please. Give all the memos. ನೀವು ಕೊಡಿ ಎಲ್ಲ.
My lords,
ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ
2:30.
sir. ಪರವಾಗಿಲ್ಲ, ಆಯಿಲ್ ಟ್ಯಾಂಕರ್ ಏನ್ ತೊಂದ್ರೆ, ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. Nothing, give. Call the cases, please. Yes.
My lord, 2:30.
No 2:30, no tomorrow. Yes.
My lord, 2:30.
No, I am not taking any memo. Yes.
My lord, I am,
ಪರವಾಗಿಲ್ಲ, ಏನ್ ಮಾಡಕ್ಕ.
my lord, I am a retired,
Lords, kind leave, my lords, one matter for 2:30.
India, my lord.
Given date for today, my lord.
No, can't help, sir. Yes.
My lord, it's
Not
a
kindly, my
Nigerian
lord.
national, my lord, it's a-
Nigerian ತಗೊಳ್ಳಿ madam ಅದು.
My lord,
You have to go back to Nigeria.
I will go back.
Yes.
My lord, there is one office objection, my lord, because of which.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ, Nigerian matter
my lord, I
ತಗೊಳ್ಳಿ.
am a retired servant, my lord.
Nothing,
30
nothing.
years
Yes,
in the
call the
army.
case. Yes.
My lord, kindly,
Mahesh
my
CM.
lord. My lord,
One
kindly,
submission, my
my
lord. My lords, being spoken to, my lord.
Oh, sir, no memos, please. Stop. Stop. Yes.
One submission, my
No
lord.
memos, please. Yes.
I'm a-
Serial number 27. my
Withdraw
lord.
ಮಾಡ್ಬೇಕಾ? Withdraw ಕೊಡಿ.
My lord, I am a
My lords,
retired
being
No
spoken to,
memos,
my lords.
please. Yes.
kindly, my lord.
No, my kindness is misuse. Nothing doing. Yes. Is this the way to behave? ಯಾವ್ದ್ರಲ್ಲೂ ಮೆಥಡೇ ಇಲ್ಲ. ಪೋಸ್ಟ್ ಮಾಡಿಸಿ, ಎಷ್ಟು ಪೋಸ್ಟ್ ಮಾಡ್ಸಕ್ಕಾಗತ್ತೆ? Can I take 1000 every day? All of you have grievance. ಎಷ್ಟು ಹಾಕ್ಸಿದ್ರು ಅಷ್ಟೇನೆ. What should happen to me? Nobody understands. What is possible by me, I will do it. Yes.
This number 2, my lord, serial number 70. Yesterday it was listed in the fresh matter. Notice has been issued and date has been given to 16 in the fresh matter list. So some days notice.
ಮುಂಚೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
So they.
ಈಗ ಅಮೆಂಡ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅದು.
ಅಲ್ಲ, ಇವತ್ತು list ಆಗಿದೆ.
ಆಗಿದೆಯಾ? ಆಯ್ತು, ಅವತ್ತು ರೀಚ್ ಆದಾಗ ಹೇಳೋಣ.
Lords, kind leave. Pension for adjournment.
No mentioning. Yes.
Appearing for the petitioner.
Ah,
My lord, it's for framing of charges.
maybe, yes. Give the memo.
Lord, wife has filed a rape case against me.
Very good, sir. Give it. Yes. Give it, sir. Give it. No problem. Give the memo. No date. Fresh matter ತಾನೆ. ಬರುತ್ತೆ.
41 notice ಆಗಿದೆ.
ಪರವಾಗಿಲ್ಲ, ಹೋಗಿ ಅಪಿಯರ್ ಆಗಿ. Yes. Speedy disposal, give it. Yes. No, ಯಾವ 86 ಇಲ್ಲ, 106 ಇಲ್ಲ. Nothing. Settlement ಯಾವ್ದಾರು ಇದ್ರೆ ಕೊಡಿ. Yes.
My lord, one for memo for withdrawal, my lord.
Yes, Mahesh.
My lord, the respondent police have registered a case against the petitioner under section 143.
Yes, what do you want? ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ, ಕೊಡಿ. Yes. ಅದೇನ್ ಪಾಠ ಮೇಡಮ್? ಜೂನಲ್ಲಿ ಹಾಕೋಣ ಬಿಡಿ. Yes. ಆಯ್ತು. ತಗೊಳ್ಳಿ ಮ್ಯಾಮ್, ತಗೊಳ್ಳಿ.
Under section 143, 188, 427 and 430, 149 of IPC. The petitioner is a practicing lawyer and a senior advocate of Tumkur Bar of Restraint. His name was not mentioned in
What
the
were you
FIR.
doing for all these years?
In violation of 144, my lords.
Identification was made to the photographs. 144 ಕಂಡಿದ್ದೀನಿ. Yes. ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ಗೆ. ಏನು ಸರ್ಕಾರ ಈ ತರ ಕೆಲಸ ಮಾಡ್ತದೆ ಅಂತ ತೋರಿಸಿದ್ರೆ ಪ್ರಾಬ್ಲಮ್. Yes. The petitioners are before this court. Petitioner accused number 1 is before the court calling in question registration of a proceedings in CC 2050/2020. The allegation against the petitioner is as follows, page 31. A perusal of which would not indicate any ingredient of the offences, as only bald and vague statements are made of the participation of the petitioner in a protest in violation of the orders. Violation of the orders is the allegation. In that light, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
POCSO police.
For the petition, my lord. Offense under section 420, 406.
506B.
Allegation is that, my lord,
ಎಷ್ಟು ದುಡ್ಡು ಕೊಡ್ಬೇಕು?
ಇಲ್ಲ ದುಡ್ಡೇನ್ ಕೊಡ್ಬೇಕಿಲ್ಲ, ನಾವು ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿದ್ವಿ. ಐ ಹಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಫೋಟೋಸ್ ಮೇಲೆ ಡೆಕೋರೇಷನ್
Photos.
21 ಲಕ್ಷ ಕೊಡ್ಬೇಕು.
ಡೆಕೋರೇಷನ್ ಅಲ್ಲ 21 ಲಕ್ಷ ಅಲಿಗೇಷನ್. ನಾವು ಡೆಕೋರೇಷನ್ ಮಾಡೋದಕ್ಕೋಸ್ಕರ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿತ್ತು. ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಡೆಕೋರೇಷನ್ ಮಾಡಿದ್ವಿ. ಅವರು ಡೆಕೋರೇಷನ್ ಮಾಡಿಲ್ಲ ಅಂತಂದು ದೇ ಫೈಲ್ಡ್ ಎ ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್.
ಅದು ಗೊತ್ತಾಯ್ತು ಆಗಿದೆ. Yes. In the meantime, next, please. Notice.
4.
Returnable by 21st April. Yes, next. 1 HCGP 2 emergent notice returnable by 27. Next.
4.
In the meantime, next.
9.
Millard.
Stay tight, sir. Yes. 451, 457. Notice. Learned HCGP is directed to accept notice. Next.
6.
Payment of wages act. I was not a director on the date of the commission of the offence.
Heard the learned senior counsel Dhyan Chinnappa appearing for the petitioner. The petitioner, who was once a director of the company which is now director,
Was a director in 2020.
director, was a director of a company which is now facing allegations of violation of payment of wages act. The learned senior counsel will take this court to the documents appended to the petition to demonstrate that the petitioner had resigned on 20th July 2020. And the allegations have sprung after the said date. In that light, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
How do you remember that date?
7.
Yes.
For the petitioner. Because the charge sheet is filed for the offences of non-cognizable offences. They have not followed mandatory provisions of section 155. They should
Permission
obtain-
ತಗೊಂಡಿಲ್ವಾ?
ತಗೊಂಡಿಲ್ಲ.
How do you demonstrate?
There is no permission at all in that.
How do you demonstrate ಅಂದ್ರೆ?
I would like to draw your lord's kind attention to ink page 13. Last 2 lines. Sorry, ink page 24. Last
Yes, government.
ಸದರಿ ವಿಚಾರದಲ್ಲಿ ಮೇಲಾಧಿಕಾರಿಗಳೊಂದಿಗೆ ಚರ್ಚಿಸಿ ಅವರ ಮಾರ್ಗದರ್ಶನದಂತೆ ಈ ದಿನ ಆತನ ವಿರುದ್ಧ ಸ್ವತಃ NCR ನಂಬರ್ ಸೋ ದಾಖಲು ಮಾಡಿರುತ್ತೇನೆ.
NCR ದಾಖಲು ಮಾಡಿ ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ.
ಅಲ್ಲ, ಹೈಯರ್ ಆಫೀಸರ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಪರ್ಮಿಷನ್ ತಗೋಬೇಕು ಅಂತ.
ಅದು ಗೊತ್ತು, ಕಾನೂನು ಗೊತ್ತು, ಅದನ್ನ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ. ಏನು ಅಂತ ಕೇಳಿದ್ದ ಅಷ್ಟೇ.
110 proceedings violation ಇತ್ತು.
ಏನ?
110 proceedings initiate ಮಾಡಿದ್ರು.
What proceedings?
110 proceedings.
ಆಯ್ತು ಸರ್, ಪರ್ಮಿಷನ್ ಎಲ್ಲಿದೆ?
Please.
155(2) ಪರ್ಮಿಷನ್ ಎಲ್ಲಿದೆ?
NCR ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ.
NCR ರಿಜಿಸ್ಟರ್ ಯಾರು ಮಾಡ? ಮೇಲಿನ ಅಧಿಕಾರಿಗಳಿಗೆ ನೋಡಿ. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಪರ್ಮಿಷನ್ ಎಲ್ಲಿದೆ? ಅದು NCR ರಿಜಿಸ್ಟರ್ ಆದ್ಮೇಲೆ. ಬಟ್ ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ ತುಂಬ CCF 2018. ಈಗೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಇಷ್ಟು ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ?
ಲಾಸ್ಟ್ 25 ಎಲ್ಲ ಫೈಲ್ ಮಾಡ್ತೀವಿ ಬರ್ತಾ ಇದೆ.
25 ಅಲ್ಲ, 7 ವರ್ಷ ಆದ್ಮೇಲೆ ಯಾಕೆ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಪರ್ಮಿಷನ್ ತಗೊಂಡಿರೋದು ಕ್ರೈಮ್ ಆಫ್ 2014.
ಹೌದು.
17 ಸಾರಿ
17
ಕ್ರೈಮ್. ಆವಾಗಲೇ ಬರ್ಬೇಕಾಗಿತ್ತು.
ಈಗ ಗೊತ್ತಾಗಿದೆ.
ಬರಕ್ ಆಗಿಲ್ಲಲ್ಲ.
ಅಲ್ಲ ಹಾಗಲ್ಲ ಅವ್ರಿಗೆ.
1 HCGP, learned HCGP is directed to secure instructions with regard to whether the permission of the learned magistrate is obtained prior to registration of the crime. As much water has flown, the proceedings are 9 years old today. Yes. List matter on 21st. No, stay sir.
Please my lord.
ನೀವು ಬಂದಾಗ ಅರ್ಜೆನ್ಸಿ ಆಗಲ್ಲ ಸರ್.
ಅಲ್ಲ, ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ಹೌದಾ? ಯಾಕೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಸರ್?
ಅಲ್ಲ,
9 ವರ್ಷ ಆದ್ಮೇಲೆ ಯಾರು ತೊಂದರೆ? 9 ವರ್ಷ ಆದ್ಮೇಲೆ ಯಾರು ತೊಂದರೆ ಕೊಡ್ತಾರೆ? 9 ವರ್ಷ ಆದ್ಮೇಲೆ ಯಾರು ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ?
I would like to draw your lordship's kind attention to ingredients. Ingredients attract.
ಅದು ನೋಡೋಣ ಆಮೇಲೆ. ಮೆರಿಟ್ಸ್. Yes. Learned HCGP ಹೇಳಿದ್ನಲ್ಲ. Yes, next.
ಅಲ್ಲ, ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್.
21st April.
Appear for the petitioner, my lord. Annexure, my lord, serial number 8. Annexure, my lord, the order of defreezing, the application was allowed. However, conditions were imposed on me, my lord.
Where is the condition? Where are the conditions?
Page 20-21 minutes.
What indemnity bond of 10 lakhs?
10 lakhs. I'm not an accused, my lord. Charge sheet is also filed. I'm not included in the charge sheet as well. The backdrop of this is, my lord, the complainant.
Indemnity bond kodake enante?
No, my lord, the problem is, if your lordships will see at page 64, I've actually filed one surety affidavit at 64. But my lord, these are documents pertaining to Bombay, and the magistrate is, my lord, not willing to accept this. He's saying it's not in standards with.
Is the condition of defreezing, is it?
Yes.
But one indemnity bond you should give.
My lord, the
some surety
personal bond I'm willing to give, my lord. They're not willing to accept the.
Surety one accept take.
But they're not willing to accept it.
We will direct acceptance of surety.
Yes.
Yes. The petitioner is before this court calling in question an order The petitioner is before the court calling in question an order dated 31/8/2024 insofar as it imposes the condition of, impose condition of surety, is it?
Yes.
Impose condition of surety, which surety while allowing an application under 451 and 457, directing defreezement of the account of the petitioner. Heard the learned counsel Srimati Kirti Reddy appearing for the petitioner and the learned additional SPP. The petitioner is not the accused in the crime, nor is an accused while filing the charge sheet in crime number 150 of 2023. But the account of the petitioner stood frozen owing to certain money trail. The petitioner then files an application before the concerned court in 450 on invoking provisions under section 451 and 457. The concerned court allows the application by the following order.
Page 20, madam.
Page
20.
20. By the following order, the learned counsel submits that the petitioner is ready and willing to offer surety, but the said surety is not being accepted by the concerned court. In the concerned court for defreezement of the account as a surety. Yen surety kottidira madam? Where is it?
Page 64, madam.
That is agreement to sale.
Agreement, my lord, the concept of sale deed and all that does not
This will
accept.
take
Agreement to sale, madam.
agreement. Where is any other surety?
I'm willing to also give bank guarantee, madam.
Bank guarantee. Don't accept bank guarantee. Bank guarantee is as good as dismissing the application.
No, my lord, but they don't have the concept of sale deed, etc. in Bombay, and this is the exact reason
They
as
can
to
give
why
any
they're not.
surety belongs to anywhere, madam.
You give anything
But
which is
We don't have
concrete. This is
anybody in Bangalore, my lord.
Allah,
and
agreement to sale antide.
Please.
If there's anything other than this, you give surety, I'll take. Don't say bank guarantee.
I'll take instruction.
Indemnity bond ಕೊಡ್ಲಿ.
But indemnity bond, because the
Yeah,
amount is
ಆಗಲ್ಲ.
there, the amount we will not be able to recover.
But this is agreement to sale. What has happened after this ಗೊತ್ತಿಲ್ಲಲ್ಲ?
No, they're not accepting this.
No.
No.
This, after this ಅಂದ್ರೆ agreement to sale ಆದ್ಮೇಲೆ, if that is in litigation, that's the only thing. So I'll direct you to give one surety, which is free of encumbrances.
Please, ma'am.
Yes, that should be
Belongs
fine.
to anywhere. The lordship is
Anywhere, yes. The submission of the learned counsel appearing for the petitioner, as observed here and above, is the surety affidavit that is rendered is not being accepted on the score that it is an agreement of sale. In that light, I deem it appropriate to direct or permit the petitioner to offer surety which is free from encumbrance of anywhere in the country for the purpose of defreezing of the account. In the event the said surety is placed, said surety is produced in terms of the order, the investigating officer shall forthwith direct defreezement of the account without broking any further delay. With the aforesaid observation, the petition stands disposed. If there ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ move ಮಾಡಿ.
Please. I'm grateful.
My lord, I am for the prisoner. Police have filed the charge sheet. I will produce the charge next week. Kindly attend.
ಚಾಲೆಂಜ್ ಮಾಡೋದು ಬೇಡವಾ?
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೇನೆ ಕಾಪಿ ಚಾರ್ಜ್ ಶೀಟ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿಲ್ವಾ ಇಲ್ಲಿ?
ಅಲ್ಲ ಇದು FIR ಇದೆ ಕ್ರೈಮ್.
ಅಮೆಂಡ್ ಮಾಡಿ, ಸಾರಿ ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಅದುವೇ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಇದು
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾಕೆ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹೊಸದೇ ಹಾಕಿ.
ಅಲ್ಲ ಯಾಕೆ ಇದರಲ್ಲಿ ಕಂಟಿನ್ಯೂಸ್ ಯಾಕಂದ್ರೆ
ತೊಂದ್ರೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್
IFR ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿ. ಅದು ಯಾವಾಗ ಬರುತ್ತೆ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟು
ನಾನು ಯಾಕೆ ಹೇಳ್ತೀನಿ ಅಂದ್ರೆ IFR ಅಮೆಂಡ್ಮೆಂಟ್ ಎಲ್ಲದರಲ್ಲೂ ಅಲೋ ಮಾಡಬಹುದು, ಏನ್ ಚಿಂತೆ ಇಲ್ಲ. There is no bar in law that once charge sheet is filed I should not consider the FIR. But if that IA has to be allowed, it will come in IAS. Then it's very fresh ಅಲ್ಲಿ ತಗೊಳಲ್ಲ.
IA ಪ್ರೆಸ್ ಹಾಕ್ತೇನೆ.
ಹೌದು, IA ಹಾಕ್ಬೇಕಲ್ಲ. IA ಅಲ್ಲಿ ಬರುತ್ತೆ, ಬರ್ಲಿ.
Yes sir. Kindly attend next week.
List after 2 weeks. ನೀವು ಹಾಕಿದಾಗ ಮೂವ್ ಮಾಡಿ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಲೀಸ್ಟ್ ಆಗೋದು ಕಷ್ಟ
ಅಂದ್ರೆ ಅದಕ್ಕೆ ಸರ್ ಹೇಳಿದ್ದು. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್
ಅಲ್ಲ ತಾವು ಡೇಟ್ ಕೊಟ್ಟು ನಾನು 2 days ಅಲ್ಲಿ ಇದು ಫೈಲ್ ಮಾಡಿ ಬಿಡ್ತೀನಿ.
ಮಾಡಿ ಸರ್.
ಅಲ್ಲ ಡೇಟ್ ಡೇಟ್
ಮಾಡಿ. ಎಂಟ್ರಿ ಮಾಡ್ರೆ ನಿಲ್ವಲ್ಲ.
ಅಲ್ಲ ಈ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾನೆ.
ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ, ಚಾಲೆಂಜ್ ಚಾರ್ಜ್ ಶೀಟ್. ಎಸ್, ಫೈಲ್ ಅ ಸೆಪರೇಟ್ ಪೆಟಿಷನ್ ಚಾಲೆಂಜ್ ಚಾರ್ಜ್ ಶೀಟ್.
ಅಲ್ಲ
ಯಾಕೆ ತೊಂದ್ರೆ ಏನು?
ಅಲ್ಲ ಇದೆಲ್ಲ
ತೊಂದ್ರೆ ಏನು?
ಅಲ್ಲ ಒನ್ಸ್ ಅಗೇನ್ ಆಫೀಸ್ ಆಫ್ ದ ಕಂಪ್ಲೈ ಅದೆಲ್ಲ
ಅವೆಲ್ಲ ಏನಿಲ್ಲ. ನೀವು 2:30 ಮೂವ್ ಮಾಡಿ ತಗೊಂತೀನಿ ನಾನು. ಚಾಲೆಂಜ್ ಇಟ್. ಎಸ್
ಡೇಟ್ ಮೇ ಕೈಂಡ್ಲಿ
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿ, ಮೂವ್ ಮಾಡಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಲಿಬರ್ಟಿ ಟು ಚಾಲೆಂಜ್ ಚಾರ್ಜ್ ಶೀಟ್. ಎಸ್ ನೆಕ್ಸ್ಟ್. ಅದರ್ವೈಸ್ ಏನ್ ಕೇಸ್ ಇಲ್ಲ ಮೋಹನ್ ಚಂದ್ರ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲೇ ಕೇಸ್ ಇರ್ಬೋದು ನನಗೆ. FIR ಏನ್ ಕೇಸ್ ಇಲ್ಲ. ಎಸ್
Your Lordships, it's a commercial dispute wherein it's given a color of criminal case and it was already B report was filed and thereafter accepted. Then later again in revision, the petition was allowed. It was with reference to the payment. It's a money recovery suit wherein we file a
Recovery suit alla.
ಅಲ್ಲ ಅಂದ್ರೆ ಫಸ್ಟ್ ನಾವು ಹಾಕೋದು ಅವ್ರ ಮೇಲೆ we file a money recovery suit.
ಅದನ್ನೇ ನಾನು ಹೇಳಿ. ಇಲ್ಲದ್ರೆ it will never see the light of the day. Yes.
Yes, Your Lordships. Initially, the money is being given and it is a chit fund which is given the money and later.
You run a chit fund business, is it?
I also run a chit fund business.
What happened to the money that you got from the complainant?
No, that with reference to it, this was initially given to them as 5 lakhs borrowed from the chit fund and which are civil case and criminal case which are filed and in fact in
Civil case pending ಇದೆಯಾ?
Civil case pending ಇದೆ. ಈಗ ಮೊನ್ನೆ ಬಂದು they have tried to ಸ್ವಲ್ಪ payment ಮಾಡಿ they have tried to settle. It is
No, you are the one who is running the chit fund, is it?
Yes, Your Lordships.
B report ಹಾಕಿದ್ರಲ್ಲ?
B report ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. And which was also then protest memo was rejected.
The petitioner is before the court calling in question so and so. The issue arose in PCR 3652 of 2015. The prior in the PCR is as follows. Page 108. The police conduct investigation and file a B report. The B report is accepted, that is challenged before the revisional court. The revisional court upturns the acceptance of B report and therefore the petitioner is before this court. If the prior that is made as quoted here and above is noticed, it would become the fulcrum of criminal law being set into motion for the purpose of recovery of money, which is sans countenance, albeit prima facie. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the date of hearing. Next.
This is a trade union dispute. The respondent
The petitioners are members of a particular union who were agitating non-payment of statutory benefits against Wonderla management. Based on this, due to the agitation, it transpires that some orders were violated. This is given a color of crime and the criminal law is set into motion against these petitioners by registering a private complaint for the aforesaid offences. Finding no ingredient of the offences and the act of wreaking vengeance against these petitioners for having agitated for demanding statutory benefits, the further proceedings cannot be permitted to continue. There shall be an interim order of stay of further proceedings. Next.
The petitioners in this case, minutes.
Wound certificate ಇದೆಯಾ?
Please, minutes.
ಎಲ್ಲಿದೆ? Page 54, 55 ಬನ್ನಿ.
54 and 55 minutes. Minutes. The
counter case.
Incident, please, minutes. ನಮಗೆ assault ಮಾಡಿದ್ದಾರೆ and then they rammed vehicle travel ಮಾಡ್ತಿರೋ they came and rammed stabbing ಇದೆ plus they hit the iron rod. ನಮ್ಮೆಲ್ಲ minutes. 307 is filed. 28th incident ಆಗಿದೆ 10:30 I am in the hospital taking the treatment, my lord. I have produced the medical records as well.
ಇದು counter case 32 of 2024 ಅಲ್ವಾ?
Please, my lord.
Name the 27.
Please.
The petitioners are initially assaulted by the complainant and others, which becomes a crime in crime number 27 of 2024. The police have registered, the police after investigation file a charge sheet in the said crime for including offences under section 307, 427, 324 of the IPC. The impugned crime is registered in crime number 32 of 2024 as a counterblast to the crime so registered by the petitioners for offences punishable under 341, 504 and 323. In the light of
341, 323, 325, 504, 506,
325 ಇಲ್ಲಿದೆ page 19 ಅಲ್ಲಿ. ನೀವು ಅವ್ರು ಹೊಡೆದಿಲ್ವಾ?
I was in the hospital, my lords.
ಅವತ್ತು ಇನ್ಸಿಡೆಂಟ್ ಆದ ದಿನ
Incident ಆಗಿದೆ ಸರ್ 10:30 they tell that ನನಗೆ ನಾವು assault ಮಾಡಿದೀವಿ ಅಂತ. At that time I have produced medical records to state that I was in hospital.
In the light of the crime being registered as a counterblast to what the petitioners have suffered and the time at which the incident is said to have been occurred, the time the incident is said to have been occurred, it shows at 10:30 AM. The learned counsel for the petitioner has produced documents to demonstrate that them being assaulted were hospitalized and were taking treatment in the hospital, and which point in time the petitioners could not have assault. But entry in the entire antide.
Well, let's enter in the entire, the de facto complaint son allidda anta ಹೇಳ್ತಾರೆ. And then the incident took
10 ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
That's in
10
complaint.
ಗಂಟೆ ಅಂತಿದೆ ಇಲ್ಲಿ. Yes.
10ರಿಂದ 10 page number 18.
So in that light, there shall be an interim order of stay for the pay the petitioner to the next.
Please.
Next.
14.
Petition Milord.
Sandalwood, sir.
ಅಲ್ಲಿ
Notice, yes.
connected matter ಇದೆ. ಅದನ್ನು ನೋಟಿಸ್
Tag along with source.
14.
I appear for petition in this matter. My lord, the petition number 2 and 3, my lord, the petition number 1 and 2 has purchased the property.
The heard the learned counsel appearing for the petitioner. The sale transaction in the case at hand takes place in the year 2017. Alleging forgery of the said sale transaction, a complaint comes to be registered after 7 years in 2024 without a speck of explanation as to the delay that is found in registration of the complaint. Solely on that ground, there shall be an interim order of stay of further proceedings till the appearance of the complainant. The complainant appearance of the complainant. The complainant would justify a delay. The interim order would stand vacated. Yes. Subject to the aforesaid, there shall be an interim order of stay for ಹೇಳಿದ್ನಲ್ಲ. Yes, next.
15.
In the meantime.
My lord, for the
ಯಾವ್ದು ಇನ್ನೊಂದು petition tag ಮಾಡೋದು ಕೊಡಿ ಅದು.
my lords.
There's one more petition pending.
Yes, my lord, sir.
Number
1214. 1214 of 2024, my lord.
1214 of 24. ಅದ್ರಲ್ಲಿ stay ಇದೆಯಾ?
Stay ಇದೆ, my lord. Copy ಅಲ್ಲಿ.
Page 62.
62 tag same. ನೋಡೋದೇ ಇಲ್ಲ ಫೈಲ್ ನ, ಸುಮ್ನೆ ಬರ್ತಾ ಇರೋದು. ಮೆಮೊ ಮಾತ್ರ ಮೂವ್ ಮಾಡ್ತೀವಿ. You should do your duty also, sir.
Sorry, my lord.
ಮೆಮೊ ಮೂವ್ ಮಾಡೋದು ಅಷ್ಟೇ ಅಲ್ಲ, ಓದ್ಕೊಂಡು ಬರ್ಬೇಕು. ನೀವು ಮೆಮೊ ಮೂವ್ ಮಾಡೋದು, ನಾನು ಓದ್ಕೊಂಡ್ ಬರೋದು. ಚೆನ್ನಾಗಿದೆ. ಎಸ್.
17.
2 to 6, 85.
For petitioner in this case, my lord,
Next,
petition
yes.
number 1 is
18.
So much called by lordship judgment.
505.
His lordship, called by lordship judgment.
ಸುಮ್ಮನೆ ಇರಕ್ ಆಗದೇ ಇಲ್ವ ನಿಮ್ಗೆ? ಏನಾರು ಒಂದ್ ಮಾಡ್ತಾನೆ ಇರ್ಬೇಕು. ಎಸ್. ಇದನ್ನೇ ಕೊಡ್ತಾರೆ ಬೇಕಾ?
And one more is criminal petition.
ಗೊತ್ತು.
Please lordship.
Yes, government. Close it. Covered ಅಂತ ಹೇಳಿ. The petitioner is before this court seeking the following prayer. ಅಲ್ಲ, ಇದು ಬೇರೆಯವ್ರದ್ದು ಅದಕ್ಕೆ. Seeking the following prayer. The entire issue is now triggered by registration of the complaint against the petitioner. The complaint, page
Page 18, your lordship.
The complaint reads as follows. A perusal of the complaint, the learned HCGP submits that perusal of the complaint would clearly indicate that the ingredients of offence punishable under section 505 of the IPC, then 353 of the present regime, the BNS, and would submit that charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಆಗಿಲ್ಲ sir.
Investigation in the list must be permitted to be continued. The learned counsel submits that the issue in the list stands answered by the judgment rendered by this court. Court reasons court now.
Please, much obliged, lordship.
Next.
Hearing for the petition number.
Meantime.
20.
Dismissed. States.
Great.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement till the next date. The further proceedings before the concerned court shall remain state. ಎಲ್ಲ clear ಮಾಡಿದಿರಾ?
Clear ಆಗುತ್ತೆ.
Till the next date. List the matter on 21st April. Yes.
21.
POCSO.
POCSO.
ಯಾರ್ಯಾರನ್ನ ಮಾಡ್ಬೇಕು?
Victim, father and the headmasters.
Headmasters for the age.
Please.
All right, but not the victim.
Even the victim.
Victim.
Because that was the admission.
What is the age of the victim now?
Now 19 years, please.
but victim will not permit.
Because that was a.
ಪರವಾಗಿಲ್ಲ, victim cross examine ಮಾಡಿದೀರ already. ಬೇರೆ ಏನೇನ್ ಬೇಕು ಅದೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ.
I believe that our love affair ಇತ್ತು because of.
ಆಯ್ತು, love affair ಇದೆ, whatever it is. What do you do with the victim, calling the victim again and again?
Just to establish and to confront few documents.
She's already given her statement.
Please.
You already cross examined her.
Please.
ಮತ್ತೆ ಬೇರೆಯವ್ರನ್ನೆಲ್ಲ ಮಾಡಿ permit, not the victim.
Victim ಬೇಕಾಗಿತ್ತು because it was a victim.
Why?
Because now she's 19 years and the instructions is that they both were in
Age,
relationship.
what was the age at the time of the incident?
17 years. Now she is 19 years.
Right, will
1
permit.
month less 19 years.
33.5 is clear, my lords.
Huh?
33.5 is clear, my lords.
33.5 is clear, sir.
Covered by my
I have
lord's
interpreted 33.5 to say that after 18 years that trigger will not apply.
Muhammad Ali Akbar.
ಎಲ್ಲಿ? Judgment ಎಲ್ಲಿ?
Judgment ತಂದಿಲ್ಲ. I've read my lord's judgment which is reported.
I know.
449 of 2022.
Yes. Get it?
Please.
The petitioner is before the court, calling in question an order of the concerned court. But ಈಗ ಯಾವ stage ಅಲ್ಲಿ ಇದೆ? ಹಳೇದಿದೆ.
Evidence.
Order of the concerned court which rejects an application filed by the petitioner under section 311 of the CRPC in terms of its order dated 13/11/2025. The 2025. The petitioner is the accused, gets embroiled in a crime for the offences punishable under the POCSO and the IPC. The police conduct investigation and file a charge sheet. DSJ ಸಾಹೇಬ್ರೆ, ಅದು ನೈಜೀರಿಯಾದ ಒಂದು 2-3 ಇದೆ, ಅದು FRR ಕಳ್ಸೋದಿದ್ರೆ ನೀವು ಮಧ್ಯಾಹ್ನ 2:15 ಬನ್ನಿ, ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಡ. ಇವತ್ತಿದೆ ಮೇಡಮ್, 2:30 ಹಾಕಿದೀವ. ನಾಳೆ ನೆನ್ನೆದು 2 ಇತ್ತಲ್ಲ, ನೆನ್ನೆ ಇವತ್ತು ಬಂದಿದೆಯಾ ಅದು? ಇವತ್ತಿದೆ, ಅದನ್ನು ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್. Yes, I have asked him to serve a copy on you.
Please.
So and so ಏನಿದೆ? Sorry? The police conduct investigation and file a charge sheet. The filing of the issue in the list does not relate to the merit of the matter, but an application being filed by the petitioner under 16/9/2025 seeking recall of CW1, CW2, CW5 and CW6 for further cross-examination. The application comes to be rejected on the score that it is only a ruse to drag the proceedings. Therefore, the petitioner is before the court in the subject petition.
Also, my lord, there's an undertaking made by the council in the bail application before this honorable court.
As also the fact that an undertaking was rendered by the petitioner before the coordinate bench, while coordinate bench that he would cooperate with the disposal of the petition. The learned HCGP submits that in the light of the undertaking, the order of the concerned court cannot be found fault with, therefore seeks dismissal of the petition. I have given my anxious. The aforenarrated facts lie in a narrow compass at this juncture. Whether the application must, under section 311 filed by the petitioner should merit consideration favorably or otherwise. The petitioner is facing proceedings for rape and 4 and 6 of POCSO. In the event of conviction, it would go more than 10 years. In such cases, it is necessary to bring home the truth, or bring home the truth with regard to the innocence or otherwise of the petitioner, as a criminal trial is an expedition towards the discovery of truth. This is the purport of section 311 of the CRPC as interpreted by the apex court in Varsha Garg versus so and so. The only impediment would be that the victim should not be less than 18 years as on the date the application is filed. As on the date of the incident, the victim was 17 years and today the victim is 19 years old. In that light, the rigor under subsection 5 of section 33 would stand diluted to a certain extent. This court in so and so has considered this issue and has permitted examination of the victim on the score that the victim was beyond 18 years at the time when the application was filed or being considered by the concerned court. Today, it is admitted that the victim is beyond 18 years. Therefore, I deem it appropriate to allow the application filed by the petitioner and direct the concerned court to fix a date for the cross-examination of these petition, of the aforesaid CW 1256 on particular dates. The concerned court shall oversee that it would not, the allowing of the application cannot be made use of as a ruse to drag the proceedings, RUSC, ruse to drag the proceedings. For the aforesaid reasons, the following got ಆ ವರ್ಷ ಒಂದು ಕೋಟ್ ಮಾಡ್ಬಿಡಿ. ನಂದು ಒಂದು ಜಡ್ಮೆಂಟ್ ಇದೆ 33(5) ಕೊಡ್ತಾರೆ ಅದು ಅಲೋಡ್ ಅಪ್ಲಿಕೇಶನ್ ಪೆಟಿಷನ್ ಅಲೋಡ್ ಅದು ಗೊತ್ತಲ್ಲ ಡ್ರಿಲ್ ಗೊತ್ತು.
Appear for the petition, my lord. My lord, in this case, subsequent filing of this petition, recently matters been committed to the Sessions Court.
Correct. It has to be. 306 IPC.
I'm challenging the charge sheet filed at present.
No problem. 306 IPC.
Yes. I'm appearing, I would represent only petitioners 1 to 5, your lordship.
1 to 5.
Yeah, because the sixth one has been separate because he never appeared for the trial court. So he's been.
You have seen the offences, Allah?
Appear, pardon?
You have seen the offences.
Yes, offense, my lord, is
rape,
accused number 1.
Promise to marry.
Yes, accused number 1.
Abetment to suicide.
Against number 1.
Yes, sir.
So far as the accused number 2 to 6 are concerned, your lordship, the petition here 1 is the father. Petition number 2 is the mother. The petition number 5 is the paternal.
Come to page 33. 33, last 2 lines of the first paragraph.
Yes, my lord. But my lord.
But illa first nodi.
33 is the charge sheet. Yes, last 2 line. Yes. ದಿನಾಂಕ 21/12.
ದಿನಾಂಕ ಅಲ್ಲ, ಸ್ಥಳದಲ್ಲಿ A456 ಆರೋಪಿಗಳು A1, 2 ಆರೋಪಿಗಳಿಗೆ ಕುಮ್ಮಕ್ಕು ನೀಡಿ ಉದ್ದೇಶಿಸಿ so and so. So 4, 5 and 6 I will straight away stay. 1, 2 and 3 after the appearance.
No, my lord, may I request lordship to refer to the charts which I produced, my lord.
Yes.
At page number 52 to 100.
Yes.
On that day which they say on 10/11/24, from morning 10:38 AM to 12 AM they are on chat, and the boy is on MG Road, she's in the cab. That date which will never happen at 12:30, what she said, my lord.
That is a matter of evidence, sir.
This thing. But beyond which the charts which I have produced as Annexure E from page 52 to 100. And then she files a case and lordship will find.
The allegation is your son, is it? That's your son.
Yes, is the petitioner.
Your son has used her for 6 months. That's why rape on promise of marriage. That's why 69. And because you said she will not get married to her, she has committed suicide.
That's my lord. Page 111, my lord.
Yes.
An agreement is registered.
Agreement. What agreement, sir?
Restraint of marriage. Restraint of marriage, page 111.
Restraint of marriage.
111 agreement ಮಾಡ್ಕೊಳ್ತಾರೆ. ಅದರಲ್ಲಿ ತಾರೀಕು ತಾವು ದಯವಿಟ್ಟು ನೋಡಿ, ಎಲ್ಲೂ ಅದ್ರಲ್ಲಿ ಉಲ್ಲೇಖವಾಗಿಲ್ವಲ್ಲ. 12 ಆಗಿರೋ ತಾರೀಕು ಏನ್ ಹೇಳ್ತಾ 10/11/24.
If there was no suicide in this, I would have granted stay straight away.
No, in this, my lord, what happened? Father, mother, and the paternal aunt. They have nothing to do with that.
Father, mother ಗೊತ್ತಿಲ್ಲ. This 3, 4, 5 ಇಲ್ಲಿ ಯಾರು ಇದ್ದಾರೆ? Who are there?
1 and 2 are the father and mother.
1 and 2 ಬಿಟ್ಟು 3, 4,
and 5 is the paternal aunt, my lord. Paternal aunt.
That time granting stay.
4
to 7 I will stay. 4 to 7.
4 to 7 ಅಲ್ಲ, my lord. 4 to 7 ಅಲ್ಲ. 1, 2 and 5 I'm saying.
One is here.
One is the father.
Number 1 is accused number 2.
Here, only my problem, what am my lord?
Sir.
Father is the Lingayat, she's a Gowda. That agreement 111, they wanted, when we refused to get it married. That is where, my lord, the police station was involved and the agreement was registered, recorded.
No problem.
But the father and mother were never involved, let's say. So accused number 1 is concerned, there's an issue, there's a different issue. So for father,
accused number 1 is impossible.
Father, mother, and the maternal aunt, my lord.
You have used the girl, you have on the promise of marriage, because it is not that it has happened over the years. It is only 1 or 2 instances.
No, the charts you told, my lord, they were out of their house. They were never in the house at all. Charts your lordship will find from page number 52 to 100.
If there was no suicide, yes.
At least, my lord, you should consider the father, mother, and the paternal aunt, my lord.
No.
Yeah, this thing. At least that extent, my lord.
3 to the charge sheet clearly narrates, complaint narrates, statements narrate that to 4 to 7 ಏನು ಇಲ್ಲ. That I will grant.
4 to 7, is that? Charges 4 to 7.
Alla, 4, accused number 4 to 7.
4, yeah. 4 to 7.
Yes. Others, no. Yes, government. 1, forget it.
Yes.
One, don't bring it only. Yes.
Yeah.
The-
There's one, I filed on the accused number one in
ಹಾಕಿದ್ದೀರಾ?
16905, when notice is ordered, 160905. Notice have been ordered.
Tag the petition along with.
16905. or
Stay
25.
ಇದೆಯಾ?
ಇಲ್ಲ, stay ಇಲ್ಲ. ಅದು only for accused number one.
Tag the petition along with so and so. The petitioners are accused 2 to 7 are now facing proceedings for offences punishable under section 64, 69, 89, 49, 316 so and so. ಇಲ್ಲಿದೆ page 19 mark ಮಾಡಿದೆ so and so. The petitioners are the mother, father and distant relatives of accused number one. Accused number one and the daughter. Daughter
Daughter ಅಲ್ಲ. Accused one complainant.
ಅಲ್ಲ ಕಂಪ್ಲೇನೆಂಟ್
The father, 1 and 2 are the father and mother.
ನಾನು ಕೇಳ್ತಿರೋ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಿ ಸರ್. ಕಂಪ್ಲೇನೆಂಟ್ಗೂ ಡಿಸೀಸ್ಗೂ ಏನ್ ಸಂಬಂಧ?
They are not related.
Who is the complainant?
Complainant is the, just was a colleague of the accused number one.
Colleague of accused number
The
one.
one working in the same.
Who died?
Nobody died. Nobody died.
64 ಅಷ್ಟೇ.
Nobody died.
Case
The
of
offense is 64, 64, 69, 89 against accused number one.
108 ಇಲ್ವಾ ಇಲ್ಲಿ?
Death ಆಗಿಲ್ಲ. She attempted suicide.
That is what? Nobody died, is it?
Nobody died.
Accused number one petition ಕೊಡಿ.
One.
ನನ್ ಮುಂದೆ ಬಂದಿತ್ತ ಇಲ್ಲ? The petitioners are accused, ಹಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ. The petitioners are accused, sorry. The petitioners are accused 2 to 7 are now facing allegations for so and so. A perusal at the summary of the charge sheet would not indicate the ingredients of the offences so alleged against these petitioners. The petitioners are said to have come in the way of the marriage between the accused number one and the colleague of the complainant. Why complainant colleague has complained?
Complainant is colleague.
Why?
They were working in the same company.
No, what happened to, why complainant has not registered the complaint?
No, that did not happen at all. She has been resigned there. She joined another job. You want me to find last sheet I've got there also she has been terminated.
They tag this petition along with so and so. There shall be an interim order of stay of further proceedings where these petitioners till the next date of hearing. It is made clear, just because the petition is tagged, it does not mean that proceedings against accused number one is stayed. The same shall continue.
Okay.
I thought it was suicide. Yes. Next.
23.
ಅದು ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಅವ್ರು. Compromise decree ಎಲ್ಲಿದೆ?
Compromise decree is not there, my lords. Memo is,
Compromise petition ಎಲ್ಲಿದೆ ಹೋಗಿ?
memo is filed, my lords.
Where is that?
Page number 59, my lords. Annexure F. Memo is filed by the plaintiff, my lords. The petitioner is defendant number 19 in that suit, my lord.
Nothing happened after this?
My lord, since there is counter claim, suit is still in existence, my lords.
The complainant and the petitioners are the parties in OS 318 of 2012. In the said suit, a memo of compromise is filed on 23/9/2025. Due to the subsistence of a counterclaim, nothing has happened thereon. But the crime comes to be registered on 25/10/2025, alleging cheating against these petitioners. ಆಮೇಲೆ agreement ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಬೇರೆಯವ್ರಿಗೆ?
Agreement, this agreement was before the compromise.
Cheating so and so. In the light of the aforesaid circumstance of the matter being purely civil in nature and pending between the parties before the civil court in the aforesaid OS, there shall be an interim order of stay in the case at hand till the next date of hearing. Next.
24.
7A. Trap.
trap, my lord.
Failed, successful?
Success, my lord.
Successful?
Success.
Petition failed.
But connected matter, my lord, it is
Hey,
state.
ಕೊಟ್ಬಿಟ್ಟಿದೀವಾ? ಕೊಡಿ.
Page number 82, my lord. Coordinate bench, my lord.
Coordinate bench.
Page number 82, my lord.
ಎಲ್ಲಿ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಸಕ್ಸಸ್ಫುಲ್ ಟ್ರ್ಯಾಪಲ್ ಅಂತೂ ಸಾಧ್ಯವೇ ಇಲ್ಲ.
But A1 is the main person, my lord, he is the AE, my lord. So far as he is
ಅಲ್ಲಿ
concerned,
you are not caught with currency?
I caught with the
ಮತ್ತೆ?
currency, my lord. My lord, it may be clubbed along with.
No, I will dismiss both. Yes.
Maybe clubbed, my lord, along with the page number.
Tag this petition along with 10225 of 2025. List them both in the fresh matters list on Friday. ಅಷ್ಟೇ ಎರಡು ಆಯ್ತು. ನಿನ್ನೆ ಜಡ್ಮೆಂಟ್ ನೋಡಿದಿರಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮತ್ತೆ. So unless it's a failed trap, nothing.
25.
Split, 18th April, yes.
Arises out of contractual.
No, sir, go to page 25. It is not as simple as you say.
My lord, now it appears that the matter is already settled between the parties.
It is settled, no problem.
Therefore, notice may be issued, they will appear.
Notice will issue.
Yes, ma'am.
1 HCGP 2 emergent notice. Next.
27 withdrawal memo.
27 withdrawal, ma'am, in terms of
28.
execution number.
113/2017.
The subject crime springs after the order passed in execution number
113/2017.
113 so and so. In the light of the issue being projected as a counterblast to the execution proceedings, there shall be an interim order of stay of further proceedings quay the petitioner to the next date of hearing.
29.
Same. Petitioner house, opposite house.
ಮತ್ತೆ ಹೊಡೆದಿದ್ದೀರಲ್ಲ ಸರ್
ಅಲ್ಲಿ ಇಬ್ರು ಕೇಸ್ ಕೊಟ್ಟರೆ ಕೇಸ್
ಎಲ್ಲಿದೆ?
ಸೇಮ್ ಅಫೆನ್ಸ್ ರಿಜಿಸ್ಟರ್ ಮೇಲೆ.
ಇನ್ನೊಂದು ಅವರು ಹಾಕಿದಾರಾ? ಅವರು ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ ಸರ್.
ನಂಬರ್ ಕೊಡಿ.
ಪಿಟಿಷನ್ ಹಾಕಿಲ್ಲ ಸರ್.
ಪಿಟಿಷನ್
ರಿಜಿಸ್ಟರ್ಡ್ ಆಗಿದೆ.
ಮತ್ತೆ ಯಾವ್ದಾರು ಒಂದು ನಿಜ ಇರ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ ನಾವು ಐಸ್ ಕ್ರೀಮ್ ಅನ್ಲೋಡ್ ಮಾಡಿ ಅಮೌಂಟ್ ಒಳಗಡೆಯಿಂದ ತಗೊಂಡ್ ಕೊಡೋ ಹೊತ್ತಿಗೆ ಟೂ ವೀಲರ್ ಅದು ಬಂದು
ಸಿ ಪೇಜ್ 20 ಎಲ್ಲ ಅಲಿಗೇಷನ್.
ಅಲ್ಲ ಅದೇ ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಬೋತಿ
ನೋಟಿಸ್ ಮಾಡ್ತೇನೆ.
ಅಲ್ಲ ಸರ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗುತ್ತೆ, ಸ್ಟೇ ಆದ್ರೆ ಅವರು ಮಾಡ್ತಾರೆ.
ಸ್ಟೇ ಆದ್ರೆ ಕಾಂಪ್ರಮೈಸ್ ಆಗಲ್ಲ. ನೋಟಿಸ್ ಮಾಡ್ತೀನಿ ಕಾಂಪ್ರಮೈಸ್. ಸ್ಟೇ ಆದ್ರೆ ನೀವೇನು ಹೋಗಲ್ಲ ಕಾಂಪ್ರಮೈಸ್.
ನೈಬರ್ಸ್ ಇಲ್ಲಿ ಅವ್ರು ಬರ್ತಾರೆ, ಕಾಂಪ್ರಮೈಸ್ ಆಗುತ್ತೆ.
ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್ ಇದೆ. ನೀವು ಕಂಪ್ಲೇಂಟ್ ನೋಡಿ ನೀವೇ
ನೋಡಿದ್ರಿ. ಮತ್ತೆ ಇಬ್ರು ಸೇಮ್ ಕಾರ್ ನಿಲ್ಲಿಸಿದಾಗ ಟೂ ವೀಲರ್ ಬಂದು ಡಿಕ್ಕಿ ಅವರೇ ಮಾಡಿರೋದು.
ಆಯ್ತು, ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್. ಬಟ್ ಒಂದ್ ನಿಜ ಇರ್ಬೇಕಲ್ಲ.
ಸ್ಟೇ ಆದ್ರೆ ನೈಬರ್ಸ್ ಸ್ವಾಮಿ. ಅದೇ
ನೋಟಿಸ್ ಮಾಡ್ತೀನಿ, ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಅವತ್ತು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸ್ಟೇ ಕೊಡುವ. 1 HCGP 2 emergent notice, list the matter on 16th April. Returnable by 16th April.
30.
The petition number 1 is the mother-in-law, petition number 2 is
The
father-in-law.
petitioners are mother-in-law, father-in-law,
Sister-in-law.
and sister-in-law are facing proceedings under the Domestic Violence Act. Finding no ingredients of such domestic violence, while all the ingredients are against the husband who is not before the court, there shall be an interim order of stay. Quay these petitioners till the next date of hearing. Emergent notice to the respond. Next.
31.
9% interest.
9% interest in there. The amount was transferred in the 2014, my lord. The trial court was ordered only 2,40,000.
Petitioner shall serve on the counsel who represents the
As
respondent.
per the Vijayan case, I am seeking. Justice Ravindra judgment as per Vijayan case.
Correct, sir. ಅದು ಗೊತ್ತು. ಒಂದು ನಿಮಿಷ ನೋಟಿಸ್ ಕೊಡ್ಬೇಡವಾ?
Please, man.
ಮತ್ತೆ emergent notice to the respondent. There shall be an interim order of stay. Application, sorry, emergent notice to the respondent, returnable by 21st April.
Much obliged.
32.
For petition.
Who is in possession?
Question respondable to children's.
Compound ಹೊಡೆದಾಕಿದ್ದೀರಾ?
Partition suit is pending.
Family members.
ಅಲ್ಲ ಇವ್ರು ಪರ್ಚೇಸರ್ಸ್ ಕಂಪ್ಲೇಂಟ್.
ಬಟ್ ಕಾಂಪೌಂಡ್ ಹೊಡೆದಾಕಿದ್ದೀರಾ? ಅದೇ ಅಲಿಗೇಷನ್.
ಆದ್ರೆ ಇವನ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಕೇಸ್ ನಂಬರ್ 2.
Yes. 1 HCGP 2 emergent notice, returnable by the 16th April.
33.
Petition
406 and 420. Wrongly charge sheeted.
Wrongly? ಎಲ್ಲ
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಕೈ ಬಿಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಆದ್ಮೇಲೆ ಇದ್ ಮಾಡಿದ್ದಾರೆ.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ.
ಮತ್ತೆ ಹೆಂಗ್ ಪಿಟಿಷನ್ ಹೆಂಗ್ ಮೇಂಟೈನ್ ಮಾಡ್ತೀರಿ?
ಚಾರ್ಜ್ ಶೀಟ್ ಮೊದಲೇ ಹಾಕಿದ್ರಿ ಸ್ವಾಮಿ.
ಹಾ, ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ನೀವು? 33 ಅಲ್ವಾ? You are accused number 2.
Accused number 2.
Witness.
Accused number 2 ಸ್ವಾಮಿ.
Accused number 2 ಕಾರ್ ಸೇಲ್ ತಾನೆ?
ಹೌದು. ಇಲ್ಲ, ಕಾರ್ ಸೇಲ್ ಅಂತ ಹೇಳಿ ಕಾರ್ಲಿ ನಾವ್ ತಗೊಂಡೋಗಿಲ್ಲ, ಏನಿಲ್ಲ, ವ್ಯವಹಾರ ಮಾಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಮಾಡಿರೋದು.
ಕರೆಕ್ಟ್. ಅದಕ್ಕೆ ನೀವು ಸೈನ್ ಮಾಡಿದಿರಲ್ಲ ವಿಟ್ನೆಸ್ ಆಗಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಎಲ್ಲೂ
ನೋಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡಿ ಕೊಡಿ. ಫೈಲ್ ಇದೆಯಾ? Come to page 27. ಮನೆಗೆ ಬಂದು 2 ಮತ್ತು 3ನೇಯರ ಸಮಕ್ಷಮದಲ್ಲಿ
ಆರೋಪಿ ಒಂದನೆಯ
ನೀವು A3 ನ A2 ನ?
A2 ಇದರಲ್ಲಿ
1 to 3 ಆಮ್ನಿಬಸ್ ಆಗಿದೆ. ರಿಕವರಿ ಆಫ್ ಮನಿ. Anyway, 1 HCGP 2 emergent notice. Next.
34.
Husband, sir.
Husband.
Notice, yes.
Lords, against the.
1
Sir,
HCGP
there is
2
no
emergent
allegations
notice.
at all, Lords. In the statements also, Lords, no one, Lords, speak
Barley,
about
let the
this.
wife come.
Any date mechanism.
They barley, yes. Next. It's better you avoid my bench. Yes.
323, 324. After cancellation of sale deed, the false case has registered against the.
In the meantime, next.
36.
Please.
Omnibus allegation, my lords.
What omnibus? Financial fraud?
Lords, I have not committed any fraud. If my lords will take the complaint, I am named 3 times in the complaint. The incentive is mentioned on page number 21 in that table.
Oh, you're accused number 6.
I am accused number 6. I have resigned. My name is not there in
The petitioner is accused number 6. Allegations galore against other accused. The period of allegations is 1/3/2025 to 1/6/2025. The petitioner had resigned from the company by that date. The notice caused against the petitioner also was replied to in the same manner. In that light, there shall be an interim order of stay of further investigation. Further investigation only against the accused number 6 on the aforesaid score. It is made clear investigation against any other accused is not interfered with. Ilvala yarilli?
No.
Only against accused number 6, sir. Next.
37.
Petitioner in this case, Madam Chair.
Fabricated appointment order.
ಇಲ್ಲ ನಂದ್ರಲ್ಲಿ ಅದರಲ್ಲಿ ಏನಿಲ್ಲ, ನನ್ನ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ನನ್ನ ಹತ್ರ ಅಥಾರಿಟಿನೇ ಇಲ್ಲ ಲಾರ್ಡ್ಶಿಪ್. ಅಥಾರಿಟಿ ಬೈ ದಿ ಒನ್ ಪ್ರಾಂಶುಪಾಲರು ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜ್, ಅವರು ಅಲ್ಲಿಂದ ಇನ್ಫೋಸಿಸ್ ಕಂಪ್ನಿ ಕೊಡ್ತಾರೆ ಅವರು.
ನೋಟಿಸ್ 1 HCGP 2 emergent notice. ಎರಡು ಅವರೇ ಅಲ್ವಾ? HCGP accepts notice for the respondents. List on 16th.
Fresh.
Learn HCGP to go through the matter and make his submissions. Yes, next.
48.
My lord, the deceased died due to multi-organ failure, my lord. The document itself shows, your lordship may kindly see page number 59, my lord.
Yes, sir.
58 and 59, my lord. See, your lordship may kindly see 58, my lord.
Yes, sir.
As, my lord.
Deceased.
As already mentioned in PM report, death is due to multi-organ failure as a complication of acute pancreatitis. The injuries mentioned in the PM report are not sufficient to cause death in ordinary course of nature. Just because one day prior to this, my lord, there was a complaint by the petitioner number 1's mother, my lord. Just as a counterblast, he died on because of
ಅಲ್ಲ ನಿಮ್ಮ ಮೇಲೆ ಏನಿದಿಲ್ವಲ್ಲ ಅಬೆಟ್ಮೆಂಟ್ ಡೆತ್ ಮರ್ಡರ್ ಅದೇನಿಲ್ಲ
murder
118 ಇರೋದು
118
ಮತ್ತೆ 118 ಗೆ ಪೇಜ್ 37 ಗೆ bani everything is seen. No,
thereafter you last me kindly see at page number 60 my lord.
Cause of death ಎಲ್ಲ ಅಲ್ಲ ಇಲ್ಲಿ
38 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
Yes,
no such injury found.
no such injuries ಎಲ್ಲಿದೆ page
Lordship 59 my lord. Based on the above observation
Illa,
and
forensic
considering the duration between the time of assault and the death, blunt trauma lower the abdomen as the cause of acute pancreatitis is unlikely. There is no injury correspondence to the statement of the eyewitness my lord. The complainant's statement.
Get the records please. The learned HCGP to secure the entire charge sheet material and place it before the court on the next date. Next Tuesday, 2nd April.
My lord, till then, my lord, stay of, till then, my lord.
Bail ತಗೊಂಡಿಲ್ವಾ?
Bail ತಗೊಂಡಿದ್ದೀನಿ.
ಸರಿ. Till then, let the records.
49.
Hearing for petitioners in this case, my lords. A commercial dispute which is colored as.
Colored? What color, sir?
This is a commercial dispute between
What
the parties.
commercial dispute? The petitioners are before this court calling in question registration of a crime in crime number 322 of 2025. The fulcrum of the crime is breach of an operating lease agreement between the parties. The operating lease agreement leads to the dispute and the dispute to registration of the crime on breach of the said agreement. Several claims are made based upon the breach of the said agreement. If further proceedings are further investigation is permitted to continue in the case at hand, it would amount to permitting the criminal law being set into motion for the purpose of on financial transactions or breach of agreements. The apex issue in the list stands answered by the judgment of the apex court in the case of 2025 SEC online SC 2060 Ankul Singh. Yes, so next.
40.
Lord, my prayer for discharge was not
Murder.
considered. No, my lords, I'll restrict my.
103.
Yes, my lords. My prayer for discharge was not considered merely because I did not make an application and it was made after a period of 60 days. That's the only issue.
Arms Act and murder.
If it could be, a direction could be issued to the Fourth Sessions Court.
To what?
To consider my application for discharge.
Charge frame ಆಗೋಗಿದೆ.
Please, my lords. On the ground that I did not make an application and it was after 60 days. And the statutory period.
Let's see. Tomorrow I'll take it.
Please.
Tomorrow, tomorrow fresh matters.
Please. Much.
41.
Senate Counsel Madhu N. Rao is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel, 2nd April. Yes.
Good.
Next.
Fresh matters.
Petitioners are the lorry owner and lorry driver, my lordship. They are arraigned as an accused.
ನೀವೇ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದೆಲ್ಲ.
Lordships.
A3 had booked the lorry.
A3 had booked the lorry.
A1 and A2 draw a live owner and driver.
And the offense is booked under EC Act and Fertilizer Act, my lordships. 18(2), the commercial tax vigilance intercepts my vehicle. They raised a demand for excess of the urea which was not forthcoming in e-way bill. They collect duty penalty from the A3, my lordships. Thereafter on 13(3).
We'll see.
13(3), they lodged an
HCGP is
FIR.
directed to accept notice for the.
It's covered by my lordship
respondents.
judgment, my lords.
No, let him go through it. List the matter on 3rd April. 2nd April. Yes.
Please, my lords. There's one more connected matter where I have sought for.
ಇವತ್ತೇ ಇದೆಯಾ?
ನಿನ್ನೆ list to serial number 71, my lords.
ಅದು ಟ್ಯಾಗ್ ಮಾಡಿ same order.
Please, my lords.
43.
List to serial number? 71.
Appearing for kindly peruse the complaint page number 13, my lord.
Yes, sir.
On perusal of the complaint, my lord, there is no ingredients of the offense.
Oh, yes,
Never
sir.
attacked
Amale.
this petitioner, my lord. Even, my lordship, I filed a memo along with some documents, my lordship. Even after lodging this complaint, my lord, de facto complaint visited the central prison to visit the petitioner, my lordship.
Michael ಹೇಳಿ.
Even after lodging complaint, this my lordship, the de facto complaint visited the Parapanagara Central Prison
Hmm.
to visit the petitioner, my lord.
ಅದಕ್ಕೆ ಯಾಕೆ to express sympathy na?
I don't know, my lord. That's
You
why
don't know?
in this regard, I produce a.
Allegation is rape.
No, there is
64.
no, in the entire complaint, my lord, there is no ingredients in the
ಈಗ
alleged offense, my
bail
lordship.
ಕೊಟ್ಟಿಲ್ವಾ?
Already bail granted, my lordship.
Bail granted.
Yeah, is on
But
bail.
why did she come to the jail?
No, after lodging this complaint, when the accused was in judicial custody, my lordship, the de facto complaint visited the central prison to contact the.
So ಯಾಕೆ? So
It
come
clearly shows
after
that
charge.
his intentionally
If
insisted
the final report is filed
even
against
till
you,
now regularly sending the message insisting the petitioner to marry the.
marry.
Yes, my lordship. Because they both are colleagues in the software company, my lordship. In that contact.
In case the final report goes against you, you come, because this is not years together, one day instance. Yes.
Even till now, my lordship, they're sending us regularly message, my lordship, through WhatsApp, my lordship.
Notice
She threatening to the petitioner, my lordship.
1 HCGP 2 emergent notice.
Kindly stay,
Letter
my
number
lordship.
by, no sir, 21st.
Till appearance of.
No sir, yes. ಈಗ bail ತಗೊಂಡಿದ್ದೀರಲ್ಲ.
Already bail
sir.
granted, my lordship.
Next.
44.
1 HCGP 2 emergent notice, 63 Copyright Act.
Allegation is of selling the counterfeit T-shirts. Where the allegation is taken on record, my lords, there should be a trademark act, not the copyright act.
We'll see. Yes. 1 HCGP 2 emergent notice. Next.
Please.
55.
A2 and A3 85. Yes.
A2 and A3.
Next. A2 A3 A4
Ibra.
A2 and A3 85. Yes, next.
Public.
46.
The second petitioner, my lord, on the date of incident, second petitioner, my lord, is not present at the instant.
ಅದು case and counter case.
First, my lord, we lodge a complaint.
Correct. 612 ನಿಮ್ದು 614 ಅವ್ರದ್ದು.
Of 14. After lapse of 2 days, my lord, they lodge a complaint. Annexure C, my lord, they produced this
1
certificate.
HCGP 2 emergent notice. On an incident that takes place on ಯಾವ date ಅದು? Date
22nd, my lord, December
22/12/2025. The two crimes spring. One by the petitioners against the complainant in 612 of 2025. 2 days later, as a counterblast, the crime is registered by the complainants against the petitioner. Own certificate idea?
Loan cert. They're not.
Is government? In the light of the crime being a counterblast to what the petitioners had registered, till the appearance of the complainants, there shall be an interim order of stay of further proceedings. Further investigation by the petitioners till the next date of hearing. Yes, next.
47.
I appear for the petitioner, my lord.
Heard the learned counsel appearing for the petitioner.
My lord, my
The
lord.
1 HCGP. Withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
No, my lord. During the pendency, they have filed a charge sheet. I may seek
Oh.
liberty to amend the petition,
Liberty.
my lord.
Amend ಮಾಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ. Yes.
Charge sheet challenge ಮಾಡ್ಲಿಕ್ಕೆ prior
ಮಾಡಿ.
amendment.
Liberty to challenge the charge.
48.
Breach of agreement with employees, suit is filed for the same cause of action in Delhi
Yes,
in
next.
2024. My lords, first FIR, my lords, filed in Patiala. After that, my lords, the second FIR.
40, next. State, sir.
Grateful, my lords.
Yes.
49. 49.
ನಿಮ್ದಲ್ಲ ಸರ್, ಅವ್ರು ಸ್ಟೇ ಅಂತ ಹೇಳಿ. ನಿಮ್ದು 406 420.
406 420, my lord. There is a delay of 1 year, my lord, in lodging the complaint. The alleged incident, my lord, happened in the year 2020, and the complaint, my lord, came to be filed in the year 2023. And my lord, there is no explanation, my lord, of whatsoever, my lord, in the complaint or in the charge sheet.
The learned counsel, the petitioner is before the court calling in question proceedings in so and so registered for offence punishable under section 406 and 420 of the IPC. The incident that happens in the year 2022 is complained of in the year 2023, which has now become the offence under section 406 and 420 without an explanation for delay. Though in the normal circumstance, only delay would not inure to the benefit of the petitioner for interdicting the proceedings. There are no ingredients of the offences found in the case at hand. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. In the meantime.
Petitioner in this case, my lords. My lords.
51.
Yes, sir. State, sir. ನಿಮ್ಮನ್ನು ಕೇಳೋದನ್ನ ಏನಾದ್ರು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಇದ್ರೆ ಮಾತ್ರ. Yes.
My lord, identical matter listed on 26th of March, my lord, kindly have it on the same day, my lord.
ಯಾವುದು?
My lord, criminal petition
91 application 138 ಅಲ್ಲಿ 2019 ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಏನಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ?
Already it has been discussed by the lower court. Same they are challenged for this honorable court.
My lord, connected matter is listed on 26th of March, kindly have it on the same day, my lord. I'm a prosecutor counsel, my lord.
ಆಯ್ತು, ಅವರ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್.
Please, my lord.
List the matter on ನಂಬರ್ ಕೊಡಿ ಯಾವುದು?
Please, my lord.
Yes. Same day. Next.
Two complaints have been registered.
3082.
Please, my lord, my lord, for one complaint, initially, my lord, NCR is registered in the same police station. For again, my lord, for the same complaint, your lordship may kindly see, my lord, both the complaints are verbatim same. Not even, my lord, a iota of difference found in the.
Let me see the investigation papers. List the matter on 1st April in the 2nd April in the fresh matters list. Investigation papers be secured and placed before the court on the next date. Yes.
Please, grateful.
53.
Annexure G, my lord, there was an interim order in the while affair stage, and pendency they filed a charge sheet.
310-4, 310-5.
319-4 not. Only on the confession have been implicated as section number 4 and 5.
425 arms act ಇದೆ madam.
Arms also recovered from A1 and 2.
This petitioner.
And I have the detailed interim order has been passed at Annexure G, bro.
Mine.
Coordinate bench. Page number 86.
ಮತ್ತೆ ಯಾಕೆ ವಿಡ್ರಾ ಮಾಡಿದ್ರಿ?
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ರು. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಅದು
ಇದ್ರೂನು ಹಾಕಿದ್ರ?
ಇಲ್ಲ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಪೆಂಡೆನ್ಸಿ ಇರುವಾಗ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ, ನಮ್ಗೆ ಗೊತ್ತಾಗಿರ್ಲಿಲ್ಲ. ದೆನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹ್ಯಾಸ್ ಚಾಲೆಂಜ್.
Commission of Dacoity.
Preparation.
Preparation, correct.
But mine, I was not there. There is allegation that I was escaped from the place. The eyewitness statements have recorded where nowhere my name was indicated.
As per my lord, page number.
ಈ ಒಬ್ರೆ ಇನ್ನೊಬ್ರೆಲ್ಲ ಸೇರಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ ಈಗ? ಅಲ್ಲಿ ಇದ್ದಿದ್ದು ಒಬ್ರೆ.
ಇನ್ನೊಬ್ರನ್ನ ಅವ್ರು ಸೇರಿಸಿದ್ರು. FIR ಅಲ್ಲಿ ಇರಲಿಲ್ಲ, 5ನೇ ಅವ್ರನ್ನ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ. ಇಲ್ಲಿ
ಯಾರನ್ನ ಸೇರಿಸ್ಕೊಂಡಿದ್ದೀರಾ ಈಗ?
A51.
A4
A4 FIR ಅಲ್ಲಿ ಇರಲಿಲ್ಲ. ಈಗ A5 ಅಂತ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಸೇರಿಸ್ಕೊಂಡಿದ್ದಾರೆ.
ಪೇಜ್ ನಂಬರ್ 71 ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇನ್ನೂ ಕೇಸಸ್ ಇದೆ ಅಂತ ಮೇಡಮ್.
ಪ್ರಿಪರೇಷನ್ ಫಾರ್ ಡೆಕಾಯಿಟಿ ಸ್ಟೇ ಹೆಂಗ್ ಮಾಡೋದು?
Only in the confession. If is the other materials on
ಏನ್ ಮಾಡಕ್ ಹೋಗಿದ್ರಿ? ಬ್ಯಾಂಕಾ?
No, bro, they are residents of Madikeri.
ಗೊತ್ತು.
They preparing to commit dacoity at Mangalore.
ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿಯಲ್ಲಿ ದರೋಡೆ
ಮಾಡಲು ಪ್ರಯತ್ನಿಸ್ತಾ ಇದ್ರು.
ಚಿನ್ನಾಭರಣ ಮತ್ತು ಇದು
ಏನ್ ಹೈವೇ ಅಲ್ಲಿ ವೆಹಿಕಲ್ಸ್ ನಿಲ್ಸದ?
A1 to 3 they are confessed that there are presence and eyewitness statements was recorded.
ಹೈವೇ ಅಲ್ಲಿ ವೆಹಿಕಲ್ಸ್ ನಿಲ್ಸಿ ಪ್ರಿಪರೇಷನ್ ಫಾರ್ ಡಕಾಯಿಟಿ.
That is A1 to 3 as per the complaint.
And we should stay this.
So far as these petitioners are concerned, Lord, the eyewitness, kindly see the
eyewitness. How are the travelers safe, sir?
So far as 1, 2, 3, Lord, there is a allegation in the complaint and the charge sheet. Kindly see the charge sheet allegation. Nowhere there is a role of these petitioners. 4 and 5.
Correct.
Charge sheet page number 71.
Please come to page 71.
Last into 2 parameter.
Four and 5 ಅಲ್ವಾ?
ಹೌದು. ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ದರೋಡೆ ಮಾಡಿ ಚಿನ್ನಾಭರಣ ಸೊತ್ತು ಹಣ ತಯಾರಿ ಮಾಡಿಕೊಂಡು
ಒಂದರಿಂದ ಮೂರನೇ ಆರೋಪಿತರನ್ನು ವಶಪಡಿಸಿಕೊಂಡಾಗ
ಖಾಸಗಿ ಕಾರುಗಳನ್ನು ತಡೆದು ಸಾರ್ವಜನಿಕರನ್ನು ವಾಹನದ ಪ್ರಯಾಣಿಕರಿಗೆ ಮಹಿಳೆಯರ ಚಿನ್ನಾಭರಣ ಸೊತ್ತು ಮತ್ತು ಹಣ ದರೋಡೆ ನಡೆಸುವ ಸಾಮಾನ್ಯ ಉದ್ದೇಶ.
Before that paragraph, 1, 2, 3 were apprehended. They confessed about these petitioners. The conspiracies that alleged, but the eyewitness statements. Eyewitness statements.
No, sir, we should not entertain these things. Impossible.
Kindly see this eyewitness statements at CW2.
Acquit ಆದ್ಮೇಲೆ ಸ್ಪ್ಲಿಟ್ ಆಗುತ್ತಲ್ಲ, ಸ್ಪ್ಲಿಟ್ ಆದ್ಮೇಲೆ ಬನ್ನಿ. ಸ್ಪ್ಲಿಟ್ ಚಾರ್ಜ್ ಆಗುತ್ತಲ್ಲ, ಅವರೆಲ್ಲ ಬೇರೆಯವ್ರೆಲ್ಲ ಅಕ್ವಿಟ್ ಆದ್ಮೇಲೆ we'll entertain.
Now the charge sheet has been filed. Only, Lord, the secondly, Lord, the petitioner has shown as absconding. He has enlarged on bail and he is cooperated for the investigation also. I'll place that order also, Lord. Kindly see the order sheet wherein they indicate in the charge sheet that the absconding accused. Now, Lord, as per the order sheet, Lord, he is enlarged on bail and he is appeared before the investigation officer. And furthermore, my lord, the petitioner is running a computer education center at Konikoppa, and in that, my lord, there are more than 100 students.
Where are the statements of other statements against these people?
The witness statement I produced, my lord.
ನಿಮ್ಮ ಹೆಸರು ಇಲ್ವಾ ಅದ್ರಲ್ಲಿ?
ಇದೆ, ನನ್ನ ಹೆಸರಿಲ್ಲ. CW2 statement, my lord.
Let us see.
Who is the eyewitness statement?
List the matter on first in the fresh matters list. Otherwise, we should not say such things.
The eyewitness also not stated anything against this petition.
ಇಲ್ಲ trial ಗೆ ಬಿಡ್ಬೇಕು. Yes.
54.
Petitioner is the mother.
Next.
55.
The main time. ಎರಡು ಅಷ್ಟೇ 54, 55.
56.
NBWY.
ಇದು ಟೈಮ್ ಕೊಡಿ ಸ್ವಾಮಿ, ನೆಕ್ಸ್ಟ್
Time
ವೀಕ್
ಬೇಕಾ? At the request of the council appearing for the petitioner, list after 2 weeks. Next.
57.
As per the direction of this honorable court, copies are served to the
57, Santosh BM.
Please.
ನಿಮ್ದು ಯಾವುದು? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇರ್ಬೇಕು.
Complaint and counter complaint.
Huh?
But R2, my lord, R2's wife, my lord.
Santosh, but come to page 48 and page 26.
So 47, your lordship may kindly take 47.
Wound certificate.
Wound certificate. Certificate. On examination, no external injuries found.
Allah,
Patient was
page 26.
Patient was advised to go for a higher ECG. ಅದನ್ನೆಲ್ಲ examine ಮಾಡಿಸ್ರಿ ಅಂದ್ರೆ ಮಾಡಿಸಿಲ್ಲ. She went away.
ಅಲ್ಲ, page 26.
26. My lord.
74.
Column number 17.
Huh?
26.
Page 26.
My lord, your lordship may kindly see the wound certificate, my lord.
Wound ಬಿಡಿ sir. 74 wound ಬೇಕಾಗಿಲ್ಲ. 74 is the allegation.
She is
outraging the modesty of a woman, wound ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲ, modesty of the woman.
So 74 ಅದೇನೆ sir.
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ. Your lordship may kindly see. Earlier, a complaint was filed by the daughter-in-law of the accused number 1. My lord, I am the uncle of the complaint in that case, my lord. My lord, as a counter blast to that, my lord, it has been filed. Your lord, I have also produced that complaint along with this.
One
Unnecessary of
CJP, 2 emergent notice in the meantime. Next.
Great.
PCR of 2016.
Page number.
ಈಗ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Fingerprints first filed a report saying that my fingerprints is not tallying. Kindly see page number 73.
What is the order and challenge?
My lord, discharge applications dismissed.
Rejected.
It is confirmed by the revisional
court.
But kindly page number 73.
Nothing. PCR of 2016.
On the material, my lord. On the material, my lord. Kindly see, come to 73, my lord. Page number.
Offense ಏನು ಹೇಳಿ?
My lord.
424. ಈಗ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿ ನಡೀತಾ ಇರುತ್ತೆ.
ಇಲ್ಲ madam. Kindly 73, madam.
No sir.
73.
Discharge is rejected. Rejection is confirmed by revisional court. Discharge reject ಆದ ತಕ್ಷಣ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿ ಟ್ರಯಲ್ is on.
ಇಲ್ಲ.
No.
ಆಗಿಲ್ಲ my lord. Kindly come to 73, my lord. On the basis of material only, not nothing else.
Yes.
Kindly see.
Get 73. To know the stage.
73.
The petitioner files an application seeking his discharge under section 239 of the CRPC. The same comes to be rejected on 13/6/24, rejection of which is challenged before the court of session, which comes to be dismissed on 16 December 2025. Charges would have obviously been framed and trial would be in motion. The learned HCGP to secure instructions in this regard and make submissions. List on first in the fresh matters list.
What's up?
Yes, next.
Challenge the dismissal order of the appeal before the district.
Non-prosecution.
Yes, my lord.
69.
59.
59.
ಅದು ಒಂದು ಕೋಟಿಂದ ಇನ್ನೊಂದು ಕೋಟಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿತ್ತು, ಇನ್ಚಾರ್ಜ್ ಕೋರ್ಟ್ ಬರೀತು, ರೀಚ್ ಆಗ್ತದೆ.
We'll restore it. We'll restore it. Appeal can't be dismissed for non-prosecution. Yes, allowed, restored.
Yes, ma'am.
Petition allowed. The petition is restored to file before the concerned court in criminal appeals so and so. Yes. Adhan barite, amal ಹೇಳ್ತೀನಿ.
Previous matter, Lord. Entire order sheet is filed, Lord.
No problems. Let's early question. Yes.
60.
Petitioner, my lord. Petitioner, mother-in-law and sister-in-law. No.
Respondent two, my lord.
Atrocities Act only we will stay, nothing else.
Other offences are also not made out, my lord.
My lord, I think they have not taken bail.
Page
also.
17.
Anticipated
Have I
bail only
issued
A1 has
have I
taken.
issued notice to you?
Police have given me a notice to
That
appear.
doesn't mean I have issued notice to you to appear.
We received a police notice based on that.
That's all right. Wait.
Page 17, para E and page 19.
Atrocities Act, I will stay, nothing else.
Other offences not made out.
No, no.
Omnibus statement as
Adu
stated.
paravailla.
Page 17, E mate, page 19.
One HCGP, the learned counsel so and so undertakes to enter appearance for the complainant registry to print the name of so and so is appearing for the complainant. There shall be an interim order of stay only insofar as the offense under the Atrocities Act is concerned. It is made clear investigation qua the other offences shall continue.
My name may be shown, my lord. File wakalat.
Learned counsel registry to print the name of Pawan Kumar.
Yes, please.
Pawan Kumar is appearing for the petitioner in place of Rakshit.
Grateful.
Next.
Grateful.
61.
The petitioner.
Except husband.
Husband is not made a party at all.
The emergent notice to the respondent, there shall be an interim order of stay of further proceedings before the concerned court qua these petitioners. Yes.
52.
My lords, in-laws are before this court, my lords.
A2, 85.
85.
63.
A2 matra tane.
No, my lords.
So
there are
A2 to A12.
A12,
Oh,
my lords.
A2 to A12. Sorry, sir. Yes. The petitioners are accused 2 to 12 are now charged with the offence punishable under section 85 inter alia. Making omnibus statements, the complainant has dragged all and sundry into the web of crime. Therefore, there shall be an interim order of stay, all and sundry with the web of crime without there being an iota of ingredient of the offences so alleged. In that light, there shall be an interim order of stay until further orders. 1 HCGP to emergent notice. Next.
63.
Plus 87 KP Act and 112 covered by judgment, my lords.
How covered?
Maharship says a rendered judgment. And actually, my lords, 112 is not attached.
'87 idunu. 79, 80.
112, my lords. 87 also is non-cognizable.
112 BNS.
87 is also non-cognizable.
Yes, ಏನ್ ಮಾಡೋಣ? Permission ತಗೊಂಡಿಲ್ವಾ?
ತಗೊಂಡಿಲ್ಲ.
ಅದು ಅಂದರ್ ಬಾರ?
ಅಂದರ್ ಬಾರ್ 87 ಪಬ್ಲಿಕ್ ಪ್ಲೇಸ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಪಬ್ಲಿಕ್ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಆಡ್ತಾ ಇದ್ರಾ?
ಇಲ್ಲ.
ಹಾ? ಏನಿಲ್ಲ.
ಇದು ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್, my lords.
ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಆಚೆ.
ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್.
17 ಅಂತ ಹೇಳ್ತಾರೆ. 17.
1 HCGP. List the matter on Friday. Learned HCGP to go through the matter, go through the papers and make his submissions. Yes.
Start for stay.
ಎಷ್ಟು ರಿಕವರ್ ಮಾಡಿದ್ರಿ?
As per my lord.
ವಾಪಸ್ ಬರಲ್ಲ ಅದು. ಗ್ಯಾಂಬ್ಲಿಂಗ್ ಅಲ್ಲಿ ಮಾಡಿ ಸಿಗಾಕೊಂಡ್ರೆ ದುಡ್ಡು ವಾಪಸ್ ಬರಲ್ಲ. Because we will be quashing it on technical grounds. Next.
Further proceedings,
Friday.
charge sheet.
Rangnath, attempt to murder.
Altercation, my lord, between the petitioner and the traffic police personnel. Lord, the fit of sudden provocation, my lord. Now it's been portrayed as attempt to murder.
307 offense, my lord.
In fact,
307.
Full accused, my lord.
Lord, it's a road rage incident.
ಅದಕ್ಕೆ ರೋಡ್ ರೇಜ್ ನ ಬಿಡಬಾರ್ದು.
In the traffic police personnel, my lord, he intervenes, which is where, my lord, some altercation has taken place.
Correct,
Lord,
sir.
projecting it as attempt to murder, my lord, is my only grievance, my lord. The limited grievance is that, my lord, invoking section 307, my lord, is the...
ಇಲ್ಲ, ಮುಖದಿಂದ ಕುತ್ತಿಗೆಗೆ ಹಿಂಭಾಗಕ್ಕೆ ಬಲವಾಗಿ ಗುದ್ದಿ.
There's no intention, my lord.
ಇಂಟೆನ್ಷನಲ್, ವಾಟ್ ಇಸ್ ಇಟ್? ಗುದ್ದದ ಮೇಲೆ ಮೆನ್ಸರಿಯ ಬರಲ್ಲ ಅದಕ್ಕೆ. ಏನೋ ಹಿಂಗೆ ವಿತೌಟ್ ಇಂಟೆನ್ಷನ್ ಹೊಡೆದ್ಬಿಟ್ಟೆ.
My lord, is now portrayed as 307. Is my respectful submission.
These road rages should stop, sir.
But in fact, this is the second FIR, my lord, stemming out of the same incident, my lord.
Why? Which is the first one?
Please.
ಕೊಡಿ ಅದು.
But the first FIR, my lord, registered by the
Then
traffic
stay
police
again,
personnel. No, the charge sheet has been filed in both the cases, my lord.
ಇದರಲ್ಲಿ ಕಮಿಟಲ್ ಆಗಿದೆ ಮೇಡಮ್ ಟ್ರಯಲ್.
5/11/25. Where is the FIR here?
Lord, it's not annexed with the petition, my lord.
ಇಲ್ಲೇ ಇರ್ಬೇಕಲ್ಲ.
Page 12, my lord.
ಇಲ್ಲೇ ಇದೆ.
No, this is in connection to the instant case.
5/11/25.
Please, my lord.
ಇದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ?
In both the cases, charge sheet has been filed.
ಹೌದು ಸರ್.
In the teeth of TT Antony's dictum.
ಅದು ಕರೆಕ್ಟ್. ಅದಕ್ಕೆ ಒಂದು ಸ್ಟೇ ಮಾಡೋಣ.
Please.
ಯಾವುದು ಇದು ನಡೀತಾ ಇದೆಯಾ ಈಗ?
Lord,
offenses ಏನು? ಸೇಮಾ?
Same. Not the same
ಇಲ್ಲ.
offenses, my lord.
One
This is a traffic offense, my lord.
ಮತ್ತೆ?
This is in connection to the collusion of the vehicle.
This is IMV offense.
Yes, ma'am.
Sorry, MV offense.
Lord, the same incident, my lord, multiple FIRs, my lord, cannot.
ಇದರಲ್ಲೇ ಹಾಕ್ಬೋದಿತ್ತಲ್ಲ ಎಲ್ಲ?
Please.
ಇದನ್ನ ಸ್ಟೇ ಮಾಡೋಣ ಬೇಕಾರೆ.
Lord,
ಇದು ಇಲ್ವಲ್ಲ?
307, my lord. Only QA 307 it may be looked into.
But you have assaulted.
Lord, assault is there, my lord.
324 ಆಗ್ಬೇಕು, not 307.
That is my limited grievance.
We'll see. Heard the Learned Counsel Rangnath Reddy appearing for the petitioner. 1 HCGP 2 emergent notice. Finding no ingredient of section 307 as the ingredients would relate only to section 324 or even 326 perhaps, but not 307. There shall be an interim order of stay of the offense under 307. I will modify it and send it.
Please, my lord, please.
Yes. List the matter on 16th April in the fresh matters list.
Highly grateful.
307 change ಮಾಡಿ will send it as 324, 326.
Only difficulty is it could be committed, my lord.
I know, that's why I've stayed it, otherwise I would not have stayed it also.
Grateful.
My lord, for the petitioner in this case, my lord. My lord, accused number 1, my lord. My lord, I have followed as a retired FDA, my lord. I have followed what the department has said, my lord. My lord, page number 18, my lord. There was no site as such. The BD has cancelled it. I'm just an my lord. After cancellation, I was.
BDA ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ ಇದರಲ್ಲಿ?
ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ.
ಬರ್ಲಿ ಅವ್ರು ಬರ್ಲಿ. 1 HCGP BDA ಯಾರು who appears?
My lord, Murugesh Charati.
Murugesh Charati is directed to accept notice for the respondent. List the matter on 9th in the fresh matters list.
Obliged.
Yes. ಇವತ್ತೇ ಕಾಪಿ ಕೊಡಿ. Petitioner to serve set of papers upon the said counsel report.
66.
Is under section 108 of BNS.
Suicide.
Suicide.
You are accused number 1.
Accused number 1. Accused number 1 to they were accused number 1 to 3. Accused number 2 and 3 have been dropped.
Yes.
Accused number 1 have been charged in the offense. As per post-mortem report, my lord, death is due to oxpasia under the influence
no
of
problem.
alcohol.
Sir,
Allah,
you are not examining murder here.
there is no
It is
instigation.
abetment to suicide.
Please, my lord, there is no instigation, my lord. On 15/7/2025, my lord, there was a case and a counter case which got registered against the deceased as well as, my lord, the petitioner. Thereafter, my lord, the deceased auto was seized. In order to release that auto, my lord, he had gone to Murgere court, where, my lord, the advocate had asked fees to the deceased in order to release the auto. Thereafter, my lord, the next day he committed suicide. And also, my lord, his wife was also pregnant and he was not earning. There is no mens rea, my lord, or nor any instigation.
Case number 12 ಅಲ್ಲಿ ಹೇಳಿದಾರೆ my lord ಇವ್ರ ಬಗ್ಗೆ.
Covered by
12 ಬಿಡಿ, page 30 ಗೆ ಬನ್ನಿ.
In the case, my lord, the Srinagar Velu versus
Death note, ಅದು ಗೊತ್ತು ಸರ್.
death note is at page number 149. There were 4 ಜನಕ್ಕೆ ಹೆಸರಾಗ್ತದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ including a PSI others, but PSI others was not registered.
What are you in relation with the deceased?
I am a police constable. While I was performing the duty, the deceased, my lord, had showed the flashlight. Police constable thinking that he is taking the video, he has assaulted the deceased. That, my lord, this honorable court had pleased to stay the.
No, the constable has assaulted the deceased.
Both of them assaulted the deceased. Well, even constable assaulted the deceased. Even, my lord, the deceased assaulted the constable. There was a case and a counter case registered against each other. Thereafter, my lord, the co-accused, my lord, are pleased to stay the proceedings.
ಯಾವುದು ಕೊಡಿಯೋದು?
And criminal petition, my lord.
Tag this petition along with so and so. Bail ತಗೊಂಡಿದ್ದೀರಲ್ಲ. Oh, so what, sir? Constable ga precedence, huh? Wait.
There is no instigation.
First, yes, we'll grant on that day, we'll see.
57.
Wound certificate ಇದೆಯಾ? ಎಲ್ಲಿದೆ? Page. ಯಾಕೆ ಹಾಕಿಲ್ಲ? ಕೊಡಿ. ಅದೇ ಫೈಲಲ್ಲಿ ಎಲ್ಲಿ ಹುಡುಕಿದ್ರು wound certificate ಇಲ್ಲ. Pain and swelling.
Medical certificate.
In the meantime, just next.
420 IPC. Is a
All
car-
for a car.
Nah,
ಯಾವ
I'm not
ಕಾರ್
a-
ಸರ್?
ಅದು ಟ್ರಸ್ಟ್
ಕಾರ್ ಅದು ಅಂತ ಕೇಳ್ತಿರೋದು.
ಕ್ರೂಸ್
ಕ್ರೂಸಾ? ಕ್ರೂಸ್ ಅಂತ ಯಾವ ಕಾರ್ ಇದೆ? Yes. In the meantime, next.
Great.
59.
Land grant, land grabbing.
Yes.
Hmm.
But I have filed the affidavit. Medical emergency are there for the wife. Despite that, non-bailable warrant is issued.
That will stall. The sword of non-bailable warrant hanging on the head of the petitioner
44 ಅಲ್ಲಿ ಇದೆ.
shall remain stayed on the documents appended to the petition which clearly demonstrate that the petitioner was incapacitated to appear before the concerned court. Next appear ಆಗ್ತೀರಾ?
Yes.
And on an assurance that he would appear before the concerned court on the next date of proceeding. List the matter on 21st April. Next date, you know?
23/6.
21st April, we'll see.
Yes.
70.
70?
Now the petitioner is accused number 2. The files are sanctioned after the approval by a risk control unit and verification team, the bank, my lord.
Yes.
They are duty bound to
What
verify the
duty bound?
details submitted by the applicant.
Verification, madam. Yes, verification. You are the one who come and conduct verification?
No, my lord,
Then?
risk control unit verification team.
Who are you then?
I am a credit control manager. Credit manager of retail assets branch.
Who submitted the business verification report?
RCU, risk control unit as well as verification.
All
team.
ಎಲ್ಲ fake documents ನೀವು approved and granted loan.
My lord, I have approved based on the
No,
report
no.
of RCU
We'll see,
verification
it's
team.
all
and-
public money. Yes,
My lord, the bank has not accused any of the current
we'll
employees.
see. Yes. One who appears, emergent notice to the respondent returnable by the 17th of April, list on 17th. Yes.
71.
No, George.
Petitioner, please.
False caste certificate.
Please.
What happened? Appeal ಹಾಕಿದ್ದೀರಾ?
It was not challenged.
And
The order of the Tahsildar was not challenged. On that, the caste was given by the father of the petitioner, please.
same certificate was given to the father also?
No, ma'am.
Then?
The caste of this petitioner was given by the father of this petitioner back in the year
ಅದನ್ನೇ
1977.
ಕೇಳ್ತಿರೋದು. Father also belongs to the same caste ಅಂತ
Father belongs to
ಕೊಟ್ಟಿದ್ದಾರೆ.
Madaliar, please. He belongs to Madaliar. But in school records, the father has given it as
In the main.
Case number 15 ಅಲ್ಲಿ ಅವ್ರ ತಂದೆ ಬಗ್ಗೆ
ಫಾದರ್ಗೂ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಮತ್ತೆ? Yes.
72.
for the petition. 498.
2 to 485. Yes, next. Next to DV Act 2 to 4. Same order, state.
74.
Petitioner side, 1 week.
138. Time ಬೇಕಾ?
Sir.
Sorry, at the request of the council appearing for the petitioner, 2 weeks. Yes, next.
75.
But I am representing the petition.
Yes, sir.
69 of the BNA.
Sole accused my lord.
Yes, sir.
My lord, it is not today that it is happening, for the last 12 years. Probably she was waiting to marry me for the last 12 years, just like Shabari in epic Ramayana. And then, my lord, apart from the merit for the matter, one serious legal issue which I raise for my lord's consideration is whether does it constitute an offence under section 69? Deha samparka agalla adaralli. Sexual intercourse agbeku adaralli. That is number one. Well, may I just request your lordship to kindly have a cursory look. Probably your lordship may have to lay down a law. Have a look at section 69 for a second, my lord.
Yes, sir.
What it says is, whoever by deceitful means. Well, deceitful means is explained in the explanation to section 69. Deceitful means shall include inducement for or false promise of employment or promotion or marrying by suppressing identity.
Heard
ಅದು
the
12
learned.
ವರ್ಷ. Have a look at the pictures.
What, sir? 2013 in the 2026 ವರ್ಗೂ
He was waiting.
waiting to get married. ಈಗ promise to marry.
ಅಲ್ಲ ಬೇರೆ ಹುಡುಗಿಗೆ ಜೊತೆ ಎಂಗೇಜ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಸರ್. 13 ವರ್ಷ ಬೇಕಾಗಿತ್ತ ಇದಕ್ಕೆ.
Have a look at the pictures, man. I refused to marry her. I refused. In fact, a tape recorder.
There is no physical relationship also.
Malad, I will place on record. My colleague is here. Otherwise, I would have sent it by now. A tape recorded version between the conversation between the two. She says, "I don't want to marry you. I am marrying somebody else."
The petitioner is the sole accused in crime number 47 of 2026, registered for offence punishable under section 69 of the BNS. The gist of the complaint is as follows.
ಇದರಲ್ಲಿ ವಿಕ್ಟಿಮ್ ಪ್ರೆಸೆಂಟ್ ಇದಾರ.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ?
ನೆಕ್ಸ್ಟ್ ಡೇಟ್
What can be done, sir? So and so. The complaint is that the complainant and the petitioner's family were known to each other, and for 12 years, from 2013 to 2026, he was he had friendship with the complainant on the promise of marriage. Therefore, it has now become the breach of promise of marriage. Alleged breach of promise of marriage has led the complainant to register the crime now. Therefore, there shall be an interim order of stay of heard learned senior counsel Sivinaj. Interim order of stay of further proceeding, further investigation qua the petitioner till the next date of hearing. List the matter on 17th April. Emergent notice to the respondent returnable by 17th April. Next.
Deployable.
76.
The petitioner, consensual relationship, my lords, that has turned sour.
313, sir.
313, my lords, is also inherently improbable because, my lords, the allegation, the
ಇಲ್ಲೇನು ಇದಿಲ್ಲ ಸರ್. 69 ಅಲ್ಲ, 376 ಅಲ್ಲ. It is 420 and 420 because of the transactions.
No transaction between us, my lords. And why 313 is improbable is 4 months of pregnancy, my lords, as admitted by the complainant. My lords, the allegation is that we have induced her or coerced her to consume tablets orally that has terminated the pregnancy. My lords, this is not possible, my lords, as per the medical termination rules.
ಅದು ಎವಿಡೆನ್ಸ್ ಆಗ್ಲಿ
After
ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಆಗ್ಲಿ ಬಿಡಿ.
Admittedly, my lords, after 12 weeks, the pregnancy, my lords, must be terminated in a medical place under supervision. This allegation itself is baseless.
Period may be wrong, sir.
So, everywhere it said, my lords, and medical examination also is there, my lords, conducted, investigation is complete. They also say, my lords, 4 months from Christmas till the date of registration of the FIR.
4 months.
And, my lords, the timing or as to when she has come and registered this crime, my lords.
And what is the other transaction between you?
No transaction, my lords.
How long was this
Admitted
relationship?
2 years, my lords, almost. And in the complaint, my lord, she says, I was in love. She was married to a Naveen Kumar, my lords, who passed away.
Already married.
She was already married to a Naveen Kumar.
That is said in the complaint?
Page number 24.
It's said in the complaint. Then, my lord, she finds another Naveen Kumar.
You are Naveen Kumar.
I'm also Naveen Kumar, my lords, and her ex-husband is also Naveen.
Maybe fond of the name. Yes.
And 2 days before my marriage is fixed, invitations are sent out. That is also a part of the charge sheet. The impugned FIR comes to be registered. I have been granted interim anticipatory bail on this ground.
The petitioner on marriage ground.
On marriage ground.
You got married, huh?
I'm married.
Yes. The petitioner is before the court calling in question proceedings in CC 41390 of 2024, registered for offences punishable under so and so. The page charge sheet ಅಲ್ಲಿ
Charge sheet, page number
Prayer లేదు.
37.
The offense is the one punishable under section 313, 417, 420. For a relationship of 2 years, the relationship of 2 years, the complainant registers the crime on the score that the petitioner has cheated the complainant, and at one instance, when the complainant was about 4 months pregnant, had induced or given medication to terminate the pregnancy. The learned counsel for the petitioner takes this court through the documents appended to the petition to demonstrate the said period, and would submit that in medical parlance, it has to be terminated only in a manner known to the procedure and not by tablets. The matter would require consideration as consensual acts have been projected to become cheating in the case at hand. In that light, there shall be an interim order of stay of further proceedings by the petitioner. To the next.
So,
77.
77, I appear for the petitions. Offenses under 316.
Sir, 27 to 26 is the crime registered. ಆಗ್ಲೇ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ. ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
16th ಆಗಿದೆ.
Learned HCGP is directed to accept notice for the respondent, secure the investigation papers and place it before the court. 6th in the fresh matters list.
May make this submission, madam. There is no complaint against the accused number 1. If my lord goes to complaint, it only
Investigation
says
papers ಬರ್ಲಿ. ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಾ?
only there are documents with the accused number 2 and accused number 3.
We'll see.
Accused
Yes.
number,
Get the investigation papers. 6th in the fresh matters list.
one more complaint is also, I have filed 482 and one accused number 2 and 3 minutes. 3942 of 2026.
Tag along with sounds.
That also let me be. 9th
Yes.
minutes.
6th.
Great.
78.
78, 78, 79, 80. All 7A.
Yes,
80 are the Rohit. ಎಲ್ಲ 7A. Failed trap. ನಿಮ್ದು? Successful trap.
Yes. My lord, what has happened?
Successful trap.
There is no demand, my lords. In the
ಅದೆಲ್ಲ
conversation,
ಇಲ್ವೇ
in
ಇಲ್ಲ.
the conversation
FIR
recorded-
charge sheet.
FIR, my lords. What has happened?
Where is yesterday's judgment? Kudi.
My lord, what has happened is,
Manjunath's judgment, no sir. Supreme Court has come down heavily.
Lords,
Coordinate benches had quashed the FIR.
my lord, the petitioner, my lords, has refused.
ಸುಮ್ನೆ ಫೋನ್ ಅಲ್ಲಿ ಕೇಳಿದ್ರು ಇಲ್ಲಿ ಕೇಳಿದ್ರು that I will accept.
Lords, in the conversation which is
And
recorded.
Supreme Court says it is immaterial whether you have received or X has received.
Lords, he has kept it on the table and he's left. Page number 41 may kindly be seen. The conversation. He said, I notice may be issued, sir.
That I will do. Learned counsel Baby Part Mural is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List these matters on 18th April. ಅದು ಅವತ್ತೆ. ಈಗೇನಾಗಿದೆ? ತೊಂದರೆ ಆಗ್ತಾ ಇದೆಯಾ?
ಅಪಿಯರ್ ಕೇಳ್ತಾ 6th ಡೇಟ್ ಇದೆ ಮಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎವ್ರಿ ಟೈಮ್ ಅಪಿಯರ್ ಕೇಳ್ತಾ ಇದೆ.
The concerned court shall fail trap.
ಮಲ್ಲ.
Concerned court shall defer its proceedings till the next date. Fail trap ಅಂದ್ರೆ ಹೆಂಗೆ?
My lord, I am not caught with the currency notes, my lord. I was at my residence, my lord.
Who has caught?
Some hotel manager, my lord, named by Namaste Vetum.
ಹೋಟೆಲ್ ಮ್ಯಾನೇಜರ್.
Hotel
ಅವ್ರನ್ನ
cashier.
ಎಂಗೇಜ್ ಮಾಡಿದ್ದೀರಾ ಇದಕ್ಕೆ?
ನಾನು
See,
he has not been made as an accused.
18th April. Yes, next.
Change start date, my lord.
18th ಸಾಕು. ಡೆಫರ್ ಮಾಡಕ್ ಹೇಳಿದ್ನಲ್ಲ. Concerned court shall defer ಅಂದ್ಮೇಲೆ ನೀವು ಶಾರ್ಟ್ ಡೇಟ್ ಕೇಳಿದ್ರೆ ಹೆಂಗೆ?
Great.
Will bifurcate failed trap and others and consider. Yes. Madam? Until 18th, till the next date.
81.
My lord, my
Notice.
notice.
Notice only. Yes.
Supreme Court
notice.
Supreme Court says that no notice is required.
ಯಾವ ನೋ ನೋಟಿಸ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್? 319 ನೋಟಿಸ್ ಬೇಡ ಅಂತ ಹೇಳಿದಾರೆ.
319.
ನೋಟಿಸ್ ಬೇಡ ಅಂತ ಹೇಳಿದಾರೆ.
ಹೌದು.
Seriously? If you don't understand the law, please look into it and come. Notice, yes.
ಅಲ್ಲ ಸ್ವಾಮಿ, kindly.
No, I notice respondents ಕೇಳಿ 319 is not a further investigation. You are drawing them back to as accused. Should they not be heard? If you don't know the law, look and come.
ಅಲ್ಲ, Supreme Court has said.
Said what sir? 319 ನೋಟಿಸ್ ಬೇಡ ಅಂತನಾ?
ಹೌದು.
ಯಾವುದು ಕೊಡಿ ಇಲ್ಲಿ?
Para number 32.
I will dismiss it straight away now.
Merely, I'll read para number 32. Merely because in certain proceedings, the person summoned had been provided an opportunity of being heard cannot be same thing as stating that it is mandatory requirement or a precondition that at the time of summoning a person under section 319 of CRPC, he should be given an opportunity of being heard. That is not the mandate of law, in as much as section 319 clearly uses the expression to proceed, which means to proceed with the trial and not to jeopardize the trial at the instance of the person summoned by conducting a mini trial or a trial within a trial, thereby derailing the main trial of the case. And
You are not challenging the notice. You are challenging the rejection of an application filed under section 319, which is confirmed by the revisional court also.
But
Sir. They were never charged.
No.
Then how can you bring someone at 319 application
I
file,
have
Madi?
video evidence.
No, sir, nothing.
Video evidence,
No.
which is at annexure.
Yes. Now notice, yes, next. Take it to Supreme Court. Yes, next.
82.
ಇನ್ನೊಂದು ಇತ್ತಲ್ಲ,
447 and final
Identical
6, along
petition.
with the SC/ST Act, atrocity.
ಯಾವ್ದು ಇನ್ನೊಂದು ಪೆಟಿಷನ್ ಇದೆಯಲ್ಲ ಯಾವ್ದು?
ಅಲ್ಲ, ಇನ್ನೊಂದರಲ್ಲಿ 44.
Criminal petition 1209 of 2022.
Yes.
ಅದ್ಯಾವ್ದು?
Criminal petition 4157/25 ಅಲ್ಲಿ case number 1 and 2. They prepared a criminal petition and obtained.
ಕೊಡಿ ಸರ್, ನಂಬರ್ ಕೊಡಿ, ಸ್ಟೇ ಆರ್ಡರ್ ಕೊಡಿ.
4157/25.
ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಟ್ಯಾಗ್ ಮಾಡಿ ಕೊಡಿ, ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ.
Yes, next.
Annexure F, my lord.
83.
144 page number.
Yes. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, ಚಾರ್ಜ್
ನಿಮ್ದಲ್ಲ ಸರ್. ನೆಕ್ಸ್ಟ್. In the meantime, only if the charges have not been framed as on today. Next.
84.
For the petitioner, my lord.
CC of 2018, sir.
Yes, my lord. My lord, he was absconded because there was a threat from the IO officer.
ಟ್ರಯಲ್ ಅಲ್ಲಿ ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ರೆ ಈಗ ಆರ್ಡರ್ಸ್ ಇದೆ my lord.
ಇಲ್ಲ, my lord.
Two
The actual fact is that he was
I will
illegally
direct
detained.
speedy trial ಅಷ್ಟೇ.
My lord, he was illegally detained.
No, sir.
And there was a brutal.
ಅದೆಲ್ಲ
assault
ಈಗ
on him,
ಹೇಳ್ಬೇಡಿ.
my lord.
2018 ಆಗಿರೋ ಇನ್ಸಿಡೆಂಟ್ಸ್ ಎಲ್ಲ 2026 ಅಲ್ಲಿ ಡೋಂಟ್ ಟ್ರೈ ಟು ಪ್ರೊಜೆಕ್ಟ್.
My lord, I'll produce the memo, my lord.
No,
IO
sir.
officer was.
8 ವರ್ಷ ಆದ್ಮೇಲೆ ಆಗಲ್ಲ.
My lord, he was illegally detained for twice, my lord.
ಯಾವಾಗ? when?
From the after making the FIR, my lord.
when?
2016, my lord.
We are in
2026, my lord.
then, sir.
He was illegally detained. my
No,
lord.
sir. For 10 years, sir.
No, my lord. He
Then?
was illegally detained, and they have attempted to recover the original
When?
voucher, cash
When,
voucher, my
sir?
lord. 2016, my lord.
You are complaining it in 2026. I will not listen to all
The
that.
threat for his life, my lord.
No.
That's the reason, my lord. It's a civil dispute, my lord, and I have
No
produced,
problem, sir.
I have produced a copy
No,
of the cash
nothing
voucher also,
doing.
my lord.
CC of 2018, crime of 2016. I will only direct speedy disposal. That's all. If you want to. Otherwise, I'll dismiss it straight away.
Crime 2015 my lord.
Crime 2015.
There is a cash
10
voucher
ವರ್ಷ
also, my
ಆದ್ಮೇಲೆ
lord.
what is all this?
No, my lord, it is a civil dispute, my lord.
Hey,
Cash
maybe,
voucher,
sir.
Cash voucher produced, my lord.
No, sir.
He has made the payment. He has been arraigned as an accused, my lord.
No. Nothing. I will only direct the concerned court to dispose it in 3 months.
Much obliged.
That only is. The petitioner is before the court calling in question, seeking the following prayer. The crime is registered in the year 2015. The police conduct investigation and file a charge sheet in the year 2018. The matter is pending for the last 8 years as CC2 in CC 2018, CC so-and-so of 2018. The learned counsel for the petitioner now projects that the petitioner was illegally detained in the year 2015 and matter is purely civil in nature. In the light of the issue being of the in the light of the matter being 11 years old before the concerned court, the only order that can be passed today is directing the concerned court to expeditiously dispose the petition dispose the petition at any rate within an outer limit of 4 months from the date of receipt of the copy of the order, if not earlier.
Much obliged.
All contentions remain open. Next.
55.
Notice, B report accepted.
Notice.
Notice, yes. 1 HCGP 2 notice.
86.
Please, my lord.
Heard the learned senior counsel AK but appearing for the petitioner. The petitioner is embroiled into the crime on the score that in a vacant construction site, bottles of beer were found which are attributed to the petitioner. This cannot become the subject matter of crime on finding the bottles of beer taken from a particular place found in a vacant construction site. Therefore, there shall be an interim order of stay of all proceedings by the petitioner till the next date of hearing. ಅಷ್ಟೇ ಅಲ್ಲ?
Can be quashed also.
ಈಗಲೇ ಕ್ವಾಶ್ ಮಾಡ್ಬೇಕಾ? ತಾಳಿ ಒಂದು ನಿಮಿಷ. ಅದೇ ಕವರ್ಡ್ ವಿಲ್ ಸಿ.
Please.
List the matter on 21st April.
87,
No representation, 2 weeks. Yes.
88,
Interim custody.
Well,
Gold.
2019, it has been seized before the police.
Learned HCGP is directed to accept notice for the respondents. List the matter on 6th in the fresh matters list. Yes.
But in the meantime, my lord, the interim custody may be given.
ಅಯ್ಯೋ ಅವತ್ತು ಇಂಟ್ರಿಮ್ ಕಸ್ಟಡಿಗೆ ಹಾಕಿದ್ದು. ಇನ್ ದಿ ಮೀನ್ ಟೈಮ್ ಏನ್ ಬಂತು? ಎಸ್.
89,
Petitioner is accused number 285. JY. Yes.
90,
ನೆನ್ನೆ ಅದಿತ್ತಲ್ಲ ಇಲ್ಲ ಅದೇ ಅಲ್ಲ? 80?
490.
89. You are not there.
I was here.
Stayed, sir. Yes. Stay is granted, sir. Yes.
Similar to yesterday.
90,
Similar to yesterday. Date is not given in any of.
ಅಲ್ಲ ಕೊಡಿ, ನೆನ್ನೆದ ಮ್ಯಾಟರ್ ಅಟ್ಯಾಕ್ ಮಾಡಿ.
Please, I'll pass.
ಇವತ್ತು 2-3 ಇದೆಯಾ?
ಇಲ್ಲ, ಇದು
ಒಂದೇ. ನೆನ್ನೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದರಲ್ಲಿ. ಸ್ಟೇ ಕೊಟ್ಮೇಲೂ ಡೇಟ್ ಬೇಕಾ?
One disposal.
ಓ
91,
ಮ್ಯಾಟ್ರ್ ಬರ್ತಾ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಡಿಸ್ಪೋಸಲ್ ಸ್ಟೇ ಇದೆಯಲ್ಲ ಇರ್ರಿ.
Please.
91.
91. Invocation the provisions.
Coca.
Coca.
Learned additional SPP is directed to accept notice for the respondent to secure, to go through the papers and make his submissions. 27th fresh matters.
Please.
Heard the learned senior counsel. Yes.
92,
17A in 13 not applicable at all. Disproportionate asset 670.
Proportionate asset.
ಮತ್ತೆ ಏನು?
Let's 13(1)A, not B.
13(1)A na? Criminal misconduct.
Criminal misconduct. But I was the Shirastedar. Allegation is the complaint was given that his property. Admittedly, complaint is not against me. Even in the preliminary inquiry, nothing is found against me. But having worked there, as Shirastedar, for that period, 2013 to 23, I am now arraigned for 13(1)A.
Doubtful about this. Yes.
13(1)A ಗೆ 13(1)A on the misconduct. Your lordships may kindly see 17A, 1 on 17.
Right, I'll take it tomorrow.
Very well.
Fresh matters.
Please.
I thought it's 13(1)E. And 13D. Yes.
93,
Notice is given to you earlier?
In the civil proceedings, yes.
Not
Your
in civil, madam.
By
By
the
the government?
By the government, yes, Your Lordship. There has been a stay on this.
On that notice also?
Yes, Your Lordship.
Page?
There's been a stay on the final order. Notice was issued, proceedings were
yes.
conducted. There's a stay on the final order.
The learned counsel for the petition heard this one. So petitioners are before this court calling in question. Petitioner is accused number 14, calls in question the registration of a crime for offence punishable under section 192A. The foundation of the crime is itself stayed by the coordinate bench of this court in WP 38035 of 2025.
Lordship, just one more submission. On the previous instance, an entire trial was conducted, criminal trial on the same offence, Your Lordship. The judgment of that is at page number 67.
Acquitted,
Acquitted, Your Lordship.
No, that is LGC.
Your Lordship, same offence, same.
The learned counsel for the petitioner would further submit that the proceedings before the land grant court has ended in favor of the petitioner, and on this identical set of facts now, the proceedings under 192A is now sought to be conducted. In the light of the aforesaid circumstance of the foundation itself being stayed at the hands of the coordinate bench of this court, there shall be an interim order stay qua the petitioner till the next date of hearing.
Much obliged.
Yes, next.
94,
The stay was operating on.
Operating. You have operated wrongly. Medical negligence.
Medical
Medical negligence alwa
No,
idu.
no, my lord. No, no.
Stay was operating against whom?
My lord's FIR was stayed.
Oh, this is suicide.
Suicide.
108.
Yes. FIR was stayed and charge sheet is filed subsequently.
There was an interim order?
Please, my lords. At
At the
page
stage of FIR.
399.
Page?
Page 399, my lords.
399.
Page 399, my lords, there is 2 volume, second volume. This is dated 23rd, my lords, 23rd of July, June, and charge sheet was filed on 7th of
And that's
July.
all right. What is the,
Please, sir.
I thought it was my order.
This petitioner A2, my lord, page number 54, ಅಲ್ಲಿ second paraದಲ್ಲಿ ಹೇಳ್ತದೆ.
Who died?
My lords, a nurse. And I was the senior anesthetist.
You were having some affair with
That
accused
is
number
what
one.
the allegation, that she suspected that I had some relationship with
What
the
was the relation between deceased and accused number one?
accused number 1 is also a doctor in the same hospital.
I know, doctor.
Allegation is that they had some relationship between accused number 1 and the
The
nurse.
anesthetist and the anesthetist and the doctor.
My lords, nurse is the deceased, my lords.
Nurse is the deceased,
Yes, my
correct?
lords. I was a senior anesthetist. So she suspected that I had some relationship with the doctor, accused number 1.
So why should that lead her to commit suicide?
That is what my
No, that's why I asked, what
But-
is the relation between accused number one and that deceased?
allegation is that she found out that I have some relationship with the doctor.
So what?
That's why she committed suicide.
So what?
That is what the
No,
complaint.
that's why I asked, what is the relation between accused number one and the deceased?
There is no relationship. He's married. He's married and he has no. He's a doctor. They work in the same
No, that's
hospital.
all right.
That's all, my lords.
My lord, page number 54, fourth ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳ್ತಾರೆ madam.
ಅಲ್ಲ ಅವ್ರಿಗೂ accused number one ಗೆ ಏನು ಸಂಬಂಧ?
ಇದೆ ಮೇಡಮ್, ಅದು ಹೇಳ್ತಾರೆ. ಮೃತ ಮಹಿಳೆಯು A1 A2 ಆರೋಪಿಯು ಐಸಿಯುನ ರೂಮಿನಲ್ಲಿ ಒಳಗಡೆ ಹೋಗಿ ಕರೆದಿದ್ದು, ಆಗ A1 ಆರೋಪಿಯು ಹೊರಗೆ ಬಂದು ರೋಗಿಯ ಸಂಬಂಧಿಯ ಬಳಿ ಮಾತನಾಡಿ ಮತ್ತೆ ಐಸಿಯುನ ರೂಮಿಗೆ ಹೋಗಿದ್ದು, ಸಮಯ 12 ಗಂಟೆಯಲ್ಲಿ ರೋಗಿಗಳನ್ನು ನೋಡಲು ಸೆಲೆಕ್ಷನ್ ಟೆಂಡರ್ ಡಾಕ್ಟರ್ ಬಂದಿದ್ದ. ಆಗಲೂ ಮೃತ ಮಹಿಳೆಯು A1 A2 ಆರೋಪಿಗಳನ್ನು ಐಸಿಯು ರೂಮಿಗೆ ಬಳಿಗೆ ಹೋಗಿ ಕರೆದಿದ್ದು.
That cannot be the reason. Anyway.
ಮತ್ತೆ ಅದನ್ನ ಹೇಳ್ತಾರೆ ಮೇಲೆ A1 A2 ಆರೋಪಿಯು ಕಿರುಕುಳ ಕೊಡೋದ್ರಿಂದ
ಅದು ಬೇಡ, ಅದಾಗಲ್ಲ. Yes. The
ಕಾಲಂ ನಂಬರ್
petition.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ.
Huh?
ಕಾಲಂ ನಂಬರ್ 17 ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ ಮೇಲೆ ಡೀಟೇಲ್ಸ್ ಆಗಿ.
That's not enough for 107.
No.
ಅದಕ್ಕೆ ಕೇಳಿದ್ದು, what is the relation between accused number one and the deceased? Nothing.
Nothing.
There must be something.
A2 ಮೇಲೆ.
Huh?
Nothing.
This petitioner A2 ಮೇಲೆ.
ಅದು ಗೊತ್ತು ಸರ್.
Yes.
Unless in
ನಾನು
the
ಕೇಳ್ತಿರೋದು
complaint-
ಯಾವುದೋ ಕಾರಣಕ್ಕೆ.
My lord's complaint also it is mentioned that she is working as a nurse and he is a doctor.
I understand. The accused, the deceased
Please, my lord.
was shocked to see you and the accused. That's the allegation. Relationship between you and accused number one.
Please, my lord.
What is her role? Is I'm asking.
Her role as in the deceased role.
Hmm.
This is a nurse in the hospital. There is no relationship between the nurse and the.
List tomorrow in the fresh matters.
95.
For petitioner. In a case of my lord road rage, FIR registered by the petitioner, my lord, his daughter and petitioner, my lord, 1 and 2 were traveling. At the time, my lord, road rage happened. My lord, they chased these petitioners and they went till the house of the petitioners. Then they made a ugly scene there, my lord. The complaint was registered, FIR was, my lord, thereafter arrest was also held. In the test, my lord, they were tested positive regarding the ganja.
Who?
The complainant and others, my lord, who were traveling.
Yaro, this complainant.
Oh, the complainant. Then after, my lord, arrest and my lord, they were enlarged on bail. They filed a private complaint without giving any complaint to police, my lord, without filing any affidavit. And
Which complainant? Second or third? Respond, you respondent yake 3?
My lord, the third respondent is a media person.
Correct.
Once the matter is referred for investigation, they held a press meet, and pursuant to the press meet, my lord, the photographs of the petitioner number 2, petitioner number 1 were published. They made a news, my lord, in a private YouTube channel. My lord, all private photographs, etc., were published. That is why, my lord, we also sought a interim prayer and also final prayer, my lord, against the third respondent.
No, this incident is of road rage.
Yes, my lord. After that, I lodged, my lord, a complaint, FIR registered, charge sheet filed. My lord, they are facing the trial. Now, in the meantime, my lord, after inordinate delay of 2 months, they filed complaint, private complaint, and now the matter is referred for investigation after 1 year. There is no complaints of, my lord, 175(3), 173 clause 4, no affidavit, not inordinate delay. Then, pursuant to this, my lord, after this order of reference, they held a press meet. My lord, they tarnished my image and reputation, and they are harassing me now. This YouTube channel belonging to the third respondent. The same area, Mangalore. Lord, I was traveling from airport to my house. At that time, Lord, this happened.
Heard the learned senior counsel Arun Sham appearing for the petition.
Number 31 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಮಲ್ಲ ಡೀಟೇಲ್ಸ್ ಹೋಗಿದೆ ಓವರ್ಟೇಕ್ ಮಾಡಿ
ಯಾರು ಓವರ್ಟೇಕ್ ಮಾಡು
ದಿಸ್ ಪಿಟಿಷನರ್ ಮೈಲ
ಕ್ರೈಮ್ ಯಾರ ಮೇಲೆ ರಿಜಿಸ್ಟರ್ ಕ್ರೈಮ್ ಯಾರ ಮೇಲೆ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಫಸ್ಟ್
ಮೈಲಾಟ್ ಅವ್ರ ಮೇಲೆ ಆಗಿದೆ
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಗಾಂಜಾ ಪಾಸಿಟಿವ್
ಮೇಲೆ ಆಗಿದೆ ಪೇಜ್ ನಂಬರ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಫಸ್ಟ್ ಆಗಿದೆ
ಅಲ್ವಾ ಅಷ್ಟೇನಾ The petitioner heard the learned senior counsel Arun Sham appearing for the petitioner. The petitioners are accused 1 and 2 on an incident that happens on
on 9/12
on 9/10/2024 at about 10:40 p.m. where the 9/12 alla 9/10/2024 about 10:40 p.m. the petitioners register a complaint against the second respondent complainant. They were found guilty. The complainant was found guilty of offences punishable under section 118/74. Was prima facie found guilty. Prima facie found involved in the ingredients of offences. In para 5 alide offences so and so, including 27B of the Narcotic Drugs and Psychotropic Substances Act, which becomes a crime in crime number
92 of 24.
Crime number 92 of 2024. The police conduct investigation and file a charge sheet. After about 2 months after registration of the crime by the petitioner and the investigation ensuing, a private complaint comes to be registered against these petitioners. The concerned court, without following the procedure as obtaining into section 175 of the BNSS, refers the matter for investigation after about a year of the incident. Therefore, on the aforesaid facts, there shall be an interim order of stay of further proceedings. Interim order as spread for till the next date of hearing.
But I also sought a direction to the third respondent not to publish or telecast by the press meet held by them, because now kindly see the interim prayer, where we have prayed, to at least make them invisible or not to make available in the public domain.
As prayed for court. Yeah.
Great.
In the meantime, yes.
97.
Ex-partner.
Where is the compromise?
My lord, I produced the compromise, my lord, at page number, my lord, 133, my lord, PCR, and compromise at 11111, my lord.
ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು. ಬೇರೆಯವ್ರದೆಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಕ್ಲೋಸ್ ಆಗಿದೆಯಾ?
ಎಲ್ಲರದು ಕ್ಲೋಸ್ ಆಗಿದೆ. ಅವ್ರು 2011 ಅಲ್ಲೇ 22 has gone out. Now he proclaims that he is the partner right now. He files an affidavit before this court that he is no more a partner.
The petitioner, the complainant and the petitioner are said to have been partners at one point in time. Two proceedings emerge. The two coordinate benches of the court have noticed the fact that the petitioner is no longer a partner and has closed the proceedings closed those cases in collateral proceedings. Now the petitioner claiming that he is a partner seeks to register the crime. In that light, there shall be an interim order of stay of further investigation qua the petitioner till the next date. Next.
I am appearing for the petitioner, my lord. In this case, my lord, this court has Lokadarat, court was otherwise challenged, and this court has dismissed the petition and directing him to approach civil court. My lord.
Straight, sir.
My lord.
Dismissed.
May I pray for a week's time? my lord?
Why,
I'm just
sir?
Seeking instructions.
Supreme Court ಹೋಗ್ಲಿಲ್ವಾ?
ಇನ್ನ ಇಲ್ಲ my lords, I am just seeking
ಮತ್ತೆ
instructions.
ಅವತ್ತೇ ಹೋಗ್ಬೇಕು ಅರ್ಜೆಂಟ್ ಸ್ಟೇ ಮಾಡಿ ಒಂದ್ ವಾರ ಅಂದ್ರೆ.
There are some observations in my lord's order, of course. I'm just seeking instructions, my lord. If I'm within the 30-day limit as well.
Jargold accused, ಮಿಕ್ಕಿದ accused.
Yes, yes.
Accused 1 and 2. ಅಲ್ಲಿ 3 and 4 ಬಂದಿದ್ರು.
Same follows.
Same order, sir.
Fix a date, my lords. I'll just, because I'm within the 30 days for the other order as well. I'm just going through my lords.
ಅದರ್ ಆರ್ಡರ್ ರಿಲೀಸ್ ಆಗಿಲ್ವಾ?
ಆಗಿದೆ.
ಅವತ್ತು ಸಾಯಂಕಾಲನೇ ಮಾಡಿ.
ಅವತ್ತು ಸಾಯಂಕಾಲ. I'm just within the 30 days since that order.
So SLP ಹಾಕ.
ಅಲ್ಲ, ಮುಂದೆನೆ I'm just seeking instructions. My lords, fix a date, my lords, of course.
No, list the matter on 6th in the fresh matters list.
So
ಅವತ್ತು ಹೋಗುತ್ತೆ.
I understand.
Yes. 100. Shant, 118.
My lords, may kindly see page 96. Statement of the student, my lords, before the magistrate. He does not take out the name of accused number 3 at all.
ಅಲ್ಲಿ ಯಾಕೆ ಹೊಡೆದಿದ್ದೀರಾ ಸ್ಟೂಡೆಂಟ್?
No, we haven't, my lords. He has missed 2 examinations.
ಅದಕ್ಕೆ ಹೊಡೆಯೋದಾ?
No, my lords. The mother of the student asked for re-examination. We provided for re-examination. Instead of the student taking up the re-examination, he went away from the school. My lords, in so far as accused number 3, my lords, may kindly see 96 statement before the magistrate.
You are A3, yeah?
I am A3, my lords. I am the secretary of the school. I run 2 schools. Page 96, my lords. This is the statement recorded in compliance with the Juvenile Justice Act. Here in this statement, my lords. 96. In page 96.
Yes.
Name of the accused number 3 is not at all said by the student.
ಅಲ್ಲ, ಯು ಆರ್ ದ ಸೆಕ್ರೆಟರಿ, ನಿಮ್ದೇನ್ ಬರಲ್ಲ ಬಿಡಿ, ಅಲ್ಲಿ ನೀವೇನ್ ಮಾಡಿರಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳಿರಲ್ಲ. ಟೀಚರ್ಸ್ ಹೊಡೆದಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ಇವ್ರು ಕೋಆಪರೇಟಿವ್ ಮಾಡಿದ್ದಾರೆ as per charge sheet column number 17 ಹೇಳುತ್ತೆ.
ಅಲ್ಲ, ಟೀಚರ್ಸ್ ಹೊಡೆದಿದ್ದಾರೆ, ಇವ್ರು ಸೆಕ್ರೆಟರಿ, ಇವ್ರೇನ್ ಮಾಡಿದ್ದಾರೆ?
ಬೇಕಾದ್ರೆ ನಿಮ್ಗೆ ಟಿಸಿ ಕೊಡ್ತೀವಿ, ನಾವು ಈ ತರ ಮಾಡ್ತೀವಿ, ನಮ್ಮಲ್ಲಿ ಇರೋದೇ ಈ ತರ.
ಆಯ್ತು, ಅದಕ್ಕೆ 118 ಏನ್ ಸಂಬಂಧ? The petitioner, accused number 3, secretary of educational institution, is before the court calling in question proceedings in CC 703 of 26 registered for so and so. The allegations are against accused number 1 and 2. The allegation is that they have beaten the child and have also indulged in ingredients of section 118 of the BNS. Insofar as the present petitioner is concerned, the statement of the student itself does not indicate any wrongdoing by the hands of the petitioner. The learned HCGP submits that the allegation against the petitioner is that he has threatened the student that they would issue a transfer certificate that would not become the ingredient of section 118 or 82 of the Juvenile Justice Act. In that light, there shall be an interim order of stay of further proceedings qua the present petitioner only till the next date of hearing. 1 HCGP, 2 emergent notice. No date.
List of fresh matters till number 1.
The 451 application.
3 ವರ್ಷ ಆಗಿದೆ.
In fact, I think it was dismissed once and then restored, and then we see that Tumkur cattle matter, my lord, where your lordship summoned the reports and.
ಅಲ್ಲ, ಪಿಂಜರಪೋಲಕ್ ಬಿಟ್ಟಿದಿರೋ ಇಲ್ವಾ ಅಂತ ಅದಾನೆ. ಈಗೇನ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋದೀಗ? ಇಂಟರಿಮ್ ಕಸ್ಟಡಿ ಸೋನ್ಸ್, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಬೈ ದ ಪಿಟಿಷನ್.
2-3 ಸಾರಿ ಹಂಗೆ
ಬಂದೂ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ. ಓ, ಆಗ್ಲೇ ಆಗಿದೆ ಬಿಡಿ. This court, there has been no representation on behalf of the petitioner throughout. This court on 2/3/2026 had passed the following order. Even today, there is no representation on behalf of the petitioner. They left with no option. This court dismisses the matter for its non-prosecution. Yes, next.
Number 2.
Petitioner in this case. Petitioner is challenging the abet charge sheet filed against the deceased, my lord.
in the road traffic accident which concerns the road traffic accident, my lord. Earlier that initially the complaint was against the respondent number 3.
Hello, you are the complainant.
I am the complainant.
Father of the victim.
Victim is deceased, my lord.
Hmm.
I am the complainant as well as the father of the.
ಏನ್ ಬೇಕೀಗ?
ನಮ್ಮ ಡಿಸೀಸ್ಡ್ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಡಿಸೀಸ್ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
Initially,
allegation that they are demanding the amount for the money for the filing the charge sheet.
accident case.
ಆಯ್ತು, ಡಿಸೀಸ್ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್.
ಅವನೇ ಓಡಿಸ್ತಾ ಇದ್ದ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಅದು ಅಲ್ಲಿ ಟ್ರೈಬ್ಯುನಲ್ ಎಸ್ಕೇಪ್ ಆಗಕ್ಕಷ್ಟೇ.
In fact, ಇದರಲ್ಲಿ the inquest Mazar ಮೇಲೆ.
Even Mazar, the 2 vehicles has been
Inquest Mazar disclosed that deceased was not the rider. He was only pillion rider.
ಇವ್ರು ಹೇಳಿರೋದೇನೋ ಅಲ್ಲಿ ರೈಡರ್.
No, it's correct. He is saying the same thing. Inquest also says the same thing. Surprisingly, post inquest, further statement was recorded, and in the further statement, they make him as a rider. And then
ಈಗ ಏನ್ ಕೇಳಿದ್ದೀರಾ?
Seeking for further investigation.
Further investigation.
I'll
see, just take
call
notice.
the IO, my lord.
The learned additional SPP to make his submissions on. We'll take it on first April.
But
3.
I'm appearing for the respondent number.
Vacating stay. Yes, sir.
Yes, my lords. My lords, the petitioners number 1 to 3 have executed a MOU in favor of the complainant herein, my lords. The MOU is at before this honorable court at the page number 40, my lords, annexure D. My lords, kindly refer to the page number 43, my lords. Permitted to. ಅದಾಗಿ ಮೇಲ್ಕಂಡ ನಾವುಗಳೆಲ್ಲರೂ ನಮ್ಮಗಳ ದರದ ನಿಮಿತ್ತ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತನ್ನು ಮಾರಾಟ ಮಾಡಲು ಇಚ್ಛಿಸಿರುತ್ತೇವೆ. ಅದಾಗಿ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಎಲ್ಲಾ ದಾಖಲಾತಿಗಳನ್ನು ಸರಿಪಡಿಸಿ ಖಾತೆ ಪಾಣಿ RTC ಮುಖಾಂತರ ದಾಖಲಾತಿಗಳನ್ನು ನಮ್ಮಗಳ ಹೆಸರಿಗೆ ವರ್ಗಾಯಿಸಿ ಕೊಟ್ಟು ಮಾರಾಟಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಎಲ್ಲಾ ಕ್ರಯದ ವ್ಯವಹಾರಗಳನ್ನು ಮಾಡಲು ಮೇಲ್ಕಂಡ ಸೋನ್ಸೋ ಅವರಿಗೆ ಅದ ನಿಮಗೆ ಒಪ್ಪಿಗೆ ಸೂಚಿಸಿ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತನ್ನು ಸೋನ್ಸೋ ಅಂತ. My lords, after this,
ಈಗೇನ್ ಅಲಿಗೇಷನ್ ಏನು?
My lords, after this MOU is being executed between the parties, my lords, there was several payments have been made. At the time of the initial talks, my lord, they have been paid 10,001 rupees, my lords, as an advance. Later part, they have been paid 15,000 rupees by way of check. After lapse of 6 months, my lords, after scrutinizing of all the documents before for the legals, they have paid an additional sum of rupees 30 lakhs. My lords, after that, my lords, we have been given the several instructions to them to mutate the kata in the name of the petitioners. But they did not make this kata, or they did not made any efforts to that. My lord, sufficient opportunity, the time has been given. As per the MOU, my lord, there was a 1 year time, but they did not. After that, my lord, I have been issued the legal notice to the complainant and the another person, my lords. It's annexure E, my lords. On 26/3/2025, forfeiting the amount and cancellation of the cancelling the MOU which has been entered between the parties. After issuance of the legal notice, my lords, after service of notice, the complainant has been filed the FIR against the petitioners, my lords.
Krishnapur.
My lord, your lordship may kindly see annexure R3. On the date when they executed the MOU, on the date when they executed the MOU, they were not the owners. That will be clear from annexure R3 at page number 22. 26
Proceedings before the DC.
DC has held that particular person is the owner.
The order above proceedings so and so. Revenue entries in their names. Who is the owner of the property?
ಆ ಕೇಸಲ್ಲಿ ಇವರು ನಾನು ಓನರ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ ಅದರ್ ಪರ್ಸನ್ ರಮೇಶ್ ಅವರು he has filed the same grant order and that special DC holds that he is the owner in ಇದರಲ್ಲಿ ನಮ್ಗೆ ಆನ್ ದಟ್ ಡೇ ದಟ್ ವಾಸ್ ಅನ್ 15/4/21 ನಲ್ಲಿ ಇವರು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡೋದು 23 ನಲ್ಲಿ ಮಾಡ್ತಾರೆ. ಆನ್ ದ ಡೇ ವೆನ್ ದೇ ವರ್ ಫುಲ್ಲಿ ಅವೇರ್. ಅದಾದ್ಮೇಲೆ ಅವರು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ತಾರೆ, ದ ಪರ್ಸನ್ ಇದು ಖಾತಾ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ. So knowing fully well they were not the owner, they have entered into an agreement with me and obtained 45 lakhs and 10,000 rupees. ಆಯ್ತಪ್ಪ ಹಣ ಆದ್ರೂ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ನಮ್ಗೆ ಅಂತ ಕೇಳಿದ್ರೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹತ್ರ ಬಂದ್ರು ಹ್ಞೂ ಅಂತ ಹೋದ್ಮೇಲೆ ಫೋರ್ಫೀಟ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ದೇರ್ ಇಸ್ ನೋ ಕ್ಲಾಸ್ ಇನ್ ದಿ ಅಗ್ರಿಮೆಂಟ್ ಫಾರ್ ಫೋರ್ಫೀಚರ್ ಆಫ್ ದಿ ಅಡ್ವಾನ್ಸ್ ಅಮೌಂಟ್.
Yes, sir.
Yes, my lord.
ಲಾಸ್ಟ್ ಟೈಮ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡು ಹೇಳ್ತೀನಿ ಅಂತ ತಾವು ಹೇಳಿದ್ರಿ 45 ಲಕ್ಷ
ವಾಪಸ್
ಕೊಡಿ ಇಲ್ಲ
ಕೊಡ್ತೀರಾ?
ಅಂದ್ರೆ ವಾಪಸ್ ಕೊಡಿ ಅಂತ
My lords, I have
ಹೇಳಿದ್ರಿ.
been,
ಇನ್ಸ್ಟ್ರಕ್ಷನ್
ಅಲ್ಲ ವಾಪಸ್ ಕೊಡ್ತೀರಾ?
My lords, I have been specifically advised the clients with respect to the same, my lord, but they have been specifically taking the condition.
Don't worry, we'll dismiss it straight.
No,
Because
as
on the face of it, it is cheating.
Exactly, my lords, in this particular aspects, my lord, as per the R series which they have been relaying, my lords, kindly refer to the annexure K, my lords. In the year 1947, my lords.
1947 na?
1947, Sanjeevappa got the Savoli Chiti. Subsequently, my lords, as on the year 1946, the age of the Sanjeevappa is around 40 years, my lords. My lords, now in the R series, my lord, they are specifically taking a contention that the petitioner, sorry, the complainant is the son of, sorry, one Ramesh is the son of the Sanjeevappa, my lords. My lords, kindly refer to the age of the Ramesh, my lords. It doesn't match to that. Where in this particular document,
Other challenge, why should they suffer?
My lords, as per those,
No, sir. Now you enter into an MOU of a property that is not free from encumbrance at all.
My lords,
Just as simple as that.
My lords, adikoskara kindly refer to the page number 43, my lord. They themselves come forward to mutate the kata in favor of the house because the petitioners are the illiterate people and they does not
No,
have
idagli investigation agli.
My lords, after the issuance of the legal notice itself, they have been filed the complaint, my lord.
Correct.
My lords, my submission before this honorable court, my lord, this MOU is been entered in the between the parties on 10/8/2023. After due verification of the documents, my lord, they have been paid the additional amount of rupees 30 lakhs.
No problem.
By way of the
Yes. Anything
check,
else?
my
Sir?
lords.
Anything else? The petitioners are accused 1, 2, 5 are now at the doors of this court calling in question registration of a crime in crime number 107 of 2025 for the following offenses. Heard so and so. A transaction takes place between, the genesis of the issue relates to a transaction. The transaction is a memorandum of understanding between the petitioners and the complainant on 10/8/2023.
Sorry, petitioner 1 to 3 and the complainant.
Petitioners 1 to
3, my lord.
ಇನ್ನೇನ ಹೇಳಿದ್ದು?
Alla petitioners there have been 4 and 5, my lord.
Petitioners 1 to 3 and the complainant. The 4 and 5 are witnesses.
Witnesses to the said MOU, my lord.
So and so. The between 1 to 3 and the complainant. Pursuant to the execution of the memorandum of understanding or drawing up of the memorandum of understanding, certain financial transactions have taken place between the two by the complainant transferring an amount of rupees close to 45 lakh. 45 ಎಷ್ಟು?
45 lakhs 10,000 and 1 rupee.
ಇನ್ನೇನಿಲ್ವಾ?
ಅಷ್ಟೇ.
45 lakhs 10,000 1 rupee.
ಹೌದು.
1 rupee. ಅದು ಬರೀ 1 rupee ಮಾತ್ರ. 1 rupee. The petitioners then cause a legal, the petitioners on coming to, the complainant on coming to know that the land was not free from encumbrance, seeks refund of the amount. At which point in time it transpires that the petitioners the petitioners have indicated that the amount has been forfeited and the agreement memorandum of understanding cancelled.
They have not made any efforts.
Memorandum of understanding cancelled. The immediately thereafter springs the crime. Springs the crime in crime number, crime number 107 of 2025 for the aforesaid offences. The learned counsel appearing for the petitioner submits that the learned counsel for the petitioner submits that the plea that is put up in the application seeking vacation of the interim order should not be considered at this juncture, should not be considered for resolution of the subject list, as the very proceeding before the deputy commissioner is a farce instituted by son of one Sanjeevappa, who also claims to be a grantee of the same land from the hands of the state. The learned counsel submits that a purely financial transaction between the petitioner and the complainant or breach of a memorandum of understanding is projected to become a crime and therefore the proceedings must not be the investigation must not be permitted to be continued. Per contra, the learned counsel M. Krishnappa, appearing for the complainant, takes this court through the documents appended to the application seeking vacation of the interim order. The same land is granted to the same land that forms the subject matter of MOU is granted to one Sanjeevappa, whose children file proceedings before the deputy commissioner, special deputy commissioner, who holds it in their favor. And ಏನ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇದು
21-22
ಅಲ್ಲ R2 ಏನು
R2 is the orders of dispersal.
Orders
ಅದು ಗೊತ್ತು ಏನು
Directions, mandamus.
ಅದು ಖಾತೆ ಮಾಡ್ಲಿಲ್ಲ ಸ್ಪೆಷಲ್ ಡಿಸಿ
when
ಆರ್ಡರ್ ಆದ್ರೂ ಅಂತ writ petition
pursuant
ಹಾಕ್ತಾರೆ.
to the order of the special deputy commissioner, the records were not the entry was the corresponding entries were not made or rejected by the Tahsildar. Therefore, the petitioner, the respondents had to complainant had to approach this court in 25210 of 2023, which allowed the claim of the complainant. With all these facts, the learned counsel submits that the crime must be permitted to be continued as as on the day of entry, as on the day of the petitioners 1 to 3 entering into memorandum of understanding, they were not the owners of the property. Knowing full well they have entered into a transaction and have lured the complainant into such transaction for a consideration, for the transfer of consideration of 45 lakhs. The learned additional SPP.
One correction, that WP 25210 was filed by the other claimant who claims that the land belongs.
ಅದೇ
Ramesh
ಅಂತ
ಅಂತ
ಹೇಳಿದ. ಅದೇ ರಮೇಶ್
He's not the
ಅವರೇ.
complainant.
Ramesh is the third person, my lord, where does not relate.
ಅಲ್ಲಿ
ಅಲ್ಲಿ
He
anyway,
claims that
maze
the
of
land-
facts.
ಸಂಜೀವಪ್ಪನ
ಅದು
ಮಗ ಅಂತ ಅನ್ಕೊಂಡು
ಇವರು ಸಂಜೀವಪ್ಪ ಮಗ ಅಂತಾರೆ.
Yes, my lord.
Ramesh
This is
claims
what the
that the
Ramesh claims that he is the grandson of Sanjeevappa.
sorry, my lord. Son of Sanjeev.
ನಮಗೂ ಸಂಜೀವಪ್ಪ
ಗೊತ್ತಾಯ್ತು, ನಿಮಗೂ ಸಂಜೀವಪ್ಪಗೆ ಸಂಬಂಧ ಇಲ್ಲ.
Sanjeev ಅಪ್ಪನಿಗೂ ಸಂಬಂಧ
ಗೊತ್ತು
ಇಲ್ಲ.
ಅದೇ
he would be saying that the land belongs to him.
no, land belongs to him is what they say, them is what they say.
Correct.
They are not children of Sanjeevappa.
That is the rival claim exists between one Ramesh.
Whatever, it's not free
Correct.
from
It's not
encumbrance
free from
ಅಷ್ಟೇ.
encumbrance.
So ಅದು ಅಲ್ಲಿ ಕರೆಕ್ಷನ್ ಮಾಡ್ತೀನಿ. Yes. The learned additional SPP also would take this court through the documents appended to the petition to demonstrate that that there were rival claimants for the land that became the subject matter of the MOU, and therefore the matter would require investigation as to the petitioners were not the owners of the property as on the date of entering into an MOU, and knowing full well they did enter into an MOU. I have given my, so the aforenarrated facts are not, the aforenarrated facts are all a matter of record. The link in the chain of events are also a matter of record. The genesis, as observed herein above, is pursuant to an MOU. The schedule in the MOU is as follows. Page 44. Pursuant to the execution of the MOU, transaction of 45 lakhs is, there has been a transaction of 45 lakhs of transfer of the amount from the hands of the complainant to the petitioners. The petitioners then, on coming to know, legal notice ಕೊಟ್ಟದ್ದು ಯಾರು?
The
Complainant
petitioners,
ಅಲ್ವಾ?
my lord. Petitioner 1 to 3.
Legal notice.
Legal notice. now-
Subsequently, they said that it's a cancellation of.
Legal notice is by complainant.
ಇಲ್ಲ ಇಲ್ಲ
ಅಲ್ಲಲ್ಲ.
ಅವರೇ ಕೊಟ್ಟಿರೋದು
By
ಸ್ವಾಮಿ.
annexure E, my lord, by the petitioner.
Annexure?
Annexure E, my lord, 46 page.
E is by whom?
By the petitioner.
By the
2 to 3,
petitioners.
my lord.
The petitioners then cause a legal notice that seeking the complainant to come forward to register the sale deed. Then comes the impugned crime. In the first blush, alva,
They only say, since you are not come forward, we're cancelling the entire agreement. That's the substance of.
who has
legal-
not come forward?
There are the complainant. So the titles are not clear. In spite of titles are not being clear.
Early anyway. The legal notice is caused on the said score page. The petitioners in the legal notice in the legal notice would contend that the 45 lakhs amount that is received by them is forfeited and the memorandum of understanding is cancelled. It is then the crime emerges by the petitioners, by the complainant in crime number 107 of 2025, based upon the said complaint. The complaint reads as follows, page 26, 27. The complaint has its foundation. The foundation is in the proceeding before the deputy commissioner. Before the deputy commissioner, claiming to be the legal heirs of one Sanjeevappa who was granted the land, the subject land, seek entry of their names in the records. The special deputy commissioner allows the claim by the following order. Page 25, 26 of the objections. The names are not entered, therefore, or the names are not entered or rejected. Reject ಮಾಡಿದ್ರೆ ಮುಂಚೆನೆ
ಅದು ಎರಡು ಹಾಕಿದ್ದಾರೆ, seeing that acquired ಆಗಿದೆ ಅಂತ ಒಂದ್ಸಲ ಕೊಡ್ತಾರೆ, ಅದು acquired ಇಲ್ಲ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ.
Anyway, yes.
ಎರಡು read
The claim of these petitioners, claim of the complainant for entry of their names had been rejected by an endorsement dated 21/4/2023. That becomes the subject matter of challenge before the coordinate bench in WP 25210 of 2023, filed by the son of Sanjeevappa, who had claimed to be the original grantee. The coordinate bench allows the petition by the following order, page 20-21. With all these, what would unmistakably emerge is the dispute with regard to the title over the property which had become the subject matter of the memorandum of understanding. What would prima facie emerge is the petitioners not being the owners of the property for entering into a memorandum of understanding and receipt of amount of 45 lakhs from the hands of the complainant. Therefore, the ingredients of the offences so laid against the petitioner are prima facie met, which are 406, 420 inter alia. In that light, the matter requires investigation in the least. The matter is not purely civil in nature as is projected, as the petitioners, not being the owners of the property, have entered into an agreement with the complainant, lured into a transaction and received 45 lakhs from the hands of the complainant. In that light, the investigation must ensue in the case at hand. For the aforesaid reasons, rejected.
Annexure R2 ಫೈಲ್ ಮಾಡಿದ್ದು ರಮೇಶ್ ಅಂತ ಕಂಪ್ಲೇಂಟ್.
ರಮೇಶ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲ, ಅದು ಹೇಳಿದ್ದೀನಿ. ರಮೇಶ್ ಸನ್ ಆಫ್ ಸಂಜೀವಪ್ಪ ಅಂತಾನೆ ಹೇಳಿ. Next.
Petition, please. This may be dismissed as withdrawn, please.
ಯಾವ್ದದು?
This matter, fourth matter.
Not pressed.
Not.
In terms of the memo. Why?
Grounds. It has become infructuous.
Grounds of arrest.
Petitioner matter, connected matter. It is a case and counter case matter, different investigation.
Case and counter case.
Case and counter case.
5.1. Yes, sir.
Page number 35 and page number 70 matter, charge sheet matter.
Different investigating officers.
Different investigation officer.
My lord, in 11/817 of 25, I filed an wakalat today. Only this.
We'll quash it and send it back for fresh investigation. The learned counsel so and so submits that he has entered appearance for the complainant in both the cases.
In the
one case matter. In one case matter, I am appearing.
Oh, correct. Yav case al nimdu?
500 of 25, I am the petitioner.
Petitioner. So our hesaru 11817 ಹಾಕ್ಬಿಡಿ.
11.
The cases, the petitioners in both these cases call in question the proceedings in so and so separate. One incident that happens on 19/7/2020 becomes the fulcrum of two proceedings. One in crime number 86 of 2020 and the other in crime number
85 matter.
In 85 of 2020. Therefore, it is a case and a counter case. The offences are identical except in one case what is projected is an offence punishable under section 307 of the IPC. The Investigation ensued pursuant to the registration of the crime. The investigation is not conducted by the same investigating officer, notwithstanding the fact that it is a case and a counter case. This court has time and again directed the state that when case and a counter case is registered, the investigating officer must be one and not different investigating officers, as this court had come across several cases where on the same incident, one would end in a B report and the other would end in a charge sheet. While that is not the issue in the case at hand, the fact remains that both the investigating officer in both the cases are different. In that light, it is in complete violation of what this court has repeatedly held. Therefore, both these petitions deserve to succeed with a direction to the concerned to appoint direct investigation to be conducted afresh by two different investigating officers. The investigating officers and file a final report before the concerned court for the aforesaid reasons on the following order. Allowed quashed. The matter is remitted back to the hands of the state to entrust the investigation to two different to the same investigating officer in both the crimes. The investigating officer shall conduct investigation and file its final report before the concerned court within 3 months from the commencement of such investigation. Ordered according. All contentions would remain open. All other contentions. Yes.
My lords, the allegation is against me is that I've asked for a written requisition in order to give a written requisition kelidivi anta, my lords, in order to give a certificate confirming the medical condition of the patient, my lords. Magistrate has gone to record the statement of the patient.
One ನಿಮಿಷ.
Please.
ಏನ್ ಕೇಳಿದಾರೆ ಅಂತ?
Magistrate has gone to record dying declaration.
ಹಾ.
Doctor refused to cooperate with the magistrate.
Why, sir? You are the doctor.
That is not the allegation, my lords. I have asked for a written requisition. That is the allegation against me. Complaint is-
ಅಷ್ಟರಲ್ಲಿ ಹೋಗ್ಬಿಡ್ತಾರ ಅವರು.
My lords, I had reasons, my lords.
What
to ask
reasons,
for
sir?
My lords, the patient was from Kerala. She was admitted in Sulya. No one accompanied her, my lords. It was in the midnight. The magistrate turned up to record the statement.
He died, is it?
No, my lords. A dying declaration record agide, my lords.
ಆಗಿದೆಯಾ? ಮತ್ತೇನ್ problem?
She subsequently recorded it, but she refused to even allow the recording of the statement. It's a clear case.
On a
Let them
usual
after
course-
discharge. It's too much of.
ಆಗಿದೆಯಾ?
The police there, judges come to the court, to the
ಆದ್ರೂ ಬಿಡ್ಲಿಲ್ವಾ?
That is even after that.
It's on a usual course magistrate barla. It was in the midnight. That's why she has informed the medical administrative officer also, my lords.
Oh no.
Let's please, my lords.
This is the case, the dereliction of duty.
No, my lords. No, my lords. She has taken all necessary action.
No, sir.
Let's please, my lords. The lordship may allow me to read the statement given by her, my lords.
Yes, sir.
Please, my lords.
Magistrate ಬಂದ್ರು ನೀವು ರೆಕಾರ್ಡ್ ಮಾಡಕ್ ಬಿಡಲ್ಲ ಅಂದ್ರೆ what is who are
My
you?
lords, she has not denied.
Then
Only asked for a written requisition, my lords. Under the-
magistrate ಬಂದ್ರು.
My lords,
Then?
no one accompanied her, my lords. It was in the midnight, my lords. It was at
Court
12.
will, magistrate will take care, sir. Why are you worried?
My lords, on a usual course.
What usual course,
On a
no?
usual course, doctor or inspector will turn up to record the statement, my lords. Here, magistrate was something very.
ಅಯ್ಯೋ
new, my
ಮಾಡಬಾರ್ದು
lords.
ಅಂತಿದ್ಯಾ?
No, my lords. I'm
It
not
is even
denying-
more.
I'm not denying that fact, my lords.
Then
Midnight, ಯಾರು accompany ಆಗಿಲ್ಲ. Case of consuming rat poison, my lords. Case of consuming rat
whatever
poison.
it is, sir, declaration
Please, my lords.
ತಗೋಬೇಕಾಯ್ತಾ?
I admit, my lords, but on a precaution I've asked for a written requisition. ಅದಕ್ಕೆ ಮೇಲೆ ನಾನು ಏನು ಮಾಡಲಿಲ್ಲ, my lords. They have continued to record the statement. Dying declaration, it is recorded, my lords. I had no intention also, my lords, to cause any intention. Initially, complaint.
ಮೌಖಿಕವಾಗಿ ಕೇಳಿದಾಗ ಅಂತಿದೆ.
Oh, ಕೇಳಿದಾರಲ್ಲ. The police has come. It is not that magistrate alone has volunteered. She herself in a statement says that police ಇದ್ರು, 4 ಜನ ಬೇರೆ ಯೂನಿಫಾರ್ಮ್ ಇರಲಿಲ್ಲ, ಅವರಿದ್ರು, ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಬಂದಿದ್ರು. After that, he has come to
ಸ್ಟೇ ಆಗ್ಬಿಟ್ಟಿದೆ ಇದು.
ಸ್ಟೇ ಆಗಿದೆ, my lords.
ಇರ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ದಿನ ಬಿಡಿ. List on 22nd April.
So I have one request to make, my lords. I have mentioned it earlier also. 28th, I am adopting a child. It's on 28th. I have asked for it.
ಓಹೋ, ಇದು ಅಡಾಪ್ಷನ್ ಪ್ರಾಬ್ಲಮ್ ಬರ್ತಾ ಇದೆ.
Adoption ಗೆ problem ಆಗಿದೆ. So
ಅದು ನೆಕ್ಸ್ಟ್ ಕ್ರೈಮ್ ಎಮರ್ಜ್ ಆಗುತ್ತೆ. ಅಡಾಪ್ಷನ್.
no, my lords. I had no intention, my lord. It is.
We'll see. Yes, next.
Its date may be given.
22nd April. Yes.
Grateful.
It's a case and counter case. This the petitioner and respondent number 2 are the neighbors in the new layout. So with regard to road, there's a scuffle. In fact, my lord, this respondent number 2 is a police personnel, it's called constable, who is responsible for all this mischief, and is the one who is the real assailant. And the largest complaint against this petitioner.
ನೀವು ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಕಾಗಿತ್ತು.
ಮಾಡಿದ್ದು ಆಗಿದೆ, ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಆಗಿದೆ. Let me go through the 2 lines with this complaint of both complaint. At he himself admits in his complaint.
Own certificate ಕೊಡಿ.
He compared this at Millard at page 30 this wound certificate, whereas the wound certificate of the respondent number 2, there is no external injuries. It's a generalized body ache, something like that. Whereas in my case, Millard, the petitioner's case at page 64, kindly peruse this page 64. Nail abrasion over forearm, above injury is simple in nature. I have sustained the simple injury, whereas
ನಿಮ್ದು ಅಷ್ಟೇ ಅವ್ರದ್ದು ಅಷ್ಟೇ.
ಇಲ್ಲ, but you absolutely. Let me go to the complaint of this petitioner at page.
ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವ ಅವರು?
ಅವರು ಮಾಡಿದ್ದಾರೆ, ಅವರು ಕೂಡ ಬಂದಿದ್ದಾರೆ.
ನಂಬರ್ ಕೊಡಿ.
7159 of 25.
Tag this petition along with 7159
of 20.
ಬರ್ಕೊಡಿ. Yes. List them both on 2nd April.
Meantime this entry mode.
ಅವತ್ತು ಎರಡು ಡಿಸ್ಮಿಸ್ ಮಾಡಲಿ, ಎರಡು ಕಾಸ್ಟ್ ಮಾಡಿ.
Have the data?
The petitioner is the owner of a Tata Kia Carnival vehicle.
Kia Carnival?
Kia, yes. It is made to order on account of the son suffering from autism. What happened was that, my lord, while the petitioner was in a judicial custody in a CH-14 prison, my lord, the car belonging to him was seized by collecting the key from the wife when it was parked in Goa. Thereafter, seizing the vehicle, the Madanayakanahalli police seeks an application before the Nelamangala learned magistrate to keep it in his custody, which was allowed by the learned magistrate, in spite of section 43 of the Karnataka Excise Act, mandated to make over to the authorized officer appointed under the Karnataka Excise Act. My lord, after his release from the prison, my lord, he had sent an application from prison also. After release from prison, my lord, he makes an application to the learned magistrate, applying BNSS to direct the release of the said vehicle. Instead of exercise the powers under BNSS, because section 43 was not applied at all before the magistrate. The learned magistrate directs that I have no jurisdiction. When first custody, he exercises the jurisdiction. When it is comes to the release, he says he has no jurisdiction.
Will issue notice. Yes.
In interim custody, my lord.
No. We close it itself.
10,000 liters of
Not
liquor.
in this car.
ಏನ್ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ರಿ?
It was not. It was in a vacant, empty vehicle. No.
Factory of manufacturing of fake liquors have been busted.
Case is
The case is
registered.
that this vehicle has been used to transport this.
It was an empty vehicle parked in Goa.
Recovery of 10,000 liters of.
From the vehicle?
No.
At the place where the.
Vehicle is parked.
Yes.
No, vehicle is parked in Goa, my lords. In
Vehicle
the
has been
railway
used
station
to
parking yard. I mentioned it. The case is registered for manufacturing, my lord, some kind of illicit stuff. Thereafter, my lord, they go to Goa, collect the key from his wife, bring the vehicle, empty vehicle from parked place in Goa.
Allah, why that happens?
This vehicle is used to transport all the materials.
Allah, how do you get it?
That is the charge sheet indicator.
Allah, that is, if you see page 61.
Yes. Last 4 lines. ಒಂದನೇ ಆರೋಪಿ ಕೃತ್ಯಕ್ಕೆ ಉಪಯೋಗಿಸಿದ GA 08 AC
ಅಕ್ರಮವಾಗಿ ನಕಲಿ ಮದ್ಯ ತಯಾರಿಸಿ ತಮಿಳುನಾಡು ರಾಜ್ಯಕ್ಕೆ ಸಾಗಣೆ ಮಾಡಲು ಅವರುಗಳ ಮನೆಯಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ಸಂಗ್ರಹಿಸಿದ 10.627 ಮದ್ಯ so this vehicle was used to transport ಅಂತ.
That's what the complaint says. But seizure was only empty vehicle from it's a parked place. And my lord, kindly see 43 provides for immediate consideration. It should go to the authorized officer. Police have no jurisdiction. police may seize, but they should make out to the section 43 of the Karnataka Excise Act to the authorized officer. He does not do so. He
Look in-
makes an application.
Look into that.
Yes, and
Just on Friday.
Please.
Friday, fresh matters.
And perhaps,
Learned additional SPP to secure instructions and make a
that's not,
submission.
one sentence should have been added. Release should be in a good roadworthy condition. All, my lord, they keep it for 2 years, 3
ಏನ್
years.
ಪೇಂಟ್ ಮಾಡಿಸ್ಕೊಡಕ್ಕಾಗತ್ತಾ?
ಅಲ್ಲ ಎಲ್ಲ ಪುಡಿ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ನೋಡೋಣ
One
ತಾಳಿ.
case,
Yes.
in one case, this honorable court, my lord, long back,
We'll see.
directed the new vehicle to be given because chassis number was different.
That will see. Yes, that will. Chassis number change ಇದ್ರೆ ಅದು ಬೇರೆ. Yes.
That was the case. And
We'll see. Yes.
Friday, my lord, that.
Friday.
Please.
For petitioner, my lord, 498A, except husband.
Husband ಇದಾರ?
ಇಲ್ಲ, my lord. From A2 to A8. ಅದು ಇನ್ಸಿಡೆಂಟ್ ನಡೆದಿಲ್ಲ my lord ಅಲ್ಲಿ.
ನಡೆದಿಲ್ವಾ?
ನಡೆದೇ ಇಲ್ಲ. For the reason which I submitted entire photographs because all accused number 2 and 3 were in the hospital. That photograph also lost, page number 100, my lord, lost. As per allegation in the complaint, incident has happened at the time of 6 p.m. The accused number 2, 3, 4, even 1 also were over there from 4:16 to night 9:36 in the hospital.
Why, sir?
Because the age-old parent, MRI for scanning and treatment and all everything. That photograph also, CCTV
Photograph
footage.
ಅಲ್ಲಿ ಏನಾಗಲ್ಲ ಸರ್, ದಟ್ಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್. ಈಗ ಯಾರ್ಯಾರು ಪೆಟಿಷನರ್ಸ್ ಇದೀರಾ ಇಲ್ಲಿ?
Age-old parents, my lord.
ಏಜ್ ಓಲ್ಡ್ ಯಾಕೆ? ಪೇರೆಂಟ್ಸ್ ಅಂತ ಹೇಳಿ ಸಾಕು. ಅದು ಬೇಲ್ಗೆ ಹೇಳೋದಲ್ಲ, ಇಲ್ಲೇ ಹೇಳ್ಬೇಡಿ. 2, 3, 4, 5, 6, 7, 8.
And all others are staying in the outside, my lord.
Child?
Outside.
Yes. Page 37 ಗೆ ಬನ್ನಿ.
Please, my lord.
ಈ 4, 5, 6, 7, 8 ಗೆ will give. Not 1, 2, not 2 and 3.
My lord, they were there because that photograph only I've been submitted, my lord.
No
Because
problem.
they went, the age-old parent, they are 70 years age.
So what, sir?
Father.
That's all right. Vasava.
Incident not at all been happened. my
Yeah,
lord.
don't tell me all.
4 to 8.
Huh?
4 to 8.
ಅದೇ 4 to 8, definitely, yes. One additional SPP2 emergent notice. There shall be an interim order of stay. The allegation against the petitioners are as follows. While allegations galore against the husband, accused number 1, the sprinkling few are against accused number 2 and 3. While there are no allegations of against accused 4 to 8, therefore there shall be an interim order of stay, qua the accused number 4 to 8. Insofar as 2 and 3 are concerned, the same would be considered on the appearance of the second respondent complainant. List the matter on 22nd April. Yes. Next.
10.
Actually, group admin was not.
Why have you left out?
He told my lord that he immediately deleted the content and also reported the police. The next day reported the police.
ಮತ್ತೆ ಇವ್ರು ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿದ್ರಾ?
ಇವ್ರು ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿದ್ರು ಅಂತ.
By accidental it has been.
And the group admin has deleted the
It was
content.
me.
POCSO ಅಲ್ಲಿ by accident.
The message was.
But group admin ಬಿಡಬಾರ್ದು. He is the one who has planted it first.
I have asked them because anyway I've said that he is not. He should have immediately complained. They complained later.
By then he had circulated.
I've asked them to include
No,
him.
not. He is the one who has perpetrated. You circulate ಮಾಡೋದು ಹಾಕಿದ್ದೀರಾ?
I've asked them to,
ಮಾಡಿರ್ಬೋದು.
I've asked them to include.
Yes, list the matter on 16th April. 16th Thursday ಇರ್ಬೇಕೇನೋ. Thursday ಆಗಲ್ಲ 17th.
Lots, 7A and 7B, 8, 9, 10 of PC Act. Let's
FIR charge sheet.
suo moto complaint.
FIR.
FIR. Suo moto complaint has been filed. Public servant was trapped and he was. I'm a private person. My name has been taken by a person who has handed over the currency notes.
Currency notes were caught with whose?
Is a public servant. Public servant. One Manoj, the stated to be person who has handed over the currency notes. And it appears on his inquiry, he revealed that I have instructed him to collect the money from one Aslam, Usman, and hand it over to this public servant. Your Lordship may kindly see the.
But who are you?
I'm no way connected.
He's the middleman to carry the cash to the.
According to the.
Carried the cash, huh?
Yes,
No, no.
he had carried the cash to the place where the accused number 1 has received the 20 lakhs.
Kindly
Right.
come to page number 35.
Evidence.
35 may kindly be seen. Page number 35. ನನ್ನನ್ನ ರಿಕ್ವಿಸಿಷನ್ ಮಾಡಿ ಎಂಟರ್ ಮಾಡಿದ್ದು ನನ್ನ
ಪರವಾಗಿಲ್ಲ ನೀವು ತಗೊಂಡ್ರು ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ ತಗೊಂಡ್ರು ಬೇರೆಯವ್ರ ಮೂಲಕ ತಗೊಂಡ್ರು ಎಲ್ಲ ಎವಿಡೆನ್ಸ್
ಕೈಂಡ್ಲಿ
ನಿನ್ನೆ ಜಡ್ಮೆಂಟ್ ಸರ್
ಅಲ್ಲ ಪೇಜ್ ನಂಬರ್ 35
ಮಂಜುನಾಥ್ ಕೊಡಿ ಸರ್
ಪೇಜ್ ನಂಬರ್ 35 ಒಂದ್ ಬರಿತಾವು ರಿಕ್ವಿಸಿಷನ್ ನೋಡಿ ತಾವು ರಿಕ್ವಿಸಿಷನ್ ಅಲ್ಲಿ ಏನ್ ಬರ್ದಿದ್ದಾರೆ ಒಂದ್ ಬರಿತಾವು ನೋಡ್ಬಿಡಿ
all that could have failed trap really will examine something
because I was not in the place also I was included as a accused subsequently
judgment ನೋಡಿ ಸರ್
kindly see
ಮಂಜುನಾಥ್ ಜಡ್ಮೆಂಟ್ ನೋಡಿಲ್ವಾ
ನೋಡಿದ್ದೀನಿ
ಮತ್ತೆ
ಅಲ್ಲ 35 ಒಂದ್ ಬರಿತಾವ್ ನೋಡಿದ್ರೆ ರಿಕ್ವಿಸಿಷನ್ ವೇರ್ the ground made out to include my name as an accused kindly see the page number 35
It's not Manjunath, it's Mahesh.
Manjunath also ಅದು connected matter
page number 35
Mahesh was accused number 2 in that
Please.
Manjunath is A1 both have been quashed both have been set aside
ಹೆಸರು ಒಂದೇ ಇದೆ ಹಂಗಾಗಿ ಅವ್ರ ಅದು ಮಾತ್ರ
page number 36 ಒಳಗಡೆ relevant portion
yes sir
36 ಅಲ್ಲಿ relevant portion ಆರೋಪಿತರಿಗೆ ಲಂಚದ ಹಣವನ್ನು ನೀಡಿದ ಮನೋಜ್ ಅವರಿಗೆ ಸದರಿ ಲಂಚದ ಹಣದ ಬಗ್ಗೆ ವಿಚಾರಿಸಲಾಗಿ RM ಕಾರ್ಗೋ ಮಾಲೀಕರಾದ ಗಂಗಾಧರ್ ದಟ್ ಈಸ್ ದ ಪಿಟಿಷನರ್ ಗಂಗಾಧರ್ ಸೋ ಅಂಡ್ ಸೋ ಎಂಬುವರು ಚಿಕ್ಕಪೇಟೆಯಲ್ಲಿ ಉಸ್ಮಾನ್ ಎಂಬುವರಿಂದ ನಗದು ಹಣ ಪಡೆದು ಆರೋಪಿತರಾದ ನಿಜಾನಂದ ಮೂರ್ತಿ ಅವರಿಗೆ ನೀಡಲು ಸೂಚಿಸಿದ್ದು
investigation papers ಕೊಡಿ
that is the only allegation against me
I'll investigation. What investigation have you made with regard to state?
Kindly see in the next page, page number 24 at the last paragraph. ನಂತರ ತನಿಖಾಧಿಕಾರಿ ವಶಕ್ಕೆ ಪಡೆದ ಹಣದ ಬಗ್ಗೆ ತಂದು ಕೊಟ್ಟ ವ್ಯಕ್ತಿಯಾದ ಮನೋಜ್ ಎಂಬವರನ್ನು ಕೇಳಲಾಗಿ
ಸದರಿ ಅವರು ಗಂಗಾಧರ್ ಎಂಬುವರನ್ನು ನನಗೆ ಚಿಕ್ಕಪೇಟೆ
ಹಸನ್ ಟ್ರೇಡರ್ಸ್ ಅವರ ಶಾಪ್ ಉಸ್ಮಾನ್ ಎಂಬವರನ್ನು ಹಣ ತೆಗೆದುಕೊಂಡು ಕೊಡುತ್ತಾರೆ
get the investigation papers
please I can understand my lord's inclusion of my name after the investigation if my involvement is there
ಅದಕ್ಕೆ ನೋಡೋಣ let's see first
please
first but first yes first in the fresh matters list
let's till then let them not precipitate the matter
nothing will happen don't worry yes
because I have been called every day
investigation ಮಾಡಲೇಬೇಕು
ಅಲ್ಲ ಹೋಗ್ತೀನಿ ಬರಿ every day ನಾನು I am asked to come there
every day again ಕೆಲಸ ಇಲ್ವಾ ನಿಮ್ಗೆ ಒಂದೇ ಕೆಲಸ
ಕೂರ್ತೀನಿ ಸಾಯಂಕಾಲದವರೆಗೆ ಕೂತ್ಕೋತಾ ಇದ್ದೀನಿ ಹೋಗ್ತಾ ಇದ್ದೀನಿ
yes we'll see first we'll grant some order on that day
please
7A
DA case my lords.
DA
Please notice the source report. The source report is at page 14. Notice ಮಾಡಿದ್ದೀರಾ
ಮಾಡಿದೆ ಅದೇ ತೋರಿಸಿದ್ದಾರೆ
page 14 source report is 8/10/2025 my lords. In the source report the assets that are taken is of the family members. The income, when it comes to the income my lords, an income of 1.33 crores is left out. And when they use the expenditure, they use the expenditure on agriculture in expenditure column. And my lords,
pass over. We'll continue at 2:30.
Please.
Hey, 2:30. Continue.
ಬೆಳಗ್ಗೆ not, I could not come, my lord.
ಆಯ್ತು ಕೊಡಿ. FIR ನಾಳೆ ಹಾಕಿ ಮಾಡಿ.
Lords, DRDO official ಮೇಲೆ FIR ಆಗಿದೆ. Why the reason is that ಅವ್ರು ಬೀದಿ ನಾಯಿ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ.
ಬೀದಿ ನಾಯಿ?
Yes, my lords. So may have it tomorrow, my lords.
ಕೊಡಿ. ಅಷ್ಟೇ ಸಾಕು. ಕಂಟಿನ್ಯೂ ದ ಲಿಸ್ಟ್. FR ಇದ್ರೆ ಬರಲ್ಲ, whoever it is. FR ನಂಬರ್ ಇದ್ರೆ ಬರಲ್ಲ. ಯಾವುದು ಮೇಡಮ್ ಅದು? ಯಾವುದು? ಪಾಲಿಸಿ ಇದೆ.
Further hearing 2:30 PM, till number 110.
ಏನು?
Filed against educational person who has opened a college. And ಇದ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. They are trying to dishonor his name and pursuance of which once B report was filed. Now again second FIR they have lodged.
ಆಯ್ತು.
Yes.
ನಾಳೆ FR ನಾಳೆ
ನಾಳಿದ್ದು ಆಯ್ತು ಪ್ಲೀಸ್ ಆಯ್ತು ಪ್ಲೀಸ್.
Further hearing 110.
I'm on 10.4. Mr. Nandkumar is leading, my lords. He's on.
Where is he?
He's just. I can give a brief. Start with a brief background, my lords.
I think AG has some personal difficulty today.
What happened? ಯಾರು? ರೂಬೆನ್?
Rubin.
ಏನಾಯ್ತು?
I'm told is not well, my lords.
I will never oppose, my lord. Absolutely no question about it. But if your lordships deem it fit, petitioners could
ಲಾಸ್ಟ್
complete
ಟೈಮ್
and then
ಇದೆ
they can.
ಲೈಕ್ ಪೀಸ್ ಮೀಲ್ ಬೇಡ ಅಂತ ಹೇಳಿ. Thursday same time. ಅಲ್ಲ Thursday there is one matter I've already given time.
Can it be next week? But can
Only on Tuesday and next 1st April.
Can I take a
That's
chance
next
on-
working day.
Please. First April.
The 2nd April.
Second.
First or second? Then
Second.
2:30.
Second 2:30. Yes.
But can I just make one request for lordships deem it fit, my lord? On that day, even if there's some difficulty on the side, we will complete, my lord, and then your lordships may.
The learned counsel, learned additional advocate general Ruben Jacob is said to be indisposed today. Therefore, list the matter on April the 2nd at 2:30 PM. In the event the counsels would not be present, whoever is present would be
I'm
heard,
so grateful.
and time would be granted to persons who time would be granted to counsels who would submit later.
I'm so grateful. Interim orders may please.
Interim orders subsisting of any kind shall continue to the next date of
Deeply
hearing.
grateful. Great.
List number 2.
ಅಲ್ಲ ಇನ್ಯಾವ್ದಾರು ಇದೆಯಾ? 2:30?
12.
Desirability of a preliminary inquiry, my lords. Right from Charan Singh, now the latest ruling is Ashish Dave, my lords.
ಎಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ.
But
ಯಾವ್ದಿದೆ?
idರಲ್ಲಿ ತಾವು, if the source report is seen, source report, on 8th is a source report, my lords.
Yes.
And in the source report, statement A is blank. My lords would notice this at page 15.
What is an ideal source report?
My lords, a check period should be there.
Correct.
The four statements have to be complete in particulars. Now, in a given scenario, my lords, if you are going to be using assets of family members, then the desirability of having a preliminary inquiry. Now, family members, my lords, if they've been declaring their income tax returns, you don't even consider it, and you don't have a preliminary inquiry, you go on to have a FIR registered. Consequences of having that FIR registered, my lords, will itself defeat the purpose of section 17. That second proviso which has been given, my lords, the SP application
Now,
of mine.
cash was found?
No.
No cash.
No. My lords, idralli check period itself, if my lords would notice page 14 alli, check period itself, they take the check period from 2014 to 2025 when he's been a public servant from 1993. Now, on page 15, assets at the beginning of the check period, 0. Then, my lords, assets description, please notice at page 16, wife.
ಅಲ್ಲ ಯಾವ್ದು zero ಇಲ್ಲಿದೆಯಾ?
First, what to 0? Page 15 ಅಲ್ಲಿ. Statement A. ಈಗ statement B ಅಲ್ಲಿ assets at the end of the check period, properties that are taken from property number 2 onwards, my lords, family members.
No, assets at the beginning of the check period ಏನು ಇಲ್ಲ. What is the beginning of the check period here?
My lords,
the day you join service.
They have not taken that. Please notice, I joined service, I'm drawing some salary from 1993.
What were you working as?
My lords, please notice the previous page, my lords, page 14, last paragraph. So from 1993,
no,
my
you were a
lords,
daily wage employee.
Yes. At 1993. So payment, my lords, for a public servant, as I'll point out, my lords, the definition of public servant is.
ಎಷ್ಟು ಸಂಪಾದನೆ ಮಾಡಿದ್ರಿ 93 ಇಂದ?
Kindly notice, I'll show it from the next page.
When did you?
My lords,
one ನಿಮಿಷ. You were regularized as what?
My lords, I was regularized as second division
assistant only.
Assistant, yes, my lords.
That is on 3/8/2015.
15.
So you worked as a daily wage employee
from
93. That is 22 years.
22 years. Now kindly notice what they take in the next page.
ಏನ್ ಸ್ಯಾಲರಿ ತಗೋಬೇಕಾಗಿತ್ತು ಅದಕ್ಕೆ?
ಅಲ್ಲ, income, my agriculture income, they've taken it under expenditure. My lords, please notice next page. Assets ಅಲ್ಲಿ for the beginning of check period 0. They don't take any assets at all. So 2025, when you're taking it as
131% is a disproportionate asset.
My lords, ಇದನ್ನ ಒಂದ್ಸಲಿ statement A ತಾವು ನೋಡಿದ್ರೆ, statement A ಅಲ್ಲಿ ಏನಿಲ್ಲ. Statement B ಅಲ್ಲಿ assets taken. From serial number 2 onwards, please notice, my lords, till serial number 14. Wives, sons, daughters' properties are taken into assets.
One moment. What does wife is a government servant or working somewhere?
She has a business, my lords.
What business?
Beauty parlor. And
beauty parlor. Beauty parlor.
Well, she has a tailoring and beauty parlor.
All right.
And income tax returns are there. Then, my lords, still serial number 14 may be noticed. It's all of the family members. My lords, here.
Till serial number 14 family members.
ಹೌದು. From
family members ಎಲ್ಲ ಏನ್
my
ಮಾಡ್ತಾರೆ?
lords, serial number 2 ಇಂದ serial number 14 ವರೆಗೆ family members. My lords, primary submission is the desirability of a P.
So that will
Please
see.
notice that. Now, please notice.
No, you have purchased properties in their name, as simple as that.
My lords,
Unless
then,
you show.
My lords, would it not be required to have a preliminary inquiry? Then otherwise we don't have a concept of PE at all. Now Supreme Court does not say, my lords, PE need not be done. They say desirability. Now desirability comes when, my lords, this started with Charan Singh, Vijay Lakshmi.
No, that's what I said in Gangadharaya, it is reversed.
And my lords, but sent back, my lords, here is being reconsidered. What has been sent back here, 2 points which is open for consideration. One is desirability of PE is open for consideration. Application of mind while passing an order under the second proviso of 17 is open for consideration. Points which are not open for consideration, my lords, whether PE is mandatory. Supreme Court said it is not mandatory, depends on case by case desirability. Second, what is not open is, my lords, whether 17 order, can it be before the registration of FIR? The Supreme Court says it may not be necessary, it could be simultaneous. 2 points not available, 2 points available. Now, in this case, now on desirability, because, my lords, the PE is dated on 8/10. Same thing is put into the FIR on 10/10. Not a day taken to even examine this, my lords. And please notice, my lords, the income from agriculture, what we have is 1.33 crores, my lords. My wife's income and my agriculture income
What agricultural income where, sir?
My lords, 18. Please notice page 18. Expenditure ಅಲ್ಲಿ serial number 2.
Agriculture, where? What do you own?
They themselves say, my lords.
What do you own agricultural income?
No, agriculture. Which are all the agriculture?
ಅಡಿಕೆ ತೋಟ ನಿರ್ಮಾಣ.
My lords.
ಯಾವಾಗ ತಗೊಂಡಿದ್ದು ಯಾವಾಗ ಅದು?
We can produce the
Serial number.
details of
See,
the
when did
agriculture
you buy-
property, but
when did you buy the
expenditure,
agricultural property?
expenditure ಅಲ್ಲಿ ಅವರೇ ತೋರಿಸಿದ್ದಾರೆ. How did they take expenditure without taking the income?
I would say, my lords, that I have received the authorization on Friday. I'll file my objection. But besides that also,
And
what needs to be borne in mind, my lords, is that the very fact that the preliminary inquiry was not mandated, but it was only said that it is the discretion of the inquiring agency to find out. It is not, he is not precluded from appearing before me and giving all these details.
Not
I will
after
consider
FIR is
it.
done, my lords.
Why
FIR
is he
has
rushing
its
to this
consequences.
No, my lords.
There's a difference after FIR and preliminary inquiry.
Oh, no, my lords.
Post FIR, consequences come. That's the reason, my lords, the additional protection that's given only for DA cases. Section 17 proviso comes there. And also, my lords, under section 17, the rank of the officer who investigates would be DYSP. Exception to that is, my lords, if in a case the state government feels this is a fit case where an inspector can do it, they do a notification. Now, this is not what is being done at present. Cases are just given to inspectors on the basis of a common notification. The whole object of the act is defeated by that.
No, no,
A high-ranked officer like DYSP is mandated under the act to investigate. And the exception is when you feel so, an inspector having sufficient experience who can do it. Now, not like that, my lords. Even this case, please notice the order 17
Sorry.
order. It's given to an inspector to investigate.
There is a common notification which now
How can
authorizes
that
an
be
inspector.
contrary to the act?
No, my lords. I wouldn't say the
Now,
statute.
then the whole
statute
object of
doesn't
the act
say-
is being defeated.
My lords, the statute doesn't say on a case-by-case basis the state government has
Then,
to
my
do it.
lords,
The state government, if
then
if
there was
my
no-
learned friend is agreed by that, he should challenge it, my lords. It's a case-by-case basis. The statute doesn't prescribe to that effect. And the whole purport of having this authorization is to see whether this officer
lords.
has the adequate expertise to go into such issues.
Let him file his objections.
One important aspect, even in IPC cases, now this is what Supreme Court holds, my lords. How you ought to have a preliminary inquiry. This was on 27th,
Ashish Dave, yes. I know.
27th February, my lords. Supreme Court, even in IPC offences, don't straight away register the FIR. At least look at whether it discloses a cognizable offence to that extent.
Justice Sandeep Mehta.
This is the latest, my lords. My lords, starting from Charan Singh till now, my lords, all flows from Lalita Kumari, my lords. Lalita Kumari, Charan Singh, then came Vijay Lakshmi, desirability, which they extracted. Even in Sudhakar Reddy, Channa Keshava, and this Ashish Dave. Otherwise, my lords, the purpose of having PE is defeated.
Well, see, let him file his
My
objections.
lords, 2025 IT returns need not be the edifice of one's defense.
No,
2025.
correct, but that should also
That is
be
what their
taken.
main case is.
That should be taken note of. Could you?
My lords, Nirankarnath Pandey very clearly says that.
My lords,
IT returns, if you're not taking it into consideration, it's quashment of FIR. Two aspects in Nirankarnath Pandey. One is IT returns, one is a period of check period. Here, we don't even have a period for check period.
My lords, if there is no period prescribed, I have judgments which say that it should be from the inception of the tender.
How do we balance?
No,
That is also by two judges.
Please, that's an anomaly in the system itself, my lords. Unfortunately for us.
Otherwise, my lords, the object of having a protection under 17 is lost. And it is only there for DA cases and no other cases.
It's not a protection, my lords.
It
It's
is a
only-
protection.
No, no, please.
I'm
I would
sorry, my
disagree.
lord, 17
Even
is a
I am very
protection.
sorry. I would say it is
17 is a protection
only to
given to a public servant.
ascertain whether the expertise is there for him to comprehend the
No, no, no.
investigation and go into it.
17
My
is you
lords may
shouldn't
read
have
this
frivolous
section.
cases against public servants. That's the object.
Well, see, file your objections. I'll grant you time till 9th.
Please.
List the matter on 9th.
Could I be protected, my lords?
What protection?
I've been called Dane and Dow
Let him
before
come
that.
in, my lords.
I will not say.
I'll not file
don't
charge sheet without the leave of the court.
That is that. He won't file. Yes, heard the learned senior counsel Sandesh Shauta appearing for the petitioner. List the matter on 9th April. ಅದು ಇನ್ನೊಂದು ಡಿ ಅದೆಲ್ಲ ಯಾವ್ದು ಎಲ್ಲ ಕೊಡಿ.
My lords,
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಹಾಕೋಣ.
the charge sheet not to be filed without the leave of
He has
court.
undertaken. He will.
ಅದು
I'll
ಬರ್ಲಿ,
inform
my
you.
lords. ನಾವು next time ಬರುವಾಗ ಇಲ್ದಿದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
I'll keep the draft charge sheet ready, my lord.
ಅಲ್ಲಲ್ಲ.
Assuming he cooperates with the investigation.
No, for us, next time for us.
The respondent shall not file the final report before the concerned court without the leave of the court.
Obliged, my lords.
Deeply obliged.
Without the leave of this court.
No, but the only problem is with the number of matters BB Patil appears for, my lords. If he has forgotten that he has told this, I'll
that
be
he
in
will
trouble.
not, sir.
I will have problems.
There are
my lords.
barely any matters I'm appearing, my lords, these days.
Obliged.
13.
13, my lord, he is accused number 6.
On the
The
previous
endorsement in
occasion.
the charge sheet, my lord, that the further investigation is
Previous
pending.
occasion, my lord, your lordship was pleased to pass an order. And calling upon my learned friend
Page 36 ಅಲ್ಲಿ.
on 13th, my lord, there's an order.
Antecedents.
Yes, yes. Page 36, my lord, your lordship can see for a moment, my lord, in the charge, in the petition. The allegation, my lord, that he is the one who hired and paid money. And the last para, my lord, ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿ 6 ರವರು ಆರೋಪಿ 1 ರಿಂದ 5 ರವರೆಗೆ ಮಾತನಾಡಿರುವ ಫೋನ್ ಪೇಗಳ ವಿವರ ಆರೋಪಿ 6 ರವರ ತಂದೆ.
ಅಲ್ಲ, you are absconding ಅಲ್ವಾ?
ಹೌದು.
ಅಲ್ಲ, that is what their case.
ಇಲ್ಲ, ನಿಮ್ಮ ಮೇಲೆ ಏನು allegation ಇಲ್ಲ because you are absconding.
No, that is not that. Not case. Their case is not I had hired accused number 1 to 5. Not and I had paid money through phone pay. Not your lordship was pleased to call upon them. Where is the phone pay? Not anything to indicate that
It's attempt to murder.
ಅಲ್ಲ, ಅದಿಲ್ಲ. ಜೊತೆಗೆ not there is nothing to indicate I had any contact with A1 to A5. Except voluntary statement, there is absolutely nothing.
I'm afraid for respondent number 2 in this case.
ಏನು?
Same thing, my lord, wherein which he is involved, he is the person. Apart from that, even the proper investigation not done by the police side also. The purely that speaking that, if at all, a father of the A6 driver and his friend, one Vijay Kumar, all are involved. Here, the matter is that they have been established in bar, GR bar and restaurant in the place of industrial area, which is not supposed to be done. The father of A6 is Kuda chairman, KGF Development Authority chairman, who is in a politically financial person. There is a PAL pending before this honorable court. To the extent of that, it has been established in the.
You are the complainant.
I am the complainant in this case.
Now, my lord, then I have spoken to SP today. Since there is already an endorsement saying that the further investigation is pending, we will further file an additional charge sheet against him.
As on date, except voluntary statement of the co-accused, there is
We
absolutely
don't know
nothing.
corroboration. ನೀವು investigation participate ಮಾಡಿದ್ರೆ corroboration.
He has been shown as
ನೀವು absconding
Oh,
ಅಲ್ಲಿ
no, I
ಯಾವ
participated.
corroboration?
Not he was, sir. He has participated.
No, ಬನ್ನಿ ಇಲ್ಲಿ.
Page 30.
No, I have surrendered on 4/7.
ನೋಡಿ ಇಲ್ಲಿ.
No, on 4/7 is surrender. Charge sheet is filed on 22/7.
No, Inspector Bill.
ಸರ್, ಆರೋಪಿ 6 ಅವರು ಫೋನ್ ಪೇ ಹಣ ಏನೇನಿದೆ?
ಅಲ್ಲ, ಫೋನ್ ಪೇ ಏನಾರು ಇರ್ಬೇಕು ಸರ್. ಸಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೇಲೆ, ಸಮ್ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್, ಫೋನ್ ಪೇ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಆರೋಪಿ 6 ಅವರು ತಲೆಮರೆಸಿಕೊಂಡಿದ್ದು ಪತ್ತೆ ಕಾರ್ಯ ಮುಂದುವರಿಸಿರುತ್ತದೆ.
ಐ ಆಮ್ ಸಾರಿ, not on 4/7 I surrender. 22/7 may not they file charge sheet. After lapse of 2 weeks.
You are on bail ತಾನೆ?
Inspector Bill is an Inspector Bill.
Not as on
No
today.
warrant to stay or quash now.
Not as on today, except one in the statement, there is absolutely nothing.
Let me see. You further investigation
But
ಮಾಡ್ತಾ
High Court
ಇದ್ದಾರೆ.
wants to frame charge, my lord.
Further investigation ಮಾಡ್ತೀನಿ ಅಂತ ಇದ್ದಾರೆ.
Alla, there is nothing, my lord. I have been named as an accused, my lord, in the charge sheet. Let my learned friend, my only request is, if there is anything except not voluntary statement of co-accused, not let my learned friend show.
Is there, my lord?
If there is anything except voluntary statement.
ಏನಿದೆ?
My lord, in this case, A1 is a rowdy sheeter.
ನೀವು ಹೇಳಿದ್ದು ಹೇಳ್ಬೇಡಿ. ಇಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ.
A1 is a rowdy sheeter. He himself admits after surrender by himself.
ಅದೇ voluntary statement.
ಅಷ್ಟೇ ನಾನು ಹೇಳಿದ್ದು, ಮತ್ತೆ ಏನು ಹೇಳಿಲ್ಲ.
And he was residing in their house and he was there in all the functions, activities on the instructions of him ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀಟಾಗಿ ಹೇಳಿದಾರೆ ಸಮಯದಲ್ಲಿ ಎಲ್ಲಾನು. ಆಮೇಲೆ ಅಮೌಂಟ್ ಕೊಟ್ಟಿರೋದು ಪ್ಲಸ್ 2,000 ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದು, ಆಮೇಲೆ ಅವ್ರನ್ನ ತೋರಿಸಿದ್ದು ಹಾಲಿನ ವ್ಯಾಪಾರ ಮಾಡ್ತಾ ಇರ್ತಾರೆ ಇವರು. ಹಾಲು ವ್ಯಾಪಾರ ಮಾಡೋದ್ರಲ್ಲಿ
ಯಾರು ಇವರ?
ಕಂಪ್ಲೇಂಟ್
ಹಾಲು
ವ್ಯಾಪಾರ ಮಾಡ್ತಾ ಇರ್ತಾರೆ, ಅಲ್ಲಿ ತೋರಿಸ್ತಾರೆ. ಅಲ್ಲಿ ಕ್ಯಾಮ್ರಾಸ್ ಇದ್ದಿದ್ದ ಕಾರಣದಿಂದ ನಾನು ಅವ್ರನ್ನ ಏನು ಮಾಡಕ್ಕಾಗಿಲ್ಲ. ಅದಾದ ನಂತರ 9 ಗಂಟೆಗೆ ಟೈಮ್ ಆಗಿರುತ್ತೆ, ಊಟ ಮಾಡ್ಕೊಂಡು ಹೊರಗಡೆ ಬರ್ತಾನೆ. ಹೊರಗಡೆ ಬಂದಾಗ ಆ ಟಿ ಶರ್ಟ್ ಹಾಕೊಂಡಿರ್ತಾರೆ. ಏಕಾಕಿ ನನ್ನ ಗಾಡಿಯಲ್ಲಿ ಹೋಗಿ ಅಟ್ಯಾಕ್ ಮಾಡಿದ್ದು ಅಂತ ಹೇಳಿ ಅವನೇ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೇಳ್ತಾರೆ. ಆ ಗಾಡಿನೂ ಸೀಸ್ ಆಗುತ್ತೆ. ಆ ಗಾಡಿ ಸೀಸ್ ಆದ್ಮೇಲೆ ಕಾರಲ್ಲಿ ಓಡೋಗಿರ್ತಾರೆ ಇವರು.
They want to frame charge against me based on voluntary statement. Not let them show, my lord, if there is anything.
Yes, Jagdish.
Anything against me.
Why do you conduct such investigation?
Because he was absconding. Lordship, if we have shown him as an absconding.
You are absconding.
Not they should have not conducted further investigation against me. They want to frame charge, my lord,
ಅಲ್ಲ,
tomorrow
who
day
asked you
after.
to be absconding? Now we'll ನೋಡಿ ಇಲ್ಲಿ.
Not even after, I'm not, charge sheet is
Charge
filed
sheet
now.
indicates that you are absconding.
On 22/7/25, not charge sheet is
Sir,
filed.
whatever it is, ಈ ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿ 6 ಅವರು ತಲೆಮರೆಸಿಕೊಂಡಿದ್ದು ಪತ್ತೆ ಕಾರ್ಯ ಮುಂದುವರಿಸುತ್ತಿದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಮಾಡಿದಾರೆ ಅದನ್ನ.
Not
If
22/7.
you don't participate in the investigation, what corroboration will you get?
22/7/25. No, corroboration ಏನಂದ್ರೆ I will not, you lost
Corroboration, if you participate in the now I will permit you to participate in the investigation, they will file additional charge sheet. If you are not guilty, fine, over. ನೀವು absconding ಅಲ್ಲಿ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ನನ್ನ ಹತ್ರ ಏನಿಲ್ಲ ಅಂದ್ರೆ nothing is against me.
No, I make one submission. The allegation is I have paid money through phone pay, for which my presence was not required.
Phone pay presence is not required, definitely.
Or
But
CDR presence is not required.
to establish the link between others and you for a conspiracy, your investigation was imperative. Why you did not participate in the investigation?
Not after I took anticipatory bail, not I participated. Not they filed
No,
charge sheet.
sir.
Not your lordship will
ತಲೆ
file.
ಮರೆಸ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತಾನೆ ಇದೆ ಇಲ್ಲಿ.
Not on 22/7/25, not they filed charge sheet. Even after 9 months, not there is no development.
ಅಲ್ಲ ಅದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇವ್ರ ಕೆಲಸ ಆಗೋಯ್ತು, ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ, further investigation ಮಾಡ್ಬೇಕಲ್ಲ
ಏನ್
ಏನಾದ್ರು.
ಮಾಡಿದೀರಾ?
Further investigation is happening, my lord. That will be done in next 2 weeks.
You cooperate with the
I'll
investigation.
definitely cooperate. No, let the charge be not framed. No? As on
Cooperate with the
today,
investigation.
as on today, in the charge sheet, there is nothing except.
Petitioner is accused number 6. Is alleged of plethora of offences including attempt to murder and arms act. The learned counsel P. Prasanna Kumar submits that charge sheet does not spell any overt act of the petitioner. It is only the accused number 1 who renders his voluntary statement that drags the petitioner into the web of proceedings, as accused number 6 is his emphatic submission. A perusal at the charge sheet indicates that the petitioner was absconding. There is no investigation worth the name conducted to draw any corroboration apart from the voluntary statement of accused number 1. There, the learned additional SPP submits that the permission has already been sought under subsection 9 of 193 to conduct further investigation, 193 BNSS, to conduct further investigation into the matter.
ಅದಕ್ಕೂ ಏನೋ 90 days time ಏನೋ ಇದೆ. Within that time, you will have.
Further investigation, I will permit, sir.
Alagi.
Further investigation into the matter. The learned additional SP further undertake that if 2 weeks' time is granted, the petitioner cooperating with the investigation, further investigation would be conducted and appropriate role of the petitioner would be placed before this court on the next date. Therefore, list this matter on 21st April in the fresh matters list. The concerned court shall not frame the charges qua accused number 6 till the next date.
Please. Shall not appeal.
Yes.
Please.
Next.
14.
This petition, my lord, other petitioners are been quashed by this honorable court. This is a BDA compensation matter, my lord. The present petitioner is an accused number 3 in this matter, my lord.
ಯಾರು ಕೋಶ ಆಗಿರೋದು ಯಾವುದು?
I have placed the order, my lord. All the order. This honorable court only.
Annexure ಮಾಡಿಲ್ವಾ?
I have placed.
ಕೊಡಿ. ಇರ್ಬೇಕು ತಾಳಿ ಕೊಡಿ.
And this is a BDA matter where compensation has been released in favor of the party who has purchased the property, my lord. Suppressing the fact that the owner, accused number 1, who is the owner of the land, my lord, suppressing the fact that it is what acquired by the BDA, my lord. And
This is that advocate.
Yes, my lord. My lord, all the other accused persons have been quashed except accused number 2, my lord.
ಇನ್ನೇನು ಒಂದು ಮಾಡಿದೆ ಯಾವುದು?
Yes, my lord. Last.
ಜಗದೀಶ್ ಎಲ್ಲಾರ್ದು ಮಾಡ್ಬಿಟ್ಟಿದೆ.
ಅಲ್ಲ ಕರೆಕ್ಟ್, ಬಟ್ ಕಂಪ್ಲೇಂಟ್ ನ ಪಾರ್ಟಿನೇ ಮಾಡಿ.
ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ?
No, my lord, this is a complaint raised by the BDA.
State is not a party?
State is a party. BDA has to be party.
BDA has filed a complaint to the police.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಬೇರೆ ಯಾವ್ದ್ರಲ್ಲೂ ಸ್ಟೇಟ್ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ.
ಯಾಕಿಲ್ಲ? ಎಲ್ಲಾದ್ರಲ್ಲೂ ಸ್ಟೇಟ್ ಪಾರ್ಟಿ.
State is party. I have made a
ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
Even complaint is made as a party. Lordship is 437, your lordship's order.
ಕರೆಕ್ಟ್, ಎಲ್ಲಾರ್ದು ಕಾಸ್ಟ್ ಮಾಡಾಗಿದೆ.
ಮಾಡ್ಲಿ.
ಕಂಪ್ಲೇಂಟ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ?
No, my lord. A complainant is a BDA who has presented a complaint to the police and police has basis.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ?
No, there was no complaint at all, madam. Complaint intersect between the BDA and the police, madam. That is the reason.
ಒಂದ್ ನಿಮಿಷ ಸರ್. ಮಾಡೋದು ಪ್ರಾಪರ್ ಆಗಿ ಮಾಡಕ್ ಏನಂತೆ? BDA ಪಾರ್ಟಿ ಮಾಡಕ್ಕೇನು?
No, my lord.
ಏನ್ ನೋ ಮೈ ಲಾರ್ಡ್? ಪಾರ್ಟಿ ಮಾಡಿ ಈಗಲೇ.
No, complainant is not a BDA, my lord. The FIR lordship has to kindly see the page number 18.
ಎಲ್ಲಾ ಕಾಸ್ಟ್ ಮಾಡಿರೋ ಕೇಸಸ್ ಅಲ್ಲಿ complainant is a party. If you want to make it. Otherwise, I'll adjourn it by 8 weeks.
Please.
Yes.
Tomorrow.
ಅದು ಹೇಳಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತಾನೆ. ನೀವೇ ಕೊಡ್ತಾ ಇರೋ ಜಡ್ಮೆಂಟ್ಸ್ ಇದು ಕವರ್ಡ್ ಅಂತ. ಕಂಪ್ಲೇಂಟ್ ಪಾರ್ಟಿ ಬೇಡವಾ?
No, my lord. In this, my lord, police is made as a party, my lord.
1 minute, sir.
Indramma is the matter.
ಇದ್ರಲ್ಲಿ ಇಂದ್ರಮಣಿ ಯಾರು ಸರ್?
Indramani is a police officer.
ಆಯ್ತು ಸರ್, ಅವ್ರು ಪಾರ್ಟಿ ಮಾಡೋದ್ ಬೇಡವಾ?
I will permit it to make today, sir.
Yes.
The date will be
first ಮಾಡಿ ಪಾರ್ಟಿ
today only.
List the matter next, 2nd April.
First step.
1st April, fresh matters, yes.
15.
Complainant's writ petition, my lords, offense is 138.
Yeah.
As against rejection of the application filed.
311 application.
311 application.
ಎಷ್ಟನೇ application?
The first application, my lords,
ಕೊಡುವ?
4th application.
my lords,
ಮತ್ತೆ
ನಾವು-
first ಅಂತ
ಅಲ್ಲಲ್ಲ,
ಇದ್ದೀರಾ?
ಇದು ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಅವ್ರ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್, ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಗೆ ಪೋಸ್ಟ್ ಆಯ್ತು. ಅವ್ರು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ರು. In the written argument, they have taken up a contention that, my lords, that we have not produced the resolution. We wanted to produce the resolution authorizing the complainant to file the complaint. That application came to be rejected on the ground that matter is posted for judgment.
Correct. I will also reject it on
Lords,
the
now
same ground.
Kindly see, my lords,
No, sir.
page 43 for a moment.
ಅವ್ರು ನಾಳೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಈ ತರ ಏನೋ ಮಾಡಿದ್ರು ಅಂತ ಮತ್ತೆ ಅದಕ್ಕೆ ಕೌಂಟರ್ ಮಾಡಕ್ ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್.
ಇಲ್ಲ, ಅವರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಿದ್ರು ಒಂದು ವಿಚಾರ ಬೇರೆ, ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ರು.
ಅವೇ ಪರವಾಗಿಲ್ಲ. ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಗೆ ನೀವು ಕೌಂಟರ್ ಹಾಕಿ ಸಾಕು, ಅದಕ್ಕೆ 311 ಅಪ್ಲಿಕೇಶನ್ ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲ, kindly see 43, page 43.
No, sir. Anything else?
Now kindly see for a moment 43.
Yes, sir.
Order dated 21/1/2026. Accused present, advocate praise time, but already time granted. Hence, case is posted for judgment with liberty to file written arguments. Call on 29/1/2026. ಅವತ್ತು 29/1 ಗೆ matter is
ನಿಮ್ದು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿ.
ನಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ.
ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿ.
Now they have taken up a contention made.
ಅಲ್ಲ, ನೀವು ಒಂದು ಕಂಟೆನ್ಷನ್ ತಗೊಳ್ಳಿ ಇದರಲ್ಲಿ.
Resolution ಇಲ್ಲ ಅಂತ, complaint will be dismissed only on the ground that, my lords,
ಅದು ಆಗ್ಲಿ, ಆಮೇಲೆ ನೋಡೋಣ. Yes.
Kindly see page 51 for a moment. This
ಅದಕ್ಕೆ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಪರ್ಮಿಟ್ ಮಾಡಬಾರ್ದು ಸುಮ್ಮನೆ.
ಇಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೀವಿ ಸರ್. ನೆಕ್ಸ್ಟ್ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಾಕಿದೀವಿ.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
page 51, my lords.
ಕೇಸ್ ಇಲ್ವಾ?
ಕೇಸ್ ಇದೆ. 138 offense.
ಕೇಸ್ ಇಲ್ದಾದ್ಮೇಲೆ 4-4-5 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಒಂದು 311, ಆರ್ಗ್ಯುಮೆಂಟ್ ಒಂದು 311.
ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾನು ಹಾಕಿಲ್ಲ, ಅವ್ರು ಹಾಕಿರೋದು.
ಅಲ್ಲ, ಆಯ್ತು, ಅವ್ರು ಹಾಕಿದ್ದಕ್ಕೆ ನೀವು ಒಂದು 311 ಹಾಕ್ಬೇಕು.
Kindly see page 51.
Yes.
First paragraph, last 3 lines.
Fourth application ಹೆಂಗೆ ಹೇಳಿ?
My lord, first application was on 3/5/2023, my lord.
That
was allowed. Then second application on 24/2024.
3/5/2023.
That is first application.
Allowed.
Then 24/24.
24/24.
Second application was allowed, my lord. 30/12/2024. Third application was allowed. Then, my lord, they said they have no further evidence on 17/21/26, my lord.
Written arguments will not make the case, sir. It is argument. Court will have to decide. Written argument is not everything.
21/26.
Now one contention.
ನೀವು ಹಾಕಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಏನ್ ಬೇಕಾದ್ರೆ.
ಅಲ್ಲ, ನಮ್ದು ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ authorization.
The petitioner
may trouble, my lords, to kindly see page
you
51
already
for
troubled, sir.
I know that. Page 51 for a moment.
Yes, sir.
Page 51. First paragraph, last 3 lines.
Hence no resolution is passed by the committee by author. ಅದನ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ವಾ ಅವರು?
ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲ, ಅವ್ರ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ರು.
Sir, argument ಮಾಡಿದೀವಿ sir. Previous order sheet
ಅಲ್ಲಿ previous order sheet ಅಲ್ಲಿ heard the argument advanced by the advocate on.
ಆಯ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ.
ಆದ್ಮೇಲೆ and reply other side praise time. ಅಲ್ಲಿಂದ ಮತ್ತೆ advocate praise time.
Yes.
Now initial applications what my learned friend has taken up a contention.
Whatever.
Are, my lords, at the time of evidence.
The petitioner is the complainant, the respondent, the accused. The two have a transaction. The transaction leads to issuance of certain check from the hands of the accused to the complainant. The check having been dishonored, the complainant is before the concerned court for offences punishable under section 138 of the Negotiable Instruments Act. The matter is pending as CC 17 of 2022. The issue in the list at this juncture is not with regard to the merit of the matter.
May I interrupt? He was working as manager in the temple, my lords. At that point of time, he misused the funds.
ಏನ್ ಮಾಡ್ಲಿ? ಅದ್ ಮೆರಿಟ್ ಮೇಲೆ ಹೋಗ್ತಾನೆ ಇಲ್ಲ.
ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅಂತ.
ಓ ಸರಿ, ಅದು ತೊಂದ್ರೆ ಇಲ್ಲ. ಆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಚೆಕ್ ಯಾಕೆ ಕೊಟ್ರಿ ಮತ್ತೆ?
ಚೆಕ್ ಅದು ಮಿಸ್ಮ್ಯಾನೇಜ್ ಮಾಡಿದ್ದು.
ಅದು ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್. ಎಸ್. The issue in the list at this juncture is not with regard to the merit of the claim of the complainant or the defense of the respondent. The petitioner files an application under section 311 of the CRPC seeking to produce certain documents. The documents are purportedly sought to be produced on account of a written argument filed by the respondent with regard to the absence of a resolution to register the complaint itself. The concerned court rejects the application on the score that this is the fourth application in third.
Matter is
Rejects
posted
the
for
application on the score that the matter is posted for judgment, and this juncture at that juncture the application under section 311 could not be entertained. The rejection of the application has driven the complainant to this court in the subject petition. The learned counsel appearing for the respondent would submit that the application now made is fourth in line. The first application was filed on 3/5/2023 under section 311, which was allowed. The second application on 20th April 2024, which was again allowed. The third application on 30th December 2024, which was again allowed. The the arguments stood concluded, and the written arguments, if necessary, the written arguments were directed to be filed. In the written arguments, there is a contention. In the written arguments, owing to a contention, the petitioner files an application under section 311 that cannot be respond ಹೇಳ್ತಾ ಇದೀನಾ ಇವ್ರದಾ ಮೇಡಮ್ ಕಂಟೆನ್ಷನ್ ಯಾರ್ದು ಹೇಳ್ತಾ ಇದೀನಿ in the learned counsel for the respondent would submit that the fourth application of this nature has been rightly rejected as the matter was posted for its judgment. I have given my anxious considerations on. Therefore, narrated facts link in the chain of events which lie in a narrow compass are not in dispute. The four applications filed by the petitioner, the three applications earlier filed by the petitioner are all a matter of record which is not in dispute. The fourth application comes about after the matter being posted for judgment only on the score that there is a written there is averments in the written argument which would cut at the root of the matter with regard to the resolution being absent for registration of the complaint before the concerned court. The learned counsel for the petitioner is now wanting to harp upon a written argument to state a written argument which would be considered by the concerned court at the appropriate time while rendering the judgment. The judgment obviously would not be rendered only on the written argument but on all other contemporaneous documents or evidence that is produced before the court. It is open for the petitioner also to file a counter written argument if he so desires, and the court, it is needless to observe that the court would consider the same and pass necessary orders in accordance with law. Finding no warrant to interfere with the order impugned, the petition stands rejected. Petition stands dismissed.
Right.
16.
This pertains to, my lords, the utterances. Same. Objection, my lords, the complainant has filed. The state, my lords, is yet.
ಯಾಕೆ ಇಷ್ಟೊತ್ತು ತಗೊಂತಾ ಇದೀರ ಫೈಲ್ ಮಾಡಕ್ಕೆ?
They have no objection.
No.
Yes, the complainants have objections.
No, complainants have, my lords. In fact,
Complainant has some oral objection.
Oral objections also, huh?
my lords, quite apart to the merits of the matter. Yes, my lords, and we'll offer that.
My humble submission, one submission, my lordship. The petitioner's apology is an insincere apology. It's not an heartfelt apology because he has tweeted apology that is handled by his managers. I will ask you to file it here in a way affidavit before this court. What else? ಅಲ್ಲಿ ಹಾಕಿರೋದು ಬಿಡಿ, ಅದು ಹ್ಯಾಂಡ್ಲರ್ಸ್ ಮಾಡೋದು, it is not we handle somebody else's, but we will file it here. That should vary.
Yes, please. All sincerity, my lords, please. May I then request my lords to consider my lords filing this on the 10th. The only reason, my lords, I'll be here before your lords on the day. I'll ensure that the affidavit.
No, I am not forcing upon.
No, my lords, we are offering it, my lords, and it's up to them. In all grace, my lords, if they could, if the complainant could consider it, I will place that affidavit and then be before your lords.
So certain times, they are impish in doing such things. What he has done is not correct. I am not supporting that.
One submission.
Really?
See, orally, when we are called orally Chamundi Deva as a female ghost, so orally it should apologize. Because there is no genuine remorse, my lordship, there is no genuine remorse.
That's if they want an oral apology record. May I make this offer, my lord?
You wanted to come here and apologize?
No, we'll go to the temple.
Chamundi,
Separately,
Chamundi, Mysore Chamundi temple, and this time, with the brother Sajjan Goyal, let him come. Let him apologize.
No problem, if you want you to come for the court and apologize.
Let him see, otherwise there will be some sort of.
May I make a submission? Please.
Let him come to the court.
I'll tell you why. If you see the law is dicey. There are so many judgments for and against. Now, you have to answer it in law. I'm not very shy of it at all. But
one submission. Chamundi, the goddess Chamundi, goddess, in Nyaya Pusa Devate, and there is a Nagadeva who is a complementary protection god actually, along with Chamundi.
Sit down to my lord's court.
It is on record. Nagadeva is a complementary protecting god along with Chamundi.
But I place an affidavit. That's their apology. But then I do that exercise. Not that quite separately, independent of the lordship's order. Also visit
he will. It's a mistake that has happened. Mistake that has happened.
And I'll make sure I place the affidavit before the 10th minutes, and I'll work with them on a date.
Better to
I understand.
writing an order is not difficult.
No, I got it. And therefore, I'm not uttering a word on this. I do understand and follow.
See, you should always have remorse.
And there should be a genuine remorse.
Of course, yes.
Even to the cops on the notice, genuine remorse. I responded to that notice. I started with an apology saying that there is a mistake. It occurs sometimes. Rashness mistakes.
No, it's only because of the magnitude or the power of influence that the actor has.
I know.
You are liking as an actor, but the sack.
Who will not? Yes.
That is there.
Because you like me as an actor, you should forgive me.
No, of course, yes. That's why. See, if it was someone else and things like that.
Yes.
My sentiments are I worship that they keep doing. I have to go and seek forgiveness also.
Let's go.
Yes. I accept. Will be before your lordships on the 10th subjects.
Absolutely. We post it on the 10th, please.
Very grateful.
Yes.
$17.
That's an appearing for additional CA number 17. Where connected matters, my lords. There are 5 connected matters.
ಏನಿದೆಲ್ಲ?
May I just make a submission? 17 and 17.2, I'll enter appearance. I don't know for what reason it's not.
What's the matter about?
My lord, it is not connected per se, but I think 17.1 and 17.2 to some extent, my lord, there could be some nexus. But 17 and 17.3 are completely different, my lord. They have nothing to do with this. It deals with offense of stalking of an ex-employee or probably a current employee of, my lord, the accused. And this was done at the behest, my lord, he had employed 2 other people also. They continued to stalk her. Now, that is a different offense altogether in 2025. The offenses, my lord, in 17.1 and 17.2 are different offenses. That also deals with, my lord, sexual harassment and whatnot. I don't want to go into the merits because I was also requested by Mr. Chintan Chinnappa yesterday for a date. He said that I'm not going to press for it, but that may be detagged, my lord, because 17 and 17.3 may not have anything to do with the other 2.
No, but that is the origination of this thing. That's
subsequent offense.
correct, but it's you say second offense happened because of first offense.
ಈಗ what are these all arising out of contractual disputes?
Not at all, my lord.
Then?
So as far as 17.1 is concerned, they say it is, my lord, it's a purely that's a contractual dispute. But as far as 17, 17.2,
ಯಾವ್ದು dealing
17.3,
ಮಾಡ್ಬೇಕು ಈಗ?
I'm sorry,
Dealing
my lord.
ಯಾವ್ದು ಮಾಡ್ಬೇಕು?
17 and 17.3 is a different offense, my lord. In 2025, it's a different
17
FIR
and 17.3.
is a different
We'll
offense
dealing
altogether.
both.
What has happened is it has arisen out of a same suit. That's our contention.
It can be called on the same day, my lord. Correct.
You file your objections, Siddharth.
Please, I'll do that, my lord.
And wherever you are petitioner in some of the things.
ಒಂದ್ರಲ್ಲಿ ಮಾತ್ರ
ಒಂದ್ರಲ್ಲಿ
17.1.
ಅದ್ರಲ್ಲಿ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀರಾ ಹಾಕಿ.
I am appearing, my lords. We'll file our objection.
File your objections in that, we'll hear it.
One more matter has to be connected.
Adu kodi. List these matters on 16th April. Objections, if any, comma, by any, comma, by then. Yes.
Please.
Fresh matters, my lord? Really, you're not taking.
Yes.
ಇಲ್ಲ ಅದರಲ್ಲಿ I'll file my wakalat because 17 and
ಯಾವ್ಯಾವ್ದ್ರಲ್ಲಿ
17.2.
ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಅದು ಹಾಕಿ.
17 and 17.2, my lords may record.
17 and 17.2.
Please.
Counsel Siddharth Suman undertakes to enter appearance for the second respondent. Therefore, the service of notice stands complete. The interim order, if any, shall stand extended till the next date of hearing.
Grateful.
I represent the petitioners. About 21 years ago, to be more precise, during the year 2005, certain properties came to be purchased by the company, that is the first petitioner. In the sale transaction, the first petitioner got itself represented by two directors, one such director being the complainant himself. What he would contend now, my lord, after a lapse of 21 years, no, I have paid the money, they have played fraud during the year 2005, the sale deed ought not to have been taken in the name of the company, it ought to have been in my name. Well, that was the grievance of the complainant in a nutshell. Police would register a crime. Subsequent to thereto, my lord, after the registration of the crime and after completion of investigation, they would file a P report.
P report has been rejected.
report.
Yes, yes. The report is rejected, cognizance is taken.
Cognizance taken as
Further investigation.
He records his own statement and is virtually nothing short of saying cognizance has been taken. Then, my lord, he would order for further investigation.
Where is the order?
Yes, my lord. May I just request your lordship to kindly turn to page. In the proceeding sheet itself, your lordship would get. Commencing from page 53, 24-1-26. My lord, may I request your lordship to kindly turn to 58, my lord, straight away. That is wrong. After taking cognizance, we can't order for further investigation. Page 58, paragraph 10, my lord.
One moment.
Yes, I'm sorry.
58, cognizance ತಗೊಂಡ್ರ order ಇದೆ.
Cognizance ತಗೊಂಡಿಲ್ಲ, order ಬರ್ದಿಲ್ಲ, but
cognizance ತಗೊಂಡಿಲ್ವಲ್ಲ. B report reject ಮಾಡಿ, it's in his power to further investigate, no problem.
No, source statement ಮಾಡ್ಬಿಟ್ಟ ಮೇಲೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ.
ಅದೇ. But on merit itself, I will write.
Yes. But 2005 sale deed, 21 years ago.
That's why B report ಹಾಕಿದ್ವಿ.
Now he realizes that we have played fraud during the year 2005. After 21 years.
Heard
and
the learned
he is
senior
himself a
counsel.
party to the sale deed. He is himself a
Correct.
party to the sale deed.
That's what. Heard the learned senior counsel, Shri C. V. Nagesh, appearing for the petitioner. The petitioners and the complainant.
But he is my father-in-law.
The second petitioner and the complainant, now octogenarians, were partners at a particular, directors of a company at a particular point in time.
Even now he continues. Even now he
continues. At a particular point in time, the accused number, the petitioners, though petitioners continue to be partners in the said company. The complainant and the second accused number 2 register a sale deed in the year 2004. 21 years later, the complainant wakes up and registers a complaint on the score that he has been cheated. The reason for cheating is that he had paid the amount for the purpose of the sale transaction, and the sale deed ought to have been registered in his favor and not in the name of the company. It is surprising that the complainant took 21 years to realize this fact. The time ticked off and the complaint now comes on in the year 2024.
But he would even file a suit also seeking for declaratory relief prior to the filing of the
Adu
complaint.
24, huh?
Howದು ಅದು 24 7/3/24
The added circumstance is that the complainant has registered, instituted
He's my
a
father-in-law,
civil
Milan.
suit.
He's my father. I am his son-in-law.
ಅಲ್ಲ ಅದಾಯ್ತು ಬಟ್ ಕಂಪ್ಲೇನೆಂಟ್ ತಾನೇ ಹಾಕಿರೋದು.
ಹೌದು page 298.
Complainant institutes a suit in OS
621 of 24.
621 of 24 seeking the same relief. The police conduct investigation. The investigation leads to filing of a B report. The concerned court rejects the B report and orders further investigation. For what purpose is surprising, as the delay of 21 years in filing the complaint itself would render the complaint full of embellishments. If the complainant has taken 21 years to realize that the sale deed could not have been executed in the name of the company but had to be executed in his name, it is too late in the day for this court to permit any further proceedings to continue against the petitioners.
But may
Therefore,
make
there
one
shall
submission,
be-
Lord. May make one submission.
Yes,
He is a party to the sale deed. He goes and
Correct,
gives the
ಅದೊಂದು
submission.
ಹಾಕಿ madam. Not 21 year, notwithstanding the fact that the complainant himself is a signatory or a party to the sale deed. ಅದೊಂದು ಹಾಕ್ಬಿಟ್ಟು ಮಾಡಿ. Yes. In that light, there shall be an interim order of stay of all proceedings before the concerned court and the investigation now directed. Yes. Further investigation now directed till the next date of hearing. 1 additional SPP, 2 emergent notice. Next. One zero eight. Yeah.
Abetment to suicide.
Yes.
My lords, merely because I was with the accused number 1, they have made.
No, sir, it's KPID.
No, my lords. There is a protection has been granted, my lords, for the
ಯಾರಿಗೆ?
accused number 2, my lords.
ನೀವು accused number 1 ನಾ?
ಅಲ್ಲ, my lords.
3.
3, my lords.
Proximity.
ನೋಡಿ ಇದು ಟ್ಯಾಗ್ ದಿ ಪೆಟಿಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಇಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ ಮೇಡಮ್, ಸೇಮ್ ಆರ್ಡರ್. ಲಿಸ್ಟ್ ಆನ್ 10th ಆಗ್ಬೋದಲ್ಲ? 10th ಇಸ್ ಫ್ರೈಡೇ. 10th April.
20.
ಪ್ರಾಕ್ಸಿಮಿಟಿ ಇದ್ರೆ ಎರಡು ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ.
Proximity.
ವಿಲ್ ಸಿ. ಎಸ್. ಇದು ಅದೇನಾ?
ಇಲ್ಲ, my lords. There's a different one.
Serial number 20, my lords, I beg to appear for respondent number 2.
Case and counter case.
Yes, my lords.
My lords, there's a sale, my lords. I've purchased. Sale agreement. I've purchased
Civil
the
matter.
property. Yes, my lords. There's
Not a license to assault. 118 ಇರೋದು.
My lords, I've covered. No.
ಅಲ್ಲ, ಈಗ ಎರಡರಲ್ಲಿ ಒಂದು ನಿಜಾನಾ?
I may just.
ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆಯಾ?
ಅದರಲ್ಲಿ photographs ಇದೆ where my mother, that is the complainant, madam.
ಕೊಡಿ.
My lords, in page number 192, even
Outraging the modesty of a woman, assault, voluntarily causing grievous hurt.
My lords, there's video also, my lords. I can produce it.
In fact, in that video, what has happened is, my lords, at 4 a.m., 4:10 a.m., they survey number 9/10 is 9/6 belongs to me. On a basis of a sale deed belonging to survey number 9/1, they come into my property to carry out OD at 4 a.m. in the morning, my lords. My lords may kindly take page number 80, my lords, 80 onwards are the photographs. My lords
ಏನು objections ಹಾಕಿ objection ಇದು?
ಇಲ್ಲ, ಇದರಲ್ಲಿ
File your objections.
I'll file my objections.
My lords, kindly.
Case and counter case ಅಷ್ಟೇನೆ ಕೊಡಲ್ಲ.
In fact, mine was the first case on
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
I have challenged it.
ನಂಬರ್ ಕೊಡಿ.
I'll get.
We'll dismiss both.
My lords, on
On
the same.
5/7, I file my complaint. Crime comes to be registered.
Investigation
2
officer
days
ಒಂದೇನಾ ಬೇರೆನಾ?
Same.
2 days later, he comes and files.
My lords, on
ಫೈಲ್
the same.
ಮಾಡಿದ್ದೀರಾ?
I have filed. In that, what has happened, my lords, I had challenged the FIR. Now charge sheet has been filed. I am filing a petition tomorrow.
ಆಯ್ತು ಮಾಡಿ.
I will I will
move ಮಾಡಿ. In the meantime, you file objections in this also.
Well, please kindly.
No,
Throw
stay,
it,
sir.
ಅವತ್ತು ಸೇಮ್ ಡೇನೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೆಲೋಡ್ಸ್. That was an area registered on 7th.
Case and counter case. ಅದು ಇದರಲ್ಲಿ 74 and 118. Yes.
My name may be reflected.
We'll take it on 9th. By then you file.
10th, my lords.
ಆಯ್ತು 10th fresh matters.
My name may be reflected.
Learned counsel so and so undertakes to enter appearance for
R2.
R2. Registry to print the name of so and so is appearing for R2. Next.
Great.
21.
Petitioner, your lords. Petitioner is complainant before trial court, your lords. The incident was taken in the year 2013. Lords, 2014 is SC. From 2014, accused respondents 1, 2, 3 are not cooperating. Lords, the evidence was.
You are the complainant.
Complainant.
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು? Disposal.
Your lords, direction for early disposal, your lords.
That I will give.
He challenged the order of 311.
311,
That may not.
for past 5 years, the accused is, one after the other application is filing.
ಆಯ್ತು. We will direct the court to conclude the proceedings within ಯಾವಾಗಿಂದ 14 SC.
SC 14. Within 2 months, your lords.
Defense evidence.
3 months, 4 months.
Lords, 3 months.
3 months, yes. The petitioner is before this court calling in question, seeking the following prayer. The petitioner is the complainant. A crime comes to be registered on 10/7/2023 on account of a death of death of
Daughter.
daughter
and granddaughter.
daughter and granddaughter of the petitioner. This becomes a crime in crime number 185 of 2023 for offences punishable under section 302, 304B and 3 and 4 of the Dowry Prohibition Act. The case is committed to the Court of Session in SC, is pending in SC 8 of 2014 and is languishing in the said court for the last 12 years. Therefore, the learned counsel would restrict his prayer at the present for a speedy disposal of the proceeding before the concerned court. The learned counsel further projects that the accused are filing applications on one pretext or the other, and the proceedings are getting delayed. Be that as it may, in the light of the prayer being innocuous, I deem it appropriate to direct the concerned court to conclude the proceedings as it is now of 12 years vintage to in an outer limit of 3 months from the date of receipt of the copy of the order, if not earlier, in accordance with law.
22.
Please, my lords. The rape allegation, my lords, where two girls.
My lord, the stage was for settlement. So, my lord,
Settlement ಆಗಿಲ್ಲ ಅಂದ್ರು?
ಇಲ್ಲ, my lord, we were not seeing eye to eye just for one aspect. So, the stage may be reverted back to settlement, my lord.
Now you are seeing eye to eye?
For one aspect, that was with respect to his locomotion in the geographical area. We had asked for 10 kilometers, but they're not in agreement with it.
Bangalore, my lord.
ಇದೆಲ್ಲ 10 kilometers ಹತ್ರ ಬರಬಾರ್ದು, ಅದ್ ಬರಬಾರ್ದು. I can answer it on its merit. It's not a problem. You can't impose these conditions
So,
in a settlement.
We are ready to amend it, my lord.
ಅದೆಲ್ಲ 10 kilometers radius ಅಲ್ಲಿ settlement.
Yes, my
ಅಷ್ಟೇ.
lord. Settlement.
They're saying I should shut my shop and show them my closure of license and everything.
ಅದೆಲ್ಲ
No, we are ready to amend.
you can't bring about business rivalry here.
Yes, my lord.
All right. Now, whatever it is, plain settlement simpliciter.
Yes, my lord.
Yes.
Please, I'm.
ಈಗ eye to eye ನೋಡಿ.
My lords, may stay the matter.
Friday.
Please, my lords, Friday. Tomorrow is the date before the trial court. My lords may kindly stay.
We'll defer it. Yes.
Please.
Friday, I'm ready, my lord.
Both the learned counsel appearing for the petition and the respondent would submit that the talks of settlement are afoot, AFOT. The learned counsel of the petitioner submits that conditions that were highly unacceptable were imposed in the terms of settlement, which the learned counsel for the respondent would now submit that he would amend or delete those things. The list on Friday to report settlement. The learned counsel submits that the court has listed the matter tomorrow. Renfreminga.
Illa, my lord. So for
Listed tomorrow. The concerned court shall defer its proceedings in the light of the talks of settlement between the parties.
Obliged.
23.
Lord, the charge sheet is filed, my lord, for offence under the Cigarette and Tobacco Prevention Act.
Kodpa.
My lord, the allegation is, my lord, he was agent on behalf of a company my lord, of delivery of pan masala. Pan masala, my lord, in a bad condition. My lord, in 7/2/24, my lord, there is a notification of government banning sale of this product. From 8/2 onwards, next day itself, he being a agent of the manufacturer has arranged to send back all these products, my lord, by debit note. 9th, my lord, they had raided, my lord, the godown of this petitioner, seized all these products and arrested the accused number 2 to 5 and produced before the court. The allegation, my lord, as per the notification itself, my lord, possession is not an offence. Notification, my lord, is of dated is 7/2/24, my lord.
Why Poisons Act?
They have invoked that also, that is without any connection, your lordship. It is in respect of the
Look, food safety is all right.
Food
Poisons
safety
Act.
is not that. Poisons Act, it is not a poison at all. They have invoked that also. But the question
Smoking is not poison. Yes, injurious.
Injury. Lakshmi, can you hear the relevancy, my lord, that after this notification, he has not procured. My lord, whatever it was procured prior to 7/2 was in the godown. My lord, there was no time at all to send back to the manufacturer. Offense, my lord.
ಮುಂಚೆ ಇದ್ದಿದ್ದಾದ್ರೆ before the notification.
No, but some of the nicotine, my lord, the why Poisons Act, your lordship has pointed asked. Nicotine was found in the one of the this thing chemical examination, my lord.
Nicotine is the ingredient of that pan masala. That is what it is as per the chemical examiner's report.
What? Which pan masala is this?
Hookah, my lord, hookah.
Hookah.
Hookah. My lord, that this was banned, my lord, from 7/2/24. Lakshmi, kindly
Correct, sir. I have upheld the ban. My judgment.
Yes, yes.
Yes.
My lord, upheld is different, your lordship, that we are not questioning that.
No, I am not on that. I am aware of it ಅಂತ ಹೇಳಿದ್ದು ಅದಕ್ಕೆ. 7/2/2024 is the.
My lord, here, my lord, ban starts from 7/2. After ban, my lord, they have not procured. There is no inward. And he has not sold. He is not a retailer.
Now, one moment.
Not a wholesaler.
No. Where is the indication that he has procured after
this?
7/2/24?
I'll get instructions, my lord, but I think there is
Charge
also
sheet, my lord, there is no material, your lord.
not about procurement, issue of discharge.
No. Storage. If it is earlier storage, the act did not say destroy it, but he should not use it.
Not used, not sold. Also, my lord, he is only.
ಏನ್ ಮಾಡಿದ್ರಿ ಮತ್ತದೆಲ್ಲ?
On behalf of a manufacturer, my lord, his role was carry forward agent to the distributor, distributor to wholesaler, wholesaler to retailer.
So what did you do with that?
Nothing, my lord. That
ಅಲ್ಲೇ
was,
ಇದೆ ಇನ್ನು.
it was, my lord, they seized it, they produced it, and then, my lord, with the permission of magistrate, this has been sent back to the manufacturer.
But you won't know the date of manufacture in that seizure.
Manufacturer also identified, my lord, magistrate has
Identified what date?
My lord, is prior to notification, your lordship.
That is identified?
Yes, yes. We have
Page.
the interim order, lordship, that.
Interim order?
Interim order, my lord, passed by the magistrate. Directing, my lord, to resend back to the manufacturer. That order is also
Page.
Lordship, kindly. That page, volume 2, your lordship.
Volume 2?
Volume 2. Release order, my lord, page 310, your lordship.
Volume 2 ಕೊಡಿ. Volume 2. ಇಲ್ಲೇ. Page
310, your lordship. Kindly 309 also, 310 also. It starts from 308, your lordship. 310, my lord. And directed, my lord, to send back to the manufacturer. Accordingly, it has been sent back. The description, my lord, debit note.
Blueberry, yeah. Blueberry?
Flavor, my lord. It is
Flavor.
My lord, different kinds of flavor, my lord, pan masala.
Oh, blueberry. What is this? Brain freeze pan masala?
Pan masala, my lord, blueberry.
Blueberry ಆಯ್ತು. Brain freeze?
Brain freeze, my lord, that is another kind of flavor it is.
Oh.
My lord, chocolate, cola, lemon.
True to its name, is it?
Yes.
Oh, brain freezes.
My lord, they are given to attract the customer. At that time, it was permissible.
But really,
I'll secure the records, my lord.
3112, my lord, it is.
Next week, my lord, I'll get the.
No,
Good.
not that, my lord.
Take it.
Here, tomorrow itself is the date. That's how, my lord.
No,
we
that will
insisted.
protect, wait, yes. Heard the learned senior counsel Hasmat Pasha appearing for the petitioner. The issue in the list is storage of banned substance or prohibited substance. Prohibited substance is hookah or the capsule that is used for smoking hookah. The notification of ban of hookah in the state of Karnataka springs on 7/2/2024.
Gazette notification, my lord, is 5th April.
No, but actually bill bandit is.
Yes.
I have considered that.
Yes, yes.
7/2/2024, which was subsequently gazetted. The petitioner is seen to have stored several items that would be prohibited under the COTPA Act, sounds under the Act. The items that were found inside, the items that were seized from the hands of the petitioner were all said to be of, were all said to be procured and stored prior to the imposition of ban in terms of a government order dated 7/2/2024. It is in fact the order of the magistrate itself that the items should be sent back to the manufacturer as they were prior to the ban being imposed. It is not the case of the prosecution even that after the imposition of the ban, the storage has happened or distribution has happened of hookah. In that light, the learned additional SPP would, however, seek time to secure the records and make his submissions. List the matter on 8th April in the fresh matters list. Till such time, the concerned court shall defer its proceedings.
Like, well, even if it goes, my lord, COTPA has to go. Otherwise.
COTPA will go. Poisons Act will see.
And IPC will remain.
Huh?
Poisons Act and IPC will remain.
IPC ಏನಿದೆ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? IPC ನೂ ಇದೆಯಾ?
Yes, my lord, they have added some.
Oh, 328, 284, 511. We'll see. Yes. Next.
Tomorrow, my lord, is not.
Defer ಮಾಡಿದ್ನಲ್ಲ.
Hand delivery, my lord.
Order upload ಮಾಡ್ತಾರೆ.
24.
Hand delivery ಬೇಕು ಅಂತ ಮೆಮೊ ಕೊಡಿ.
Let's 304 and 498A, my lords, against the aunt. I'm accused number 6, my lords. The death note is in page number 246.
You are in relation what?
I'm an aunt, my lords, of accused number 1.
Your melon is death note.
Yes.
Earlier, 498A case was registered. And in that 498A case, she was also an accused. And subsequent to that, harassment continued. Therefore, she writes a death note specifically naming accused number 6, the petitioner.
Charge sheet ಅಲ್ಲಿ.
Page number 9.
In fact, death note melody is extracted in FSL report at page 246. ನನ್ನ ಗಂಡನ ಚಿಕ್ಕಮ್ಮ ಪಲ್ಲವಿ. At page 246. ನನ್ನ ಗಂಡನ ಚಿಕ್ಕಮ್ಮ ಪಲ್ಲವಿ ಇಷ್ಟು ಜನ ಕಾರಣರು.
ಅಲ್ಲ ಅದು ಗೊತ್ತು, ಅಲ್ಲೂ ಇದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲೂ ಇದೆ ಅದು. ಎಲ್ಲರೂ ಸೇರಿ ಕಾರಣರು ಅಂತ.
There is a case against her.
Anyway,
498A.
One additional SPP to emergent notice.
Accused number 4 has been granted relief, my lords. I've given it. And I live separately with my husband, my lords, accused number 4. And made the allegation is against that ಮನೇಲಿ ಇದ್ದಾಗ ಟಾರ್ಚರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. But I was living separately with accused number 4.
Accused number 4 the name ಇದೆಯಾ ಡೆತ್ ನೋಟ್ ಅಲ್ಲಿ?
Yes.
ಆಮ್ನಿಬಸ್ ಇದೆ 1 to 6 ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಇಲ್ಲ ಅಲ್ಲ?
ಅಲ್ಲ, we need to see whether Muddegowda is an accused in 498A. 498A is the first case.
Tag this petition along with Criminal petition 1839 of 2026. List them both on 1st April in the fresh matters list.
Payment protection.
Just look at it.
Therefore, the petitioner in this matter, petitioner is challenging the proceedings in criminal miscellaneous number 136 of 24 for issuance of
If issuance of?
fine levy warrant, my lord, FLW.
FLW.
Please.
Yak recovery?
The recovery and in the earlier proceedings before between the petitioner and the respondent, there was a compromise entered upon, which was recorded. I have produced the.
You have breached the compromise?
No, my lord. After that, I was regularly paying, making him the payments. All of a sudden, he misused my another check issued as a security. ಇನ್ನೊಂದು complaint file ಮಾಡಿದ್ರು. That got dismissed.
Shall serve on the counsel who represents the respondent by respond before the concerned court.
Please.
There shall be an interim order of stay of the fine levy warrant issued against the petitioner till the next date of hearing. Yes,
Much obliged.
26.
The petitioner is an advocate, not is practicing before this court, please, Lord. But there is a private dispute between the complainant and one Manjulam, Lord. So she filed a suit, Lord, wherein the interim order has been granted, Lord. So after that, the police protection has been granted, please, Lord. So the allegation against now, Lord, the case has been filed against my clients. Lord, kindly come to the complainant, Lord. The only allegation is, Lord.
Why not for?
Please.
351.
ಫೋನ್ ಮಾಡಿ ಗಲಾಟೆ ಕಾರಣ ಆಗಿದ್ದಾರೆ ಅಂತ
Serious allegation.
It may end up in conviction also. Yes. In the meantime, yes, next. Additional SPP is directed to accept notices.
27.
This is a settlement, my lord. 9th, my lord. 69 of BNS, my lord. 9th.
Settlement ಆಗ್ತದೆ. ಯಾವತ್ತು ಬೇಕು?
9th, my lord.
List the matter on 9th to report settlement.
By mistake, my name is not shown, my lord.
Nishit.
69.
69
ಹೌದು.
offense. Come on, merits. ಏನು?
ಅವರು ಫಾರಿನ್ ಹೋಗ್ತಾರಂತ ಇಬ್ರು ಫಾರಿನ್ ಹೋಗ್ತಾರೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಆಯ್ತು ಸರಿ, ಸೆಟಲ್ಮೆಂಟ್ ಬೇಡ. ವಾಟ್ ಇಸ್ ಆನ್ ದಿ ಮೆರಿಟ್? ಎಷ್ಟು ವರ್ಷ ರಿಲೇಶನ್ಶಿಪ್?
1.5 years, my lord.
ಆಯ್ತು, 9th ಬರ್ಲಿ. I won't report settlement ಬೇಡ, let it come. List on 9th. You get the complainant anyway. No submissions ಅಂತ ಹೇಳಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕ್ಲೋಸ್ ಮಾಡಿ.
My name may be shown, my lord.
Register to delete the name of?
My colleague only, by mistake, my
Rama
name.
Reddy.
Sure, my name is not shown. My colleague's name is shown, my lord.
Or register to print the name of Nishit Kumar Shetty along with along with zones. Yes. Next.
28.
I purchased the property in the month of May 2025 for a sum of rupees 4.5 crore. Well, I have started putting construction.
Putting up
construction. But in the month of October 25, my vendor brother files a complaint against his own brother saying that his signature was forged and he has stopped the construction. But the complaint is his relative. He called for the settlement. Without allowing us to enter the house, my lord,
Why did you flash the arm?
No, I did flash.
ಮತ್ತೆ Arms Act.
Only 25 saying that I am not having the valid license and there.
License ilva?
I have license, my lord. I have produced the copy. No, it is not been shown.
No, without flashing, why would we?
Not flash, my lord. That's not the case. The only section 25 has been invoked, saying that I am not having the valid license and there.
ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತು? ಸುಮ್ನೆ ಯಾಕೆ ಇನ್ವೋಕ್ ಮಾಡ್ತಾರೆ if you don't flash the gun?
No, that is not the case. That's not the case. That's not the case, my lord.
Why would they simply invoke 25, sir?
The complainant called the police to the house and he has given a complaint at house and the police have taken the complaint.
Page 19.
Page 19. ಲಾಸ್ಟ್ ವಿನಾಕಾರಣ ಮನೆ ಒಳಗೆ ಬಂದು ಅವ್ಯಾಚ್ಯ ಶಬ್ದಗಳನ್ನು ಬೈದು ಜೀವ ಬೆದರಿಕೆ ಒಡ್ಡಿ ಪಿಸ್ತೂಲನ್ನು ತೋರಿಸಿ ಮನೆಯ ಗೇಟಿನಿಂದ ಅಕ್ರಮವಾಗಿ ನುಗ್ಗಲು ಪ್ರಯತ್ನ.
Over phone, my lord. Over phone.
Phone ಅಲ್ಲಿ ಪಿಸ್ತೂಲ್ ತೋರಿಸಿದ್ರಾ?
That is what the
video
allegation.
call.
That is what the allegation. He called me and threatened me like this ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. Over phone.
ಎಲ್ಲಿದೆ? ಅನಿಲ್ ಶೆಟ್ಟಿ, ಆದರ್ಶ್ ಶೆಟ್ಟಿ ಹಾಗೂ ಇತರ ಸೋನ್ಸೋ ಎಲ್ಲಿದೆ ಅದು ಓದಿದ್ ನೀವೀಗ?
Page 19 last.
Page number 22.
Yes.
Page number 22. ಈ ದಿನಾಂಕ 7/3/2000 ಸಂಜೆ ಸುಮಾರು 6:04 ನನ್ನ ಮನೆಯಲ್ಲಿ ಇರುವ
ಮೊಬೈಲ್ ನಂಬರ್ ಬಂದಿದ್ದು ಅಂದ್ರೆ ಸೋನ್ಸೋ ಮಗನೇ
ಕರೆ ಮಾಡಿದಾಗ
ನಾನು ಓದ್ಬಿಡಿ ಏನು ಅಂತ ನಾನು ನೋಡ್ತೀನಿ. ನಾನು ಶೂಟ್ ಮಾಡುತ್ತೇನೆ
Or phone.
ಫೋನಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ ನೆಕ್ಸ್ಟ್ ಮೇಲೆ
ಹೋಗಿ ನೋಡು ಯಾರಿದ್ದಾರೆ. No, narration is clear. You can't doubt this straight away. Just get the investigation papers. The learned additional SPP is directed to accept notice, secure the papers of investigation and submit on the next date, 8th fresh matters. 8th April.
Meantime,
Bail ತಗೊಂಡಿಲ್ವಾ?
they have alleged trespass, my lord. I have not even entered the house. That's what the
Bail,
complaint.
ನಾನು ಕೇಳಿದ್ದು ಒಂದೇ ಒಂದು, bail ತಗೊಂಡಿಲ್ವಾ?
I need to check, my lord.
Yes, 8th April, yes.
But I have been cheated, my lord.
You've been cheated.
I've been cheated, my lord. I have produced the photographs. I have put up the construction. After putting up construction, the brother comes and says.
8th will see.
They
No,
wanted
that's
to-
not the issue. The issue is Arms Act, yes.
I'm sir only for the license, my lord.
We'll
I have
see,
produced the
yes.
copy of the license, my lord.
List on 1st April level. 1st April in the fresh matters list, yes.
29.
Your Lordships, here for the petitioners in this matter, Your Lordships, the petitioner is the accused, Your Lordships. We had filed a 311 application, Your Lordships, to recall witnesses PW9 and PW18. It came to be allowed, Your Lordships, on 3/1/2026. Your Lordships will get the order on page number 13, Your Lordships, with the direction that 5,000 rupees has to be deposited on or
All right.
before 7/1, Your Lordships.
All right.
Due to miscommunication and we could not communicate them within the stipulated
Deposit
time, Your
ಮಾಡಿಲ್ವಾ?
Lordship. Illa Swami, but we are ready to deposit, Your Lordships. PW9 and PW18 ಬಂದ್ಬಿಟ್ಟು IO, Your Lordships. ಅವ್ರನ್ನ cross examine ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ.
Yes, we'll allow it. The petitioner is before this court seeking the following prayer. The petitioners are accused in
SC number 311 of
ಯಾವ್ದು madam ಇದು?
113 of 2004.
The petitioners are accused facing proceedings. The issue in the list is not with regard to the merit of the matter. An application is filed under section 311 in special case 113 of 2014 seeking recall of prosecution witnesses PW9 and PW18. The application comes to be allowed with the condition that the amount should, the 5,000 rupees should be deposited before the concerned court on or before within 1 week from the date of passage of the order. Due to inadvertent gap in communication, it transpires that the amount of 5,000 is not deposited, and therefore the opportunity of cross-examination, further cross-examination is now at jeopardy. In the learned counsel submits that immediately the deposit would be made and the concerned court be directed to permit further cross-examination. In that light, I deem it appropriate to permit the petitioner to deposit the amount in the next 3 days. In the next 3 days, and the court to fix the date for further cross-examination of PW9 and 18 as it has allowed the application. For the aforesaid reasons, the following order allows so and so quashed. The matter, the concerned court shall permit further cross-examination of the petitioner of PW9 and PW18 on the date fixed by it, subject to the deposit of 5,000 rupees in the next 3 days. Ordered accordingly. Yes, next.
30.
Private complaint, my lord, for offence under section 420 and 465. Lord, the brief facts is like this, my lord. Lord, the complainant father has acquired land in 2 survey numbers, my lord, by under Karnataka Land Reforms Act. This petitioner's father is also was a owner, my lord, of the land reforms, the owner of few acres, my lord. Thereafter, after the order passed by the tribunal, the complainant father was allotted few lands. Accordingly, he sold the property in 2003. Thereafter, my lord, now the complainant comes before the court and files a PCR that 2003 was sold, it was forced, and it was sold to accused number 4. My lord, I have sold my property to accused number 4. I have nothing to do with the accused number, the complainant's father, and complaint is none
On
Uh-huh.
additional SPP to emergent notice in the meantime. 20 ವರ್ಷ ಆದ್ಮೇಲೆ
23 FIR.
FIR 23.
Please, one submission, my lord, if lordship.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ?
Charge sheet ಆಗಿಲ್ಲ. ಅಲ್ಲ, one submission.
ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋದು ಇಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ, one submission, my lord, kindly see the order sheet.
ಸ್ಟೇ ಬೇಡವಾ?
ಇಲ್ಲ, ಅದಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಯ್ತು, ಅದು ಆಮೇಲೆ ಬರೆಯೋಣ. ಫೈನಲ್ ಆರ್ಡರ್.
Learned
ಈಗ
magistrate.
ಸ್ಟೇ ಮಾಡಿದಿನಲ್ಲ,
31.
ಎಲ್ಲ ರೀಸನ್ ಈಗಲೇ ಕೊಡ್ಬೇಕಾ ಸ್ಟೇಗೆ? ಮತ್ತೆ 30?
People petitioner seeking mandamus, my lord,
Mandamus ಏನಕ್ಕೆ?
In-
ಬೇರೆ ಕೋರ್ಟ್
police has
ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ?
incomplete filed charge sheet, my lord.
Incomplete file charge sheet.
Even
According to him, my
accused
lord,
number 3
based
has
on
made
a-
statement, the jewelry of the complaint is pledged in the Bhairava jewelry.
Complete, ಯಾವಾಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮುಗಿಸ್ತೀರಿ?
According to him, accused number 3 has given a statement, voluntary statement that the certain gold items was pledged in a shop, in a Bhairava shop. That item has not been recovered is the contention. The course of
ಅಲ್ಲ
investigation.
ಅದೇನಾಗಿರ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮುಗಿಸಿ
ಮುಗಿಸಿ ಆಗಿದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಮತ್ತೆ ಇನ್ನೇನ್ ಬೇಕೀಗ?
He wants us to go and recover the article from the shop. It is not a first, it is not a stolen article. And fact, my lord, we have recorded a statement of
First,
those people.
you file this application before the court if you want. I will not direct.
And the statement, my lord, disclosed that the petitioner himself has gone to pledge the article.
The petitioner is before the court seeking the following prayer. The prayer of the petitioner is to complete investigation. Investigation is completed and charge sheet is already filed. He has another prayer that there should be seizing of the jewels as per the statement of accused number 3 recorded by the second respondent. The application, no application of the kind is preferred before the concerned court, and the reserving liberty to the petitioner to file an application of the kind that is preferred before this court, before the concerned court. The petition stands disposed. Next.
32.
32. But allegation is, I made A5 in this case, not. Allegation is that the A4 called A5. A5 was not in the scene. A4 called A5. A5 is not named in the FIR. He called and A5 told him that you're na complaint not page 36, last line. It says, Johnny anna phone madi.
Johnny
means Janardhan. Janardhan. 36 last line. 36 last line. Complaint. Shall I just read that? Johnny anna phone madi.
Johnny anna.
ಈ ಡ್ಯಾಶ್ ಒಲೆಮಾದಿಗ ನನ್ನ ಮಗ ನಾರಾಯಣ ಸ್ವಾಮಿಯನ್ನು ಮುಗಿಸಿಯೇ ಮನೆಗೆ ಬರಬೇಕೆಂದು ಹೇಳಿರುತ್ತಾನೆ ಎಂದು ಹೇಳಿ ಆಕೆ ಸ್ಟಿಕ್ ನಾರಾಯಣ ಸ್ವಾಮಿ ಎಡಗೈ ಹೊಡೆದನು ಇಷ್ಟೇ. The allegation is that this Janardhan was somebody somewhere else, A5, and A4 calls A5. Not in the phone records that I have given, they have enclosed records for call data records till 2/4/24. Incident happened on 5/4/24. They have not given the phone records. If this was true, the phone records had to be enclosed, but consciously they end the phone records up to 2/4/24. The relevant 5/4/24 phone records up to 5/4/24 is not enclosed.
You are accused number 5.
5. And I'm not on the scene, Lord.
Accused number 2 ಗೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ?
2 ಸ್ಟೇ ಆಗಿದೆಯಾ?
Records ಇಲ್ಲ.
5 is not on the scene, Lord.
1 minute. Who is accused? Naveen K. What accused is he? A2, correct. A2 stay put. ಇಲ್ಲ ಇದೆ order.
Yes. Please.
Yes.
We are not
Tag
noticed.
same order. ಯಾವ್ದು ಬೇರೆನಾ ಅದು?
ಬೇರೆದಾ? ಬೇರೆದು.
Same accused number 2 is Naveen.
ಈ ಕ್ರೈಮ್ ನಂಬರ್ ಅಲ್ಲ.
ಬೇರೆ ಬೇರೆ ಕೇಸ್ ಇರಬೇಕಾ? ಬೇರೆ ಬೇರೆ ಕೇಸ್ ಇರಬೇಕು.
ಇಲ್ಲ ಇಲ್ಲಿ ವಿಕ್ಟಿಮ್ ಅಂಡ್ ಕಂಪ್ಲೇನೆಂಟ್ ಆರ್ ರೌಡಿ ಶೀಟರ್ಸ್.
ಅದಕ್ಕೆ ಹಂಗಾರೆ ಬೇರೆ ಬೇರೆ ಕೇಸ್ಗಳಿದೆ.
ಒಂದ್ ನಿಮಿಷ ಇದೆ ನೋಡಿ, ಏನ್ ಬೈದಿರೋದೆಲ್ಲ. ಇದು ಕ್ರೈಮ್ 47. ಇದು ಬೇರೆ. ಕಂಪ್ಲೇನೆಂಟ್ ಸೇಮ್.
ಕಂಪ್ಲೇನೆಂಟ್ ಸೇಮ್.
ಎಸ್ ವಿಲ್ ಸಿ ಕಾಪಿ ಇಲ್ವಾ?
ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ.
Learned at the learned senior counsel Vivek Reddy appearing for the petitioner. Counsel on record.
You get it records.
Counsel on record shall serve set of papers upon the learned additional SPP forthwith. Same crime. Same allegation.
Very same allegation.
Same complainant. Tag the petition along with WP 14115 of 2023. This court grants an interim order of stay in favor of the accused number 2, albeit in a different crime, but by the same complainant, on the reason that multiple complaints are being registered against several accused by the very respondent, invoking the provisions of the Atrocities Act as well, like it is done in the case, idralilva idiyalla, like it is done in the case at hand. In that light, there shall be an interim order of stay of further proceedings till the next date of hearing, reserving liberty to the state or the respondent to file application seeking vacation of the interim order. Yes, list on 17th April.
Please.
Notice to Rob.
Emergent notice to second respondent returnable by 17th.
Please. Oblige.
33.
I appear for the petitioner. I've taken steps in office today
The
morning.
B report has been filed, my lord, it doesn't.
Learned counsel, additional SPP on instructions would submit that the police after investigation have filed a B report. In that light, the petition in the form that it is presented is rendered infructuous, reserving liberty to the petitioner to knock at the doors of this court in the event any order is passed on the B report which would go against the interests of the petitioner. The petition stands disposed.
Grateful, my lord.
Appearing for the petitioner, my lord.
ಏನು 7A? Failed, successful?
Successful, everything is clear.
Seeking for short adjournment, my lord.
ಸ್ಟೇ ಏನು ಕೊಟ್ಟಿಲ್ಲಲ್ಲ?
No implement.
ಏನಿಲ್ಲ ಬಿಡಿ, ಈಗಂತೂ ಆಗದೇ ಇಲ್ಲ. With the judgment you can't.
Manjunath and
Mahesh and Manjunath, whatever. Learned counsel appearing for the petitioner seeks a week's time. List the matter next week.
Grateful, my lord.
Yes.
35.
I appear for the petitioner. Would your lordship permit me to appear?
7A?
Interim order ಇದಲ್ಲ. DA case.
13(1)B.
Not to precipitate ಅಂತ
Oh,
ಇದೆ.
13(1) ಇದು. Interim order ಇದೆಯಾ?
ಇಲ್ಲ 13(1)B disproportionate effect.
Not to precipitate.
Please, next week I'll file my objection.
Learned counsel K. Prasanna Shetty seeks a week's time to file statement of objections. 9th April, objections if any, by then interim protection granted shall continue to the next week.
Please.
Next.
Obliged.
36.
Lord, appearing for the petitioner, Lord, I challenge the statement under 183 that is recorded of the victim without the presence
without
of the mother.
yes.
So it is in fact indeed recorded in the presence of mother.
ಇಲ್ಲ ಅಂತ ಇದ್ದಾರೆ.
Lordship,
My lord,
ರೆಕಾರ್ಡ್ಸ್ ಕೇಳಕ್ಕೆ
page 25, my lord, annexure A.
ಹಾ ನೊಂದ ಬಾಲಕಿ ಸೋ ಹೇಳಿಕೆಯನ್ನು
ನನಗೇನು ಆಗಿಲ್ಲ ಅಂತ ಬಾಲಕಿ
ಅಲ್ಲ ಎಲ್ಲಿ ಮದರ್ ಎಲ್ಲಿದ್ದಾರೆ?
ಅಲ್ಲೇನೆ ತಾಯಿ ಬೇಕು ಅಂತ ಹೋದ ಕಾರಣ ತಾಯಿಯ ಸಮಕ್ಷಮ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಳ್ಳಲಾಯಿತು.
ಸಮಕ್ಷಮ ಹೇಳಿಕೆ ಅಲ್ಲ, ತಾಯಿಯ ಸಮಕ್ಷಮದಲ್ಲಿ ಅಂತ ಹೇಳಿದೆ ಇಲ್ಲಿ.
ಅಲ್ಲೇನೆ ತಾಯಿಯ
ನನಗೆ ಯಾರು ಆಗಿಲ್ಲ ಈ ಹಂತದಲ್ಲಿ ಬಾಲಕಿ ತಾಯಿ ಬೇಕೆಂದು ತಾಯಿ ಹೋದ ಕಾರಣ ತಾಯಿಯು ಸಮಕ್ಷಮ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಳ್ಳಲಾಯಿತು. ಅಲ್ಲಿ ಆಯ್ತು, ಇಲ್ಲಿ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್.
It is before the court.
My lord,
ಅಲ್ಲಿ ಪಡೆದುಕೊಳ್ಳಲಾಯಿತು ಎಲ್ಲಿ?
the portion in bold might be read, my lord.
ಹಾ
ದಿನಾಂಕ 5/11/25 ನೊಂದ ಬಾಲಕಿ ಹೃತಿ ಎ ಐಸಿರಿ ರವರ ಹೇಳಿಕೆಯನ್ನು ನ್ಯಾಯಾಧೀಶರ ಚೇಂಬರಿನಲ್ಲಿ ನ್ಯಾಯಾಧೀಶರು ಹಾಗೂ ಬೆರಳಚ್ಚುಗಾರ್ತಿಯನ್ನು ಹೊರತು ಪಡಿಸಿ ಬೇರೆ ಯಾರೂ ಇಲ್ಲ ಹಾಗೂ ಬಾಲಕಿ ಹೇಳಿಕೆ ನೀಡುತ್ತಿರುವ ಕೊಠಡಿಯಲ್ಲಿ ಆಕೆಯನ್ನು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಯಾರೂ ಇಲ್ಲ ಎಂಬುದನ್ನು ಖಾತ್ರಿಪಡಿಸಿಕೊಳ್ಳಲಾಯಿತು.
That's correct, but very next statement.
My lord,
very next statement.
Absolute violation.
ಬೋಲ್ಡ್ ಆಗಿ ಎಂಫ್ಯಾಟಿಕ್ ಆಗಿ
ಅದು ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಪ್ರಾಬ್ಲಮ್.
ಅದೇ ಪ್ರಾಬ್ಲಮ್, ಯಾರೂ ಇಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ ಕರೆಕ್ಟ್, ಬಟ್ ವೆರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೆಲೋಡಿ.
ಅಲ್ಲ ಇದು ಎಲ್ಲೋ ಮಾಡಿದ್ದು, ಇಟ್ಸ್ ನಾಟ್ ಹಿಯರ್. ಸಿ ಸಮಕ್ಷಮ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಳ್ಳಲಾಯಿತು ಬೇರೆ ಔಟ್ಸೈಡ್, ನಾಟ್ ಇನ್ ದಿ ಕೋರ್ಟ್.
It is in the court. In fact, I've been told Milord,
this is not the way it is should be done.
But now the matter.
This is the complainant himself.
Now the matter is pending before the trial court. This is only 183 statement.
Correct. ತಗೊಳ್ಳಿ ಮತ್ತೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ನ.
ಅಲ್ಲ, now the posted for evidence. Probably before the in evidence they can record the statement, Milord. But this is only for corroborative material. It is not that this
correct, but that is the mandate of the law.
That's correct, Milord. According to me, my lord, that statement as is recorded in the presence of.
No, this is clear that nobody else was there while recording the statement.
Very next line, your lordship may see, my lord.
This why this ambiguity?
My lord, there are.
ನಾಳೆ ದಿನ acquit ಆಗ್ಬಿಡ್ತಾರೆ.
That's correct. The only now, my lord.
The whole problem is tomorrow he'll get acquitted on this.
Now this statement.
Accused is the father, my lord. Accused is the father.
What is the age of the child?
2 years 10 months.
2 years 10 months.
Yes, my lord.
When offense in POCSO?
3B42 5N, my lords. Medical records also.
4 to on 2 years old child.
Yes, my lord. There are injuries, my lords.
Huh?
And it is recorded without the presence of the mother, my lord.
No, now
Only after the
now let the
child
mother.
has
Allah, child's the
asked for the mother.
2
Then
years,
the
10
mother-
months, without the mother, how did you record even? What is this?
It's exactly, my lord. Mother was present.
It's impossible to, what 2 years, 10 months in the child in the without mother, ಏನ್ record ಮಾಡಕ್ಕಾಗತ್ತೆ?
My lords, the ಮಗು ಅಮ್ಮನ ಕೇಳ ಆದ್ಮೇಲೆ
ಏನು
ಕಳ್ಸಿರೋದು, my lords.
GNWC ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಏನು ಪೆಂಡಿಂಗ್ ಇಲ್ಲ, my lords.
ಮತ್ತೆ?
There's no dispute.
Lordship can.
There is injuries, my lords. The medical record says there are injuries.
By the father?
Yes, my lords.
No, I will not come in a way, my lord. If lordship feels it is, the certification is wrong, your lordship may
It
direct,
is
my lord,
wrong.
no problem.
Tomorrow he should not,
I
if he has
understand.
done this act, he should not get acquitted
I
by
understand. I'm not
these
I'm not coming in that way.
trivialities or
Coming
technicalities.
in that way, my lord. But I think my learned friend should say, because she was
ಇಲ್ಲ,
present.
see, 2 years, 10 months child at.
There's no way she
There is no way evidence can be taken without the presence of the mother. Record ಮಾಡ್ಬೇಕು ತಾನೆ correct ಆಗಿ.
ಮಾಡ್ಬೇಕು. Now its matter has been a special CCS numbered. It is probably before the special court for
ಅಲ್ಲ,
trial.
special court correct. Will direct the special court to record the statement
Anyway, now
in the presence of the mother.
correct.
To
Time of
not to
recording it.
not to undo everything that has happened.
Exactly.
We will direct the statement to be taken in accordance with law in the presence of the mother.
At the time of evidence.
Time
Otherwise,
of-
unnecessary harassment for a child to go
My
back
lord
and
may see
record.
page number 56, my lord.
Yes,
medical.
2 years, 10 months. ನೀವು ಒಂದ್ಸರಿ ಎವಿಡೆನ್ಸ್ ತಗೊಂಡಾಗಿದೆ ಮತ್ತೇನು? ಏನು ಹೇಳಿದ? Nothing is said, is it?
No, your lordship,
No,
may,
nothing
your
is
lordship may
said.
record one more submission, my lord. Your lordship may record that this particular statement may not be considered for the purpose of evidence, either to contradict or corroborate. The only probably contention of the petitioner is that in this statement she has not made any statement. Probably that is why
No,
their
the thing is,
apprehension.
nothing is made here.
Correct. That is why I think, my lord, their apprehension. Your lordship.
Now the accused should not get away with this.
My lord, it is not being made because the child was put under fear, my lord. She was in the court along with only the judge and the Bella Chugarti.
So therefore, your lordship can observe and say this should not be either for
Statement ಓದಿದ್ರೆ
corroboration or
ತದನಂತರ ಮಗು
contradiction.
ಬೇಕು ಅಂದಾಗೆ ಕರ್ಸಿರೋದು ತಾಯಿನ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಕರ್ಸಿರ್ಲಿಲ್ಲ.
ಬಟ್ ಆಚೆ ಕೂರಿಸಿದ್ರಾ?
ಏನಾಗಿತ್ತು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಬಟ್ ರೆಕಾರ್ಡ್ ಆಗಿರೋದು ಈ ತರ ರೆಕಾರ್ಡ್ ಆಗಿದೆ.
No, tomorrow he'll get acquitted like this.
I understand, my lord. I'm not coming in.
ಇದ್ರಲ್ಲಿ ಏನು ಹೇಳಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು straight away he'll get acquitted. And if the father is with the 2 years and 10-year-old, 2 years and 10-month-old child.
According to me, my lord, she said it because your lordship may see she did not answer it.
Then how will she answer in the absence of the mother?
Correct, no, no. She say the statement says she goes before the mother, she stays with the mother, and she did not answer. Doesn't mean that she has not said anything. Because that is what
No,
one
that's
of the
all right. Tomorrow, see, if the statement mother ಜೊತೆಗೆ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ this is nothing is done ಅಂತ ಆಮೇಲೆ
I understand
ರಿಮಾಂಡ್
that.
ಆಗೋದು ಎಲ್ಲ ಆಗೋದು ಯಾಕೆ?
Your lordship may observe.
No, it is
only-
better to nip this here only.
ಆಗ್ಬೋದು.
Yes.
Or your lordship may direct, my lord, we will
Now the
we'll
court
take
will
it before the special.
ಮತ್ತೆ victim
That's the only
ಕರ್ಸ್ಬೇಕಲ್ಲ.
my-
What
my
is this? How many times?
That's the only issue, my lord.
How
Otherwise,
many? The magistrate should record it properly. The date of the incident, you know?
I 26/10/2025.
The child herself has complained, is it?
Yes,
Mother
my lord.
notices it.
While changing the diaper.
ಹೌದು.
No, but
Your
tomorrow,
lordship, the direct, my lord, will record. Let that not be a.
this should not become a ground. Tomorrow, if the man has done that
He's
on
been
a
enlarged
2-year-old.
on bail on the very same ground, my lords.
See,
He's been enlarged on bail on the very same ground.
this is the problem.
No, they should have, if that is the case, they should have filed a requisition, something.
Well, whatever it is, now he's enlarged on bail. How can you grant bail to such a man? If there is evidence. And he says medical evidence is clear.
Page
Medical- in
56,
fact,
my
lord,
lord,
the statement
says
according
Hyman
to
is
me,
absent.
Mere being silence of a 2.5-year-old daughter cannot be considered no offenses happened. In fact, there is a
Correct. Then
statement
how bail was granted?
that the judgment may not dealt with the exactly identical issue.
Correct, but ಇದೇ reason bail ಕೊಟ್ಟು ನಾಳೆ ಇದೇ reason acquit ಆದ್ರೆ?
ಆಗ್ಬೋದು, lordship. We'll record a statement within weeks'
Yes.
time.
I think can't help.
We can't. The only thing is harassment to the child. 1 second. That's the only.
That's the concern of the court as well. But ನಾಳೆ ದಿನ the accused should not get away.
Understand?
He is saying bail is granted on this ground. The petitioner, complainant, is before the court, calling in question an order, the act of the court recording the statement of the victim child, which at the victim child, contrary to the mandatory provisions of 26(1) of the POCSO Act 2012, hereinafter referred to as the Act for short. Facts in facts in brief, germane, are as follows. The petitioner, first petitioner, the second respondent is accused number 1. Accused number 1 and the petitioner complainant get married on 26/5/2022. A child is born from the wedlock. On 26/10/2025, it is the allegation of the it is on a complaint or the child traumatized is said to have narrated to the mother that while changing the diaper, the father has indulged in acts which would become ingredients of the offenses under the POCSO Act. Yes. Sounds. The pursuant to the said narration by the child, a crime number comes to be registered on 28/10/2025 for offense 28 in crime number 157 of 2025 for the aforequoted offenses. The trial is on. The issue is not with regard to the merit of the matter. The concerned court examines the child. The examination of the child is done on 5/11/2025. The examination is as follows. Reads as follows. The learned counsel for the petitioner submits that the examination of the child is contrary to subsection 1 of section 26 of the POCSO Act, which mandates that the statement of the child should be recorded in the presence of the mother. The aforequoted statement recorded of the child, which at the relevant point in time was 2 years and 10 months, is not in the presence of the mother. There is certain ambiguity with the second paragraph that is narrated that statement was taken in the presence of the mother. However, there is ambiguity. The learned counsel submits based upon this ambiguity, notwithstanding the fact that there was prima facie medical evidence against the father for having indulged in acts on a child of 2 years and 10 months. The bail, he was enlarged on bail solely on the score that there is violation of section 26(1). In that light, to avoid a future circumstance of projection of an illegality in the at the fag end of the trial, it is necessary to nip it in the bud. The statement must have been recorded by the magistrate under section recorded by the magistrate in terms of section 26(1) of the Act. Section 26(1) of the Act reads as follows. In terms of section 26(1), a statement of the child must be recorded in the presence of the mother. Here, the absence or presence of the mother is itself ambiguous, as the court has recorded statement contradictory to each paragraph. Therefore, to steer clear the controversy, notwithstanding the fact that the child will have to be brought back to the court as a one-off situation to a one-off problem, I deem it appropriate to permit such exercise to be done by the concerned court. Therefore, the concerned court only for the folly of the court not acting in accordance with law or not recording the statement that would be in tune with section 26(1) of the Act. And for the aforesaid reasons, the following order: the petition stands disposed. The court shall now record the statement of the victim child in the presence of the mother on a particular day fixed for the said purpose in accordance with the provisions of the Act and provisions of the Act.
Should add one para, my lord, that certificate hereafter in case in the future, this
ಯಾವ್ದಕ್ಕೆ?
thing, certification by the magistrate
ಹಾ,
should carry mandatory that
ಯಾವ್ದ್ರಲ್ಲಿ certification?
that parent was present ಅಂತ ಇದ್ರಲ್ಲಿ that is the
Ah,
problem.
that's what,
Had
ಅದು
one
ಹೇಳಿದ್ದೀನಲ್ಲ. It is, since, one para ಹಾಕಿ. Since the child is now being brought back for recording of a statement which is completely contrary to section 33(5) of the Act, it is solely on the folly of the learned magistrate. Therefore, the learned magistrate, while recording the statement, shall bear, recording the statement, the statement recorded by the magistrate shall bear such clarity that it is in tune with section 26(1) of the Act, 26(1) of the Act, failing which the matter would be viewed seriously on the court if the court is now passing orders which is prejudicial to the interest of the complainant or the victim.
My lord, evidence of the victim may be deferred till record.
The statement shall be recorded on date fix ಮಾಡ್ಬಿಡ್ತೀನಿ. The statement of the victim shall be recorded on 30th.
Friday, Saturday, any day.
ಅದಕ್ಕೆ ಯಾವತ್ತು ಅಂತ ನೋಡ್ತಾ ಇದ್ದೀನಿ. 28 ಮಾರ್ಚ್ ಕಾಪಿ ನಾಳೆ ರಿಲೀಸ್ ಮಾಡ್ಬೋದಲ್ಲ? 28, the statement shall be recorded of the victim child in the presence of the mother shall be recorded on 28 March. Till the recording of the statement, further evidence of the victim, further evidence shall be deferred. The court shall regulate its procedure once the statement is recorded to proceed further in evidence.
Your lordship generally also say, my lord, that hereafter magistrate.
ಅಲ್ಲ, ಅದು ಬರ್ದಿದ್ದೀನಿ, ಕೊನೆಗೆ ಒಂದು ಪ್ಯಾರಾ ಹಾಕಿದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ. Yes. Will be viewed seriously ಅಂತ ಅದಕ್ಕೆ ಬರ್ದಿದ್ದೀನಿ.
Matter is listed tomorrow, my lord. I request hand delivery.
Final order hand delivery ಹೇಳ್ತಾರೆ ಬಿಡಿ. ಇಲ್ದರ್ ಲೈವ್ ಇದೆ. I am live. Yes.
It appears it was wrongly listed today, my lords. It was supposed to be by 9/4.
ಇದು ಹೇಳಿದ್ರಲ್ಲ. Yes. List the matter on 9.
Returnable by 9/4.
9/4 ಅಂತಾನೆ ಇದೆ. Returnable ಇಲ್ಲಿ ಡೇಟ್ ಹಾಕಲಿಲ್ಲ ಅಷ್ಟೇ. List on 9/4/2026. ಬಂದಿದೆಯಾ? ಇಲ್ಲ.
If at all interim order.
Interim order subsisting will continue to the next date of case.
38.
Lookout circular, my lords, on the basis of 498A. The proceedings, my lords, have been stayed by your lordships. I am unable to travel back, my lords, with my daughter.
ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಸರ್?
To Dubai, my lords, Emirates.
Dubai?
Yes, my lords.
ಈಗ not a good time to go.
But school and right now, yes, my lord, but school admission.
Not a good time to go. ಸ್ವಲ್ಪ ದಿನ ಇರಿ.
It has been stayed by your lordships. In fact, she was arrested on the basis of a lookout circular. She was A6. On the basis of the arrest, she was remanded to judicial custody with the child for 4 days, my lords. I'm only seeing.
ಯಾರು originator? ಯಾಕೆ 498 ಅಲ್ಲಿ lookout circular?
ಬಂದಿಲ್ಲ, ದುಬೈಯಲ್ಲೇ ಕೂತಿದ್ರು ಅಂತ ಮಾಡಿ.
Lords, interim orders at page 53. My lords has stayed the
498 ನ ಸ್ಟೇ ಮಾಡಿದೀವಾ?
53 ನಲ್ಲಿ entry number 6.
My order.
Yes, my lords. The lordship's order. That matter is pending, my lords.
ಹಸ್ಬೆಂಡ್ ಗೂ ಸ್ಟೇ ಮಾಡಿದೀವಾ?
ಇಲ್ಲ.
ಮತ್ತೆ
husband is I am not the husband, my lords. I am relative. I am relative. Accused number 6.
Accused number 4.
4, sorry. I am sister-in-law.
ನಿಮ್ಮ ಮೇಲೆ ಯಾಕೆ?
ಮೇಲೂ ಇದೆ allegation, the omnibus.
ಅಲ್ಲ, LOC ಯಾಕೆ?
My lords, I am not even given a copy.
Why, Jagdish sir? Distant relatives ಮೇಲೂನು LOC ಶುರು ಮಾಡಿದೀರಾ?
498 ಗೆ LOC ನ ಹಾಕ್ಬಾರ್ದು ಅಂತಾನೆ ಇದೆ.
ಮತ್ತೆ we should not. You want to go back to Dubai?
Yes, my lords. My husband is in Dubai.
That instead of
this is Srimati,
that instead of quashing, my lord, let there be an order to recall it, my lord, instead of.
ಎಲ್ಲ ಮಾಡಿ. The petition calls in question a lookout circular issued by the Bureau of Immigration. The Bureau of Immigration is only the executant. The originator is the state. The offense is the one punishable under section 498A of the IPC. Inter alia. The petitioner is accused number 4, is now stranded in India and her husband is in Dubai. The allegation against against the present petitioner is so omnibus and vague made by the complainant that there is an detailed interim order granted by this court staying all further proceedings. Despite this, it is surprising as to how the originator in a case of 498A has yielded to the pressure of the complainant, or only to assuage the complainant has generated a lookout circular against the petitioner. The lookout circular in an offense under section 498A of the IPC. In that 498A. Therefore, the learned additional SPP to secure instructions with regard to withdrawal of the lookout circular, as lookout circulars cannot for the asking be issued in offenses under 498A except in exceptional circumstances where the accused would evade trial and run away from the country. ಅಲ್ಲ ನಾವು ಪಾಸಿಟಿವ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ಪ್ರೆಸಿಡೆಂಟ್ ಆಗ್ಬಿಡುತ್ತೆ ಆಮೇಲೆ. ಅದಕ್ಕೆ ನಾನು ನಿಮಗೆ ಕೇಳಿದ್ದು.
Lordship, record my submission since there is a stay.
In the light of the interim order granted and subsisting and the offense being the one punishable under 498A and the petitioner being a distant relative who was residing in Dubai all through merits all through would undoubtedly lead to undoubtedly would lead to ಇದು ಕ್ವಾಶ್ ಮಾಡಿದ್ರೆ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗುತ್ತೆ. ಅದಕ್ಕೆ seek instructions as to when the respondents would recall the LOC that is hanging on the head of the petitioner. List day after tomorrow. Friday akla?
Friday.
Friday fresh matters.
Great.
39.
For the complainant respondent in this case, my lords, I seek for a week time, my lords. I'll file my statement of objections in this. Yesterday, I filed my wakalat in the said matter.
Cognizance is
The
not taken
registry
by
has taken the cognizance.
cognizance.
Can they set it back?
We'll send it back ashte. You want to file objections? Haki.
Well, please.
ಹಾಕ್ತೀರಾ ಏನು?
ಹಾಕ್ತೀನಿ.
List the matter on 2nd April, 3rd April, 2nd April. Yes. That will continue. At the request of the council appearing for the respondent Rahul Reddy, who seeks time to file statement of objections. Next.
40.
Initiated the criminal proceedings for recovery of money. The petitioner, my lord, he was an employee at Forest Corporation. My lord, during the undertaking of logging work between 2004-5 to 2006-7, my lord, he misappropriated the amounts. The work is like this, my lord. ಈ ನೆಲ ತೋಪಿನ
8,62,000.
ಪ್ಲೀಸ್
ಏನ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ರೆ ವಾಪಸ್ ಕೊಡ್ತೀನಿ ಅಂತ?
ಅಲ್ಲಲ್ಲ, ಅಂಡರ್ಟೇಕಿಂಗ್ ದಿ ಲಾಗಿಂಗ್ ವರ್ಕ್. ಆ ಮರ ಕಟ್ ಮಾಡಿ ನಾವೇನು ಕಳಿಸ್ತಾ ಇದ್ವಲ್ಲ,
ಆಯ್ತು.
ಅದೇನ್ ವರ್ಕ್ ಅಂತಂದ್ರೆ ಮರ ಕಟ್ ಮಾಡಿ ಲಾಟ್ ಹಾಕಿ, ಆ ಲಾಟ್ ಹಾಕಿದ್ಮೇಲೆ ಅದನ್ನ ಲಾರಿ ಲೋಡ್ ಮಾಡಿ ವೇ ಮಾಡಿದ್ಮೇಲೆ ಡೈರೆಕ್ಟ್ಲಿ ಫ್ರಮ್ ಕಾರ್ಪೊರೇಷನ್ ಟು ದಿ ಲೇಬರ್ಸ್, ನಾಟ್ ಟು ದಿ ದಿಸ್ ಪರ್ಸನ್ ಈಸ್ an employee. For recovery of money, my lord, they've initiated the criminal proceedings.
No, the issue is misappropriation of funds. The allegation is misappropriation. Misappropriation crime ಆಗ್ತದೆ, ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ ನಿಮ್ಗೆ? Recovery of money, no, whatever it is, misappropriation is
for recovery of
419-420 straight away.
Allalla. For recovery of money, my lord, there is a remedy provides under the statute. They have to file
ಏನ್ remedy sir?
Civil suit ಹಾಕ್ಬೇಕು.
ಯಾರು?
Corporation ಅವರು.
ಅಲ್ಲ, what, you are an employee?
Please, my lord, I was an employee
of the forest department.
In the forest
no,
department.
Sir, anything else?
ಅಲ್ಲಲ್ಲ. In the year, my lord, 2000
ಎಂಪ್ಲಾಯೀಸ್ ಮಿಸ್ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಮಾಡೋದು, ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿ ರಿಕವರ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋ ಕಾನೂನು ಬರೆದ್ಬಿಟ್ರೆ ಆಯ್ತು.
ಅಲ್ಲಲ್ಲ,
ಆಮೇಲೆ ಎಸ್
ಅಲ್ಲ, in the year 2000
ಎಲ್ಲ ಮಿಸ್ಅಪ್ರೋಪ್ರಿಯೇಷನ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಡಿ, ಎಲ್ಲ ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕಿ.
ಅಲ್ಲಲ್ಲ, in the year 2013, my lord, superannuation is completed.
ಅದು ಹೇಳಿ ಪರವಾಗಿಲ್ಲ, ಅದ್ ಬಿಟ್ಟು ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕ್ಬೇಕು ರಿಕವರಿ ಆಫ್ ಮನಿಗೆ ಅಂತ.
It's completed his superannuation in the year 2013. They filed complaint in the year 2022.
That we will see. There is delay. That's all right.
Please.
Because 2003 incident.
And he has agreed to pay back.
Other, you can't register crime for that. Misappropriation, yes.
They could have recovered.
ಯಾವಾಗಲೂ ಮಾಡ್ಬೋದಿತ್ತು. ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ರಿಕವರ್ ಮಾಡಬಾರ್ದಾಗಿತ್ತು.
ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಹಂಗಾಗಿ
ಅಲ್ಲಿವರೆಗೂ ಏನು ಯಾವಾಗ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಇವರು
ಹಂಗೆ ಹಾಕಿದೆ.
The petitioner,
Let him deposit ಮೇಲೆ.
a former employee of the forest guard,
ಅಲ್ಲ junior assistant.
junior assistant in the forest department is now before the court challenging the act of registration of the crime. Crime is registered on account of alleged misappropriation of funds by the petitioner and his and the undertaking said to have been given by the petitioner that he would return the amount in 2003. The petitioner attains the age of superannuation and retires on attaining the age of superannuation in the year 2013. The crime has sprung in 2022, seeking that the undertaking was given in 2007. It has not been acted upon, therefore the crime is registered. The delay has defeated the prima facie defeated the claim of the prosecution. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing.
I'm grateful.
ರಿಟೈರ್ ಆಗಿ 10 ವರ್ಷ ಆಗಿದೆ ಬಿಡಿ, 70 ವರ್ಷ ಆಗಿದೆ.
ಅಲ್ಲ ರಿಟೈರ್ಡ್ ಆಗಿ 13 ವರ್ಷ ಆಯ್ತು.
13 ವರ್ಷ ಆಯ್ತು. 2013 ಅಲ್ವಾ ರಿಟೈರ್ ಆಗಿದ್ದು? 13 ವರ್ಷ ಆಯ್ತು. ಕರೆಕ್ಟ್.
Grateful.
ಮುಗಿತಾ ಇದು?
Reporting settlement 96.
Offense?
498.
Parties?
Terms of.
ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. MCL ಆಗಿರೋದಾ ಇಲ್ಲ?
ಇಲ್ಲ.
ಇಲ್ಲ ಆಗ್ತಾ ಇರೋದಾ?
ಆಗ್ತಿರೋದು.
ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಕೇಸಲ್ಲಿ ಆಗಿದೆಯಾ?
ಇನ್ನ ಆಗಿಲ್ಲ ಸರ್, ಇಲ್ಲೇ ಮಾತ್ರ.
ಇಲ್ಲೇ ಆಗ್ತಾ ಇರೋದು.
Because they say 498A.
Compounding application. In Vijay.
Please, great.
All sheet signatures.
Great.
97.
Petitioner, Your Lordship.
Offense?
406 and 420, Your Lordship. Your
Respondent?
Lordship, the matter has been settled, Your Lordship.
Where?
No, Your Lordship, the parties are not here. The mother of the petitioner has passed away and senior is also out of the town.
ಯಾವತ್ತು ಬೇಕು?
At the discretion of this honorable court, Your Lordship.
ಯಾವತ್ತು ಮೇಡಮ್? 10th? 10th?
Obliged, Lordship.
4 PM report settlement.
Obliged.
98.
Let's Child Marriage Act, my lord.
Child marriage.
Child marriage?
Yes.
No
9
settlement.
and 11.
No, my lord. Section 9 and 11, 17 years, 10 months. My lord. 2 kids are there, my lord. Now they have registered the marriage, my lord. 23 lakh.
Child Marriage Act. ನಾನೇ ಮೊನ್ನೆ ಬರ್ತಿದ್ದೀನಿ ಸೆಟಲ್ ಮಾಡಂಗಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ, my lord.
No sir.
17 years, 10 months.
No, you so?
After that, my lord, this has not been registered, my lord.
No, no sir.
Marriage was settled.
Come on merits, no settlement.
At least on them.
ಏನ್ ಪೋಕ್ಸೋನ?
Not more POCSO.
ಬರೀ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಅಷ್ಟೇ. ಹಂಗಾರೆ ಪೇರೆಂಟ್ಸ್
As per incident, victim 16 years, 9 months, my lord.
No, no. 17 years, 10 months.
they would say religion permits, but I have said that also.
2 months ಅಲ್ಲಿ ಇದು ಮಾಡಿದ್ರು.
2 months?
Actually, this suomoto complaint, my lords, were in the.
ಸುಮೋಟೋನೇ ಆಗೋದು.
Actually, thing is that, my lords, ಮನೆಯಲ್ಲಿ ನಿಶ್ಚಯ ಮಾಡ್ಕೊಂಡಿದ್ದಷ್ಟೇ, ಮದುವೆ ಆಗಿರ್ಲಿಲ್ಲ. After that, after attaining.
That's a matter of evidence. ಅದು ಬರ್ದಿದ್ದೀನಿ.
After attaining the age of majority, my lords, it has registered.
Child marriage I will not sir. ನಾನೇ ಬರ್ದ್ಬಿಟ್ಟು ನಾನೇ ಸೆಟಲ್ ಮಾಡ್ತಾ ಕೂತಿದ್ರಾಗ.
2 kids.
No,
no POCSO, my lord.
ಪರವಾಗಿಲ್ಲ. ಅದೇ ನೋ ಪೋಕ್ಸೋ. ಪೋಕ್ಸೋ ಆದ್ರೆ ಸೆಟಲ್ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದೆ ಈಗ. Because parents ಮದುವೆ ಮಾಡಿದ್ರೆ ಅವ್ರೇನ್ ಮಾಡ್ಬೇಕಾಗಿದೆ? Yes, this will come on merits, no settlement in this. List the matter on 9th April.
9th. Much.
Permission.
99.
Serial number 40.
Wait sir. Yes. 19 ಇಲ್ಲ ಅಂದ್ರೆ 10th April ಗೆ ಹಾಕ್ಬಿಡಿ.
99.
ಇಲ್ಲ 99 ಹಾಕಿ. 10th ಹಾಕಿ. ಇದ್ದಾರಾ? ಪೆಟಿಷನರ್ ಎಲ್ಲಿ? ನೀವೇ ಪೆಟಿಷನರ್. ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಲ್ಲಿ? ವಿಡ್ರಾವಲ್ ಮೆಮೋನಾ? ಅಯ್ಯೋ ಥ್ಯಾಂಕ್ ಯು.
100.
Offense.
Can I
406
have,
or 408?
request for tomorrow, my lord?
ಆಯ್ತು.
There are other two matters also, all three to be.
ಆಯ್ತು. ನಾಳೆ ಆಗುತ್ತೆ ಮೇಡಮ್. ಟುಮಾರೋ.
ಬೇರೆ ಎರಡು ಮ್ಯಾಟರ್ಸ್ ನಾಳೆ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
ಆಯ್ತು.
101.
The same matter. The first one 90. Same matter.
Same. Learned counsel so and so enters appearance. Same other tag ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್. ಸುನಿಲ್ appear ಆಗಿದೆ. Yes.
102.
Lords, in this case, we are filing application for compounding the offense.
Offense ಏನು ಸರ್?
Offense is under section 66 of
IT Act.
IT Act.
ಸರಿ ಕೊಡಿ.
66, 67. Why not for
Oh, compounding application. Inveji.
both the parties are present.
Yes.
103
Where are the parties?
petitioner and
Complainant. All right. Yes.
next matter, my lords, also
103.
between the same parties.
Case and counter case.
103.
Filing this joint affidavit.
ಕೊಡಿ. Offense ಅದೇನಾ?
ಅಲ್ಲ ಅದರಲ್ಲಿ
My lord, it is 504, 506.
ಆಯ್ತು. Yes. Next. Entry model continue. Entry model ಎಲ್ಲಿದೆ? ಅರ್ಜನ್ ಆಗಿರೋದು entry model continue. Yes. Next.
104.
Parties are law students, my lords.
Parties are law students. Offense ಏನು?
324.
ಯಾಕೆ ಹೊಡೆದಾಡಿದ್ರ?
Just slap ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಸ್ಲ್ಯಾಪ್. ತಪ್ಪಡ್.
ಮೂಟ್ ಕೋರ್ಟ್ ಮಾಡಿರ್ಬೇಕು. ಮೂಟ್ ಕೋರ್ಟ್ ಮಾಡಿರ್ಬೇಕು. ಕ್ರೈಮ್ ಹೆಂಗಾಗತ್ತೆ?
ಲಾ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅಲ್ಲೇ ತಪ್ಪಡ್. Yes. All right. Sign out.
Yes. Obliged.
105.
55 and 105 plus 3, my lords.
55 ಬೆಳಗ್ಗೆದ.
Yes.
498 ಏನ?
498.
Yes. 55 and 105. ಎಲ್ಲ ಹಾಕಿದಿರ ಎಲ್ಲ?
For respondent, your
Council so and so.
filing wakalat and along with affidavit.
ಅಲ್ಲ 105 ಯಾವುದು?
105 ಇದು ಸರ್.
ಈಗ?
ಹೌದು.
Parties are present? All right. Yes. And 6. ಅಲ್ಲ ಅವಿನಾಶ್ 155 ಜೊತೆಗ ಇದೆ. 105 ಮಾತ್ರ. 105 ಮಾತ್ರ.
106.
I am for respondent 2 minutes. Filing my
498A. These have resolved their disputes, Your Lordship. The complainant does not wish to prosecute the case.
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿದ್ದೀರಾ? Resolve the dispute ಅಂದ್ರೆ how?
They're reconciling.
Oh, they're living together. All right. Any terms you have drawn? Settlement?
No
Nothing.
terms. They don't want any terms to be recorded.
Huh?
They don't want terms to be recorded.
Then how do we close it?
As if that it can
Some
be recorded
affidavit.
that-
Some affidavit is needed.
Let the respondent file a memo, my lord, not
At
interested.
least a memo. Something.
The respondent will file a memo that.
You
does
file a
not-
memo. I'll on that memo I will pass up. Something should be there to close it.
Please, Your Lordship.
I will not record anything. It's all right.
Yes, sir. We'll file a
Since
memo.
it's a reunion, we'll not record anything. But if a memo ಹಾಕಿದ್ರೆ I'll close it.
I'll.
ಈಗಲೇ ಮಾಡಿ.
Yes, sir.
ಈಗಲೇ ಕೊಡಿ. Ask the complainant to sign it. That's all. But the petitioner is before this court seeking the following prayer. Counsel for the respondent. The complainant is complainant advocate ಇದರಾ?
They just filed the wakalat.
ಯಾರು? Sorry. The complainant, the learned counsel appearing for the complainant submits that the complainant is not willing to pursue the matter any further, more so in the light of the fact that the husband, the petition accused and the complainant have now decided to live together. In that light, the proceedings stand quashed. ಒಂದು ಮೆಮೊ ಹಾಕ್ಸ್ಬಿಡಿ ಅಷ್ಟೇ. ಅದು ಮಾಡಿ. Sorry? Then come on merits. Not now. We'll post it on 1st April. And no counsel for the petitioner submits the talks of settlement have. All right. Settlement have failed. List the matter on 8th in the fresh matters list. Intermodal idea. List the matter on 8th. Intermodal subsisting will continue to the next day. ಏನ್ ಮೇಡಮ್ ಅದು? ಕೊಡಿ.
More matter. Fresh matter, fill number 1. Prasad sir.
Petitioner, my lord, is the business of hallmarking of gold. On 15
Hallmark.
Hallmarking of gold, my lord. So he's in that business. On 1510, my lord, an FIR comes to be registered on the ground that, my lord, he had no license. My lords may kindly see the license.
License ಇದೆಯಾ?
On that day, license was given, but we were not given the hard copy. So it comes by way of email. We were, now kindly see the license, my lord.
Page?
License at page number 46. Relevant portion is at 47. From 9/9/2025 to 8/9/2028. This is given on 15/10/2025.
ಅಲ್ಲ 10/10 ಅಂತ ಇದೆ.
That was the day it was sent to me. Now kindly see the next page, 47.
Next page, yes, 15/10/2025.
Yes, the FIR was registered on the same day.
The petitioner is before the court calling in question.
It comes with a retrospective effect.
Calling in question registration of a crime in crime number 84 of 2025 for offences punishable under section 17. So the sole reason for registration of the crime against the petitioner is that he was rendering a hallmark upon the gold without having a license. The crime is registered on 15/10/2025. The license is granted on the same day on 15/10/2025, and he was found to be rendering such hallmark on the same day. The license operates retrospectively from 9/9/2025 to 8/9/2028, as could be gathered from the certificate so issued. Therefore, it is not a case where the petitioner has rendered the hallmark on 15/10/2025 without having license. In that light, there shall be an interim order of stay.
1811 in the
ಇಲ್ಲ ಇಲ್ಲಿ ಬನ್ನಿ.
FIR page 17 ಮೇಲೆ.
FIR ಬಿಡಿ, ನೀವು come to page 47. The recognition shall be valid from 9/9/2025 to 8/9/2028.
Even otherwise, before that also I had for the 3
Ah.
preceding years.
But he was issuing certificate from 8/11/2028, 11/8/2025.
Now kindly see
prior to the
annexure G, page 44. Relevant portion is at 45. That also I have license. From 9/9/2022.
9/9/2022 to 8. The renewal ಅಷ್ಟೇ problem.
Renewal ಅಷ್ಟೇ. Now
It's
renewal
not
comes.
fresh license. He had license from 9/9/22 to 8/9/25.
Then it
So
came-
11/8 cover ಆಗಿದೆ ಅದರಲ್ಲಿ. The learned additional SPP submits that the petitioner has rendered hallmark on 11/8/2025 without a license, therefore the crime is registered. That submission also would be unacceptable in the light of the fact that the petitioner did have license from 9/9/2022 to 8/9/2025 and had applied for renewal. The renewal has come about on 15/10/2025 with retrospective effect from 9/9/2025, the next day of its expiry on 8/9/2025. Therefore, there shall be an interim order of stay of all investigation.
Yes.
Of all investigation qua the petitioner till the next date of hearing.
Great.
Next.
Lords, I appear for the petitioners.
Ah.
Lords, here petitioners are husband and in-laws, my lords. My lords, this is
498 ಏನ?
ಹೌದು. This is classic case of wife abuse. Wife abusing the husband.
Wife abusing the husband?
Yes, my lords. Page number 132, my lords. This is a depression. I go to depression because of her torture.
You
And
go
then,
to
my lords-
depression.
Yes, my lords. And also, my lords, the wife abusing me is at 142. She has smashed the finger that fed her.
ಇದು ಯಾರೋ ಬೇರೆ ಮಾಡಿರ್ಬೇಕು.
ಇಲ್ಲ my lords. ಅಲ್ಲಿ 142 ಅಲ್ಲ ಇದೆ. Marital disharmony ಅಂತ ಒಂದು ರಿಪೋರ್ಟ್ ಇದೆ. ಅದು ನೆಕ್ಸ್ಟ್ my lords.
Marital disharmony.
Yes, my lords.
X-ray ಗೊತ್ತಾಯ್ತಾ ಅದು?
ಅಲ್ಲ X-ray 143. 142 ಅಲ್ಲಿ
ಅಲ್ಲ X-ray ಅಲ್ಲಿ marital disharmony ಅಂತ ಗೊತ್ತಾಯ್ತಾ?
It was the report from the hospital 1. And also, my lords, the in-laws conditions are even worst. 140.
She's abused them also, is it?
My lords, ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳ್ತೀನಿ. 161 ಅಲ್ಲಿ my lords, the mother-in-law photo ಇದೆ. She has gone for operation and liver operation ಆಗಿದೆ. She was discharged on March 10th. And my lords, in 164, the father-in-law is supposed to get operated.
ಸರಿ, ಅದಕ್ಕೆಲ್ಲ ನೀವು ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, ನಾವೇನು ಮಾಡಿಲ್ಲ.
ಯಾಕೆ ಮಾಡಿಲ್ಲ?
My lords, ನಾನು
Finger
this is a
smash
problem.
ಆದ್ರೂ ನೀವು ಯಾಕೆ
My
ಸುಮ್ಮನೆ
lords,
ಇದ್ದೀರಾ?
when my finger was smashed, when I went to my elders and when I told all this, they said a very wrong statement, which they said ನೀವು ಗಂಡ್ಸಾಗಿ ಇದೆಲ್ಲ ಸಹಿಸ್ಕೋಬೇಕು ಅನ್ನೋ ತರ ನಮಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ.
ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೇಕು, ಅದನ್ನ ಸಹಿಸ್ಕೋಬೇಕು ಅಂತ ಯಾರು ಹೇಳಿದವ್ರು ನಿಮ್ಗೆ?
How can I, my lords?
How can you? Why?
73 to 131 page number, my lords. All the
How
things
can you
out of
register
love
a-
I have done for my wife. 73 to 131.
ಪರವಾಗಿಲ್ಲ ಸರ್, your finger is smashed by your wife ಅಂದ್ರೆ first thing is register a crime.
I was already in the depression, my lords. In ಮತ್ತೆ ಹೋಗಿ
Depression.
ಲೈಫ್ ನ ಇನ್ನೂ ಹಾಳು
You could not
ಮಾಡ್ಕೊಳ್ಳೋದು
go
ಬೇಡ
to
ಅನ್ನೋ ಒಂದೇ ಒಂದು
depression, sir. Go to
ಕಾರಣಕ್ಕೋಸ್ಕರ.
the police station.
My lords, ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಗೂ ಹೋದೆ, my lords. For the same reason, ಅಂದ್ರೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋದ್ರೆ ನಮ್ಗೆ ಹೇಳೋ ಬುದ್ಧಿವಾದ ಅಷ್ಟೇ, ಸ್ವಲ್ಪ ಸಹಿಸ್ಕೋಬೇಕು ಅಂತ ಹೇಳಿ. ಅಕಸ್ಮಾತ್ ಈ ಸ್ಮ್ಯಾಶ್ ಫಿಂಗರ್ಸ್ ಇಟ್ಕೊಂಡು ಮಹಿಳೆಯರು ಹೋಗ್ಬಿಟ್ರೆ, my lords, the world will be upside down. ಬೇರೆ ಕೆಳಗೆ ಹೋಗ್ಬಿಡ್ತಾರೆ, my lords.
Heavens will fall down.
Then I'll secure the records, my lord, because 23/2/2026. Let me see who smashed whose finger.
ಅಲ್ವಾ?
ಸ್ವಲ್ಪ ನೋಡೋಣ.
ಅದಕ್ಕೆ
ಮೇಲ್ ತಗೊಂಡಿದ್ದೀರಾ?
ತಗೊಂಡಿದ್ದಾರೆ.
ಬೇಲ್ ತಗೊಂಡಿದ್ದೀವಿ. ಆ ಬೇಲ್ ಇವಾಗ ಯಾಕೆ ಬಂದಿರೋದು ಅಂತ, my lords, ಬೇಲ್ is in page number 150. ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಗೆ ಒಂದು ಕಂಡೀಷನ್ ಇದೆ. ದಟ್ ಕಂಡೀಷನ್ ಇಸ್ ದ ಇದು ಇವಾಗ 25 days ಅಲ್ಲಿ ನಾನು ಬಂದು ಸಬ್ಮಿಟ್, ನಾನು ಅವ್ರ ಜೊತೆ
ಅಲ್ಲ, ಬೇಲ್ ಅಲ್ಲಿ ಕಂಡೀಷನ್ ಏನಿದೆ?
ಹೌದು, ಕಂಡೀಷನ್, my lords, is that before the petitioner shall surrender before SHO IO within 15 days from this order ಅಂತ ಹೇಳಿದೆ. I am not in a position to come on because the father-in-law and mother-in-law are totally bedridden.
ಇದೇನಾ ಮೂವ್ ಮಾಡಿದ್ ನೀವು?
Yes, my lords.
Totally bedridden in Uttar Pradesh.
Uttar Pradesh, my lord. All happened, my lords.
ನಮ್ಮವರೇ ಅಲ್ಲಿಗೆ ಹೋಗಿ ಕರ್ಕೊಂಡು ಬರಲ್ಲ.
Why will they will not go to
ಹೇಳ್ಬೋದು,
Uttar
my lords.
Pradesh.
ಆಮೇಲೆ ಇಲ್ಲಿ ಬೇರೆ ಏನಾಗುತ್ತೋ ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ.
ಎಲೆಕ್ಷನ್ ಟೈಮ್ ಅಲ್ಲೆಲ್ಲ ಹೋಗಲ್ಲ ಅವರು.
ಅಲ್ಲ, ಬೆಂಗಳೂರಲ್ಲಿ ಇರೋದು, ಬೆಂಗಳೂರು ಯಾವ ಎಲೆಕ್ಷನ್ ಇಲ್ಲ, my lords.
ಅಲ್ಲ, ಅಲ್ಲಿ
my lords, for the same.
I'll get records, my lord. Let me have it done.
Get the records
First, man.
At least in-laws, my lords. ಅವ್ರಿಗೆ 164, my lord, 164.
ಆಯ್ತು, wait will protect you.
Specific allegation ಕೂಡ ಇಲ್ಲ. ಅದ್ರ ಜೊತೆಗೆ ಆಮೇಲೆ 5/4/2026 ಗೆ he has to he was supposed to go to hospital.
Who is the wife here?
Wife is the complainant here.
ಅಲ್ಲ, ಇಲ್ಲಿ ಯಾವ ಫೋಟೋಗ್ರಾಫ್ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ?
ಆ ಫೋಟೋಗ್ರಾಫ್ mother-in-law.
Mother-in-law ನಾ ಅದು?
Page 103 ನಲ್ಲಿ ಇದೆ.
Anyway, strength lies ಗೊತ್ತಿಲ್ವಲ್ಲ ಎಲ್ಲಿ ಅಂತ.
I'll get the record. Anyway, it is on bail.
They are on bail, but don't precipitate, don't call them. Yes.
At least, my lords, the complaint, my lords, 58, my lords, allegation.
List the matter on 8th April in the fresh matters list.
Last one. Only allegation against the mother-in-law is this.
I'm granting you some protective order. Wait, sir. List the matter on 8th in the fresh matters list. The learned additional SPP to secure. Charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ.
Learned additional SPP to secure the investigation papers and place it before the court on the next date. The respondent shall not precipitate the matter till the next date by summoning the petitioners for investigation.
Great.
The indirect stay adu.
Grateful.
Voting settlement seal number 3.
But smash ಏನಾರು ಉಲ್ಟಾ ಆಗಿದ್ರೆ ಇದು ಸ್ಮ್ಯಾಶ್ ಆಗೋಗುತ್ತೆ.
ಇಲ್ಲ, my lords. ಆತರ ಸಾಧ್ಯನೇ ಇಲ್ಲ.
Seal number 3, P. Prasanna Kumar.
Yesterday's matter. One matter is in list number 3, serial number 3.
ಅದರ ಜೊತೆಗೆ ತಗೊಂತೀನಿ. ಏನಕ್ಕೆ ಬಂದಿ? ಯಾವ್ದಿದು?
498A. Not LOC not is in serial number 3, list 3. Not I had requested for permission to travel.
LOC, correct.
The same issue. Main issue is now settled.
Settled
ಆಗಿದೆ. Settled ಆಗಿರೋದು ಈಗ the case now called is not the matter that is settled. Consequential order is not the LOC matter.
Settle ಆಗಿದ್ರೆ LOC close ಮಾಡಿ.
Today's divorce petition was filed. That is posted for tomorrow.
ಆಯ್ತು.
Let the petitioner appear before the lower court tomorrow and finish up the divorce proceedings, and then he can.
That's all right, no problem. We'll recall the LOC.
Please.
ಇಲ್ಲ ನಾಡಿದ್ದು ಹಾಕೊಂತೀನಿ.
ಇಲ್ಲ, ಇದು ಮುಗಿದೋಗ್ಬಿಡುತ್ತೆ ಅಂತ ನೋಡಿ. Again, not they will have to come all the way from Kolar.
Kolar.
We already filed
all the way from Kolar.
We have already filed an application, not, and the DD is being handed over.
Tomorrow, I have no objection.
DD is being handed over.
ಬೆಳಗ್ಗೆ 5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ, 20 ಲಕ್ಷ, ಈಗ 15 ಲಕ್ಷ ಇದೆ. That is being not paid now.
ಆಯ್ತು, ಏನ್ ಮಾಡೋಣ ಹೇಳಿ ಈಗ?
The petitioner is going to appear tomorrow before the lower court in the divorce proceedings. I have no objection to quash the.
They will appear.
Yeah, I have stayed for almost 3-4 months to settle everything.
He will appear. Otherwise, if LOC won't be subject to his appearance, I will recall the LOC. That's all.
ನಾಳೆ ಮುಗಿಸ್ಲಿ ಅಷ್ಟೇ. That's all.
ನಾಡಿ ತಗೊಂತೀನಿ ಬಿಡಿ.
ಅಲ್ಲ ಬೇಡ, again, my lord. This is the fourth time, my lord, it is coming on the same stage.
Yes. So, 498A. The LOC petition ಯಾವುದು?
ಅದು list 3 serial number 3.
ಅದು ತಗೊಳ್ಳಿ. The in the light of the settlement arrived at between the parties and the sole reason 498 ಅಲ್ಲಿ ಏನು LOC ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇದು? And is being again another misuse of LOC. The in the light of the settlement arrived at between the parties and the lookout circular being drawn solely on the score of the registration of the crime against the petitioners, the LOC in the light of the settlement stands recalled. All this would be subject to the petitioner appearing before the concerned court tomorrow in MC. Sorry, before the concerned family court where the matter is listed between the two, tomorrow.
Please.
Date ಹಾಕ್ಬಿಡಿ tomorrow. The petitioner hands ಅಲ್ಲೇ ಕೊಡ್ತೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ.
The
I want to hand it over 5
petitioner
lakhs.
hands over a demand draft of rupees 15 lakhs. Apart from the 5 lakhs that was already paid, and the same is acknowledged, receipt of which is acknowledged by the complainant who is present before the court and the counsel for the complainant. ಇನ್ನೇನ್ ಬೇಕು?
498 ಅದೊಂದು.
ಇನ್ನೂ 5 lakhs ಇದೆಯಾ?
ಅದು that will be
The
tomorrow,
learned
madam.
counsel for the petitioner Prasanna Kumar submits that 5 lakhs would be paid tomorrow in the before the family court. The said undertaking is recorded. Yes. ಏನಿಲ್ಲ ಅಲ್ಲ ತೊಂದರೆ ಆಯ್ತು ಮೂವ್ ಮಾಡಿ ವಾಪಸ್ LOC ರೆಸ್ಟೋರ್
withdraw, my lord, domestic violence case.
ಎವ್ರಿಥಿಂಗ್ ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ವಾ ಅದನ್ನ? ಮತ್ತೆ ಬಿಡಿ. All three close. Yes.
Please.
Number 4.
My lord, kindly have it on tomorrow, my lord. Serial number 4, end of the list.
ಏನು offense ಏನು?
109 BNS, my lord.
Attempt to murder.
My lord, ಅದು due to undue influence complaint, false ಆಗಿ complaint ಕೊಟ್ಟರೆ ಅದು is admitting.
ಅಲ್ಲ ಮಾಡಬಾರ್ದು ಅಂತಿಲ್ಲ, ಬಟ್ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ? ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಿರಾ?
Investigation 25/2/2026.
No sir.
Seems to be dangerous Shiva.
ನಿಮ್ಮ ಹೆಸರಾ?
My lord, it is my nickname, my lord.
ಡೇಂಜರ್ ಶಿವು.
Is my
ಮತ್ತೆ 307 ಆಗದು ಮತ್ತೆ.
My lord, it is the nickname given by the
because of the activities.
No, my lord. In the locality.
In the locality you are dangerous.
Not like that, my lord.
ಮತ್ತೆ ಇನ್ನೇನು ಡೇಂಜರ್ ಶಿವ ಅಂದ್ರೆ ಏನಿದು?
In the FIR they have mentioned like that.
Yes.
26 cases against him. 26 cases.
Close the you are really dangerous.
My lord.
26 cases.
Yes, my lord. This case is
grounds of arrest ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದೆಲ್ಲ.
Larger than the undue influence by the political pressure, my lord.
ಇದೊಂದು ಸ್ವಲ್ಪ ಫೈಲ್ ಕೊಡಿ ಒಂದು ನಿಮಿಷ.
My lord, the parties are not before this honorable court, my lord. Kindly have it.
ಒಂದು ನಿಮಿಷ ಸರ್.
Page 15 ಇಂದ ಶುರು ಆಗುತ್ತೆ. 307 ಬೇರೆ ಹಿಂದೆಗಡೆ ಇದೆ. ಆರ್ಮ್ಸ್ ಆಕ್ಟ್ ಇದೆ. 302 ಇದೆ.
ಆರೋಪಿ 1 ಶಿವಕುಮಾರ್ ಅಲಿಯಾಸ್ ಶಿವ ಅಲಿಯಾಸ್ ಡೇಂಜರ್ ಶಿವ ಅಲಿಯಾಸ್ ಬೇಡ ಬಿಡಿ.
302 ಎರಡು ಒಂದು
this complainant admit ಮಾಡ್ಕೊಂತ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಏನು ನೀವು ಡೇಂಜರಸ್ ಅಂತ?
Not dangerous ಅಂತ ಅಲ್ಲ.
302 ನೇ 3 ಇದೆ.
Political pressure ಇಂದ ಅದು
No,
complaint
sir.
ಕೊಟ್ಟಿರೋದು ಸ್ವಾಮಿ.
Political pressure. Nothing. ಇದ್ರಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಮಾಡಲ್ಲ ನಾನು. ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ 15 ದಿನನೂ ಆಗಿಲ್ಲ.
Kindly have it on tomorrow, my lord. My senior.
ಗಾಯಗೊಂಡು ಚಿಕಿತ್ಸೆ ಎಲ್ಲ ಇದೆ. ಏನ್ ಥ್ರೆಟನ್ ಮಾಡಿದ್ದೀರಾ ಕಂಪ್ಲೇಂಟ್ಗೆ?
No, my lord.
ಮತ್ತೆ
He is voluntarily coming, my lord. ನಾವು ಇಂಟಿಮೇಟ್ ಮಾಡಕ್ಕಾಗ್ಲಿಲ್ಲ. ವಿತೌಟ್ ಅದು ನಾಳೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಅಂತ. Otherwise, complainant and accused both will be before this honorable.
He has already been convicted for 10 years in earlier.
My lord, kindly have it on tomorrow, my lord. Both
ಆಯ್ತು,
the parties
ತೊಂದರೆ
will
ಇಲ್ಲ.
be.
ಸೆಟಲ್ಮೆಂಟ್ ಅಂದ್ಕೋಲ್ಲ, ಮೆರಿಟ್ಸ್. ಕಮ್
Kindly
ಆನ್
have it on
ಮೆರಿಟ್ಸ್.
tomorrow, my lord. Please.
ನಾಳೆ ಆಗಲ್ಲ. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಡೇ ಆಫ್ಟರ್ ಫ್ರೈಡೆ.
Grateful.
26 ಕೇಸ್ ಇದೆ. ಸೆಟಲ್ಮೆಂಟ್ ಹೆಂಗಾಗುತ್ತೆ? ಆಗಲ್ಲ. ಎಲ್ಲ 307 ಕರೆಕ್ಟ್ ಆಗಿ ಹೆಸರಿಟ್ಟಿದ್ದಾರೆ ಲೊಕ್ಯಾಲಿಟಿಲಿ. ಡೇಂಜರ್ ಶಿವ. ಎಸ್.
Grateful. Parted matter. Serial number 111 parted matter.
ತಗೊಂತೇನೆ ಒಂದು ನಿಮಿಷ ವೇಟ್. ಮುಗಿತಾ 230 ಇದು? ಯಾವ್ದು ಪಾರ್ಟೆಡ್ ಏನು? ಯಾವ್ದು ಮೇಡಮ್? ಇದು ಥರ್ಡ್ ಲಿಸ್ಟ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Number 3. Fresh matter still number 1.
Prithvish.
Appear for the petitioner, my lord.
ಇದು
Wildlife
easy
Protection
act la?
Act. Wildlife Protection, yes, my lord.
Wildlife protection.
Yes, my lord.
Yes, Jagdish. File ilva?
This is the case, my lord, that they are raising a
True, sir.
contention that cognizance was taken and further.
Cognizance is not taken.
This case
It
cognizance
is
is not taken.
covered by my order.
Oh, it's not covered by.
I have challenged only WLR.
We'll see. Sachin ಜೊತೆ ಕನೆಕ್ಟ್ ಆಗಿರೋದಲ್ವಾ ಇದು?
Yes, my lord.
ಇನ್ನೊಂದಿನ ತಗೋಣ. Well, 6th, 7th April.
Please, deeply.
Entry models would continue. Raghunath.
Number 2.
ಏನು ಇಡಿ ಇದೇನು?
Impugn by the issuance of section 50 PMLA notice.
ಸಮನ್ಸ್ ಹೆಂಗ್ ಚಾಲೆಂಜ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Lord, it is completely vague, my lord.
ಸಮನ್ಸ್ ಯಾವಾಗ್ಲೂ ವೇಗೆ.
Bereft of any foundational facts. No material.
Division bench has held it can be done ಅಂತ.
Lord,
Summons cannot be challenged.
Lord, some foundational facts, my lord. Be it the predicate offense, the crime number, or Lord, absolutely nothing on that. My lords may kindly peruse me. At ink page 21, my lord.
ಅಲ್ಲ ಅದು ಹಂಗೆ ಇರೋದು ಸಮನ್ಸ್ ಫಿಲ್ ಇನ್ ದಿ ಬ್ಲಾಂಕ್ಸ್ ಇರೋದು ಯಾವಾಗ್ಲೂ.
Basis of allegations, my lord, I'm not disputing.
ಈ ಸಮನ್ಸ್ ಇರೋದೇ ಹಿಂಗೆ ಫಿಲ್ ಇನ್ ದಿ ಬ್ಲಾಂಕ್ಸ್ ಇರೋದು.
Although, my lord, registration of ECIR is not mandatory. Some reference to predicate offences. As
ಇದೇ
to why, my
ಕಷ್ಟ
lord,
ವಿಲ್ಸ್. ಎನಿವೇ ಐ ಹ್ಯಾವ್ ಮೈ ಸೆಲ್ಫ್ ಹೆಲ್ಡ್ ಇನ್ ದಟ್
please.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕನ್ಫರ್ಮ್ ಮಾಡ್ತಾರೆ ಇದೇ ತರ. ವೇರ್ ಇಸ್ ದ ಜಡ್ಜ್ಮೆಂಟ್?
Lord, right now, my lord.
ಚೀಫ್ ಮಿನಿಸ್ಟರ್ಸ್ ಇದು.
Please, the Parvati is.
Yes.
This is the.
That Supreme Court has affirmed it.
Please.
ಇದರಲ್ಲೇ ಐಡೆಂಟಿಕಲ್ ಸೇಮ್ ಸಮನ್ಸ್.
Please.
Anyway, you serve on Madhu Rao.
I'll do that.
I'll take it on Friday.
Kindly.
ಯಾವತ್ತಿದೆ?
No precipitate.
ಯಾವತ್ತು ಕರೆದಿದ್ದಾರೆ?
Lord, they've been continuously, my lord, they've been.
List the matter on 1st April in the fresh matters list. The petitioner shall serve set of papers upon.
I undertake.
ಏನ್ predicate offense ಏನು?
Lord, KPID Act.
ಕಷ್ಟ.
Statutated and it's been attached.
ಅದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
Not stayed, my lord. But
We'll see. Yes.
the attachment has already been taken by the competent authority.
Let's see. Yes. Difficult to sustain the challenge. Anyway, list the matter on 1st April. Madhu and Rao is directed to accept notice for the respondent. The respondent enforcement directorate shall not precipitate the matter till the next date of hearing.
Highly grateful.
Yes, sir. ಅವತ್ತಿಗೆ ಅಷ್ಟೇ
Please.
ಕಷ್ಟ. ಡಿವಿಷನ್ ಬೆಂಚ್ ಬರೆದಿದೆ. ಕಾಂಟ್ ಚಾಲೆಂಜ್ ಸಮನ್ಸ್.
Please.
Yes. Fresh matters on 1st April. Let's continue. ಮುಗಿಸ್ಬೇಡ.
Let's to continue. Admission 41.
ಇದು ಇವತ್ತು ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇನ್ನೊಂದಿನ ಮಾಡೋಣ. That is on 1st April. Yes.
Did we take up?
Next is 1st April only.
4th at least.
ಆಯ್ತು 4th fine.
Please.
42.
Petitioner.
Extension of stay na.
Last occasion,
Last occasion ಏನಾಯ್ತು?
for the coordinate bench, please lordship, I have requested the adjournment. The adjournment was granted, and again the adjournment is not extended. Sorry,
Adjournment is not extended.
Sorry, interim order is not extended. Interim order is extended, and again the interim order is not extended. It is written in the order sheet, please.
Yeah, by specific order, interim order is not located. The coordinate bench of this court on 26/9/2023 had granted an interim order. The
Appearing for respondent number 2, my lord.
has appeared before. Is both learned counsel state settlement ga.
ಇಲ್ಲ ಅದು ಫಸ್ಟ್ ಸೆಟ್ಲ್ಮೆಂಟಿಗೆ ಹೋಗಿತ್ತು ಸ್ವಾಮಿ ಆಗ್ಲಿಲ್ಲ.
As a last chance list on 24/6 interim order grant earlier extended to the next date. Yen last chance? What last chance?
For settlement.
498 ena.
498 against the in-laws.
Yen come on merits.
In this case, please, Lordship.
Huh?
The charge sheet was filed, please, Lordship.
I think interim order extension my date point number. List the matter on 2nd April. For admission, interim order granted on 26/9/2023 shall stand extended till the next date of hearing.
Grateful.
43.
Challenging the Sessions Court order, where Sessions Court has held there no linkage with UAPA provisions has been invoked.
Stay in illala.
Namde petition.
Huh?
Namde
petition. Elli SP? Oh, correct. Yes. Notice ಮಾಡಿದಿರಾ?
Notice ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
ಕೊಟ್ಟಿರೋದು ರೆಂಟ್ ಕೊಟ್ಟಿರೋದು ಬಿಲ್ಡಿಂಗ್ PFI. List on no representation by of the respondent. List the matter on 8th April. Yes, next.
Appear for petitioner, my lord. Appear for petitioner, my lord. What is
IO? Yes, next.
Compromise. Swami, compromise ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ. Kindly have done second.
Compromise.
Yes, my lord. 376.
List the matter on 16th April to report settlement.
Swami, see 2 or 6.
Huh?
Yep. April 2nd or 2nd, my lord.
April 2nd document. Yes, April 2nd.
Kindly extended stay. 44, my lord. Serial number 44.
Oh, yes, sir.
Kindly extended
45 for the second respondent.
Interim order there.
It's against the parents and brother. Charge sheet is already filed against the first accused, and I had withdrawn with respect to first petitioner.
Interim order.
Nothing.
Last week, my lords have made the order.
Oh, your observation. You are not present, is it?
Sorry.
Adhan delete ಮಾಡೋಣ. ಅದು no representation ಅಂತಿದೆ ಇಲ್ಲಿ ತೆಗೆದ್ಬಿಟ್ಟು list the matter on 8th interim order subsisting will continue to the next date. Re-upload ಮಾಡಿ. Yes.
46. Interim order.
It may be delinked, my lords, minus 46.1. It may be delinked.
Offense ಏನು?
471, 468. Only on the basis of self-incrimination. Voluntary statement ಮೇಲೆ confession statement ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ. Already there is a stay, but it may be delinked because he is a beneficiary. I'm the officer who has passed an order. Ours is, grounds are totally different. Only for the crime number, I think they have connected it.
All right, yes. Interim order ಇದೆಯಲ್ಲ? ಎಲ್ಲ 8th ಹಾಕಿ ಮೇಡಮ್. ಯಾವ ವರ್ಷದ 24 ಅಲ್ಲ? 8th ಹಾಕಿ. 8th April.
47.
Maybe delinked.
ವೈ ಅವತ್ತು ನೋಡೋಣ.
ಯಾಕಂದ್ರೆ ಅವ್ರದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಏನು ಹಾಕಿಲ್ಲ.
ಆಯ್ತು ನೋಡೋಣ. ನಿಮ್ ಕೇಸ್ ನಿಮ್ ಸ್ಟ್ರೆಂತ್ ಅಷ್ಟೇ.
47. Interim order.
Same date. IO. ಯಾರು ಇಲ್ಲ ಅಲ್ಲ? 48.
Sorry, not appear for the
petitioner.
48.
Arun will take it on 8th.
8th order.
That will continue, sir. Yes.
For petition, my lords.
Vacating stay ನೀವೇ ಹಾಕಿರೋದಾ?
ಅವ್ರದ್ರಲ್ಲಿ.
Yes. Next.
48.
Appear for petition, my lord. Raise for a shock accommodation, my lords. Date may be fixed.
Interim order ಇದೆಯಾ?
Please, my lords.
Same 2 weeks.
Date may be fixed, my lords.
ಇದು 2 weeks ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್. Yes. IO. Next.
49.
Appear for the respondent. Appearing for the petition in this matter.
BB. ಕೊಡಿ.
Lord. For the respondent. Kindly have it tomorrow or not?
Tomorrow? Yes. Tomorrow ಆಗಲ್ಲ. Day after tomorrow.
Please.
ಏನು?
The trap is unsuccessful. There is no
Failed
demand. There is
trap.
no. Yes, it's a
Sorry.
failed trap. No, my lord. It's a failed trap. Dinner will argue, my lord. 2, there was no work which was pending on his file.
ಅದು
3, there is no demand.
List day after tomorrow in the fresh matters list. If it's failed trap, we'll consider.
Please.
Next.
50.
Refer for the respondent, my lord, 50.1, my lords. The dereliction of duty, my lords.
Huh?
Dereliction of duty, we need some.
Idu 7 na?
This is combination of both public servants as well as common general public.
Intermodal ideyalla?
Okay, there is an intermodal.
16th.
Public.
IO.
Please.
51.
Appearing for the petitioner, madam. Seek a week's time.
16th. Yes, IO.
Order may be extended.
52. Interim.
ಇದು ಅರ್ಜೆನ್ಸಿ ಮಾಡ್ತಾರಲ್ಲ ಎಲ್ಲಿ ಇವತ್ತು ಇಲ್ವಾ?
Lordships ಇದ್ದಾರೆ ಕೊಟ್ಟೋಲ್ 18 ಅಲ್ಲಿ ಮ್ಯಾಟರ್ ರೀಚ್ ಆಯ್ತಲ್ವ?
ಆಯ್ತು ಬರಕ್ಕೆ ಹೇಳಿ. ಅವರೇ ಅರ್ಜೆಂಟ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
Please no, your lordships. He was present, your lordships. Matter reach ಆಯ್ತು ಅಂತ ಮಾತ್ರ ಹೋದ್ರು ಸ್ವಾಮಿ. Because he was not. It's already been 5 and matter reach.
Oh, I should not sit after 4:45.
There's
Yes.
nothing like that, your lordships.
All right. Sorry.
It may be taken up in April 1st week.
8th. Huh?
ಇಲ್ಲ ಸ್ವಾಮಿ, not the matter ಇದ್ರೆ matter ಗೆ first preference ಕೊಡ್ತಾರೆ.
ಆಯ್ತು 8th. Yes.
Grateful.
4 o'clock. Entry ಮಾಡಿ. 4 o'clock. ಯಾಕೆ ಅಷ್ಟೊತ್ತಿಗೆ ಬೇಕಾ ನಿಮ್ಗೆ? 4 o'clock ತಗೊಳ್ಳಾ?
Please.
ಆಯ್ತು 4 PM and 8th. ಮತ್ತೆ ಅದು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ I'll dismiss the vacating stay applications.
53.
ಇಂಪಾರ್ಟೆಂಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಯಾಕೆ ನೀವು ಬರ್ತಾ ಇಲ್ಲ? ಬರ್ಬೇಕಲ್ಲ.
Lordships ಇದ್ರು, your lordships.
4 PM. 50?
53.
Yes.
Interim order is there.
Vacating stay is there, sir.
Respondent 2 was filed.
Vacating stay ಯಾರು ಹಾಕಿರೋದು ನೀವಾ?
Number 2, okay.
Then post it on 8th and for admission. Interim order continues till then.
Covered by my lordship
ಏನು?
judgment.
Offense.
Someday judgment.
Offense.
323 and 506.
323, 506.
Brothers and
List the matter on
civil dispute ಇದೆ.
first on 2nd April in the fresh matters list.
Please.
ಮುಗಿಸ್ಬಿಡೋಣ ಅವತ್ತು. ಚೊಂಬಾ
ಚೊಂಬು ಏನೋ
ಚೊಂಬ್ ಮ್ಯಾಟ್ರಾ?
ಚೊಂಬು ಅಂದ್ಬಿಟ್ಟು ಚೊಂಬೆ ಸಿಗ್ತದೆ. It's not ಚೊಂಬು ಮಲ. Some sort of metal, rare metal.
ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ.
Some sort of rare metal, my lords.
ರೇರ್ ಮೆಟಲ್.
ಅಷ್ಟೇ, my lord. I don't know what they have given for the trading.
ನೀವೇ ಫಸ್ಟ್ ಹೇಳಿದ್ದು ಇದೊಂದು ಚೊಂಬು ಎಕ್ಸ್ಪೆರಿಮೆಂಟ್ ಮಾಡ್ತಾರೆ.
Government said that. ಏನೋ ಚೊಂಬು ಸಿಕ್ಕಿದೆ ಅಂತ.
ಓ ಚೊಂಬು
I
ಸಿಕ್ಕಿದೆ.
never said.
ಅಲ್ಲ ಚೊಂಬು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಹೇಳಿ.
No, my lord.
ಈ ಮೆಟೀರಿಯಲ್ ತೋರಿಸಿ ಚಂಪ್ ಮಾಡಿದ್ದಾರೆ, ಚಂಪ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಚಂಪ್ ತೋರಿಸಿದ್ದಾರೆ.
They recovered some chombu in this.
Chombu?
No, that. And charge sheet not at file, my lord. And there is no stay also.
Interim order ಕೊಟ್ಟಿದ್ದೀನಿ ಮೇಡಮ್.
Not to file the charge sheet. Now they prepared the charge sheet only on the basis of accused number 3 and 11, my lord.
There's lot of siphoning of funds. ಎಷ್ಟು crores ಹೇಳಿದ್ರಲ್ಲ? ಎಲ್ಲಿ?
So far as I have concerned, ಇಡೀ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ನಂಗೆ ಇಷ್ಟು ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಾನು ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. ಎಂಟೈರ್ ಕಂಪ್ಲೇಂಟ್ 5 ಪೇಜ್ ಕಂಪ್ಲೇಂಟ್ ಬರೀತಾರೆ. ಪ್ಯಾರಾ ನಂಬರ್ 4ರಲ್ಲೇ ನನ್ ಮುಗ್ದೋಗತ್ತೆ. ನನ್ನನ್ನು ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದು A1 ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ.
You are A3.
A3 ಮತ್ತೆ A11. ಎಂಟೈರ್ ನನ್ನ ಅಕೌಂಟಿಗೆ ಹಾಕಿದೀನಿ ಅಂತಾನು ಹೇಳಲ್ಲ. A7
ಎಷ್ಟು ಅಮೌಂಟ್ ಬಂದಿದೆ ಅಕೌಂಟಿಗೆ?
ಅಫಿಷಿಯಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಏನು ಮಾಡಿಲ್ಲ.
ಅನ್ಅಫಿಷಿಯಲ್ ಆಗಿ ಬಂದಿದ್ಯಾ?
ಅಲ್ಲ, ನೋ ಮೈ ಲಾರ್ಡ್, ಎಂಟೈರ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿರೋದು ಪರ್ಸನಲ್ ಅಕೌಂಟ್ಸ್ಗೆ. 7 ಮತ್ತೆ 9
ಆಯ್ತು. ಪರ್ಸನಲ್ ಅಕೌಂಟ್ಗೆ ಎಷ್ಟು ಬಂದಿದೆ?
ನನ್ನ ಅಕೌಂಟಿಗೆ ಎಕ್ಸಾಕ್ಟ್ ನಂಬರ್ ಗೊತ್ತಿಲ್ಲ, ಬಟ್ ಇಟ್ ಇಸ್ ಇನ್ ಅ ಲ್ಯಾಕ್ಸ್, ನಾಟ್ ಇನ್ ಅ ಕ್ರೋರ್ಸ್.
50 lakhs they received A3.
A3 ಪರ್ಸನಲ್ ಅಕೌಂಟ್ಗೆ.
ಹೌದು.
From whom?
Total ಮೇಲೆ 30 crores.
30 crores.
Yes.
30 crores total, not ಇವ್ರಿಗಲ್ಲ.
ಅಲ್ಲ,
ಎಂಟೈರ್ ಅಲ್ಲಿರೋದು.
ಇವ್ರಿಗೆ 50 ಲಕ್ಷ ಬಂದಿದ್ಯಾ?
ಇಲ್ಲ ಮೇಲೋರ್ 5 ಲಕ್ಷ 50 ಅಂತ ಹೇಳ್ತಿರ್ಬೋದು.
ಒಂದು zero ವ್ಯತ್ಯಾಸ ಆಗಿದೆ ಅಂತ.
ಎಕ್ಸಾಕ್ಟ್ಲಿ ಮೇಲ್.
ಚೊಂಬಲ್ ಸ್ವಲ್ಪ ಹೆಚ್ಚು ಕಡಿಮೆ.
ಇದ್ರಲ್ಲಿ ಒಂದೇ ಒಂದು ಐ ವುಡ್ ಲೈಕ್ ಟು ಬ್ರಿಂಗ್ ಟು ದ ನೋಟಿಸ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್. ಅಕ್ಯೂಸ್ 7, 9 ಅವರಿಬ್ರದ್ದು ಅಕೌಂಟ್ ಫ್ರೀಸ್ ಆಗಿದೆ. ಎಂಟೈರ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅವ್ರ ಪರ್ಸನಲ್ ಅಕೌಂಟ್ಗೆ ಆಗಿರೋದು. 10 ಲಕ್ಷ, 20 ಲಕ್ಷ, 30 ಲಕ್ಷ, ಈವನ್ ಬೆಳಗಾಂ ಎಲೆಕ್ಷನ್ಗೂ ಅವ್ರು ದುಡ್ಡು ಇಸ್ಕೊಂಡಿದ್ದಾರೆ. ಅಕ್ಯೂಸ್ 7 and 9 ಎಲ್ಲೂ ನಾನು ಇಷ್ಟು ದುಡ್ಡು ಇಸ್ಕೊಂಡಿದೀನಿ ಅಂತ ಎಂಟೈರ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಒಂದೇ ಒಂದ್ ಲೈನ್ ಇಲ್ಲ. ಆದರೆ
one- one-
ಇವತ್ವರೆಗೂ ಅರೆಸ್ಟ್ PC ಜೆಸಿಲ್
ನಿಮಿಷ.
ಇದ್ದಿದ್ ನಾನ್ ಮಾತ್ರ.
Anita madam, who is the complainant? What is the relation between you and the complainant?
Nothing. I never had any relationship. Accused number 1, 3,
What is the
7.
transaction between you and the complainant?
Nothing.
Yes, Jagdish.
I'll place the entire material, my lord.
Go to get the entire material. Anyway, I have directed not to file the charge sheet alla.
My lord, there is the last occasion you have permitted to file the charge sheet.
ಹೌದಾ?
ಹಾ.
ಎಲ್ಲಿದೆ? ಇಲ್ಲ.
And on 15/3 pass
Oh,
over
liberty to
ಮಾಡ್ತಾರೆ
challenge them.
ಟ್ರಯಲ್ ಅಲ್ಲಿ
ಈಗ
ಪಾಸ್ ಓವರ್
ಹಾಕ್ಬಿಟ್ಟಿದಾರಾ?
ನೋ ಹಾಕು ಇಲ್ಲ. LOC ಬೇರೆ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ನಾನು ರಿನ್ಯೂವಲ್ ಗೆ ಬಂದಿದೆ.
ನೀವು ಎಲ್ಲೂ ಹೋಗ್ಬೇಡಿ ಇರಿ.
ಅಲ್ಲ ನಾನು ಬಂದೇ ಇಲ್ಲ ಇಂಡಿಯಾಗೆ.
ಎಲ್ಲಿ? You are in Malaysia, is it?
No, I'm in Dubai. Now I can't even come.
Now you can't.
But now the problem is ನಾನು ರಿನ್ಯೂವಲ್ ಪಾಸ್ಪೋರ್ಟ್ಗೂ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ ಅದೆಲ್ಲ ಮಾಡೋಣ.
And I have placed one
place all the investigation material.
till then stay, my lord.
1 minute. They
ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೆ ತಾವು ನೋಡಿದ್ರಿ. I'll place the entire now charge sheet seems to have, I'll check
My
now
lord,
the charge sheet.
they learned
Vargu they have not arrested any of the accused.
arrested.
Any of the accused.
Bail ತಗೊಂಡಿಲ್ವಾ?
ನಾನ್ ಬೇಲ್ ತಗೊಂಡಿದ್ದೀನಿ. ನನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಜೆಸಿಲ್ ಇದ್ದಿದ್ದು ನಾನು, ಪಿಸಿಲ್ ಇದ್ದಿದ್ದು ನಾನೇ.
One moment madam.
12 ಜನದಲ್ಲಿ ಯಾರನ್ನೂ ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ಲ.
Additional SPP to secure the entire records and place it before the court. This court on 5/3/2026 had passed the following order. Instructions be sought whether the charge sheet is placed before the concerned court as liberty was granted. In the event it is not filed as on today, the same shall not be filed till the next date. List on
The lordship is berated us because last time I made a submission.
ಮತ್ತೆ ಯಾಕೆ ಹಾಕಿಲ್ಲ?
I'll check. I don't know whether it filed.
My
or
lord,
not.
one more
if
submission.
not filed ಅಂದೆ
My lord, one small submission, my lord. ಇಬ್ರು ಅಕ್ಯೂಸ್ ನ ಇಟ್ಕೊಂಡು ಚಾರ್ಜ್ ಶೀಟ್ ನ ಎಂಟೈರ್ ಎನ್ಕ್ವೈರಿನ ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ದಾರೆ. ಬೇರೆ ಯಾರು ಸಿಕ್ಕೇ ಇಲ್ಲ.
Wait, let me see the charge sheet.
It is
Produce all the
1800
material.
pages they said.
Produce all the
Just ಹಾಕಕ್ಕೆ ಹೇಳಿದ್ರೆ ಅದು ಹಾಕಿಲ್ಲ.
I'll check, my lord. I think it filed. I'll verify.
No, my
Just
lord,
check.
it is
Wait.
not filed.
Wait, madam. Yes. List the matter on first Akla,
ಆಗ್ಬೋದು.
1st April, fresh matters list. Yes.
Date will-
Next.
55.
Moved for? Yes. The petitioner has moved the matter seeking to withdraw the petition, disposed in terms of, the matter is disposed as withdrawn. Next.
56.
For the petitioner, my lord. Lord,
ಎಲ್ಲಿ ಇವರಿಲ್ಲ?
last time ಬಂದಿರಲಿಲ್ಲ.
ಹೇಳಿ ಏನು ಅಂತ.
Lord, offense under section 75, 79 and 351, my lord.
75, 79.
Section 75, 79, 351 clause 2, 352 and 3 clause 5, my lord. Sexual harassment, criminal intimidation, my lord. My lord, admittedly, this complaint is filed on 23/7/2025. The petitioner, my lord, joined the company on probation, my lord, on 14/4/2025. Lord, it was on probation she had joined for 6 months. My lord, we got a feedback, my lord, and a mail was sent to her. And we said, my lord, there is an unprofessional behavior and she is loud. And is loud in the office. And
Loud
she-
in the office.
Loud in the
Ah,
office.
yes.
And she uses abusive language. And my lord, we have produced it as Annexure D. That is the report, my lord, which was issued. Now, my lord, subsequently, we terminated, my lord, around 23/6/2025. My lord, this termination, my lord, is produced as Annexure E. After the termination, my lord, she writes a letter to the Labour Commissioner complaining about us. In the complaint also, my lord, no allegation of sexual misbehavior is there. She just says, as per Annexure F, your lordship may kindly turn to Annexure F. She writes a complaint that I have been terminated without giving notice. Other than that, my lord, there is no complaint at all. Now, after all this, proceeding starts, my lord, on 9/7/2025 before the Labour Commissioner. Subsequently, my lord, she files a complaint after on 14/4/20 on, my lord, 23/7/2025. That is almost 1.5 months, my lord, later. Now, if your lordship kindly sees the complaint, the complaint is against 3 persons who are working in the office. The complaint, my lord, FIR is at, my lord, page 25. The allegations, my lord, against the petitioner number 1 is that, my lord, that I have made sexually colored remarks. Then, my lord, as far as petitioner number 2 is concerned, my lord, she says that I
Heard
have.
the learned counsel Bipin Hegde appearing for the petitioner. The respondent party in person was not present on the previous occasion. Awaiting the appearance, the matter was awaiting the appearance, the court passed an order on 23/1. The court passed the following order on 23/1/2026. Again, on 26/2/2026, the matter was listed, and today, and on 11/3/2026, the respondent party in person has remained absent throughout. The learned, therefore, the counsel for the petitioner is heard. The learned counsel appearing for the petitioner would take this court through. The petitioners are before, petitioners accused
1 to 3 months.
1 to 3 are at the doors of this court calling in question the registration of a crime in crime number?
Lord,
in crime number 303 of 2025 registered for the following offenses priorly there. The fulcrum of the allegation, it is the case of the complainant that she joins the service on 14/4/2025 as assistant manager in a company by named Resource Pro Private Limited, where the present petitioners were also co-employees. Co-employees, office bearers.
Office bearers.
Office bearers. Owing to certain conduct of the respondent, it transpires that the second respondent gets terminated from service. The termination is questioned before the Labour Commissioner, alleging certain misgivings in the management of the Resource Pro Private Limited. The learned counsel submits that there was no allegation with regard to sexual harassment at any time meted out, meted out against the complainant made at any time before the Labour Commissioner. On 23/7/2025, the subject complaint comes to be registered before the jurisdictional police, alleging offences punishable under section 75 and 79 of the BNS, which would touch upon sexual harassment of the complainant. A perusal at the ingredients would, a perusal at the complaint would not meet the ingredients that are necessary to drive home an offence, drive home an investigation even for the offence under section 74. What is alleged is sexually colored remarks. However, the complainant remains absent throughout. In order to grant one last opportunity to the complainant, list the matter on 8th at 2:30 p.m. for further hearing. In the event the complainant is not present, orders would be passed on hearing the petitioner. Yes.
In fact, the complaint before the Labour Commissioner also has been closed.
The learned counsel for the petitioner at this juncture submits that the complaint made before the Labour Commissioner is also now closed for want of tenability. Yes.
57.
Petition to quash 138 proceedings. Your Lordship is directed to serve the copy on the.
Sir, ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ.
ಯಾರು ಬಂದಿಲ್ಲ?
My lords.
Then we'll post it on first in the fresh matters list. Next date ಏನು? Next date ಏನು? ನೀವಿದ್ದೀರಾ?
ನಂದು ಮ್ಯಾಟ್ರ್ 4 ಸಾಟರ್ಡೆ ಬರ್ತದೆ ಅದು.
ಓ, ಈಗ ರಿಯಲೈಸ್ ಆಯ್ತಾ?
ಅಂತ ನೋಡಿದೆ ಬೇರೆ ಮ್ಯಾಟ್ರ್. Could it be taken as?
ಅದು ಬೇರೆ ದಿನ ಕೊಡ್ತೀನಿ.
7th my lord, 7th play.
It's in the first week of April, my lord.
First week of April. List the matter on 1st of April.
Please.
In the event there would be no representation, this court would be constrained to grant an interim order. Next.
498A, Your Honor. After issuing legal notice by the accused number 1, the complaint has been
That ground is not available, madam. 2, 3, 4. ಯಾಕೆ ಸ್ಟೇ ಆಗಿಲ್ಲ?
This is first time reaching the matter.
ಫಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ, ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಮುಂದೆ 2 ಸರಿ ಬಂದಿದೆ.
ಬಂದಿದೆ ಸ್ವಾಮಿ, ಬಟ್
ನೀವು ಹೋಗೋದೇ ಇಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ.
ಇಲ್ಲ ಇಲ್ಲ Your Honor.
Husband is not before the court?
No, Your Honor. Only parents and sister.
The petitioners are accused 2, 3 and 4 are alleged of offence punishable under section 85 inter alia. A perusal at the summary of the charge sheet would indicate all the offences, horrendous enough they are against the husband accused number 1. In that light, there shall be an interim order of stay of further proceedings qua these petitioners till the next date of hearing. 1 additional HCGP 2 emergent notice. Next.
59.
Offense under 138, my lords. Our only ground, my lords, is that they have suppressed a crucial date in order to meet the statutory timeline under 138, my lords.
Well, how do you demonstrate the crucial date?
If my lords permit me.
Not here. You produce it there. I'll direct the court to consider it.
My lords, that issue is decided, my lords. That is in the impugned order. The learned magistrate disregards our argument that entire point on the date being suppressed, and thereafter says that it is only a small delay, therefore it is being condoned.
Yes,
Not in the 11 days, my lords. That is
2 days is the delay, my lords.
2 days
So,
delay.
It is not
filed for condonation of delay.
Application hakidira.
And that has been considered.
Well, application is allowed.
It is allowed, my lords.
Anything
My lords,
else,
that
sir?
is one aspect of it, my lords. The other aspect is that they have provided the reason for condonation of delay that is provided is subsequent. May I just draw my lord's attention to a
Yen
list
reason,
of
sir?
dates. My lords, they say they have undertaken a religious pilgrimage, my lords.
Oh, so what?
That pilgrimage is undertaken after the period of delay, my lords. It is not.
Preparation for pilgrimage.
But my lords, they also say that it was filed.
I will observe that it was only preparation pilgrimage.
My lords.
No, sir.
My lords, if they were going
Quite
to
on
seek,
merit, sir. What is all this?
certainly, my lords, I will leave it to my lords, but that reason that they should have provided, they have disregarded, my lords, the date on which the reply to the notice is.
ಎರಡು ದಿನ ಅಲ್ವಾ? ಎರಡು ದಿನ.
11 ದಿನ ಆಗತ್ತೆ ಸ್ವಾಮಿ. It is not.
ಆಯ್ತು 11 ದಿನನೇ ಇಟ್ಕೊಳ್ಳಿ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರಲ್ಲ.
May I make then one request, my lords, on a subsequent date, by order dated 27th October last year, cognizance take, may my lords be provided kindly liberty to challenge that order. my lords.
Whatever.
Cognizance
Learned
is
counsel for
granted.
the petitioner seeks leave of this court to withdraw the petition and raise a challenge to the order of cognizance that is taken by the concerned court. Reserving such liberty, disposed. Next.
61 also, my lords.
Same. Yes.
60.
Yes, for second respondent. In this case, husband also granted stay, please lordship.
60. ಹಸ್ಬೆಂಡ್ಗೂ ಕೊಟ್ಬಿಟ್ಟಿದೀವ?
ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾನೇ ಕೊಟ್ಟಿರೋದು.
Coordinate bench, please.
Coordinate bench.
ಇದರಲ್ಲಿ my humble submission, please lordship. He has issued a legal notice on 3/10/2020.
Legal notice argument ಬೇಡ, ಬೇರೆ ಏನಿದೆ ಹೇಳಿ.
There is a specific allegation against the husband and in-laws also, please lordship. Now the FIR registered, immediately the stay was granted. The statement only.
We'll see. There is no representation on behalf of the petitioner. As a last chance, list the matter on 2nd April. In the event the petitioner would not be present, interim order would be vacated. Next, yes.
Grateful.
Subject to the condition petition, interim order stands extended. Yes, next. 60?
2 laws.
Alteration of charge. 216 CRPC challenge, man.
On the alteration of charge, yes. List on 16th. Next.
63.
63, 64.
Please.
In LGC.
LGC. What has happened here, my lords, I have been in possession of this property since 1998, built a house. The allegation is that there is a Raj Kalwe. Surveys were conducted which are challenged before this.
LGC proceedings, what ground?
On the ground that there is B Kharab and I have built upon a Raj Kalwe and I am in.
How can I examine that in
My lord,
482?
there is a judgment of the coordinate bench of this honorable court. Annexure J, page 93, where this honorable court has held that there is no B Kharab or Raj Kalwe passing to the survey numbers. And on the same ground, the LGC case is initiated.
Same petitioners, huh?
Same petitioners.
Heard the learned counsel Kamala Charan appearing for the petitioner. M1 HCGP 2 Urena 1 HCGP 2 HCGP accepts notice for both the respondents. The learned counsel for the petitioner submits that the coordinate bench of this court has clearly held that the land of these petitioners did not encompass B Kharab, the land which belonged to the government. The said finding has become final. The crime emerges on this. The LGC proceedings are instituted on the same ground which the coordinate bench holds that there is no Kharab. In that light, there shall be an interim order of stay of further proceedings before the concerned court till the next date.
64.
Four, same, yes.
My lords, there are another 19 or 20 such petitions that are filed. My lord, maybe
ಕೊಡಿಯಲ್ಲ.
ಇಷ್ಟು. ಅದು ಕೆಲವೆಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹಾಕಿದೆ. Only
ಕಂಪ್ಲೈ
office-
ಮಾಡಿ.
ಇಲ್ಲ, ಅದು only office objection is you have made the state as respondent number 2, state is not required. My lords, that objection may.
ನೀವು ಬರ್ಲಿ ಬಂದಾಗ ತಾನೇ ಓವರ್ರೂಲ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ.
ಇಲ್ಲ, ಅದು ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಇದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ.
ಹಾ, ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ, ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ನಾ ಮಾಡ್ತೀನಿ. Yes.
55.
Order of externment, my lord, there is no nexus and proximity. The lordship may kindly come to page.
Externment completely covered by.
Yes, my lord.
Suraj Sabra order ಕೊಡಿ.
Your lordship's order. my
Not
lord,
mine. ಆಮೇಲೆ
No,
Suraj Jed has held something else. Covered by that, but
It is,
reason ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಗಾರಿಲ್ಲ.
He has to file an
Interfere
appeal.
ಆಗೋಂಗಿಲ್ಲ. ಜಡ್ಮೆಂಟ್ ನೋಡಿಲ್ವಾ?
Really, reasons illa, my lord. There is no,
Yeah.
kindly see, my lord, there is no application of mind at all. Lord, the all crimes, my lord, now only
You
two
look into
cases.
that judgment.
Subsequently, that my lord it came before your lordship, went up to writ appeal. Writ appeal also confirmed your lordship's order.
ಯಾವುದು?
Justice Suraj Govindraj Sabr's order na.
ಫಾಲೋ ಮಾಡಿ ಬರ್ದಿದ್ದೆ.
Maheshwari Timarodi's order.
ಕರೆಕ್ಟ್. ಇವ್ದು ತರನಂದ್ ಪೂಜಾರಿ ಅಪಿಯರ್ ಆಗಿದ್ದು.
It went up to division bench confirmed that order. It followed everything, my lord.
But in this case, my lord, there is no, two cases are pending.
ನೋ ಸರ್, ಅದೆಲ್ಲ ಬರೋದು ಜಡ್ಮೆಂಟ್ ನೋಡಿ. ಸೂರಜ್ ಅವ್ರದ್ದು ಜಡ್ಮೆಂಟ್ ನೋಡಿಲ್ವಾ? You look into Suraj Sab's judgment. He has completely analyzed the entire act. When the finest judgments written, you just see. ಏನು ಬಿಟ್ಟಿಲ್ಲ ಅದರಲ್ಲಿ. I'm just following that. I'm just following that order. ಅಷ್ಟೇ. I will follow that order even now. Dismiss.
Day after tomorrow.
ಆಯ್ತು, no problem. Friday. Fresh matters. Heard the learned senior counsel Arun Sham appearing for the petition. Get the, what homework do you do? You don't know that externment judgment ಅಂದ್ರೆ ಹೆಂಗೆ?
ಗೊತ್ತಿದೆ.
ನೋಡಿ. He is here. Vasad sir ಇರ್ಬೇಕಾದ್ರೆ you will get it instant. When the finest judgments written. In fact, I had written something contrary. That report should be given natural justice. All that is not necessary ಅಂತ ಬರುತ್ತೆ. Following Supreme Court judgments. So I was wrong there. He has corrected my error. Yes.
66.
Yes, sir, petition. Well, tomorrow. Yes.
Tomorrow?
The senior went to Mysore.
Mysore?
My lord, 66, I am appearing for the respond number 2, my lords. There are several
New Mysore
allegations,
leader.
my lord. No, my lords.
Yes. At the request of the council appearing for the petitioner. List on
Serial number 69 also.
8. ಅದು ಬರ್ಲಿ ತಾಳಿ. ನೀವು ಮೈಸೂರಿಗೆ ಹೋಗ್ಬೇಕಾ? ಇರಿ ಸರ್. ಎಸ್. Next.
67. Appear for the petition.
Time ಬೇಕಾ?
My lord, the stay was given on the condition that the
Grant.
petitioner appeared before the court.
You have appeared?
He's appeared this morning, my
How do you demonstrate that? Order sheet ಕೊಡ್ಬೇಕು.
lord. This morning he has appeared, my lord.
Fine. Yes, list the matter day after tomorrow in the fresh matters list. We'll close it. Yes. Get the order sheet.
68.
ಏನಾಯ್ತು? ಗೊತ್ತಾಯ್ತು. ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತಾ?
Settlement ಅಲ್ಲ, my lord, we have written, my lord, to the authorities, when now dispute is raised, and the dispute raised by the, my lord, petitioner can be allowed.
ಯಾವ dispute raised by the petitioner?
Like the allotting site to me, what we have said, my lord, that can be allowed, so that, my lord, I can reconvey, not back to them.
Well, stay ಆಗಿದೆಯಾ?
ಇಲ್ಲ investigation.
ಇದೇನು investigation continue ಆಗ್ಲಿ ಬಿಡಿ.
Lordships had asked, my lord, for the investigation papers to be placed before your lordship.
ಹಾ.
It's been 60 days, my lord, it's nothing.
ಜಗದೀಶ್ ಸರ್.
I'll place it. There are 2-3 other matters, my lord, everything can.
ಅಲ್ಲ ಇನ್ನೊಂದಿತ್ತಲ್ಲ?
The 30 your lordship was pleased to dispose of, so far as, my lord.
Oh, that is disposed, correct. 175
Formally,
follow ಆಗಿಲ್ಲ ಅಂತ. Anyway, ಇದರಲ್ಲಿ investigation papers ಕೊಡಿ. We'll take it on
Next week.
yes, first or second. First.
Or 7th or 8th.
No,
7th.
first.
ಬೇಡ, first investigation papers ಕೊಡಕ್ಕೇನ. Then I'll take it later on the next day or something. List the matter on first. The investigation papers as was directed be placed before the court on the next date. Heard so and so. Yes.
69.
I same of the Mysore go.
70.
Yes.
Yesterday, my lord,
7 A na?
7 yesterday, notice has been issued.
Yesterday?
Notice has been issued and the matter has been adjourned to 18th.
ಎಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ?
No, no, today, this
ಮತ್ತೆ
matter
ಯಾಕ್-
is discharged yesterday.
ಮತ್ತೆ ಯಾಕೆ ಬಂತು ಇವತ್ತು?
No, my lord,
18th ಹಾಕಿ ಮೇಡಮ್.
18th fresh matter.
List on 18th April. Yes. Next.
71 adjourned. 72.
70?
72 no.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ 2/6 ಸ್ವಾಮಿ. ನಿನ್ನೆ ಬಂದಿತ್ತು.
NBW ನಾ?
NBW
2/6 ಇದೆಯಾ?
26
ಅಪೇರ್ ಆಗಿದ್ದೀರಾ?
ಇಲ್ಲ, ಅಪೇರ್ ಆಗಿಲ್ಲ.
ಮತ್ತೆ ಯಾವತ್ತಿತ್ತು?
ಲಾಸ್ಟ್ ಮಂತ್.
ಸರಿ ಆಯ್ತು ನೋಡ್. List the matter and on the 3rd of June 2026. ಅಪೇರ್ ಆಗ್ಬಿಟ್ಟು ಬನ್ನಿ. Yes. Next.
73.
ಅರ್ಜೆಂಟ್ ಮಾಡಿ ಮೇಡಮ್ 2 weeks ಇಲ್ಲ ಅಂದ್ರೆ.
74.
ಹಾ.
74.2 million.
ಹ್ಮ್
74.2 million.
74 ಏನು ಇಂಟರ್ ಮಾಡಿದ್ಯಾ?
ಇದೆ ಸರ್.
Yes, 2 weeks ಆಯ್ವು. Next.
75.
For the petition matters, I have served the copy into the advocate.
ಇಲ್ಲ ಇದಾರಲ್ಲ.
ಇಲ್ಲ.
ಹ್ಮ್.
ಅಲ್ಲಿಂಗ್ ವಕಾಲತ್
138
Yes, ma'am.
ಏನು?
11 application.
311. Day after tomorrow in the fresh matters list, we'll dispose it. Registry to print the name of so and so as appearing for the respondent. Next. Yes.
76.
Offense under 376, my lords, false promise to marriage.
Enter ಮಾಡಿದ್ಯಾ?
ಹೌದು ಮಾಡಿದೆ.
ಸರ್ವ್ ಆಗಿ ಯಾವತ್ತಾಗಿದೆ ನೋಡಿ ಮೇಡಮ್? 23 ಇದ?
23, my lords, we have served, we have filed affidavit, done everything possible, my lords. My lords, the facts are like this, my lords. In 2015, complainant got married. In 2018, my lords, she meets the petitioner herein.
After marriage?
After marriage. From 2018 to 2023, both were in a relationship, petitioner as well as a complainant. The allegation is that, my lords, the petitioner persuaded the complainant to seek divorce so that they both can get married.
She sought divorce, huh?
She got divorce in 2021. That is subsequent to meeting, having a physical relationship with the petitioner herein. From 2018 to 2023 was the physical relationship, my lords, for 5 years. Subsequent to which she asked for the marriage, my lords. Petitioner, that is what the allegation is. Petitioner goes on to say that, my lords, mother is not accepting the said relationship. This is how the entire complaint springs, my lords. She goes on to file a complaint. My lords, squarely covered by your lordship's judgments. I'm placing 3 judgments of your lordships, my lords.
ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಲಮ್ ನಂಬರ್ 7 ಪೇಜ್ ನಂಬರ್
ಏನಿದೆ ಹೇಳಿ ಸರ್?
ಅಲಿಗೇಷನ್
ಏನ್ ಅಲಿಗೇಷನ್?
ಮೆಲಾಟ್ ಸಾಕ್ಷಿ 1ರವರ ಇಷ್ಟಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ
5 ವರ್ಷ 5 ವರ್ಷ ಇಷ್ಟಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ಸಾಧ್ಯವೇ?
ಡೀಟೇಲ್ಸ್ ಇದೆ ಮೆಲಾಟ್.
Yes, allowed cost.
Deeply.
In 10 days, I'm allowed.
Obliged.
Preliminary hearing 77. 14 proceedings.
ಏನಿದು?
Reinvestigation.
ಯಾವುದಕ್ಕೆ?
Atrocity Act ಇದ್ರೂನು false caste information ಕೊಟ್ಬಿಟ್ಟು IO has transferred it to the magistrate court.
Oh.
Directed last year.
Thereafter, I filed a complaint before the DCRE and DCVC has passed orders.
ಇದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಪ್ರಾಬ್ಲಮ್ ಏನಾ? ಎಲ್ಲಿ ನೀವು ಎಷ್ಟು ಮನೆ ಇದೆ ಒಂದೇನಾ?
308 ಫ್ಲಾಟ್ ಇದೆ.
308 ಫ್ಲಾಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಕೇಸ್ ಹಾಕಿದ್ದೀರಾ ಈಗ?
9-10 ಹಾಕಿರ್ಬೋದು.
9-10 ಹಾಕಿದ್ದೀರಾ?
ದಿನ ಮಾಡ್ತಾ ಇರ್ತಾರೆ, ನಾವೇನ್ ಮಾಡೋದು? ಕರೆಂಟ್ ತೆಗಿಯೋದು, ನೀರ್ ತೆಗಿಯೋದು, ಹೊಡಿಯೋದು.
ನಿಮ್ಗ?
Yes. ಅವ್ರಿಗೆ ಅಧಿಕಾರನೇ ಇಲ್ಲ
ಕರೆಂಟ್ ತೆಗಿಯಕ್ಕೆ. ಎಸ್ ಜಗದೀಶ್ ಸರ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಹೇಳಿದ್ನಲ್ಲ.
contention matter, the caste certificate, continue to be in a scheduled caste and get the record.
Get the records, yes. Further investigation ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
I will only think to see if he is.
ಇಲ್ಲ, reinvestigation because.
Further ಎಲ್ಲ. Yes. ಒಂದಕ್ಕೆ ತಗೊಳ್ಳ. 1st April, yes. Next.
78.
Okay, for the petitioner, my lords. In this case, the petitioner is a director of a company that rents bikes. He rented a bike to A3. A3 has been convicted. He pays a fine and he gets away.
You are the director of the company.
Please, my lords. I'm a director of the company. A3 then gives a bike to his friend who causes an accident. And the person riding the bike is A2. I've not been made an accused in the FIR. Only in the charge sheet, to a very limited extent, I've been recognized as a director of the company that is leased bike.
Who appears the respondent? Served. List on 27th in the fresh matters list. We'll dispose it.
17th, my lords.
Huh?
Oh.
You want 17th, is it?
17th April.
Huh?
17th. 27th Friday.
Yes.
Okay, great.
What 17th
Sorry,
you
I
want?
thought it was
April
April
27th. No.
I'm sorry.
No, since the respondent is not there, we'll close it.
Please, no.
Yes, next.
59, Lord, I'm the petitioner, my lord, in 12097. But I'm a freelance web developer.
Freelance web developer.
So respondent number 2 is a US citizen. I built the website. She asked me to upgrade the website. But for the purpose of upgrading the website, I created a mirror server so that the inflow can be tolerated. What happened, Lord, in the SSLC examination? On the date of examination, several mirror servers are created to, Lord, sustain the traffic. Now, I created a mirror server and then started developing the website. In the meanwhile, she changed the website, changed the password, saying that I have shifted the data from her server to my server for the purpose of upgradation. Then, by the time I developed the website and tried to put it to the original server, she changed the password. But this is most important. On 30th of December 2021, she files a civil suit for a mandatory injunction directing me to give the source code. But I filed the written statement.
Source code of the mirror.
Mirror scope, yes. And also to restore the entire website to her, provided the. In the meanwhile, I also demanded the payment for my work. She did not pay till today. That's a fact. On 20th of January 2022, I filed the written statement. The matter was referred to mediation. The mediation failed. Immediately after the mediation filed, she files a FIR on 6/6/2022, alleging violation of section 66 of the IT Act, suppressing the very filing of the civil suit with the identical facts, identical prayer.
That is pending?
Matter is pending. After the mediation filed, the FIR is filed on the ground that I shifted the data from her server to my server and I refused to restore it back. She changed the password. My amount is not paid. Now the counter demand is $100,000 US plus $10,000 US every week. If you pay, I'll release the entire the liability. This is the virtual blackmailing of, and I'm under digital arrest by the respondent number 2. The classic case of digital arrest.
May I, my lords?
Yes.
My lords, this is not a case as oversimplified in my opinion. It is a technical matter.
I'm sorry. Yes, please complete.
My lord, because it is a technical matter, I'm making these submissions.
What do you want?
My lord, serial number 79, I have filed for mandamus direction to the police to file a report on my complaint of 2023. In this matter, they had filed an earlier 2022 petition for quashing, which is tagged and come before me. Now, all I'm asking is for a direction to the police to file report. In response to their criminal petition for quashing, my lords, I am a citizen of Britain and I had engaged the services of the respondent to maintain my website, my lord. What my website is, my lord, I am an international journalist, specifically in the field of tunneling, my lords. All over the world, tunneling, whatever work happens, I report that in the form of an online magazine right from 2008. The accused came into picture in 2014. I had engaged somebody else. The website was already running and I replaced my service provider. The accused here is a service provider. This being said, my lord, from 2014 till 2021, the services were being provided by the respondent, which is maintenance of my website. Now, what is this website?
What
my
is the criminality?
criminality, my lord? The website has 3 different instances, my lords. One which is open to the public, which we open and see, and 2 which are the admin EC2 instance and third.
All right.
There were some dispute with respect to payment of invoices. This payment of invoice agilla ant heli, ratro ratri, the public instance, my lord, the one that is open to the public, he transferred it to his server. Now these websites run on a server, and the owner of the server will have access to what can happen in the website, which the complainant has, since it's her website, and even the respondent had, because he is the one who is maintaining the services. He transferred the public instance to his server. Had it been only transfer, my lord, I would not have filed this complaint. He transferred it and he deleted it in my server. He has admitted it in his petition itself. In a reply to, in one of the pleadings, there is an admission that there was a deletion. Now the question is, why should it be deleted? It was deleted, my lord. I don't know, my own service provider has done this, which is why I changed my password, because the other 2 EC2 instances have details of my advertisers, confidential information. I did not expect my own service provider to do this. I thought this was someone else, and I did that. During a communication, I get to know that it was him indeed who has done it. Now, after this, there was a negotiation, and I learned that time that because there was a dispute and he was agitated with so-called non-payment of dues, he did that. Now, the question here is, my lord, the criminality is deletion of the EC2 instance from my server.
Now, what is the civil suit that you filed
Identical. Page 43, my lord.
Filed for, and what is the relief sought there?
Civil suit is for mandatory injunction to give me the hosting services back to me. It's not for source code. He has filed a counter suit for source code. In fact, my lord.
So fight it out there.
My lord, but there is a criminal action in this case, which has. My lord, kindly see the emails that have been. He held me to a ransom to give back to host the website itself, my lord. How can that, just because, merely because a civil suit is
No, that's not the law. I'm not on that. Merely because civil suit is pending. It's not the criminal case should not continue.
In fact, if civil suit is being spoken of, there was an interim order in the civil suit, not a ad interim order. After hearing the party, for execution of that interim order also, it took 2.5 years. My website was off for 2.5 years. I had no business. For that interim also, I had to file a contempt, and it's only in the contempt that that interim order was fulfilled. In fact, my lord, there are emails which admit to say that the website can be hosted with an AMI instance. Which AMI instance I will not have access to edit anything.
That's a mirror created by him. How can you access?
Why did he not give me that?
Her own document, page 42.
He admits
everything. I don't
that
pay
he
me.
could have
Website
done
is
that.
running. Website is running. I'm sorry. I'm sorry.
Kindly see the emails, my lord. He says that AMI mirror image is possible, but I am not sure if that will have all the facilities that is hosting services is possible.
It will not have.
To give that also, he asked for money.
There is nothing. Nothing he can give. There is no.
I said,
that
do
can
not
happen
pay
with
money.
that.
You don't pay any money. This is their document, page number 42. They have
Lord,
produced.
I
said,
asked
don't pay
myself
any money
this
outside.
question, my lord.
In
I
their own-
asked myself
their own
this
document,
question
page number 42.
to draw an
Status of
analogy.
objection.
You ask yourself.
I'm asking, my lord.
Answer
If
yourself.
there is if I have a intellectual property right on a design I have created for somebody in their house, for instance, the house in itself. House is created, the architect has built the house, there is some payment dues. Does it mean he can come and you have not paid 20%, so I will
create another house?
No, I will distort the.
He's like, my lord,
Mirror house?
she asked me to repair the boarding house. I shifted the children to a new place. The moment I wanted to put them back, she locked it. This is exactly what is done.
No.
Then I said, I will not,
he just
don't even pay
destructed
the
my
amount.
house.
Please
He
open
just
the lock so that the
demolished
children
my
get.
house. Whether he has a copyright or not is secondary, my lord. That is secondary. But can he, on the claim of having a copyright, delete my own website is the
No,
question.
it's not deleted. It's not deleted. She
There is an
locked the
admission that he has
password.
deleted.
Password is locked. There is
My
a
lords, kindly see the
footprint of
admission
the
in their own
website.
petition. my
By
lords.
the submissions, what I gather is, he is your service provider. You have developed a website.
I developed.
You have developed.
I developed. I developed the website. Then for about 5 years, she handed over the work to somebody else. Then because I'm very good in Malad in these kind of things, she again came back to me. Please upgrade it. For the purpose of
Only
upgrading,
upgradation.
I cannot do it in the old
So
website. It has to be the-
upgradation goskara you mirrored it.
Yes, because it has to sustain the traffic. It has to sustain the infrastructure. By the time I opened the new server, I shifted the data. She thought that I've stolen the data and locked the original server. I said, please don't pay me the money. Please open the lock. I'll restore it.
So
And suit is filed.
My lord,
And that is referred to mediation after filing of the written statement. Mediation filed and the FIR is filed.
My lords, all
Stay
this
ಇದೆಯಾ?
Pardon me?
Interim order ಇದೆಯಾ?
Illa.
interim order to protect my data is there in my petition, my lords. There is no interim order in their petition.
Your
I'm
lordship,
told,
in read petition number, that serial number 79, we already filed charge sheet, lordship. So madam was
Imralla.
directing the respondent one. So ಅದು read petition file ಮಾಡಿರೋದು ಹಾಟು ಕಡೆಯಿಂದ.
Charge sheet challenge
ನಾವು ಆಲ್ರೆಡಿ
ಮಾಡ್ತೀರಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೇವೆ. ಸೊ ಅವ್ರು FIR ಕ್ವಾಶಿಗೆ ಹಾಕಿದ್ರು, ಅದು ಸಹ ಚಾರ್ಜ್ ಶೀಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿರೋದ್ರಿಂದ they have to challenge before.
You're not aware. Charge sheet challenge ಮಾಡ್ಬಿಡಿ. We'll take it. ಇದ್ರಲ್ಲಿ ನಿಮ್ದ್ರಲ್ಲಿ interim order ಇದೆಯಾ?
2026.
Alla, they are seeking mandamus to file the charge. That has become
That will
infraction.
become
That has
infractions if
become
the charge
infractions.
sheet
Charge
is
sheet
filed.
ಹಾಕಿದ್ರೆ.
And FIR ಕ್ವಾಶಿಗೆ ಹಾಕಿದ್ರು, ಅದು ಸಹ
ಅದೇ, we'll
charge
reserve
sheet.
liberty to challenge the charge
Yes,
sheet.
yes, yes.
An interesting point. We'll answer it.
That's what-
Yes. The 79.1 heard the learned
79.1.
counsel appearing for the petition. The prayer sought in the petition is now redressed with the statement of the learned additional SPP that final report is placed before the concerned court. The final report is the charge sheet. It's 79 ಅಲ್ಲಿ. They heard the learned senior counsel as Basavaraj appearing for the petitioner. I'll reserve liberty to challenge the charge sheet. The
Before APP and scrutiny, SCC number ಆಗ್ಬೇಕು.
CC number ಮತ್ತೆ
CC number ಆಗ್ಬೇಕು, ಸಬ್ಮಿಟ್ ಆಗಿದೆ.
ಆಗಾರ ಇಟ್ಕೊಳ್ಳಿ. Yes, CC number ಕೋರ್ಟ್ ಬಂದು ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲ?
ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗಿದೆ, APP ಮುಂದೆ ಇದೆ ಸ್ಕ್ರೂಟಿನಿ.
Then, my lord, you
10-3-20.
Then I'll
kindly stay-
consider it.
stay- Kindly stay the filing of the
10/3/26 ಗೆ
charge.
ಫೈಲ್ ಮಾಡಿದೀವಿ.
Then we'll hear
1
it.
or 2 days ಅಲ್ಲಿ ಆಗ್ಬಿಡುತ್ತೆ.
We'll hear it then. Yes.
Kindly stay the.
ಅವ್ರದ್ದು ಇರ್ಲಿ, ನಿಮ್ದು ಇರ್ಲಿ. ಎರಡು ಏನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಬೇಡಿ. List the matter on 2nd April in the fresh matters list. Charge sheet, if not numbered as on today, shall not be taken further, proceeded further till the next date of hearing. Yes. Heard the learned senior counsel ಅಂತೆಲ್ಲ put ಮಾಡಿ. Your petition next time we'll see. Anyway, our final report ಹಾಕಿದಾರಲ್ಲ ಈಗ.
Very good. In fresh matters, my lord.
Fresh matters. Yes.
For the petitioner, my lordship, may be taken up any
For
other day.
the respondent number 2, my lordship.
Maybe tomorrow it may be taken up, my lordship.
Tomorrow ಆಗಲ್ಲ sir.
My
Day after,
lordship,
my
they
lordship.
they are saying this very same thing before the trial court also, my lordship.
ಏನಿದು?
They have said, this is a summons trial, my lordship. ಅವರು ಬಾಯೋದಂಗೆ ಅವಾಚ್ಯ ಶಬ್ದಗಳನ್ನ
ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ
threaten
ಬೈದಿದ್ದಾರಾ?
ಮಾಡಿರ್ತಾರೆ ನಮ್ಮನ್ನ.
ಏನು ಅವಾಚ್ಯ ಆಗಿದೆ?
ಬಾಯೋದಂಗೆ ಬೈದಿರ್ತಾರೆ ಸ್ವಾಮಿಗಳೇ. ಅದಕ್ಕೋಸ್ಕರ there is a audio recording with respect to that. The complaint is an advocate. ಅದು ದೇವಸ್ಥಾನ ಕಟ್ತಾ ಇರ್ಬೇಕಾದ್ರೆ ಮತ್ತೆ ಸೊಸೈಟಿ ಒಳಗಡೆ ಹೋಗ್ಬೇಕಾದ್ರೆ ಇವ್ರು ಬಾಯೋದಂಗ್ ಬೈದಿರ್ತಾರೆ.
ಆಗ್ಲೇ ಬೈತಾರ?
ಅಪ್ಪಂದ ನೀನು ಬರೋದಿಕ್ಕೆ ಅಂತ
ನೀವು ಅದನ್ನ ರಿಪೀಟ್ ಮಾಡಬೇಡಿ.
Yes. Without taking permission from the magistrate.
ಅಲಿಗೇಷನ್ ಗೊತ್ತಲ್ಲ, ಅವಾಚ ಶಬ್ದದ ಉವಾಚ. I will dismiss this.
My lordship, after 2 days, my lordship, senior
ಏನ್
ಬರ್ತಾರೆ.
stay ಏನಿಲ್ಲ.
ಏನಿಲ್ಲ sir.
ಮತ್ತೆ ಯಾಕೆ ನಿಮ್ಗೆ
ಹಳಿದ
ಅರ್ಜೆಂಟ್? List the matter on 6th in the fresh matters list. Next.
6th ಇದಕ್ಕಿದೆ ಸ್ವಾಮಿ, ಚಾರ್ಜಸ್ ಇದೆ, ಟ್ರಯಲ್ ಕೊಟ್ಟ.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಕ್ಕಿದೆಯಾ?
ಹಾ ಹೌದು ಸ್ವಾಮಿ. Any day
charges
before.
frame ಆಗಿಲ್ಲ
ಮತ್ತೆ?
ಸ್ವಾಮಿ, charges frame ಆಗ್ಬೇಕು.
Stage
Yes, yes, 6,
From
6,
past
next.
3 years they are not appearing before the court at all.
ಕಂಪ್ಲೇಂಟ್ ಅಡ್ವೊಕೇಟಾ?
ಕಂಪ್ಲೇಂಟ್ ಅಡ್ವೊಕೇಟ್ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾಗ ಅಸಿಸ್ಟ್ ಪಿಪಿ ಮಾಡೋದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾಗ ಇವಾಗ ಬಂದಿದ್ದಾರೆ. ಆಫ್ಟರ್ 3 years they have come before this court challenging that filing for a discharge, my lord.
6th fresh matters. Yes.
Much obliged.
Orders
Withdrawal in terms of
82.
same non-filing of ಹೌದಾ? 82 ನಾ?
Seeking times memo for withdrawal, my lord.
Which one? 82?
Yes, my lord.
Yes. In terms of next, you are the petitioner or respondent?
Petitioner. I am.
ಈ ಕಡೆ ಬನ್ನಿ sir. Respondent giving memo for withdrawal? Yes.
Not seeking modification of interim order, my lords.
Modification, why, sir?
Lords, reason is this, my lords. In the previous date of hearing, proclamation was stayed, my lords, subject to appear before the
ಈಗ appear ಆಗಿದ್ದೀರಾ?
My lords, Dubai ಅಲ್ಲಿ ಇದ್ರು, my lords.
ಬರ್ರಿ ಬರ್ಬೇಕು ಇಲ್ಲ ಅವೆಲ್ಲ ಮಾಡಿಫೈ
ಬಂದಿದ್ದಾರೆ, my lords. Kindly,
ಅಪಿಯರ್ ಆಗಿ
my lords, ಇವಾಗ proclamation ಮತ್ತೆ restore ಆಗ್ಬಿಡುತ್ತೆ, my lords.
ಸರಿ, ಯಾವತ್ತು ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
My lords, in the next week, my lords.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಏನು ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Lords, next date ಇರೋದು September 2nd.
ಮತ್ತೆ
Lords, in the next week, we'll advance the matter and we'll appear.
The petitioner undertakes to advance the matter and appear before the concerned court, subject to the said condition. The proclamation, the interim orders granted shall continue. List the matter on 16th April. In the event no such steps are taken, the proclamation would stand restored and no indulgence will be shown.
Deep progress.
84.8.
ಇದ್ಯಾವ್ದು BC ಮೈಲಾರಪ್ಪ ಕನೆಕ್ಟ್ ಆಗಿ ಅದೇನ ಇದು? ಹಾ, ಏನ್ ಮಾಡಿದ್ರಿ? ಸೆಟ್ಲ್ ಆಗ್ಲಿಲ್ವಾ? Came from Delhi for what settlement?
84.8 has been wrongly tagged.
You came from Delhi for this?
No, not for 5 of the accused, because the matter has already been watched on the basis of settlement.
No, this matter is wrongly tagged, is it?
Yes, but
Give it.
No, my lords, 84.2, it is not.
84.8, sir.
8 and 2, 84.2 and 84.8 are wrongly tagged. Now, these are two
That is,
matters.
crime number is different.
Different.
Copy is not been served on that.
One ನಿಮಿಷ, 84.2.
And 80.4, not 8.
D-link 84.2 and 84.8.
In this case, 5 out of 9 accused.
In which 2 or 8?
8. Both, Malad. It is the same case. Those 5 accused, the matter has been quashed on the basis of compromise. In fact, the main allegation was against accused number 2, Malad, that he took 1.5 lakh rupees in cash from the complainants. In fact, Malad, the complainant does not even have the locus. It is the driver. For accused number 2, Malad, his driver's friend gave him 1.5 lakh rupees in cash.
What's the offense, sir?
420.
ಬೇರೆಯವರು ಕೋಶ ಆಗಿದ್ರೆ ಮತ್ತೇನು?
ಇಲ್ಲ, ಬೇರೆ ಇದ್ರಲ್ಲಿ ಕ್ವಾಶ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ನಮ್ದ್ರಲ್ಲಿ ಆಗಿಲ್ಲ, ಕಾಂಪ್ರಮೈಸ್ ಆಗಿಲ್ಲ. Copy is not been served on me.
He'll serve the copy.
Cases, connected cases are there.
Day after tomorrow.
Malad, against the allegation was against accused number 2. He has already.
This is on compromise, sir.
Yes,
That is on compromise.
yes, Malad.
Complainant is here. You settle it with him now.
Malad, I am on merits. Malad.
Merit student.
Merits, Malad.
You will come on merits.
Yes, Malad.
When do you come again?
Malad, tomorrow is possible, Malad.
Tomorrow is not possible at all. Day after tomorrow, yes. Day after tomorrow, fresh, D-link 84.2 and 84.8, list them both. Day after tomorrow in the fresh matters, list counsel for the respondent so and so undertakes to enter appearance for the complainant petitioner to serve set of papers upon the complainant.
Two more connected cases.
84.2. 84.2.
Ada
84.8.
day after tomorrow, sir.
Lordship, our main matter, my lord, 84, my lord.
Main matter yavat hakana?
My lord, any nearest date, my lord, for lordship.
Main matter on 8th.
Lord, 84.3
Interim order may be
delayed
extended,
because it pertains to allegations of forgery and
84 point?
3 millets.
ಯಾಕೆ ಕನೆಕ್ಟ್ ಆಯ್ತು ಮತ್ತೆ ಇದೆಲ್ಲ?
The matters they've been connected by the
Only
petitioner,
two.
they saying that.
84.3 D-link. Yes.
My lord, interim order may be extended.
Interim orders will continue. Yes, next.
My lord, 84.5, my lord.
80?
4.5 appearing for the respondent.
Case and
Lord,
counter
the
case.
Case and counter case was filed by the complainant.
Iರ್ಲಿ next 8th ಕೇಳೋಣ ಸುಮ್ಮನೆ. Yes.
No, in
Lord,
that matter, my lord,
84.5
they have
is
been
our
issued in a
matter.
paper publication in the Imagni paper publication, my lord. They are issued to the against to the petitioner who are the de facto complainant Pavitra, and they have been published to the paper publication by the Mailaraya. And the paper is going to be published on 26/6, my lord, 26/3 and this month.
ಯಾಕೆ ಸುಮ್ಮನೆ ಇರಕ್ಕಾಗಲ್ವಾ?
They were.
My lord, we are not, my lord, my lord, this is, my lord, we are taking high objection, my lord.
This is the case, I will dismiss it straight away.
Taking objection to this type.
If I show indulgence, don't think that you can do all this. ಕೊಡಿ ಇಲ್ಲಿ.
Showing, my lord. Madam, ತಗೊಳ್ಳಿ.
My lord, we are taking serious objection to this type of submissions by them, my lord.
Who has published? Who has
They are
given
not
this?
published, my lord. ಇವರೇ ಮಾಡ್ಕೊಂಡು
ಒಂದ್ ನಿಮಿಷ wait.
ಇವರೇ ಮಾಡ್ಕೊಂಡೆಲ್ಲ ನಮ್ಮ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಹಾಕ್ತಾರೆ. FIR ಮೇಲೆ FIR ಆಗ್ತಾ ಇದಾರೆ ನಮ್ಮ ಮೇಲೆ. ಇವರು
ಪ್ರವೀಣ್ ಗೌಡ್ರೆ
pressure
ಏನಿದು?
ಹಾಕೋದು ಇದೆಲ್ಲ ಮಾಡ್ತಾ ಇದಾರೆ ಎಲ್ಲ ಕಡೆ ಬಂದು.
We make one submission.
Yes.
In fact, there are messages
I'll also place a recording where Rama Devi had called me. He can't deny it. Her No, own we'll number. deny it, my lord. No. 1 second, let me complete.
ಅವ್ರು
Let me
wait.
complete. They are in the modus of operandi that whomsoever appears, and they are trying to pressurize them. She says, President ಆಚೆ ಹೋಗಿದ್ದಾರೆ, Vice President ಆಚೆ ಹೋಗಿದ್ದಾರೆ, ನೀವಾಗ ಕೆಲಸ ಮಾಡ್ತೀರಾ, ನಿಮ್ಗೂ ಹಿಂಗಾಗುತ್ತೆ. This what the recording, I'll place it before this court. Now, this publication they're sent by, let there be a thorough investigation. Now I filed a suit. Now there's an injunction has been granted today. And now the contents, adalta contents ನೋಡ್ತು ಅಂತಂದ್ರೆ, you can't even imagine. I don't know. Now, what is their problem with the girl and boy? I go to an extent of making a statement that, okay, I had an affair with somebody. What is his problem? What is this got to do with my life?
Calling bell problem.
Calling bell problem. My lord, may I make my submission now, my lord? ಇವರು ಪ್ರತಿ ಸರಿ ಇವರೇ ಡಾಕ್ಯುಮೆಂಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಕೊಂಡು ಅದನ್ನ ಪಬ್ಲಿಷ್ ಮಾಡ್ಬಿಟ್ಟು ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಏನು ತರಲ್ಲ, ಸುಮ್ನೆ ಹಿಂಗ್ ಆಫ್ ಹ್ಯಾಂಡ್ ಕೊಡೋದು. ನಮ್ಗೆ ಅಟ್ಲೀಸ್ಟ್ ರಿಯಾಕ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕೊಡ್ಬೇಕು ಅವ್ರು.
ಅಲ್ಲ, ಆಫ್ ಹ್ಯಾಂಡ್ ಕೊಡೋದು ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್. If you don't encourage restraint and start doing all these things, I will dismiss and direct thorough investigation to be conducted by independent investigating agency.
My lord, ಇವ್ರದ್ದು my lord, ಇವನ್ ಬೇಲ್ಗೆ.
I'll tell you one thing, sitting in a glass house, you can't throw stones at somebody else. You are yourself in a problem now. What is this you are doing?
My lord, ಅವರೇ ಮಾಡೋದು ಇದು. ಇವನ್ ನಮ್ ಬೇಲ್ಗುನು ಕೋರ್ಟ್ ನುಗ್ಬಿಟ್ಟು ಬೇಲ್ ಕೊಡ್ಬೇಡಿ, ಅಸೋಸಿಯೇಷನ್ ನುಗ್ಗೋದು.
ಕೋರ್ಟ್ ಬಂದ್ಬಿಟ್ಟು ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, ಪ್ರತಿ ಸರಿ ಅವರು ಪ್ರತಿ ಒಂದ್ ಸರಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
dignifiedly opposed and we have argued the matter.
ಇಲ್ಲ, ಡಿಗ್ನಿಟಿ ಎಲ್ಲೂ ಮೇಂಟೈನ್ ಮಾಡಿಲ್ಲ, ನಮ್ಗೆ ತುಂಬಾ ತೊಂದರೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದೇನ್ ಮತ್ತೆ ನೀವು ಮೇಂಟೈನ್ ಮಾಡಿದೀರಾ?
Let them serve a copy on us.
ನೀವು ಮೇಂಟೈನ್ ಮಾಡಿದೀರಾ?
We didn't do it, my lord. ಅವರು ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ತುಂಬಾ ಪ್ರೆಷರ್ ಟ್ಯಾಕ್ಟಿಕ್ಸ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇರೋದು. ಬ್ಲಾಕ್ ಮೈಲಿಂಗ್ ಟ್ಯಾಕ್ಟಿಕ್ಸ್, ಪ್ರತಿ ಸರಿ ಬ್ಲಾಕ್ ಮೈಲ್ ಮಾಡೋದು. They were expecting something, my lord, and doing all this.
What expecting something, sir?
My lord, if not, why would somebody do that, my lord? We have not done it. We'll give a reply to that, my lord. Let them put it on record.
I'll put it
WhatsApp
on record.
anತಾರೆ, ಅದನ್ನ ಏನು ಕೊಡಲ್ಲ ಕೋರ್ಟಿಗೆ.
May make one submission. I'll put all the contents of WhatsApp message what Mr. Mailaraya has been sent. Let my learner friend look into it. Whether they are my sister or brother, whomsoever of this woman in this country, they have been they should be respected because she was working under him. That doesn't mean that. ಬೇರೆ ಬೇರೆ ಅರ್ಥದಲ್ಲಿ ಹೇಳಿರ್ತಕ್ಕಂಥದ್ದು ಅವ್ರ ನಂಬರ್ ಇಂದನೇ ಬಂದಿರ್ತಕ್ಕಂಥದ್ದನ್ನ ಟೈಪ್ ಮಾಡಿ ತಮ್ಮ ಮುಂದೆ ಕೊಡ್ತೀನಿ, ಆ ಫೋನ್ ಕೊಡ್ತೀವಿ, ತಾವೇ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿ. Let my learner friend also know about it. And he used a play card of stating that he is a Dalit. ಇದೊಂದನ್ನ ತಗೊಂಬಂದು ಎಲ್ರಿಗೂ ಹೆಂಗ್ ಮಾಡ್ತಾ ಇದ್ರು. ನನಗೆ ರಮಾದೇವಿ ಕಾಲ್ ಮಾಡಿರ್ತಾರೆ, ಸರ್ ಸಂಘದಿಂದ ಬರ್ತೀವಿ ಅಂತ. What am I said? You can't talk all this. ನನಗೆ ಅದನ್ನ ಎದುರಿಸಕ್ಕೆ ಬರಬೇಡಿ. This is what I've used.
Become a fashion, my lord, to say
no.
Dalit ಅಂತ ಒಂದು ವರ್ಡ್ ಯೂಸ್ ಮಾಡೋದು.
One minute,
sir.
Who has sown the seeds of all this?
My lord,
you.
ಇಲ್ಲ, ಅವ್ರು ಏನ್ ನಾವು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀವಿ, ಅವರು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ತರಲಿ, ನಾವು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀವಿ. ಅವ್ರು ದಲಿತ್ ಅಂತ ವರ್ಡ್ ಯೂಸ್ ಮಾಡ್ಕೊಂಡು
he will file everything.
ನಾವು FIR ಹಾಕಿಲ್ಲ.
And if I find that what he says is correct, I am going to order a different investigation. Not entertaining this is a different thing. You'll have to face it.
ನನ್ನ ಮಕ್ಕಳು ಸ್ವಾಮಿ ಇಂಜಿನಿಯರಿಂಗ್ ಓದ್ತಿರೋ ಮನೇಲಿ ಓದಕ್ಕಾಗಲ್ಲ.
just because he makes submissions,
you put everything on record.
ಏನು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ತರಲ್ಲ ಅವರು.
You put everything on record. Yes. ನಾನ್ ಸೆಟಲ್ ಮಾಡ್ಲಿ ಅಂತ ಇಂಟೆಲಿಜೆನ್ಸ್ ತೋರಿಸಿದ್ರೆ ನೀವು
ಅಲ್ಲ, my lord, last time also
the allegation itself is horrible. Why do you go in the wee hours and ring the calling bell of a woman?
My lord,
a woman's house.
My lord, ಇದು ಒಬ್ರು ಚಂದನ್ ಅಂತ ಒಂದು ಪೊಲೀಸ್.
Why did you go?
My lord, ಪೊಲೀಸ್ ಆಫೀಸರ್ ಒಬ್ರು ಚಂದನ್ ಅಂತ ಇದ್ದಾರೆ. ಈ ಅಡ್ರೆಸ್
whatever it is, why did you go?
ಈ ಅಡ್ರೆಸ್ ಇದೆಲ್ಲ ಸರ್, ಈ ಅಡ್ರೆಸ್ ಫೇಕ್. ಇವರು ಸುಮ್ನೆ ಅವರ ಬೇರೆ ಮೂರ್ FIR ಅಲ್ಲಿ 3 ಅಡ್ರೆಸ್ ತೋರಿಸಿದ್ದಾರೆ. ವಿಲ್ ಸಬ್ಮಿಟ್ ಇಟ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ಮೈ ಲಾರ್ಡ್. ಇವ್ರದ್ದು ಕೈಂಡ್ಲಿ ನಾಟ್ ರೆಸ್ಟ್ ಪ್ಯೂರ್ಲಿ ಆನ್ ದೇರ್ ವರ್ಡ್ಸ್ and
I have not passed any order. I have asked him to place everything on record.
Yes, we'll also react to it.
Also I made this statement. I stand by my words. I said, let there not be any stay. Even I will go. I'm ready to go on for the investigation. Let them also submit.
We don't trust any of his statements, my lord. We will reply to it.
You file it, sir. Praveen Gaur, ನೀವು ಹಾಕಿ. Gautam, you also file.
Sayer office na adal ಬರ್ದಿದ್ದಾರೆ. On website there's one AI picture where he has said he has used such a word that on a woman stating that all
My lord, one
unwanted
police
things
officer
are.
involved idare idralli. They are
Who was
hell
involved?
bent on
No,
fixing.
we'll
Yes, my
definitely
lord.
direct investigation.
Human Rights Commissioner complaint ಇದೆ. ಇವ್ರು
Whatever
ಏನೇನ್
it is,
ಮಾಡಿದ್ದಾರೆ?
we'll direct investigation
Yes,
of a proper kind in this.
Yes,
If this is the
Even these
attitude of,
people should not be spared,
if
my
this
lord.
is the, whoever it is,
And
whoever,
entering-
they will not fight shy from
bail ಗೆ
investigation.
one bail ಗೆ they don't give the courtesy of a human being, my lord. They enter into the court of a judge and
ಅರೆ,
pressurize
ಅದು
the
judge
judge.
complain ಮಾಡ್ಬೇಕು. Why are you worried?
We are facing it, my lord, as a human being. How it is possible, my lord? Every time Dalit word use ಮಾಡೋನು ಎಲ್ಲಿ ಒಂದ್ FIR ಹಾಕಿಲ್ಲ ಅವ್ರ ಮೇಲೆ.
ಆಯ್ತು, we'll see.
ಇದು
Misusing of that
ಅದೇ calling bell case.
Gautam's client's problem with his girlfriend.
ಅಲ್ಲ ಇದೆಲ್ಲ ಮೆಲಾಡ್ ಇವರು ಸುಮಾರಿದೆ ಇವ್ರ ಬಗ್ಗೆ ಹೇಳೋದು ನಾವು ವಿಲ್ ಸಬ್ಮಿಟ್ ಮೆಲಾಡ್ ಅದನ್ನ ನಾವು ಜಸ್ಟ್ ಸಿಂಪಲ್ ಆಗಿ ಏನೋ ಒಂಥರ ಅವ್ರು ಹೇಳ್ಬಿಟ್ರೆ ಇದಾಗೋದಿಲ್ಲ.
ಆಯ್ತು, ಹಾಕಿ, ನೀವು ಹಾಕಿ ಎಲ್ಲ ಫೈಲ್ ಎವ್ರಿಥಿಂಗ್.
ಅಲ್ಲ, let the date may be fixed, my lords.
ನಾಡಿ ಫ್ರೈಡೆ ಆರ್ ಫಸ್ಟ್ ಏಪ್ರಿಲ್ ಯಾವತ್ ಬೇಕು?
Monday, my lords.
ಫಸ್ಟ್ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ರಜಾ ಅಲ್ಲ, ಫಸ್ಟ್ ಏಪ್ರಿಲ್. ಸೆಕೆಂಡ್ ಏಪ್ರಿಲ್, ಆಲ್ ರೈಟ್.
84.3 is connected with this matter. He has submitted that it is not connected.
Let him not, ಏನಾಗಿದೆ, in the meantime, they are circulating all sorts of messages.
My lord, ಅವ್ರು ಮಾಡ್ತಾ ಇರೋದು my lord, ಇವ್ರು ಹೇಳೋದೇನಂದ್ರೆ ಭಾರಿ ಸಾಚ ಇವರು.
No,
ಒಂಥರ ಇವರು
if that is being, stop it, all right? Till I hear it, encourage restraint. Yes, list the matter on second. You file everything, whatever is to be filed.
high-handed
And if there is any circulation by him,
If
by
they
that
are
date,
doing it,
you
my
let
lord,
me know.
if they are doing it, my lord.
Whatever we have got, we'll file it.
Please file, we will consider it, yes.
He has taken ನಮ್ಮ ಲಾಯರ್ family.
ಅಲ್ಲ my lord,
photo ಹಾಕೋದು.
my lord, ಇದು
90
ಹೆಂಗಂದ್ರೆ
photo ಹಾಕಿದ್ದು,
my lord, ಇದು ಒಂಥರ ಪ್ರೆಜುಡಿಸ್ ಮಾಡೋದು. ಇವ್ರದ್ದು ಅಟೆಂಪ್ಟ್ ಏನಂದ್ರೆ ಪ್ರೆಜುಡಿಸ್ ಮಾಡೋದು. ಒಂದ್ ಏನೋ ಲಾಯರ್ ಫ್ಯಾಮಿಲಿ ಅಂತೆಲ್ಲ ಹೇಳ್ಕೊಂಡು ಇವ್ರದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಇದೆಯಲ್ಲ, ಇಟ್ ಇಸ್ ವೆರಿ ಹೈಲಿ ಅಬ್ಜೆಕ್ಷನಬಲ್ my lord.
He will put it on record also, sir. He will put it on record.
The other day, I also made a submission. It's not the question of a lawyer. It's a question of a victim and a woman who is supposed to be respected.
Pavitra is not a lawyer, my lord.
No, she is not. When did I say that she is a lawyer? She is a woman. She has to be
ಇವಾಗ
respected.
woman.
That's all right, yes.
Now
We'll take it on, ಯಾವತ್ತು? Second April.
Yes.
List the matter on 2nd April. The objections will be filed by then. You file everything, whatever is to be filed.
ಅಡ್ವಾನ್ಸ್ಡ್ ಆಗಿ ಕಾಪಿ ಕೊಡ್ಲಿ.
We'll submit.
Yes.
Please.
Next.
We tender our apologies, madam.
ಯಾವ್ದಕ್ಕೆ?
We didn't do anything, my lord.
that
We have
will
not
help.
done anything,
Yes,
my lord.
yes.
So apologies.
Praveen Gowda in knowledge. Yes.
85, my lord, I undertake to file wakalat.
Petitioners, my lords.
85 ಏನ್ ಮೇಡಮ್ ಇದು?
So 138, my lord, in the
138
appeal,
matters,
they
my
filed an application on section 391 to produce additional documents. It has been dismissed, my lord. That is under challenge.
That's last. Italy, this honorable court had directed us to serve a summons over the trial court advocate, the same thing.
ಇವ್ರೆ
has been done.
ಮಾಡಿದಾರೆ.
How-
Yes. ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ.
ಹಾಕಿಲ್ಲ, my
Learned
lords.
counsel Dilip Kumar.
What they have challenged is, my lord, there are two cases. One case, the document which has been sought in this case is not connected to this case, but connected to the other case. In that case, they have already produced. In that case also, they have been convicted. But these documents are
We'll
immaterial.
see, whatever. If a document is producible, we'll permit.
Not in this case.
We'll permit
connected to
if
this
it is
case.
needed, we'll permit. We'll see. ನೀವು objection ಹಾಕಿ ಅಥವಾ ವಕಾಲತ್ ಹಾಕಿ first.
Yes,
I
my
will file.
lords.
I'll take it on second.
Grateful, my lords.
Second in the fresh matters list, learned counsel so and so undertakes to enter appearance for the respondent registry to print the name of so and so is appearing for the respondent. Second, interim order subsisting would continue till the next date of hearing.
Grateful, my lords.
86.
The petitioner, my lords. Needful done, my lords. Trial court, we have matter on 26. my
Learned
lords.
counsel submits needful has been done, office to verify, interim order continue ಮಾಡಿ. Please next. Extension ಎಲ್ಲ ಚೇಂಬರ್ ಕಳಿಸಿ ಮಾಡಿ. 88, 89 ಎಲ್ಲ ಚೇಂಬರ್ ಕಳಿಸಿ. ಮಿಕ್ಕಿದ್ದೇನು ಆಯ್ತಲ್ಲ, ಇನ್ನೆಷ್ಟು ಇನ್ನೂ ಇದೆಯಾ?
My lords, this 90.
ಕರೆದು ಬಿಡ್ತೀನಿ ತಾಳಿ ಮೇಡಮ್. ಎಸ್
90.
ಇನ್ನು 65 wait. Yes.
That's
90.
the petitioner 90, 90.1 and 91.
My lords, parties are actually family dispute.
All right.
Offenses in 1990.1 are under 498A and 306, whereas 91 is a 138 against a minor child's bank account.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಅಲ್ಲಿ.
There is a stay, my lords. I'm only asking for reference to mediation. There's
All
a,
right, we'll refer it to, who appears for the respondent? Respondent Mohan served.
my lords, I'm informed that they are logged in.
Mohan, MK Mohan, anybody representing? Unmute, madam. We'll refer it to mediation. That is enough. Unmute other parallel, mark the other parallel. The learned counsel appearing for the parties would submit that if the matter is referred to mediation, there are chances of settlement. In that light, parties are directed to appear before the mediations and so and so. On, when do you want it, madam?
My lords,
2nd
in
April?
fact, there is a mediation already. The next date is 2nd April.
2nd April.
2nd
Yes.
April maybe.
On April the 2nd, 2026. List the matter on 9th April. Interim order subsisting will continue to the next date of hearing.
Much
Yes. The registry is directed to transmit the papers for the purpose of mediation. Next.
91,
My lords, same order in 91 as well.
Same order. Yes.
92,
Your Lordship, we filed an application before the victims, my lord.
We are for the victims.
One victim, there's only one victim.
What is recalling, madam?
Yes.
What application?
We filed an application, my lord, for the recalling of that order. They settled the matter without,
Oh, yes, this matter. Without the informant being the party. List the matter on 27th in the fresh matters list, so that it will reach. Yes. I've recalled it or notice matra issue agirade? Yes, all right. B group will take it another day. Irade mooru kardu bidi. Okay, yes.
Appear for the petitioners.
Prithvish, entry order ideyalla?
ಇದೆ.
IO 2 weeks. Yes.
Short date.
CBI ಐತಲ್ವಾ?
Petitioner has retired.
Oh, then
Any short date?
we'll take it on 16th.
Obligation.
94?
For the petitioner, my lord, challenging the 138 proceedings, my lord. The allegation is that, my lord, that,
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು?
138
ಎಂಟೈರ್
proceedings.
ಪ್ರೊಸೀಡಿಂಗ್
Yes,
ಸ್ಟೇ
yes.
ಇದೆಯಾ?
ಇಲ್ಲಮ್ಮ.
ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಹಾಕಿದೆ ಮತ್ತೆ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಕ್ ಹೇಳಿದ್ರೆ ಅದಾದ್ಮೇಲೆ ರೀಚ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ.
List the matter on first in the fresh matters list.
My lord, fourth ಗಿದೆ.
First is before fourth. Yes.
95,
For petitioner, my lord, interim order ಇದೆ.
ಇದೆಯಾ?
FA for the respondent. my lord.
Vacating stay ಹಾಕಿದ್ದೀರಾ?
Lords will file minutes.
ಏನು?
Allegations, my lord.
Offense?
329,
Hate speech, my
351.
lord.
Huh?
Hate speech. Private complaint.
Hate speech ಗೆ ಲೇಟ್ ಸ್ಪೀಚ್ ಆಗೋಯ್ತು. ಇನ್ನೊಂದು ದಿನ ತಗೋಣ.
Lords will fix a date.
List on 18th.
Copy not served.
ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ. ಇನ್ನೂ ಹಾಕೇ ಇಲ್ಲ ಅವ್ರು, ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. Please. List the matter on 17th April IO. Next.
Interim order. Great.
ಅಷ್ಟೇ.
further hearing. 111,
Oh, yes.
Administrator is appointed.
Let them have an election, Lord. We don't have any objection. Sorry. Let them have election, Lord. We don't have any objection. After publishing a new voters list, Lord, giving a 3 months notice, my Lord.
It's
let them
special
have
order
election.
ಆಗಿದೆ. Yes,
Yes, my lords, I have filed an impleading application in.
who is to answer? Oh, yes,
473.
madam.
State. My lord, if I may, the first petition, my lord, which is filed, writ petition 24000 of 23, is challenging the procedure when we notified the council for elections, since the last elections were held way back in the year 2003. And for whatever, there have been 4 returning officers appointed at some point.
We'll direct holding of the elections
Yes,
now.
my lord, that's what we also insist, my lord.
Fresh process
we
will
are-
be directed, my lords.
meanwhile-
There's also another.
No, but after drawing the voters list,
Please,
3
my
months,
lord,
that
difficulty.
procedure is completed?
No, my lord, the difficulty is now there are some people who claim to be lifetime members. However, now we have said there can be no lifetime members. Everybody has to renew their membership. And once you pay renewal fees,
No.
you'll
See,
be considered for counting.
In accordance with law, the returning officer, whoever it is, will draw the voters list. And then I will grant you 2 or 3 months time to complete the election process.
There is in a procedure, my Lord. 3 months they have to give a notice
Under section 43, 3 months before they have to prepare a voter list, then they have to hold an election. 43.
Yes, madam.
My lord, some of the members who claim to be lifetime members are refusing
is-
to renew their membership.
Whatever it is, procedure will be followed and elections will be conducted.
Please, my lord, they
This
raise
can't go on
objection.
23 ನಂಗೆ ಇದೆಯಾ?
My lord, they
Adu-
come
meanwhile,
challenging
madam,
the
what happened,
appointment
madam?
of administrator and they stall the elections themselves. We've made attempts. They find objections at some point. Now, the lifetime members say, we will not renew our membership, therefore you should allow us to vote without renewal. We're saying every person has to renew their membership and you will be counted in for the voters list.
No, meanwhile, what happened, my lord?
Without their cooperation,
After
my lord,
interim
there
order
will be
granted by
another.
this honorable court, my lord.
No, we'll pass appropriate orders.
Well,
You take it as disposed, I'll pass orders.
Yes, in
Well,
seven
once-
four
once
seven
again-
three, my lord,
well,
the
one
challenge
more-
is that they have put a qualification for applying for the post, my lord.
What qualification?
That they should have some experience and
Huh.
adanna that it is not prescribed anta adanna
So contrary to the statute ಇದ್ರೆ ಬರಲ್ಲ. No,
it is not contrary to.
ನಿಮ್ಗೆ ಏನ್ ಬೇಕಾದ ಹಾಕೊಳಕ್ ಆಗಲ್ಲ. Whatever is in the statute, you hold it.
Let it happen as per statute. Our only
That's
concern
all.
is election should happen. They should not shift over it for
Elections will
decades.
happen. These three will take it as disposed, will.
Another 2 matters are there, my lord.
ಇನ್ಯಾವ್ದು?
ಯಾರದ್ರಲ್ಲಿ 2 matter ಇದೆ, ಇನ್ನು ಬೇರೆ.
ಅದೇನು?
ಅದು ಒಂದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ they have appointed because of interim order granted by this honorable court, my lord, one in for appointment this election, my lord. Another, my lord, a nomination which has been done by the government. Now, my lord, they have appointed an administrator, my lord.
Then we'll take it at 2:30 day after tomorrow. You come at 2:30, madam.
Section 45, my
ತುಂಬಾ
lord.
ಲೇಟ್ ಆಗೋಯ್ತು.
ಆಯ್ತು, please.
2:30 day after tomorrow. ನೀವ್ ಯಾರಿಗೆ? ಜೊತೆಗಿದ್ದೀರಾ? 54 ಪಾಸ್ ಓವರ್ ಆಯ್ತಾ? ಏನಾಯ್ತು? ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿ, I'll consider, I'll direct. Yes. So ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
1 to 4 list 2 to 4 ಆಗೋಗಿದೆ.
ಆಯ್ತು, husband not before the court. 2 to 4.
1 to 4.
108 minutes, runs of orders.
108.
Serial number 108.
ಏನಾಯ್ತು?
Orders.
ಯಾವ್ದಪ್ಪ ಅದು? ಏನ್ ಬೇಲ್ ಮ್ಯಾಟ್ರಾ?
ಇಲ್ಲ ಸರ್. Criminal
50 lakhs.
Please.
Yes. We'll see. ಮತ್ ನಾಡಿದ್ದು ಹಾಕ್ತೀನಿ, ಮಾಡಿದ್ ಮಾಡಿ.
Oblige.
Millard, after 7, Millard, senior counsel is not available.
Dictating, sir, not arguments. Yes.